formation, was used in the sham espionage trial against another CIA agent, Richard Craig Smith. During Rewald's trial, Justice Department prosecutors and CIA witnesses denied that Rewald was a CIA employee, and denied that BBRDW was set up by and for the CIA, funded by the CIA, and all activities controlled by the CIA. Rewald had to sign a standard CIA agent security agreement, Secrecy Agreement 1. I, Ronald Rewald, hereby agree to accept as a prior condition of my being employed in, or otherwise retained to perform services for, the Central Intelligence Agency, or for staff elements the Office of the Director of Central Intelligence, the obligations contained in this agreement. 2. I understand that in the course of my employment or other service with the Central Intelligence Agency I may be given access to information which is classified with the standards set forth in Executive Order 12,065 amended or superseded, or other applicable executive order, and other information which, if disclosed in an unauthorized manner, would jeopardize foreign intelligence activities of the United States government. I accept that by being granted access to such information I will be placed in a position of special confidence and trust and become obligated to protect this information from unauthorized disclosure. 3. In consideration for being employed or otherwise retained to provide services to the Central Intelligence Agency, I agree that I will never disclose in any form the following categories of information or materials, to any person not authorized by the Central Intelligence Agency to receive them. A. Information which is classified pursuant to executive order and which I have obtained during the course of my employment or other service with the Central Intelligence Agency. B. Information, or materials which reveal information, classifiable pursuant to executive order and obtained by me in the course of my employment or other service with the Central Intelligence Agency but which because of operational circumstance or oversight, is not formally marked as classified in accordance with such executive order, and which I know or have reason to know has not been publicly acknowledged by the agency. C. Information obtained by me in the course of my employment or other service with the Central Intelligence Agency that identifies any person or organization that presently has or formerly has had a relationship with a United States foreign intelligence organization, which relationship the United States government has taken affirmative measures to conceal. 4. I understand that the burden will be upon me to learn whether information or materials within my control are considered by the Central Intelligence Agency to fit the description set forth in paragraph 3, and whom the agency has authorized to receive it. 5. As a further condition of the special confidence and trust reposed in me by the Central Intelligence Agency, I hereby agree to submit for review by the 254. Central Intelligence Agency all information or material including works of fiction which contain any mention of intelligence data or activities, or contain data which may be based upon information classified pursuant to executive order, which I contemplate disclosing publicly or which I have actually prepared for public disclosure, either during my employment or other service with the Central Intelligence Agency or at any time thereafter prior to discussing it with or showing it to anyone who is not authorized to have access to it. I further agree that I will not take any steps toward public disclosure until I have received written permission to do so from the Central Intelligence Agency. 6. I understand that the purpose of the review described in paragraph 5 is to give the Central Intelligence Agency the opportunity to determine whether the information or materials which I contemplate disclosing publicly contain any information which I have agreed not to disclose. I further understand that the agency will act upon the materials I submit and make a response to me within a reasonable time. 7. I understand that all information or materials which I may acquire in the course of my employment or other service with the Central Intelligence Agency which fit the descriptions set out in paragraph 3 of this agreement are and will remain the property of the United States government. I agree to surrender all materials reflecting such information which may have come into my possession or for which I am responsible because of my employment or other service with the Central Intelligence Agency, upon demand by an appropriate official of the Central Intelligence Agency, or upon the conclusion of my employment or other service with the Central Intelligence Agency. 8. L. Agree to notify the Central Intelligence Agency immediately in the event that I am called upon by judicial or congressional authorities to testify about, or provide information which I have agreed herein not to disclose. 9. I understand that nothing contained in this agreement prohibits me from reporting intelligence activities which I consider to be unlawful or improper directly to the Intelligence Oversight Board established by the President or to a successor body which the President may establish. I recognize that there are also established procedures for bringing such matters to the attention of the agency's Inspector General or to the Director of Central Intelligence. I further understand that any information which I may repeat to the Intelligence Oversight Board continues to be subject to this agreement for other purposes and that such reporting does not constitute public disclosure or declassification of that information. 10. I understand that any breach of this agreement by me may result in the Central Intelligence Agency taking administrative action against me, which can include temporary loss of pay or termination of my employment or service with the Central Intelligence Agency. I also understand that if I violate the terms of this agreement, the United States government may institute a civil proceeding to seek compensatory damages or other appropriate relief. I understand that the disclosure of information which I have agreed herein not to disclose can, in some circumstances, constitute a criminal offense. 2. I understand that the United States government may, prior to any unauthorized disclosure which is threatening me, choose to apply to any 255 appropriate court for an order enforcing this agreement. Nothing in this agreement constitutes a waiver on the part of the United States to institute a civil or criminal proceeding for any breach of this agreement. Nothing in this agreement constitutes a waiver on my part of any possible defenses I may have in connection with civil or criminal proceedings which may be brought against me. 12. In addition to any other remedy to which the United States government may become entitled, I hereby assign to the United States government all rights, title, and interest in any and all royalties, remunerations, and emolument that have resulted or will result or may result from any divulgence, publication, or revelation of information by me when carried out in breach of paragraph 5 of this agreement or which involves information prohibited from disclosure under terms of this agreement. 13. I understand and accept that, unless I am provided a written release from this agreement or any portion of it by the Director of Central Intelligence or the Director's representative, all the conditions and obligations accepted by me in this agreement apply both during my employment or other service with the Central Intelligence Agency, and at all times thereafter. 14. I understand that the purpose of this agreement is to implement the responsibilities of the Director of Central Intelligence, particularly the responsibility to protect intelligence sources and methods, as specified in the National Security Act of 1947, as amended. 15. In any civil action which may be brought by the United States government for breach of this agreement, I understand and agree that the law of the Commonwealth of Virginia shall govern the interpretation of this agreement. 16. Each of the numbered paragraphs and lettered subparagraphs of this agreement is severable, if a court should find any of the paragraphs or subparagraphs of this agreement to be unenforceable. I understand that all remaining provisions will continue in full force. 17. I make this agreement in good faith, and with no purpose of evasion. Signature. Date. The execution of this agreement was witnessed by the undersigned, who accepted it on behalf of the Central Intelligence Agency as a prior condition of the employment or other service of the person whose signature appears above. Witness and acceptance. I gained possession of hundreds of CIA documents relating to BBRDW, and they clearly show that BBRDW and its subsidiaries were organized, funded, operated, and controlled by the CIA through its over 24 CIA agents within the companies. The verdict and out-of-proportion prison sentence. The trial started in mid-1985 before a federal jury in Honolulu, and a guilty verdict was reached on most charges on October 21, 1985. Judge Fong, who had repeatedly violated important due process protections, sentenced Rewald to 80 years in prison. This 80-year prison sentence ensured that Rewald would die in prison and his knowledge of CIA activities would go to the grave with him. Making matters worse for Rewald during his remaining life in prison, he had suffered an injury in a polo accident that caused him serious health problems, which were made worse by the incredibly bad medical care in prison. Eventually Rewald lost control over his bladder and bowel movements and was confined to a wheelchair. Suspicious reward for Tanabe Barbara Tanabe became affiliated with a CIA proprietary or asset after Rewald was sentenced to federal prison. She left Station Con and became president and chief operating officer of the Pacific Division of a powerful public relations firm based in Washington, D.C., that was reportedly a CIA proprietary or asset, Hill and Knowlton Communications, Pacific. Hill and Knowlton is famous for its CIA connections and for its propaganda news releases, one of many media assets receiving CIA money. Aiding and abetting by Ninth Circuit Court of Appeal judges. Rewald filed a notice of appeal with the Ninth Circuit Court of Appeals on December 20, 1985, and his attorney, A. Brandt Carruth of Van Nuys, California, filed the two appeal briefs on March 21, 1988. Because of classified documents involved in Rewald's defense, one brief of 108 pages was marked secret and sealed as required by CIPA rules. I had learned from 1974 to the present date that the Ninth Circuit Court of Appeals judges routinely engaged in a cover-up, as will be well recognized by the time the reader gets to the end of this book. They refused to provide relief to Rewald from the travesty of justice. They aided and abetted the gross injustice. They allowed the 80-year sentence to stand, fabricating facts to support their decision. Aiding and abetting by Supreme Court justices. Also aiding and abetting this travesty of justice and the cover-up of CIA activities were the justices of the U.S. Supreme Court, another group that I found routinely covering up. Even while Rewald languished in prison, the CIA attempted to have him assassinated. American Broadcasting Company presented a two-part report on World News Tonight that aired on September 19 and 20, 1984. The program featured a former CIA contract agent, Scott Barnes, describing a plan in which the CIA hired him to infiltrate the prison where Rewald was an inmate and check on Rewald's activities. According to Barnes, two CIA agents, John Stein and Gene Wilson, hired him to investigate whether Rewald was blowing the whistle on the CIA's operations. Barnes said during the ABC show that in November 1984 he met two men whose last names were Stein and Wilson, and two Office of Naval Intelligence agents at the Royal Hawaiian Hotel in Waikiki, and that during the meeting Barnes was told, "Rewald is no longer an asset, he is only a liability." Barnes stated that he was then directed to kill Rewald. Barnes refused. CIA threatening, and then buying, a major news source. In November 1984, CIA Director William Casey complained to the Federal Communication Commission about the ABC television network for having aired a show featuring CIA agent Scott Barnes. In the television presentation, Barnes said he was asked by two CIA agents in Honolulu to kill Ronald Rewald. This airing had the danger of revealing the CIA role in BBRDW and could expose an endless number of other covert CIA proprietaries and operations. Casey was a founder, major investor, and director in Capital Cities Corporation, which then took over the ABC television network a few months later, in March 1985. As stated in National Affairs, the CIA director openly attacks a leading network and threatens its broadcast license, ultimately causing it to issue a retraction of a story. Meanwhile, wearing his other hat as an investor, founder and close confidant of the Capital Cities management, Casey also stands to further his private business interests, as well as those of his friends, who were mounting a takeover of ABC. The combination of the media being infiltrated by CIA assets, funding of all forms of media activities, threats to revoke its government-granted license, and business interests linked to government officials, are key reasons why the media has engaged in a complicity of silence at a great cost to America. In April 1993, prison officials at Terminal Island placed a block on Rewald's outgoing phone calls so that any calls to me would be automatically blocked. The following November, after the first printing of Defrauding America came out with reference to Rewald, prison authorities seized all of his records, preventing him from disclosing to me evidence of CIA-related corruption. Civil suit against government. Rewald filed a lawsuit against the CIA, seeking to have the investors who were defrauded by the CIA join in the action. Justice Department attorneys sought to dismiss Rewald's action on the grounds that Rewald seeks monies based on his intelligence gathering services on behalf of the United States, citing Totten v. United States, 92 U.S. 105.3, degree. At his criminal trial, Justice Department prosecutors claimed Rewald had no significant CIA connections. During the civil trial they reversed themselves. Examining thousands of pages of judicial papers and other government documents, it became obvious to me after examining thousands of pages of court documents, briefs, appeal court decisions, and other papers, that Rewald had been framed by people in control of the Justice Department and the CIA, and federal judges. The court documents established that Rewald was in fact a CIA agent. The tactic used by federal judges to ensure that Rewald is forever silenced and discredited, and would die in prison, would prevent Rewald from introducing evidence showing that BBRDW and its subsidiaries were primarily funded by CIA funding sources, that the movement of money, including the investors' funds, were controlled by the CIA, that the many offshore bank accounts controlled by the CIA proprietary had ample funds in them until the funds were secretly removed shortly after BBRDW's cover was blown. These and other documents would have shown that Rewald was the titular head of a CIA proprietary, in which much of the money flow and other activities were controlled by the many CIA agents operating inside BBRDW and its subsidiaries. Funding the operation of the many worldwide offices over a 6-year period could never have been accomplished through the relatively small amount of investors' funds placed in BBRDW. Without being able to show that BBRDW was organized by, funded and controlled, by the CIA, Rewald was made a scapegoat to cover up for the covert CIA operation. The Ninth Circuit Court of Appeals judges covered up for this travesty of justice, as I repeatedly discovered since 1975, when I sought to report the criminal activities described within these pages, and sought relief from the actions taken to silence me. Happy day for Rewald. Although Rewald had 70 years to go on his prison sentence, and would not be due for parole for many years, the parole board notified Rewald in 1995 that they were holding a parole hearing concerning him. I and many other people submitted papers on his behalf, referring to the outrageous travesty of justice associated with the Judicial and Justice Department attacks upon Rewald. In my writings to the parole board I submitted a copy of the second edition of Defrauding America and a letter to the board, outlining the outrageous nature of Rewald's sentence. I ended the letter with a statement that I would like to me the next edition that the great injustice inflicted upon Rewald finally ended. Famed attorney Melvin Belli wrote letters outlining the outrageous attacks by Justice Department and CIA officials, and the federal judge, against Rewald, outlining the misconduct being perpetrated. Rewald was released in June 1995, and went to live with a daughter in Los Angeles. Several days after Rewald's release, his wife was diagnosed as having cancer, which necessitated months of surgery and chemotherapy. Funding secret bank accounts for U.S. officials. In March 1996, I acquired several boxes containing hundreds of CIA documents generated from the CIA's secret operation in Hawaii, and within these boxes I found highly sensitive material, including notes that Rewald had made while the titular head of BBRDW. Certain notes and information provided to me by Rewald divulged CIA drug-related activities, including drug money laundering. As I gathered from looking over the material and by talking with Rewald, he was unaware of much of the CIA activities originating out of BBRDW. Dynamite disclosures of CIA-funded bank accounts for high-level officials. Deeply embedded in these documents was an envelope labeled Attorney-Client Information. The information was dynamite, divulging secret activities, including CIA drug trafficking, and CIA funding of secret overseas bank accounts for high U.S. officials. The information in this envelope included information from the Green Book that the CIA sought to get from Rewald while he was in the hospital recovering from the combination suicide and assassination attempt. The notes in the envelope listed high-level people with secret CIA-funded accounts. The names on the left side of the notes were the aliases Rewald used to identify the people on the right for which there were secret bank accounts opened and funded by the CIA through BBRDW. Irwin M. Peach, George Bush, Mr. Bramble, George Bush, Commander Quinn, Star General Hunter Harris, Mr. Apin, Robert W. Jinks, Mr. Gray, Robert Allen, Farrah Fawne, Jackie Voss, General Sheikh Arnold Braswell 3. Mr. Branch, Richard Armitage. Mr. Denial, William Casey 3, 3. Slimy Affirm, Stanley Sporkin 3, 4. Captain Perjury, Ned Avery, Attorney Dorite, Robert Smith. Rewald's notes also indicated that fictitious names were used to hide money for B.K. Kim, Philippines President Ferdinand, and Imelda Marcos, among others. Former senior editor of Forbes, James Norman, had been reporting 5. that a secret group in the intelligence community, outraged at what was going on, infiltrated bank money transfer systems and discovered large quantities of money sequestered in overseas bank accounts for government figures. One of these people was allegedly Vincent Foster, who made a number of one-day trips to Switzerland to conduct bank activities. These notes, written by Rewald over 10 years earlier, when he was head of BBRDW, provided additional evidence of U.S. officials hiding their money in secret bank accounts overseas. The accounts were in financial institutions in Hong Kong, Switzerland, and the Caymans. Information on another sheet that I found in Rewald's papers revealed activities engaged in by CIA agents embedded into BBRDW and its various subsidiaries. These are the activities in which Rewald refused to get involved, including CIA drug trafficking. These notes revealed other activities that I hadn't known about earlier. While Rewald was hospitalized in Honolulu, sources kept him informed of some activities being taken to remove and hide the funds being removed from BBRDW and subsidiary accounts. General Hunter Harris called President George Bush to alert him that the cover on BBRDW had been blown, and wanted instructions as to how to proceed. CIA head, William Casey, then called Robert W. Jinks, and told him to work with Robert Allen. Jinks was then ordered to proceed to Texas to get bank account numbers and then to go to the Cayman Islands where the accounts were located. Rewald's notes indicated that someone from CIA headquarters at Langley, or an associate of Robert Allen, eventually went to the Cayman Islands and moved BBRDW's funds to another offshore country. Robert Smith, who wasn't directly involved in the money transfer but aware something was going on, learned that a general in Texas was to give Robert Jinks bank account information and that he, Robert Smith, was to go to the Caymans to retrieve the hidden money. General Arnold Braswell was to assist in this removal, but he was too shook up by what was going on and, combined with his drinking problem, was unable to carry out any instructions. Braswell was not used. Similar efforts were being taken to remove funds from BBRDW and subsidiary accounts in Hong Kong and Switzerland. About this time, funds were being received from secret arms sales and Rewald said that Ned Avery diverted these funds away from BBRDW. While these events were taking place, Robert Allen sought to force Jackie Voss to disclose the whereabouts of the Green Book that listed these accounts so as to destroy the records. Seeking help from the FBI, Voss sought help from the FBI from the threats made by Allen, but higher Justice Department officials ordered the FBI to stay clear of all activities related to the CIA's BBRDW. Rewald wrote in his notes that he had met President George Bush twice in Hawaii, and had been invited to meet with the president in Washington for lunch or dinner, along with someone that Rewald identified as Brady. All of these people were described in Rewald's notes by their code names, but a separate sheet of paper identified who they were, except for Brady. I asked Rewald about these, and he stated that he made the list of names with secret offshore bank account numbers. I asked Rewald, referring to the fictitious names for offshore bank accounts, "Do I correctly understand that you made up the alias names yourself?" "You mean, Peach for Bush?" "That was done well after the collapse and was done to disguise my reference to the accounts so that someone picking it up wouldn't know what I was talking about. These people certainly had these accounts." Parrott's knowledge of the bank accounts responding to my questions about the secret bank accounts listed in his memorandum, Rewald said, "The names you are talking about, Perjury, Quinstar, peach, and so on. That was in response to an inquiry from a politician out of Texas, a little bald-headed guy, who ran for president about 4 or 5 years ago. He had hired an investigator who contacted me, and they had a lot of facts and information on some of our operations, and he was trying basically to find out whether someone that they had an argument with was involved in this operation. That's when I put together those names and I passed the information on, and I said that is what this person did and what that person did. I asked, were these people informed of their balances? We sent out monthly statements. I asked, where did the money come from to put in those accounts? His answer opened still another can of worms. They came from the agency funding mechanisms. Were these substantial amounts? I asked. Oh yes, our bank accounts were always full. It was not unusual for us to have hundreds of millions of dollars in various banks in Hong Kong and Shanghai banks, in Cayman banks, Netherlands Antilles banks, Swiss bank accounts. Referring to the serious implications of what he had just said, I remarked, for Bush and the others to have secret bank accounts, funded by the CIA, there are serious implications in that fact. Well, there are. Seeking to enlarge upon what he had just told me, you say that the CIA was putting money into his account. The original money was put in by him or for him. The percentage rate that we were paying was set by the agency. That was 20%. But that was the same as Hong Kong was paying on accounts. So it is not unusual. That was just to be competitive with what investment banking operations were giving at that particular time. You must remember this was 1980, 81, 82. At that time, 20% was not an unusual amount to pay in Hong Kong and other areas. 262. Referring to the notes listing the secret bank accounts, Rewald said, after I was found in the Sheraton Waikiki Hotel in 1983, I was taken to the hospital. The very first thing that was done was a phone call from Commander Quinstar to Irwin M. Peach to alert him, and get instructions. The DCI had Mr. Apin called back from Australia or the Far East after Rewald was released from prison after 10 years. The article written by senior staff writer Walter Wright appeared to be another piece paid for by the CIA. The article was headed, Conman Rewald Let Out of Prison. The Honolulu Advertiser continued its long-term cover-up of the CIA operation in Hawaii. 265. Secrecy accrued. A. I acknowledge the fact that because of the confidential relationship between myself and the U.6 Govern sent, I will be the recipient of information which, in ITILF, or by TB impliciticans to be driven therefrom, will be such that its unlawful disclosure or loose handling may adversely affect the interest and the security of the United States. I realize that the method of collecting and of using the information, as well, as the identity of persons involved, are as secret as the substantive information itself and, therefore, must be treated by me 6bh an equal degree of secrecy. 2. I. Abal always recognize sent WT the U.6 Government bas the sole interest in L, information which J or Pi organization may possess, stockpile or acquire pursuant to this understanding. Ho advantage or gain will be sought by me a result of the added significance or value such information may have, due to the government's interest in it. Warning of missile attacks on U.S. airliners. While Rewald was in prison at Terminal Island, he met another prisoner, Mohammed Akbar Bey, the son of one of the Afghan rebel leaders who he had previously met while Rewald was the head of the CIA operation in Hawaii. As a result of this meeting, negotiations commenced between Afghan rebels and Justice Department and CIA officials in which the rebels offered 30 to 40 SAM missiles to the United States at virtually no cost. These were missiles being sought by terrorists at the same time. The rebels would give these missiles to the United States in exchange for the release from federal prison of the son of one of the rebel leaders. Bey was in prison for a drug-related offense. Rewald was a key part of the negotiations because the rebels trusted him, while they did not trust Justice Department and CIA officials. Also involved in these negotiations was Long Beach attorney, John J. Reed, who was believed to be one of the many attorneys fronting for the CIA. Justice Department and CIA officials knew that terrorists were bidding on these missiles and that if they rejected the missiles, terrorists would acquire some or all of them. At that time, 25 commercial aircraft had already been shot down by SAM missiles in Africa, the Middle East, and the Soviet Union. Terrorism against the United States was increasing, and it could be expected that U.S. commercial aircraft would be targeted with any missiles acquired by terrorists. Questionable agenda. After months of negotiations frustrated by Justice Department and CIA officials, the missiles were rejected. Anyone familiar with the mentality of these two agencies would not have any problem believing that Justice Department and CIA officials wanted the missiles to fall into the hands of terrorists. The downing of one or more commercial aircraft would justify their existence and expansion, as well as justifying imposing draconian security measures upon the American people. Concerned about the probable consequences of rejecting the SAM missiles, Rewald provided me with information and documents concerning the missile negotiations. I then sent by certified mail a detailed 3-page letter to Senator Arlen Specter and every member of the House and Senate Intelligence Committees, warning that surface-to-air missiles were about to be turned over to terrorists because of the actions by Justice Department and CIA officials. I stressed that he had considerable documentation and memorandums outlining the negotiations, and that failure to immediately contact me and my CIA source would permit the terrorists to acquire the missiles, and that one or more U.S. aircraft would probably be eventually shot down. Not a single one responded. History of commercial aircraft downing by missiles. In the preceding 2 decades, over 24 commercial aircraft have been shot down by surface-to-air missiles in Africa, the Middle East, and Russia. It could be assumed that it is only a question of time before missiles are used to down aircraft in the United States. For any responsible person or group, such as the members of Congress who received the warning letters, to ignore the threat of missiles falling into the hands of terrorists is contempt for the lives that would be lost. My 3-page letter to Member of Congress follows. 268. Dear Senator Specter, my sources in the intelligence community have recently given me details of efforts by Afghani rebels to turn over to the United States, without charge, 30 to 40 Stinger missiles, with the possibility of an additional 100 missiles thereafter. Incredibly, this offer was rejected by Justice Department and Central Intelligence Agency officials. There is a strong probability that one or more of these rejected missiles will be used to shoot down commercial airliners. If this occurs, not only will the carnage be horrendous, but it will inflict severe financial havoc upon the aviation industry and upon air travel. The following is a brief description of what has transpired, synopsis of CIA and Justice Department tactics ensuring that the SAM missiles will be available to terrorists. Recent information provided to me by one or more of my many contacts in the CIA community describes the dates, places, and people involved in offering the missiles to the United States, and the rejection of this offer. These sources provided me with precise details of the negotiations to give the missiles to the United States, the agreement by Afghan rebel leader, General Rashid Dostum, and a CIA attorney. CIA headquarters was initially made aware of the offer through a letter sent by a former CIA agent whom I have known for about 5 years, and who I consider very honorable and reliable. That letter went unanswered. The agent, concerned about the consequences of commercial airliners being shot down with these missiles, then contacted another CIA employee at CIA headquarters, who then tried to force a response from high CIA officials. This latest action forced CIA officials to finally respond. Negotiations then commenced, which involved, among others, the former CIA agent who headed a major CIA proprietary in Hawaii, a CIA attorney in the Los Angeles area, an Afghani located in California, and an Afghani rebel general in Afghanistan. The general agreed to turn over the missiles without cost to the United States, and simply requested the release of an Afghani being held in federal prison on a drug charge arising from a possible KGB setup. At the same time that the Afghan general was offering to give these missiles to the United States, these same missiles were being sought by terrorist groups who bid large amounts of money for them. One obvious possible use for these missiles in terrorist hands would be to shoot down commercial airlines. Incredibly, CIA and Justice Department officials rejected the offer, ensuring that the missiles would fall into the hands of terrorists, where some of them may be at this very moment. The Afghani initially offered to give to the CIA 30 to 40 Stinger, with a possibility that 100 more would be delivered thereafter. The CIA and Justice Department requested serial numbers for several of the missiles to determine that the missiles were actually available. These 269 serial numbers were then provided, and the numbers were confirmed by U.S. authorities as authentic. After telephone contact was made with this Afghan general, a written agreement was signed by a Los Angeles area CIA attorney, the Afghani in California, and the former CIA agent who the Afghans were using to ensure that the CIA and Justice Department kept their word. Underscore knowledge of corrupt CIA and Justice Department activities. My prior experience as a federal and then a private investigator, and a confidant to many former CIA and other deep cover people seeking to expose government corruption, has enabled me to recognize the corrupt conduct of these two government agencies. I strongly feel that this rejection indicates a secret agenda that could inflict additional great harm upon America. This conduct would be compatible with the corrupt activities and harm that I have detailed and documented during the past 30 years of attempts to expose the activities of corrupt government officials and employees. Possible reasons for refusing the missiles. There are several possible reasons for the CIA and Justice Department refusing to accept the missiles, and each of them is in character for these two groups. Two of these reasons are listed here. Attempt to prevent exposure of an earlier CIA and Justice Department scandal. The offer to provide the missiles at no charge went through a former CIA agent who was made the titular head of a large and covered CIA proprietary in Hawaii, Bishop, Baldwin, Rewald, Dillingham, and Wong. This covered operation that was based within the United States had offices in 17 countries, and replaced another CIA operation and scandal known as Nugan Hand Bank with headquarters in Australia. After a Honolulu television station blew the cover on BBRD&W, officials in control of the CIA and Justice Department sought to cover for the CIA operation by fraudulently charging with criminal conduct the head of that CIA proprietary. If the missiles had been accepted, it is possible that this sacrificed agent would be identified and the massive fraud involving the Hawaiian and Nugan Hand operations would then surface. CIA need for continuing crises. Another possibility for CIA and Justice Department rejection of the Stinger missiles is that the CIA wants the missiles to fall into terrorists' hands, and actually wants an airliner to be shot down. The shoot-down of a commercial airliner could then be used to justify the continuation of CIA activities. This scenario is not as bizarre as it sounds when a person understands the history of corrupt CIA and Justice Department activities and the great harm inflicted upon the United States through criminal activities. I describe these activities in books that I have written, Defrauding America and to a lesser extent, Unfriendly Skies. A prior air tragedy involved with CIA Justice Department misconduct PAM AM 103. Despite the cover-up by the CIA and Justice Department, substantial evidence indicates that the Pan AM 103 tragedy was made possible by CIA misconduct associated with a pattern of illicit drug smuggling into the United States. My deep cover contacts, along with information obtained from other sources, indicates that the CIA and DIA had an established drug pipeline from Nicosia and Beirut into the United States using Pan Am aircraft. Pan Am's involvement started at Frankfurt, Germany. Ironically, one of the same DIA agents involved in that drug pipeline, Michael T. Hurley, was used to retaliate against a witness who testified to Congress concerning the Justice Department's involvement in the Inslaw scandal. Justice Department officials retaliated against Michael Reconnaissance for testifying before Congress about the Justice Department's involvement in the in a perverse way, I was slow to catch on. I feel silly. I wasn't paranoid enough. A story of government conniving and manipulation, and in Elliot Richardson's words, complemented and allowed to run its course by ill will at the higher level, meaning former Deputy Attorney General Jensen. Series of killings protected federal officials following a pattern. Many people who posed a threat to U.S. officials because of what they knew turned up dead. The most publicized killing related to INSLAW was freelance reporter and author Danny Casolaro, who was investigating criminal activities implicating Justice Department officials and writing a book on the subject. Casolaro was killed at the Sheraton Inn in Martinsburg, West Virginia on August 10, 1991. A CIA operative had met Casolaro earlier at a restaurant, advising Casolaro that he knew of a person who could give Casolaro additional evidence proving the link between Justice Department officials and the INSLAW scandal. Shortly before his death, Casolaro met with a former CIA Special Forces operative who had worked for a company involved in the INSLAW case and who was also a good friend of Justice Department official Peter Vidanieks. Vidanieks was the Justice Department official who later threatened Reconnaissance if he testified before a congressional committee in the INSLAW investigation or gave affidavits into the INSLAW civil action. The CIA operative set up a meeting between Casolaro and Vidanieks, and it is at this meeting that Casolaro was killed. Casolaro traveled to Martinsburg, Virginia, about 40 miles from Washington, to meet the informant. The following morning, August 11, 1991, Casolaro was found dead in the bathtub of his room in the Sheraton Hotel, his wrists slashed 10 times. His briefcase and all his notes were missing. Casolaro had been talking almost daily with CIA contract agent Michael Reconnaissance, and had stayed with Reconnaissance and his common-law wife, Bobby, at their residence near Tacoma, Washington, obtaining additional evidence. Casolaro's death was one of at least half a dozen closely linked to the INSLAW matter. Casolaro's death bred numerous articles linking Justice Department officials with INSLAW. 32. Despite identification in Casolaro's personal belongings listing his relatives, the police made no effort to contact Casolaro's family before placing a suicide label on the death and ordering an immediate and unprecedented embalming of the body. No permission was sought from Casolaro's family and no check was made for incapacitating drugs that may have been given to him. This unusual penance destroyed any evidence that might have linked Casolaro's death to others. Casolaro had suspected his life may have been in danger and said several. 321. A typical article was entitled, "The Dark World of Danny Casolaro," a 4-page article in the October 28, 1991 issue of The Nation. INSLAW and Crimes at Justice 287. Times to his brother, a medical doctor, that if anything happened to him that looked like an accident, for him not to believe it. After Casolaro's murder, INSLAW's attorney Elliot Richardson again demanded that the Justice Department conduct an investigation, citing the fact that Casolaro found evidence proving the existence of misconduct by high Justice Department officials over whom the Attorney General had supervisory responsibility. Richardson was in effect asking the U.S. Attorney General to investigate criminal misconduct implicating Attorney General Edwin Meese and his staff. Senate investigation probably motivated by media attention to the INSLAW matter, the Senate Permanent Subcommittee on Investigations, chaired by Senator Sam Nunn, conducted a typical congressional investigation in 1989 into the theft of the Promise software and into problems in Chapter 11 courts. Justice Department officials blocked the investigation by refusing to produce documents and refusing to allow Justice Department personnel to be questioned under oath. Attorney General Thornburg refused to appear before the committee, even though he had a duty to do so. The Senate committee also had a duty to force the Attorney General and other federal employees to appear. Instead, the committee disbanded the investigation and issued an incomplete report. Confirmation by CIA assets. Several CIA operatives and contract agents, including Gunther Russbacher and Michael Reconnaissance, offered to testify before the congressional committees to provide evidence. Only Reconnaissance was allowed to give testimony, showing that the Promise software was stolen by Justice Department officials, given to Earl Bryan, and sold to numerous foreign countries, including Canada, Libya, Iran, Iraq 322 and South Korea. The INSLAW contract with the Justice Department to install the Promise software did not constitute a sale. Similar to the purchase of software such as WordPerfect, the buyer of that software only has a license to install and use it, and not to turn around and sell it, as Justice Department officials and their associates subsequently did. Threat of prison if the testimony was false. The Senate reported the stonewalling, stating that its inquiry into Inslaw's charges had been hampered by the department's lack of cooperation. The report stated that it had found employees who desired to speak to the subcommittee, but who chose not to, out of fear for their jobs. The report addressed not only the Justice Department's misconduct in the Inslaw affair but also its misuse of Chapter 11 through its U.S. Trustee Division. The report concluded that the Justice Department politicized the U.S. Trustee Program, forcing the Inslaw company with whom it did business into bankruptcy, by refusing to pay for the Promise software program. These were serious charges of misconduct by officials in an agency over whom Congress had oversight responsibilities, requiring Congress to fully investigate the matter and bring it to a satisfactory conclusion. As usual, they engaged in, at best, misfeasance by allowing the criminal and corrupt activities to go unpunished and to continue. The report agreed with the findings of Judge Basin, who blasted the Department of Justice in his decision. The judge's decision stated in part, took, converted, stole, by trickery, fraud and deceit. An institutional decision. At the highest level simply to ignore serious questions of ethical impropriety, made repeatedly by persons of unquestioned probity and integrity, and this failure constitutes bad faith, vexatiousness, wantonness, and oppressiveness, engaged in outrageous, deceitful, fraudulent game of cat and mouse, demonstrating contempt for both the law and any principle of fair dealing. The Senate report included articles appearing in Barron's 3 and the American Lawyer 34 which went into great detail describing the Justice Department and U.S. trustee misconduct. One article in Barron's 25 described the Justice Department's attempts to bankrupt and destroy Inslaw, misusing the U.S. trustees and the bankruptcy judges to carry out their scheme. The article stated in part, Justice officials proceeded to purposefully drive the small software company into bankruptcy, and then tried to push it into liquidation. Ultimately, the series of willful, wanton, and deceitful acts led to a cover-up. Basin called statements by top Justice Department officials ludicrous, incredible, and totally unbelievable. Some of the evidence against the department came from one of its own. During the course of the litigation, Anthony Paciotto, Deputy Director of Department's Executive Office for United States Trustees, told how the Justice Department had pressured trustee officers to liquidate. Later, a superior confirmed Paciotto's story. But at the trial, a horrified Paciotto listened while his superior changed his testimony. Close to tears, he, too, recanted. Judge Basin ordered Justice to pay Inslaw about $6.8 million in licensing fees and roughly another $1 million in legal fees. In November, Judge Basin rejected a Department of Justice motion to liquidate Inslaw. 1 month later, the Harvard Law School graduate and former law professor discovered that he was not being reappointed. The report described the normal process of government obfuscation followed by loss of interest by the press, stating, it seemed as if the controversy was winding down, it would follow a natural course in the press, and then fade from view. Inslaw would become another shocking event that slinks off into obscurity. Someone occasionally might dimly remember and idly ask, whatever did happen to Bill Hamilton and those Inslaw people? A real shame. I heard the judge was back teaching law somewhere. The Barron's article described the efforts of Anthony Paciotto, a Department of Justice insider, who blew the whistle on the Justice Department's misuse of this powerful federal agency against Inslaw and his small company. In an interview with Barron's, Paciotto explained how the Justice Department blacklisted Inslaw. It was a tale that involved 2 U.S. trustees, a federal judge who told 2 versions of the same story, and a Justice Department that routinely refused to pay certain suppliers. Pattern of harassment that helped drive Inslaw into Chapter 11. The Justice Department was trying to starve Inslaw. They didn't just push to bankrupt the software firm, they wanted to liquidate it, converting it from Chapter 11 to Chapter 7, as soon as possible. Why? Tony Paciotto that his boss, Thomas Stanton, director of the Justice Department's Executive Office for U.S. Trustees, was pressuring the federal trustee overseeing the Inslaw case, William White, to liquidate Inslaw. Cornelius Blackshear, the U.S. trustee in New York at the time of Inslaw's Chapter 11 filing, knew all about Stanton's plan. Paciotto said that Judge Blackshear had repeated this tale of pressure in the presence of United States Court of Appeals Judge Lawrence Pierce in the judge's chambers in Foley Square in New York. Blackshear met with a Justice Department representative, and signed a sworn affidavit, recanting, and said that he had confused Inslaw with another case, United Press International, which had also been involved in bankruptcy proceedings in Judge Bason's court. Cornelius Blackshear left his position as United States trustee and became a United States bankruptcy judge the following fall. 326 A lot dirtier than Watergate. Ronald LeGrand, chief investigator for the Senate Judiciary Committee, told William Hamilton and his attorney that a trusted Justice Department source confided that the Inslaw case was a lot dirtier for the Department of Justice than Watergate had been, both in its breadth and its depth. Despite the oversight responsibilities of the Senate group, despite the requirements of federal criminal statutes, the Senate committee refused to take any action against the criminal acts of federal employees in the U.S. Department of Justice, and did nothing to alleviate the harm inflicted upon the innocent owners of the Inslaw Company. In this way they aided and abetted the criminal activities, of which Inslaw was only the tip of the iceberg. House investigation. The Congressional Subcommittee on Economic and Commercial Law of the Committee on the Judiciary also held hearings concerning the Inslaw matter and the related death of Danny Casolaro. Congressman Jack Brooks chaired the committee investigation. U.S. Attorney Meese and the Justice Department group stonewalled the House committee just as they had done with the Senate committee, refusing to turn over requested documents, fraudulently, stating that the key documents had been accidentally destroyed or could not be found. How convenient. At the start of the hearings, Congressman Brooks stated, "As incredible as this sounds, federal bankruptcy judge George Bason, who will be testifying later, has already found much of the first part of the allegation to be true." In his decision on the Inslaw bankruptcy, Judge Bason ruled that the department took, converted, and stole Inslaw's proprietary software using trickery, fraud and deceit. The judge also severely criticized the decisions by high-level department officials to ignore the ethical improprieties on the part of the Justice Department officials involved in the case. Over 30 people testified during the committee hearings, revealing how Justice Department officials had stolen the software, schemed to force Inslaw into bankruptcy, and then stole the computer program. Among those who testified before the House committee was former Chapter 11 Judge Bason, who heard the case against the Justice Department. He testified, "The judicial opinions that I rendered reflected my sense of moral outrage that, as the evidence showed and as I held, the Justice Department stole Inslaw's property and tried to drive Inslaw out of business." Those opinions were upheld on appeal by Judge Bryant in a memorandum that noted my attention to detail and mastery of evidence. Revealing Justice Department retaliation for rendering a decision unfavorable to that agency, Judge Bason testified, "Very soon after I rendered those opinions, my application for reappointment was turned down. One of the Justice Department attorneys who argued the Inslaw case before me was appointed in my stead." Although over 90% of the incumbent bankruptcy judges who sought reappointment were in fact reappointed, I was not among them. By placing one of their own as a judge on the federal court system, the Justice Department officials expanded their pattern of influence. Congressman Brooks stated in the final committee report, "Despite the dramatic findings by the two courts, the department has steadfastly denied any wrongdoing by its officials, claiming that its conflict with Inslaw is nothing more than a simple contract dispute. I find this position a little hard to swallow." The September 10, 1992, report accused high Justice Department officials of criminal misconduct and recommended appointment of a special prosecutor. The 122-page report stated in part, "There appears to be strong evidence, as indicated by the findings in two federal court proceedings, as well as by the committee investigation, that the Department of Justice acted willfully and fraudulently, 327 and took, converted, and stole, INSLAW's enhanced promise by trickery, fraud, and deceit. It appears that these actions against INSLAW were implemented through the project manager from the beginning of the contract and under the direction of high-level Justice Department officials. What is strikingly apparent from the testimony and depositions of key witnesses and many documents is that, engaged in an outrageous, deceitful, fraudulent game of cat and mouse, demonstrating contempt for both the law and any principle of fair dealing, high-level officials at the Department of Justice conspired to drive INSLAW into insolvency and steal the promise software so it could be used by Dr. Earl Bryan, a former associate and friend of then Attorney General Edwin Meese. Dr. Bryan is a businessman and entrepreneur who owns or controls several businesses including Hadron Incorporated, which has contracts with the Justice Department, CIA, and other agencies. The circumstances involving the theft of the promise software system constitute a possible criminal conspiracy involving Mr. Meese, Judge Jensen, Dr. Bryan, and several current and former officials at the Department of Justice. The committee's investigation largely supports the findings of two federal courts that the department took, converted, stole INSLAW's enhanced promise by trickery, fraud, and deceit, and that this misappropriation involved officials at the highest levels of the Department of Justice. One of the principal reasons the committee could not reach any definitive conclusion about INSLAW's allegations of a high criminal conspiracy at Justice was the lack of cooperation from the department. Throughout the two INSLAW investigations, the Congress met with restrictions, delays, and outright denials to requests for information and to unobstructed access to records and witnesses since 1988. Some of the documents held by the department's chief attorney in charge of the INSLAW litigation had been misplaced or accidentally destroyed. The ultimate goal of the conspiracy was to position Hadron and the other companies owned or controlled by Dr. Bryan to take advantage of the nearly $3 billion worth of automated data processing upgrade contracts planned to be awarded by the Department of Justice during the 1980s. The enhanced promise software was stolen by high-level justice officials and distributed internationally in order to provide financial gain to Dr. Bryan and to further intelligence and foreign policy objectives of the United States. Numerous potential witnesses refused to cooperate, for the stated reason that they were fearful for their jobs and retaliation by the Justice Department, or that attempts had already been made to intimidate them against cooperating. The department's unwillingness to allow congressional oversight into its affairs, in spite of an alleged cover-up of wrongdoing, greatly hindered the committee's investigation of the INSLAW allegations. The committee also encountered serious problems with obtaining cooperation from U.S. intelligence and law enforcement agencies. The committee also encountered virtually no cooperation in its investigation of the INSLAW matter beyond U.S. borders. The Government of Canada refused to make its officials available to committee investigators for interviews without strict limitations on the questioning. Referring to an even worse level of corruption, the committee report stated. 292. According to Legrand, a trusted source, described to the Hamiltons as a senior DOJ official with a title, had alleged that the two senior criminal division officials were witnesses to much greater malfeasance against INSLAW than that already found by the bankruptcy court, malfeasance on a much more serious scale than Watergate. Legrand told the Hamiltons that D. Lowell Jensen did not merely fail to investigate the malfeasance of Vidaniques and Brewer but instead had engineered the malfeasance right from the start so that INSLAW's software business could be made available to political friends of the Reagan/Bush administration. Can identify about 300 places where the promise software has been installed illegally by the federal government. Dr. Bryan sold promise to the Central Intelligence Agency in 1983 for implementation on computers purchased from floating point systems and what the CIA called promise data point. Dr. Bryan has sold about $20 million of promise licenses to the federal government. Department officials hinted to CIA officials that they should deny that they are using promise. Reassignment in 1990 to a DIA intelligence position in the state of Washington, prior to Michael Riccanaci-Utto's March 1991 arrest there on drug charges, was more than coincidental. The agent was assigned to Rekanasi Utto's home state to manufacture a case against him. Mr. Coleman stated he believes this was done to prevent Mr. Rekanasi Utto from becoming a credible witness concerning the U.S. government's covert sale of promis to foreign governments. The committee encountered numerous situations that pointed to a concerted effort by department officials to manipulate the litigation of the Inslaw bankruptcy, as alleged by the president of Inslaw. During this controversy, one key department witness was harassed and ultimately unauthorized destruction of government documents. Department employees were involved in the illegal destruction of documents related to the Inslaw case. Rekanasi Utto stated that a tape recording of the telephone threat was confiscated by DIA agents at the time of Rekanasi Utto's arrest. The timing of the arrest, coupled with Mr. Rekanasi Utto's allegations that tapes of a telephone conversation he had with Mr. Vidaniques were confiscated by DIA agents, raises serious questions concerning whether the department's prosecution of Mr. Rekanasi Utto was related to his cooperation with the committee. 9. Conclusion. Based on the committee's investigation and two separate court rulings, it is clear that high-level Department of Justice officials deliberately ignored Inslaw's proprietary rights in the enhanced version of promis and misappropriated the software for use at locations not covered under contract with the company. Instead of conducting an investigation into Inslaw's claims that criminal wrongdoing by high-level government officials had occurred, Attorney Generals Meese and Thornburg blocked or restricted congressional inquiries into the matter, ignored the findings of two courts and refused to ask for the appointment of an independent counsel. These actions were taken in the face of a growing body of evidence that serious wrongdoing had occurred which reached to the highest levels of the department. The evidence received by the committee during its investigation clearly raises serious concerns about the possibility that a high-level conspiracy against Inslaw did exist and that great efforts have been expended by the department to block any outside investigation into the matter. Finally, the committee believes that the only way the Inslaw allegations can be adequately and fully investigated is by the appointment of an independent counsel. Findings. The department ignored Inslaw's data rights to its enhanced version of its promis software and misused its prosecutorial and litigative resources to legitimize and cover up its misdeeds. Several witnesses, including former Attorney General Elliot Richardson, have provided testimony, sworn statements, or affidavits linking high-level department officials to a conspiracy to steal Inslaw's promis software and secretly transfer promis to Dr. Bryan. The promis software was subsequently converted for use by domestic and foreign intelligence services. This testimony was provided by individuals who knew that the Justice Department would be inclined to prosecute them for perjury if they lied under oath. No such prosecutions have occurred. The reviews of the Inslaw matter by Congress were hampered by department tactics designed to conceal many significant documents and otherwise interfere with an independent review. The department actions appear to have been motivated more by an intense desire to defend itself from Inslaw's charges of misconduct rather than investigating possible violations of the law. The department stole through trickery, fraud, and deceit Inslaw's promis software. Aiding and abetting. Every Republican congressman on the committee voted against the report, claiming there was no support for the findings by the two federal judges and the committee investigators. This cover-up tactic duplicated the obstruction of justice in the October surprise scheme. The Republican bloc stated in their dissenting report, "Those entrusted with the enforcement of our laws in the executive branch are better qualified than members of Congress to assess the utility of settling a legal controversy on terms favorable to a private litigant." These Republican congressmen held that the very same Justice Department officials should be the only persons permitted to investigate their own misconduct. The Republican congressman eulogized the very same Justice Department officials who had been found by two federal courts to have engaged in corrupt acts. The dissenting opinion by the Republicans stated fairness to DOJ requires fairness. Justice Department employees destroyed documents, threatened witnesses, used government agencies to steal the livelihood of innocent citizens. Trapdoor alterations assured that the congressional investigation would go no further. Justice Department officials and their business associates continued their sale of the stolen promis program. Meese's friend and business associate, Earl Bryan, sold copies of InSlaw software to intelligence agencies all over the world, collecting millions of dollars in the process. Who says crime doesn't pay? Israel's Mossad, which knew the software was stolen, obtained the Promise software from Earl Bryan in 1982 through a front company called Digim. The Mossad installed their own trapdoor into the software, permitting the Mossad to secretly enter the database after it was sold to other countries, including Nicaragua, Colombia, Chile, and Brazil. In this way the CIA and the Mossad could spy on the countries that bought the program, including friendly nations. The trapdoor alteration of the Promise program was accomplished for the Mossad through Ben Menashe, using a computer software company in Chatsworth, California. After the CIA and Justice Department, working together, made the trapdoor changes, Bryan sold the first program to Jordan via his company, Hadron. The Mossad then secretly entered the computer program without Jordan's knowledge, revealing the success of the trapdoor. The CIA and Mossad approached Robert Maxwell, a British citizen and secret Mossad agent, through Senator John Tower in 1984, authorizing Maxwell to sell the Promise software to East Bloc countries, including Russia. Maxwell's Berlitz language schools, scattered throughout the world, made him an excellent source to carry out the plan. Maxwell also purchased an existing computer company owned by the Mossad, Digim, which had offices in several foreign countries, to install the software. According to Ari Ben Menashe, by 1989, sales of the stolen Promise software brought in $40 million. Not bad for criminal activities using U.S. Department of Justice facilities, with the activities financed by U.S. taxpayers' dollars. Software for drugs. Guatemala purchased the Promise software. The vast network of computers needed to operate the program was furnished by IBM in 1985, using money obtained from shipping drugs to the United States. Even the drug cartels used the Promise software. Unhappy with the U.S. sanctioned shipment of chemical weapons to Iraq from Cardoen Industries in Chile, Ben Menashe threatened to expose the sale of Promise software and the hidden trapdoor, if the U.S. did not discontinue the shipments. Justice Department officials retaliated, seeking to silence him by charging Ben Menashe with selling aircraft to a foreign country. Justice Department prosecutors and a federal judge caused Ben Menashe to be imprisoned for a year pending trial, until a New York federal jury acquitted him. Selective media coverage. A February 5, 1990, article in the legal newspaper, The Recorder, criticized Michael Shaheen, Jr., head of the Justice Department's Office of Professional Responsibility, for outrageous, deceitful, fraudulent acts and the cover-up of such acts. Professor Bennett Gershman at New York's Pace University School of Law and author of Prosecutorial Misconduct was quoted as stating, "It is a joke to say justice polices itself." The heading in a March 15, 1991, Miami Journal article read, "Justice Department perverts justice in InSlaw case." The article stated in part, "In the matter of the Department of Justice and the InSlaw case, a remarkable thing is happening, the stench gets worse. Until recently, it could be said of this shameful affair that it smelled only to high heaven. It is now beginning to smell to outer space. As Attorney General, he ought to be doing his damnedest to get to the bottom of this disgraceful matter. Instead, he has stalled, he has stonewalled, he has taken refuge in legalisms, he has obstructed efforts of 2 congressional committees to dig out the facts. And this isn't even his scandal. He inherited the mess from Ed Meese." A Vancouver Sun headline on April 5, 1991, stated, "Probe of hot software charge urged." The article stated in part, Solicitor General Pierre Cadieux should go before a parliamentary committee to answer charges the RCMP and CSIS are using stolen computer software, opposition MPS said Thursday. The Promise software was allegedly pirated by U.S. Justice Department officials and sold by associates of former President Ronald Reagan to government agencies in Canada, Libya, Iraq, and Israel, according to affidavits filed in U.S. bankruptcy court last week. An article in the Financial Times of London on April 5, 1991, referred to the Inslaw matter. A bizarre series of allegations including claims of misconduct by Mr. Robert McFarlane, the former National Security Advisor to President Ronald Reagan, have surfaced as a result of a seemingly obscure legal action involving the U.S. Department of Justice and a small Washington computer software company called Inslaw. The charge: Israeli intelligence forces are using an Inslaw computer software system illegally provided by Mr. McFarlane, several members of the Washington establishment and U.S. press reports suggest Inslaw may be only the tip of an iceberg that could have implications for U.S. foreign policy in the Middle East. An October 25, 1991, Daily Journal headline stated, "The Promiscat plot thickens," with the subtitle, "Scandal over Justice Department software could run very deep." The article revealed that the scheme was to deliver Inslaw's stolen software to a company in which Attorney General Edwin Meese had an interest, and then the stolen software would be sold to the Justice Department in a $250 million contract to automate Justice Department litigation divisions. Syndicated columnist James Kilpatrick headlined his August 29, 1991, article stating, "Odor of a situation needing a probe." The article stated in part, "Some months ago, writing about the Inslaw case, I said the affair was beginning to stink to high heaven. With the death of Danny Casolan, a freelance investigative reporter, the stench grows worse. There is reason to believe that Danny Casolaro went to Martinsburg to crack the case. He had told friends that Inslaw was part of an octopus of criminal activities in high places, including the BCCI and the savings and loan scandals. Organized crime in the Justice Department." An October 27, 1991 article written by former U.S. Attorney General Elliot Richardson, appearing in newspapers throughout the United States, stated, "Organized crime in the U.S. Justice Department, the stench at the U.S. Justice Department." The former Attorney General called for appointment of independent counsel to investigate the alleged corruption by Justice Department officials. 339 in the Chapter 11 misconduct involving Inslaw. Richardson called for an independent counsel to investigate the Justice Department's misconduct on the basis that the nation's highest law enforcement agency was heavily implicated in Chapter 11 corruption. Richardson's charges that the Justice Department was a criminal enterprise was more correct than his words suggested. "I found out about the criminality of those officials and prosecutors in the Justice Department for the past 30 years, starting while I was a federal investigator. Attorney General William Barr, for instance, was legal counsel for the CIA during 1976 and 1977 while George Bush was director of the agency. In the mid-1980s, Barr was reportedly an attorney for the CIA's Southern Air Transport, using the alias of Robert Johnson. 33. He coordinated and directed the unlawful weapons shipments to Central America from Arkansas, drug smuggling on the return flights, and drug money laundering from the drug operations. After Barr became Attorney General, he obstructed justice and covered up for these crimes against the United States. He, and prior Attorney General Edwin Meese, knew about the treasonous and criminal October Surprise Operation, Inslaw, Iran-Contra, and other crimes against the American people. The list goes on and on, with the heads of the Justice Department guilty of far worse crimes than many prisoners languishing in federal prisons. Other criminality surfaced. Another pattern of corruption surfaced as congressional investigators questioned Michael Reconnaissy-Utto. They learned that he helped arrange the transfer of $40 million bribe money from the Reagan-Bush team to the Iranians during the October 19, 1980, weekend meetings in Paris. This revelation provided further evidence that the October Surprise Operation did indeed take place, but the Senate and the House kept the lid on this awesome scandal. Inslaw's attorney, Elliot Richardson, requested an affidavit from Reconnaissy-Utto concerning his knowledge of the Justice Department's role in the Inslaw matter. When Justice Department officials learned of these requests, Peter Vidanieks of the Justice Department threatened Reconnaissy-Utto during a telephone call. Vidanieks warned Reconnaissy-Utto that if he gave evidence to the Congressional Committee, serious things would happen to him and his wife, Bobby. Reconnaissy-Utto taped this telephone conversation. Despite Justice Department threats, Reconnaissy-Utto submitted testimony to Congress and an affidavit to Inslaw's attorney. The March 21, 1991, affidavit stated, I, Michael J. Ricanasciotto, being duly sworn, do hereby state as follows. 1. During the early 1980s, I served as the Director of Research for a joint venture between the Wackenhut Corporation of Coral Gables, Florida, and the Cabazon Bank of Indians of Indio, California. The joint venture was located on the Cabazon Reservation. 2. The Wackenhut Cabazon joint venture sought to develop and/or manufacture certain materials that are used in military and national security operations, including night vision goggles, machine guns, fuel-air explosives, and biological and chemical warfare weapons. 3. The Cabazon Band of Indians are a sovereign nation. The sovereign immunity that is accorded the Cabazons as a consequence of this fact made it feasible to pursue on the reservation the development and/or manufacture of materials whose development or manufacture would be subject to stringent controls off the reservation. As a minority group, the Cabazon Indians also provided the Wackenhut Corporation with an enhanced ability to obtain federal contracts. In's Law and Crimes at Justice 299. Through the 8A Set-Aside Program, and in connection with government-owned contractor-operated facilities. 4. The Wackenhut Cabazon joint venture was intended to support the needs of a number of foreign governments and forces, including forces and governments in Central America and the Middle East. The Contras in Nicaragua represented one of the most important priorities for the joint venture. 5. The Wackenhut Cabazon joint venture maintained close liaison with certain elements of the United States government, including representatives of intelligence, military, and law enforcement agencies. 6. Among the frequent visitors to the Wackenhut Cabazon joint venture were Peter Vidanieks of the U.S. Department of Justice in Washington, D.C., and a close associate of Vidanieks by the name of Earl W. Bryan. Bryan is a private businessman who lives in Maryland and who has maintained close business ties with the U.S. intelligence community for many years. 7. In connection with my work for Wackenhut, I engaged in some software development and modification work in 1983 and 1984 on the proprietary Promise computer software product. The copy of Promise on which I worked came from the U.S. Department of Justice. Earl W. Bryan made it available to me through Wackenhut after acquiring it from Peter Vidanieks, who was then a Department of Justice contracting official with responsibility for the Promise software. I performed the modifications to Promise in Indio, California, Silver Springs, Maryland, and Miami, Florida. 8. The purpose of the Promise software modifications that I made in 1983 and 1984 was to support a plan for the implementation of Promise in law enforcement and intelligence agencies worldwide. Earl W. Bryan was spearheading the plan for this worldwide use of the Promise computer software. 9. Some of the modifications that I made were specifically designed to facilitate the implementation of Promise within two agencies of the Government of Canada, the Royal Canadian Mounted Police and the Canadian Security and Intelligence Service. Earl W. Bryan would check with me from time to make certain that the work would be completed in time to satisfy the schedule for the RCMP and CSIS implementations of Promise. 10. The proprietary version of Promise, as modified by me, was, in fact, implemented in both the RCMP and the CSIS in Canada. It was my understanding that Earl W. Bryan had sold this version of Promise to the Government of Canada. 11. In February 1991, I had a telephone conversation with Peter Vidanieks, then still employed by the U.S. Department of Justice. Vidanieks attempted during this telephone conversation to persuade me not to cooperate with an independent investigation of the government's piracy of In's Law's proprietary Promise software being conducted by the Committee on the Judiciary of the U.S. House of Representatives. 12. Vidanieks stated that I would be rewarded for a decision not to cooperate with the House Judiciary Committee investigation. Vidanieks forecasted an immediate and favorable resolution of a protracted child custody dispute being prosecuted against my wife by her former husband, if I were to decide not to cooperate with the House Judiciary Committee investigation. 13. Vidaniques also outlined specific punishments that I could expect to receive. 300. From the U.S. Department of Justice if I cooperate with the House Judiciary Committee's investigation. 14. One punishment that Vidaniques outlined was the future inclusion of me and my father in a criminal prosecution of certain business associates of mine in Orange County, California, in connection with the operation of a savings and loan institution in Orange County. By way of underscoring his power to influence such decisions at the U.S. Department of Justice, Vidaniques informed me of the indictment of these business associates prior to the time when that indictment was unsealed and made public. 15. Another punishment that Vidaniques threatened against me if I cooperated with the House Judiciary Committee is prosecution by the U.S. Department of Justice for perjury. Vidaniques warned me that credible witnesses would come forward to contradict any damaging claims that I made in testimony before the House Judiciary Committee, and that I would subsequently be prosecuted for perjury by the U.S. Department of Justice for my testimony before the House Judiciary Committee. Further affiance saith not. Michael J. Recanasi Utto. Signed and sworn to before me this 21 day of March 1991. Notary Public. Richard Bobbian submitted an affidavit dated March 22, 1991 into a federal court proceeding in the District of Columbia, describing the sale of InSlaw software by Earl Bryan to Iraq, Korea, Libya, and Chile. The affidavit follows. I, Richard H. Bobbian, being duly sworn, do hereby state as follows. 1. During the past several years, is remarkable both for its credulity in accepting at face value denials of complicity in wrongdoings against InSlaw and for its failure to pursue leads making those denials implausible. Former Attorney General Elliot Richardson and his staff prepared an 80-page report plus exhibits exposing the errors and falsehoods in the BUA report. Richardson's report referred to the obvious absurdity of Justice Department officials using their own personnel to investigate themselves. The report pointed out the lunacy of the BUA report taking at face value the statements of those people who were part of the corrupt acts and who had everything to gain by lying, and for discrediting the testimony of those who had no reason to lie and risked perjury charges if they did lie. The Richardson report exposed the refusal of the BUA group to obtain the testimony and documentary evidence that would expose the Justice Department misconduct and which would have contradicted the BUA report findings. The Richardson report stated in part, the BUA report denigrates the findings of the bankruptcy court without clearly acknowledging that those findings were affirmed and supplemented by two other entities independent of DOJ, the U.S. District Court and the House Judiciary Committee. The BUA report focuses only on those facts that its authors deemed relevant to the conclusions they intended to reach. The report's remarkable credibility toward professions of innocence by the very individuals heretofore identified as the principal culprits in the theft of the software. To accept the self-serving, long after the fact and post hoc rationalizations of these individuals over their testimony at trial, which testimony clearly evidenced their propensity for lying and covering up the truth, as found by two federal courts, is ludicrous. A separate adversarial hearing ensued on this subject, and the bankruptcy court found that DOJ officials had InSlaw and Crimes at Justice 307. In fact, secretly attempted in 1985 forcibly to convert InSlaw from a Chapter 11 reorganization into a Chapter 7 liquidation in order to prevent InSlaw from seeking redress in the courts for DOJ's theft of the Promise software in April 1983. Cover-up by Attorney General Janet Reno and Clinton administration. Attorney General Janet Reno then accepted the BUA report as the final word, and stated that she would not conduct any further investigation into the matter. That decision covered up for the criminality related to InSlaw and the criminal mindset in the Justice Department. She also acted to cover up for other criminal activities of federal officials, including BCCI, BNL, and others, as described elsewhere in these pages. The Clinton administration, through its Attorney General, was continuing the pattern of criminal cover-up and related crimes that I had discovered in that department for the past 30 years. Simultaneous murders and retaliation. Recanasi Utto sought help from various people to gather supporting documents for this grand jury proceeding. Among those gathering documents were his wife, Bobby, and CIA contacts, including Ian Spiro, who resided near San Diego with his wife and their 3 children. Spiro had reportedly worked with Reconnaissance and the CIA. Spiro never provided Reconnaissance with the INSLAW data. Spiro's wife and 3 children were found murdered in different rooms of their home near San Diego on November 1, 1992. Each of them had been shot in the head. Several days later, police found Ian Spiro's body in a parked car on the Borrego Desert east of San Diego. Even though the murders were a state responsibility, the FBI did damage control by intruding into the investigations, stating that Spiro had killed his family and then committed suicide. Large number of related murders protecting Justice Department and other officials. Danny Casolaro had evidence that would have assisted Reconnaissance, but he was killed. Earlier legal counsel and others who had worked with Reconnaissance were also killed, including attorneys Alan D. Standorf and Dennis Eisman. Earlier, an investigator hired by Reconnaissance, Larry Guerin, was killed. The skeletal remains of Reconnaissance's friend, Vala Delahanty, were found on April 12, 1993, in a nearby ravine. Another attorney, John Crawford, who worked with Reconnaissance, died of a reported heart attack in April 1993. Reconnaissance had relied upon Ian Spiro to obtain evidence needed for his defense, but Spiro and his family were killed. Almost simultaneously, a business and social acquaintance of Spiro was killed. Several months later, attorney Paul Wilcher, who sought to expose the INSLAW and October Surprise scandals, who shared data with me, was found dead in his Washington, D.C. residence. These deaths, and dozens of others, protected key officials in the government of the United States, especially within the U.S. Department of Justice. Another CIA operation by Justice Department officials, a state civil trial that had the potential of exposing criminality on the part of Justice Department officials, occurred during 1994 in Los Angeles, involving 308 INSLAW figure Earl Bryan. Justice Department officials sent Assistant U.S. Attorney Stephen Zipperstein to Los Angeles to either block the start of the trial or prevent exposure of information relating to the INSLAW affair. Zipperstein was put in charge of the Justice Department investigation into the death of Danny Casolaro, whose death was linked to INSLAW. Zipperstein was also the Justice Department official who intercepted Paul Wilcher when Wilcher sought to deliver his 100-page declaration to Attorney General Janet Reno. Wilcher was found dead shortly after giving his information to Zipperstein. Cover-up by Clinton's Justice Department. For whatever reason, President Clinton's Justice Department conducted an investigation into the INSLAW affair in 1994. The investigation was conducted under the control of Webster Hubbell, the de facto head of the Justice Department, close associate of President Clinton, and Rose law firm partner with Hillary Clinton. As expected, Hubbell cleared the Justice Department of any wrongdoing in the case. Ironically, before the year was out, Hubbell pleaded guilty to several criminal offenses, adding to the list of former Justice Department officials found guilty of criminal acts. Hubbell went to prison. Framing Reconnaissance. After Reconnaissance testified to Congress about the Justice Department's theft of the INSLAW software, Justice Department officials carried out their threat. Justice Department prosecutors charged Reconnaissance with a criminal offense, claiming he had intended to manufacture amphetamines at his mining operation in Washington. To ensure the success of this prosecution against Reconnaissance, Justice Department officials transferred DIA agent Michael Hurley from his Middle East assignment in Nicosia to Tacoma. According to information received from reliable sources, Hurley was DIA agent in charge at the infamous Mena, Arkansas Drug Center for CIA operations in the early 1980s before being assigned to Iran and then Nicosia. The jury apparently believed the Justice Department prosecutors and Hurley's testimony, and returned a verdict of guilty, causing Reconnaissance to be sentenced to a long prison term. Former Defense Intelligence Agency agent Lester Coleman, 3 worked for the DIA in the Middle East, alongside Hurley in the DIA's Nicosia office. Coleman stated that he discovered the DIA had copies of the stolen Inslaws Promise software and that the DIA was involved in selling it. According to a book authored by Coleman called Trail of the Octopus, the DIA was involved, or covered up for, a CIA DIA Lebanese-Syrian drug operation using Pan Am aircraft out of Frankfurt. This operation made possible the placement of the bomb on Pan Am Flight 103, which exploded over Lockerbie, Scotland. More about this in later pages. On July 24, 1997, I received a fax from Hurley threatening to sue me, which appeared to be an attempt to block the printing of this book. Chapter 17. BCCI, Bank of Crooks and Criminals. Thousands of people worldwide surfaced in the media in 1991. This was the Bank of Credit and Commerce International. As could be expected, it had heavy ties with the CIA, terrorist organizations, drug traffickers, and any other crooked financial transaction shunned by most other banks. It financed terrorist activities, financed drug trafficking deals, defrauded depositors. Following a standard pattern, Justice Department officials and the various divisions including the FBI and other government agencies kept the lid on the worldwide criminal activities of the bank. It wasn't until law enforcement agencies in Europe and a state prosecutor in New York City prepared to file charges that the bank's corrupt operations were shut down in the United States. BCCI was a private bank operating in over 70 countries, including the United States. At one time BCCI had over 400 branches in 78 countries and assets of over $20 billion. Its holding company was based in Luxembourg and its principal operation in London. The primary bank supervisor for BCCI was Luxembourg Monetary Institute, the Central Bank of Luxembourg. The BCCI scandal was related to other criminal activities including BNL, Iraqgate, Iran, and the Iran-Contra affair, among others. BCCI and BNL both played a role in the Iraqi armament buildup, during which funds provided by U.S. taxpayers were forwarded by the Atlanta branch of Italy's Banca Nazionale del Lavoro. There were numerous cross-dealings between the banks. BCCI used its international connections to fund loans to BNL, which funded the Iraqi weapon buildups, which then required the U.S. taxpayer to fund much of the Persian Gulf War. Cover-up of the Bank of Crooks and Criminals. Millions of people throughout the world lost billions of dollars, made possible. TS World's worst banking scandal, inflicting huge financial losses on 310. By the cover-up actions of officials in foreign countries and in the United States. Part of these losses would not have occurred had officials and attorneys in the United States not engaged in criminal activities, including cover-up, misprision of felonies, obstruction of justice, aiding and abetting the criminal activities. Congressional committees, Justice Department personnel, the FBI, and CIA, all knew about the corrupt BCCI operation for years. Source of startup funding. BCCI commenced operations in Pakistan in 1972, with much of its funding provided by Bank of America and the CIA. *45 Bank of America claims that it sold its BCCI interest in the early 1980s, but records indicate that the bank continued to control much of BCCI's operation until shortly before BCCI was shut down. In the early 1970s, CIA operative Gunther Russbacher described to me how he transferred sizable amounts of CIA funds into the bank for the startup operations. Made to order for CIA activities. The CIA knew about BCCI's activities, finding this mindsafe suitable to its own operations. If, for argument, the CIA had not been partners in the corrupt BCCI activities, its worldwide network of operatives and assets should have discovered the BCCI activities that brought about the world's worst banking loss. BCCI was custom-made for the covert and corrupt activities of the CIA, the Mossad, drug dealers, and terrorists. My CIA contacts, including Russbacher, told how CIA operatives used the bank to launder money from CIA enterprises. These included drug trafficking proceeds, the looting of savings and loans, funding unlawful arms shipments, financing terrorist operations, 34-degree undermining foreign governments, and other covert activities. manipulating U.S. checks and balances. Investigative reports indicated that BCCI was able to manipulate the spy agencies of numerous countries, including the US, Israel, China, Saudi Arabia, and Pakistan, among others. BCCI was supplying funds for terrorist organizations such as Abu Nidal. BCCI rigged international commodity markets that permitted certain insiders to make hundreds of millions of dollars in profits, offset by the same amount lost by depositors. BCCI was laundering drug money for drug cartels throughout the Americas, Europe, and the Middle East. Bank of America involvement. Bank of America was heavily involved in BCCI from the date of its inception in 1972. It put up an initial cash investment amounting to 25% of the stock, which was later increased to 45%. Bank of America and the CIA had a major ownership in BCCI at that time. Bank of America loaned money to people to buy stock in BCCI, possibly as fronts, making Bank of America's interest considerably higher. 3 out of 7 members of BCCI's board of directors were former senior executives at Bank of America, some of whom were on leave from BAFE. A class action lawsuit, 4 filed in San Francisco courts, 48 by a class of defrauded BCCI depositors, charged that Bank of America officials had considerable control over BCCI and had more knowledge of its illegal operations than previously disclosed. The lawsuit charged that Bank of America had a major ownership interest and control in BCCI, and that Bank of America loaned millions of dollars to BCCI frontmen so that they could unlawfully purchase financial institutions in the United States. The suit charged that 5 Bank of America officers were either on BCCI's board of directors or helped manage the bank. One of them, P.C. Twitchin, allegedly approved all BCCI loans over $5 million. The suit charged that in 1978 Bank of America hired the son of Pakistani General Zia for a position, even though he was completely unqualified, solely to bribe important Pakistani officials. The suit charged that through a correspondent banking relationship with BCCI, Bank of America continued to conspire with and aid and abet BCCI activities until the summer of 1991. The suit charged that the wrongful acts of BCCI could not have been accomplished without the active and knowing assistance of Bank of America. The president of an Atlanta bank controlled by BCCI was a Bank of America official, adding to the evidence that BAFE had heavy interests in the activities constituting the world's worst banking fraud. Bank of America had a symbiotic relationship with the Bank of Crooks and Criminals, which continued years after the criminal activities became public. Bank of America made large profits from its relationship with the rogue bank. But fearing that its direct ownership in BCCI could be embarrassing, Bank of America officials started selling its interest in BCCI, lending money to front men to acquire these interests. The mother of all scandals, stated syndicated columnist Jack R. Payton in the San Francisco Examiner 34. As he wrote of the BCCI affair, "Top BAFE alumni filled major posts at BCCI," was another headline in the San Francisco Chronicle. The article named top executives of Bank of America who filled high-level positions at BCCI. Another San Francisco Chronicle article was entitled, "BAFE, BCCI dealings hit $1 billion plus a day." Bank of America was a crucial repository for large infusions of cash needed by BCCI to keep its worldwide financial empire afloat. The article stated that the transactions continued throughout the 1980s, long after BCCI's corrupt activities were known to thousands of people. The article also mentioned congressional sources who found that Bank of America's daily activities with BCCI reached $1.3 billion a day in some years, and that the relationship continued even after the U.S. government indicted 2 BCCI officers and 9 BCCI executives in 1988 on charges of laundering over $32 million in drug money. The article quoted banking sources stating that the level of financial transactions that Bank of America conducted with BCCI was rare for a foreign correspondent bank. According to a San Francisco Chronicle article quoting a congressional source, Bank of America did not sever ties after BCCI's corrupt activities became common knowledge. The congressional source added that as late as March 1990, Bank of America kept two of its accounts open with BCCI's Miami office, 2 years after the Miami office had been indicted and was widely known for alleged money laundering deals involving drug money for former Panama dictator Manuel Noriega, among many others. Bank of America kept BCCI in business. Without these financial transactions from Bank of America, BCCI would have occasionally run out of funds. Bank of America was instrumental in permitting BCCI to continue stealing depositors' money. Without this help, the corrupt activities of BCCI would have been discovered years earlier. The author of numerous books on financial institutions' 3 registered degree told how Bank of America's $1 billion daily money transfer was strange and unusual. He estimated that the deposits were a Ponzi game, probably involving letters of credit, which banks used to handle foreign trade payments. Meyer wrote that a great deal of BCCI sham activities were in bogus letters of credit. Bank of America sold some of its stock to a BCCI subsidiary called International Credit and Investment Company, making a $27 million profit on the transaction. That same company, ICIC, has since been identified as the BCCI entity that handled some of BCCI's most notorious deals. These included fraudulent insider loans that were never repaid. Congressman Frank Riggs asked the House Committee on Banking, Finance, and Urban Affairs to investigate Bank of America's ties to BCCI, stating in a letter to Congressman Henry Gonzalez, chairman of the committee, that there is very clear evidence that Bank of America had links to the scandal-ridden BCCI. In his letter to Gonzalez, Riggs wrote, "I believe that the links that have already been found between BCCI and BOF are of such far-reaching implications that a hearing is needed now." Riggs continued, "It troubles me that BOF continued to handle as much as $1.3 billion of BCCI deposits per day even after BCCI was indicted for money laundering in 1988. Riggs pointed out that there existed a close financial relationship between Bank of America and International Credit and Investment Company, a BCCI subsidiary in the Cayman Islands. Riggs added, "We know that Bank of America, a founder of BCCI, also provided a startup loan to ICIC. We also know that BOF later sold its BCCI holdings to ICIC and provided financing to ICIC for the purchase. BOF made more than a 600% profit off this transaction." Bank of America money laundering. Bank of America was fined $7 million in 1986 for 17,000 separate acts of money laundering. *5. Bank of America's name surfaces throughout BCCI's sordid history. Despite the widespread knowledge by U.S. banking and intelligence agency personnel of the BCCI criminal activities during its 2 decades of corrupt operations, Bank of America officials, who controlled much of the BCCI operation, claimed they knew nothing about the corrupt unlawful activities. Unlawful acquisition of U.S. banks and savings and loans. BCCI, as represented by Clark Clifford and Robert Altman, tried to convince U.S. regulators in the 1970s to allow BCCI to purchase a bank holding company. When U.S. regulators refused to allow this purchase that was barred by U.S. law, BCCI then loaned money to people who bought shares in American banks, including Financial General Bank Shares Incorporated. When BCCI secretly sought to acquire in 1978 Financial Gear Bank Shares Incorporated, the stockholders of Financial went to court to block a takeover attempt, citing questionable activities by the BCCI front men. The stockholders requested supporting documents from Bank of America. To keep the BCCI activities from the public, from the stockholders, and from the government, attorneys Clark Clifford and Robert Altman threatened to sue Bank of America if the bank produced the requested documents. Bank of America officials then refused to produce documents that would otherwise expose these activities. 352 With the help of powerful U.S. law firms willing to subvert U.S. laws and interests, BCCI was able to violate U.S. banking laws, engage in a pattern of criminal activities, and inflict billions of dollars of harm to people throughout the United States and other countries. But U.S. taxpayers came to the rescue, and are now paying the price for these corrupt acts heavily involved with U.S. officials and law firms. After secretly and unlawfully purchasing Financial General Bank shares, its name was changed to First American Bank Shares. Altman was rewarded by being named president of the holding company and given stock that eventually netted him several $1 million profit, in addition to his monthly compensation. Many politicians were also paid off handsomely. When billions are stolen, it is possible to pay well for those helping in the scheme. They all played the part of the amiable dunce, claiming they did not know First American Bank Shares was controlled by BCCI or that the criminal activities existed. These covert ownerships that were harming U.S. interests were fraudulently hidden by many law firms and attorneys, including Clifford and Altman. Clifford, chairman of First American Bank Shares, said he didn't know of any ties to BCCI, in spite of the fact that his law firm represented BCCI. He was chairman of BCCI Front Companies, and was the main U.S. lawyer for BCCI in the late 1970s. Clifford was frequently called the number one fixer in the Democratic Party. First American Bank in New York was part of the BCCI operation. BCCI secretly acquired First American's parent, First American Bank Shares of Washington, D.C., in 1983. Federal law restricted the operations of BCCI's offices, prohibiting BCCI from accepting deposits in the United States. This restriction was violated, causing many depositors to lose their deposits. BCCI secretly acquired Independence Bank in Encino, First American, and invested in Centrust in complex financial deals that were difficult to detect. BCCI acquired various U.S. banks including First American Bank in Washington with its many branches, National Bank of Georgia, Independence Bank in Encino, California. Saudi Arabia involvement. The biggest and most prestigious bank in Saudi Arabia, National Commercial Bank, was implicated in the BCCI scandal. District Attorney Robert Morgenthau, County of New York, brought a fraud indictment against the largest banker in Saudi Arabia, Sheikh Khalid bin Mahfouz, charging the Saudi bank with failing to report purchases of stock in Washington's largest bank holding company, First American Bank Shares, which was illegally and secretly controlled by BCCI. The purchase of the stock was financed by loans from the Saudi bank to people acting as fronts for BCCI. The Saudi bank loaned money to BCCI in a manner that permitted BCCI's illegal operations to continue. Canadian involvement. Canadian politicians were also implicated. When members of Canada's Parliament were forced to investigate BCCI activities, they learned that the former Deputy Commissioner of the Royal Canadian Mounted Police, Henry Jensen, who had supervised the BCCI investigation from 1987 to 1989, had gone to work for BCCI as a paid consultant shortly after his retirement. Canadian officials refused to cooperate in the INS-law investigation. Canadian officials have been charged with covering up sensitive facts relating to the Aero Airlines DC-8 crash at Gander that killed 248 American GIs under suspicious circumstances. Aero was a CIA front company. Congressional hearings. A BCCI insider, Abdur Sakia, testified at a Senate Foreign Relations Subcommittee on Terrorism, Narcotics, and Internal Operations about events that he had seen as a BCCI officer. He described a July 1988 meeting at the Washington offices of Clifford and Warnke, at which Clifford joked to one of the BCCI officers, "Welcome aboard. We will tell more lies now." Sakia testified to meetings at which Altman and other senior BCCI executives referred to secret agreements under which BCCI retained control of Independence Bank of Encino. Clifford and Altman have consistently denied knowledge of any relationship to BCCI. Sakia told how the CIA used BCCI for money transfer in the Iran-Contra affair. Former Federal Budget Director Burt Lance in the Carter administration testified before Congress that he was convinced the CIA recruited the founder of the Bank of Commerce and Credit International to use the bank for CIA purposes. Acting Director of the CIA, Richard Kerr, testified to the Senate subcommittee that the CIA knew in 1985 that BCCI had secretly gained unlawful control of Washington's largest bank holding company. Savings and loans and BCCI. The savings and loan debacle had numerous connections with the BCCI scandal. Savings and loan figure Charles Keating served on the board of a Bahamas-based investment company, Trend Invest Limited, along with Alfred Hartman, who was a director of BCCI. Reports given to me by CIA sources state that the Keating Group, among others, moved hundreds of millions of dollars into offshore bank accounts and trusts. Attorneys at the law firm of Alvarado, Russ and Worcester, representing over 15,000 investors who were defrauded by the Keating Group, stated, "It was clear to us back in 1989 that Mr. Keating had been involved in significant movement of cash offshore. Two failed savings and loans, SunTrust Savings Bank in Miami and Viking Savings in Santa Monica, California, had direct or indirect connections to BCCI. Viking Savings and Loan was secretly acquired through money provided in part by California Democratic State Senator Alan Robbins, who contributed $900,000. Robbins allegedly obtained the money from BCCI Independence Bank of Encino, California. Viking was acquired by Michael Goland, a pro-Israeli candidate. Goland used money to mount a 1984 Senate campaign against Republican Charles Percy, who Goland felt was anti-Israel. BCCI had a secret and illegal 28% ownership in SunTrust Savings Bank. SunTrust's failure will cost the American taxpayer over $2 billion. SunTrust was run by David Paul, a major fundraiser for the Democratic Party and a close friend of Senator Kerry, who investigated the BCCI scandal, and to this day hasn't taken any significant action. Senator Kerry was chairman of a key campaign committee for Senate Democrats in the late 1980s, while Paul was the chairman of the committee's fundraising arm. Gaith Pharaon, a Saudi Arabian financier, openly acquired a 28% stake in SunTrust, acting as a front man for BCCI. A BCCI front purchased the Bank of Georgia in 1977, in which former budget director during the Carter administration, Burt Lance, had a substantial financial interest. Lance sold his shares in National Bank of Georgia to Saudi businessman and BCCI front man Gaith Pharaon, who then sold them to First American Bank Holding Company in Washington, D.C., another secretly controlled BCCI operation. BCCI had tentacles in other criminal activities including Iraqgate and the bank primarily owned by the Italian government, Banca Nazionale del Lavoro. Both of these scandals implicated high U.S. officials. BCCI, Bush, and Clinton. One of the men behind the founding of BCCI was Jackson Stevens, who headed Stevens, Inc., located in Little Rock, Arkansas. Stevens Incorporated was a large U.S. investment bank with numerous hidden connections, including one with Harken Energy, to obtain the oil drilling rights off Bahrain. George Bush, Jr., was a consultant and member of the board of directors of Harken, before the oil drilling contract was signed. Stevens' firm helped secure a loan from a BCCI-affiliated Swiss bank for Harken Energy. Bill Clinton's involvement in the BCCI affair was shown in a February 1992 Article 353 under the headline Clinton and BCCI. The article reported that the Clinton campaign had a $2 million credit line from a bank with connections to BCCI. The credit line was from Worthen National Bank in Little Rock, Arkansas, controlled by Little Rock billionaire Jackson Stevens and managed by Kurt Bradbury. Stevens was involved in the 1970s deals in which BCCI unlawfully acquired Washington's First American Bank. Stevens' links to BCCI were reported in an Arkansas Democrat article titled "Reports Link Stevens to BCCI." The article stated that an employee of Stevens acted as chairman, president, and chief executive officer of Worthen National Bank. In addition, the article stated that in 1977, Stevens Incorporated assisted BCCI to unlawfully take over First American Bank shares. Another Arkansas Gazette article entitled "Little Rock on the BCCI Route to Power," stated in part, Kurt Bradbury, then a financial analyst for Stevens Incorporated, and now chairman and chief executive officer of Worthen National Bank of Arkansas, provided research about Financial General, including a copy of its latest annual report. Financial General was the parent company of the National Bank of Georgia, the bank run by Burt Lance. It was the purchase of Financial General and the National Bank of Georgia that evolved into First American Bank shares, operated by attorney Clark Clifford in Washington. An article in Spotlight 354 tied Democratic presidential candidate Clinton to the BCCI scandal and charged that the mainstream press was concentrating on Clinton's extramarital activities and his draft dodging during the Vietnam War while ignoring Clinton's involvement in the BCCI scandal. The article referred to New York Post writer Mike McAlery's reporting of the connections between Clinton and the BCCI mess. Money allegedly came from Arkansas billionaire Jackson Stevens, who reportedly brokered the transaction that enabled BCCI to gain unlawful and covert control of two U.S. banks, First American Bank shares and the National Bank of Georgia. Houston oil consultant Michael Amin, who was on the payroll of the U.S. State Department as a consultant, was highly instrumental in working out the Bahrain deal. Amin had close contacts with Amajor BCCI shareholder, Kamal Adam, who was also a former chief of Saudi Arabian intelligence. Many links. Alfred Hartmann, a Swiss banker, was a BCCI director and chairman of its Swiss unit, Banque de Commerce et Placements SA, or BCP for short. Hartmann was also chairman of BNL's unit in Zurich, Switzerland, known as Lavoro Bank. Hartmann was vice chairman of a joint venture institution in Geneva called Bank of New York Intermaritime Bank. Hartmann was involved in the BCCI and BNL banks and in the Bank of New York Intermaritime Bank. An officer of Bank of New York, Bruce Rappaport, also had close ties to the CIA and the Mossad. Profits for sabotaging America's interests. Many attorneys, public relations firms, members of Congress, and others made handsome profits at the expense of the American taxpayers and the thousands of depositors who lost their life savings. Carter, while President of the United States, owed money to a bank with connections to BCCI and was bailed out along with his banker friend, Bert Lance, by Farone. Farone first loaned $3.5 million to Lance through BCCI and then 354 March 2, 1992. BCCI, Bank of Crooks and Criminals AE. Bought control of Lance's bank for an additional $2.40 million. 355 Several days later President Carter approved the sale of F-15s to Saudi Arabia. BCCI paid for former President Jimmy Carter's trips around the world after he left the White House. BCCI wrote off a $160,000 loan to an Atlanta consulting firm operated by Andrew Young, former mayor of Atlanta. 35 degrees The loan had been made by National Bank of Georgia, which had been acquired by BCCI frontman Gates Farone. Young had served as U.S. ambassador to the United Nations during the Carter administration. Enlarging on his many trips to Africa, Young promoted BCCI to individuals and governments in Africa and Central America. Mayor Young received a retainer for introducing third world leaders to BCCI. A former BCCI official provided about $11,000 in travel accommodations to Reverend Jesse Jackson. White House aide and attorney Ed Rogers went to work for a BCCI frontman, Kamal Adam, in October 1991. Adam was a frontman in the illegal purchase of Washington's First American Bank. In a press conference, President Bush denied knowing Adam, although the facts indicated otherwise. Adam was head of Saudi Arabia's spy agency while Bush was head of the U.S. Central Intelligence Agency. Despite Rogers' young age, 33 years, and his lack of legal experience, BCCI offered him $600,000 up front for 2 years' work plus expenses to leave his job as White House aide and assistant to Chief of Staff John Sununu. He obviously wasn't being paid for his legal knowledge, but for his political contacts with the Bush administration. Rogers, a young attorney who had never practiced law and had relatively little experience, stated on his application to register as a foreign agent that he had been hired for his legal expertise. The two most probable reasons for Rogers to be hired by a mastermind in the BCCI web were either for his influence in the White House, or with the urging of the White House to facilitate the various covert activities between President George Bush, other White House officials, or the CIA. Abu Dhabi's role takes on political dimensions because the ruling family of Abu Dhabi contracted with a firm operated by President Bush's deputy campaign manager, James Lake, to handle public relations. That firm has been paid over $1 million over a 12-month period to have the U.S. media define Abu Dhabi as a victim of the scheme to illegally gain control of banks in the United States. Abu Dhabi was uncooperative in providing documents and refused to allow any of its citizens to testify. Lake was sitting in on White House campaign strategy meetings while also providing information to Sheikh Zayed bin Sultan Al Nahyan 357, who controlled a major portion of BCCI's shares. Public relations firm sellout of U.S. interests. BCCI hired a public relations firm led by prominent Republican Robert Gray and Democrat Frank Mankiewicz, which was paid fees of $50,000 a month while it spread false information to Congress and the public, protecting BCCI. The accounting firm responsible for inspecting BCCI, Price Waterhouse, received 355. The Jack Anderson syndicated column. 356. Wall Street Journal, September 3, 1991. 357. Sheikh Zayed bin Sultan Al Nahyan was President of the United Arab Emirates. 318. A $600,000 loan from BCCI. 358. An employee of Price Waterhouse, who audited the financial statements of BCCI and covered up for the irregularities, received over $100,000 from a BCCI affiliate within 2 years after leaving the accounting firm. The same practice continued as private auditors kept the lid on the corrupt activities. San Francisco attorney Henry Fields and the law firm of Morrison and Foerster were used by BCCI frontman, Gaith R. Ferrone, to obtain regulatory approval for the purchase of Independence Bank of Encino, California. Fields assured regulators that Ferrone would be the sole owner of Independence. But Ferrone signed an agreement putting 85% ownership of the California bank in the hands of a BCCI subsidiary. Immediately after the California bank changed hands, Ferrone hired another Morrison and Foerster attorney to be on the board of directors of Independence Bank. Many attorneys in the United States and overseas were involved in the complex activities of BCCI, and not a single one spoke out, typical of their role in almost every scandal I have already mentioned. CIA connections. The CIA provided part of the startup funding for BCCI. It moved large amounts of money through BCCI during its entire operation. Former CIA Director Richard Helms tried to arrange for the purchase of First American by BCCI and failed. Clark Clifford then sought to arrange the purchase using BCCI front men, obtaining U.S. regulatory approval based upon Clifford's false representations. Jeb Bush, one of President Bush's sons, Jeb Bush, had numerous dealings with BCCI and was frequently in BCCI's Miami office. Jeb Bush's company invested in real estate with a company controlled by a BCCI customer, who was later sent to prison for defrauding BCCI and other banks. Bribery was everywhere. BCCI had a bribery list of U.S. elected public officials. Reference was made to this list during congressional testimony before the House Banking Committee, which was chaired by Representative Henry Gonzalez. One method reported for conveying bribes to members of Congress was through the Chicago Commodity Exchange, Chicago Board of Trade, Chicago Board Options Exchange, and the Chicago Mercantile Exchange. Money was put into commodity exchange accounts overseas under the name of a particular member of Congress. Periodically the congressman would be informed that there was money in his account, and he was then advised how he could withdraw it if huge amounts of cash were brought into Chicago to orchestrate this scheme. Both political parties implicated. As in many of the scandals mentioned in this book, both political parties were implicated, receiving large financial contributions or bribes from the illicitly operated bank. As in the savings and loan scandal, members of Congress were. 358. Wall Street Journal article by Peter Truell. BCCI, Bank of Crooks and Criminals. 349. Handsomely rewarded for either looking the other way or obstructing any investigations. The key to continuing the corruption and harms inflicted throughout the world by BCCI was bribing U.S. and other officials. Senator Orrin Hatch, the senior Republican on the Judiciary Committee, was one of hundreds of congressmen who received money from BCCI officials. He was more openly protective of the BCCI corruption. Senator Hatch issued a glowing endorsement of the Justice Department's plea bargain settlement with BCCI's money laundering operation in Tampa, Florida, which was a slap-on-the-wrist settlement blocking further investigation into high-level BCCI corruption. It also prevented investigation of Hatch's involvement with BCCI. Although BCCI pled guilty to several dozen felony counts, Senator Hatch said in his Senate floor speech that there was no systematic money laundering uncovered in the BCCI case. Hatch has extolled senior management, directors, and shareholders of BCCI for the responsible way they behaved. This probably reflected the mindset of U.S. congressmen. Senator Hatch's speech had been prepared by the same BCCI cutouts that perpetrated the sham against the American people, Washington attorney Robert Altman and his law office. Immediately after giving the unusual speech defending the crime-infested bank and those who made the crimes possible, Senator Hatch placed a telephone call to BCCI's chief executive officer, Swaley Naqvi. Hatch requested a loan for his business associate, Munzer Hourani, a Houston businessman. In another instance, Senator Hatch's office misused his Senate office trying to protect BCCI against drug money laundering charges. When the media exposed this attempt, Hatch sought to divert attention from himself by blaming a former member of his staff, Michael Pillsbury. Pillsbury had represented Senator Hatch by seeking a more favorable outcome in the 1989 money laundering indictment in Florida against BCCI officials. Hatch sought to sidestep blame by asking the Senate Ethics Committee to investigate his former aide. Senator Hatch was involved with a part owner of BCCI, Mohammed Hammoud, a front man for BCCI in First American Bank share purchases. Hammoud's loose talk about the BCCI operations threatened politicians and crooks worldwide, possibly causing his May 1990 death under mysterious circumstances in Geneva, Switzerland. The insurance company refused to pay death benefits because the corpse was 4 inches shorter than shown on Hammoud's last physical examination. Senator Hatch was one of the senators to whom I sent evidence of these various scandals and who refused to receive my evidence. It is understandable that a member of Congress already implicated in one or more scandals or criminal activities would refuse to receive evidence of other criminal activities. The same argument can surely be applied to each of the other senators and representatives who refused to receive the testimony and evidence of our group of whistleblowers. One of the infamous Keating 5 senators from the savings and loan scandal, Senator Alan Cranston, intervened on behalf of BCCI. 35° Cranston wrote a letter to the Federal Home Loan Bank Board at the request of David Paul, owner of BCCI-related SunTrust Savings Bank 3 of Miami, requesting relief from regulatory actions, while simultaneously receiving political contributions which are usually bald-faced bribes. Senator Cranston repeatedly intervened on behalf of the biggest crooks in the savings and loan debacle while refusing to receive my evidence of massive criminal activities. He also intervened on behalf of the crooks in the world's worst banking scandal. That same scenario applied to many other members of the Senate and House. Congress forced to investigate the media attention over BCCI's activities forced Congress to conduct an investigation. The Senate Foreign Relations Subcommittee on Terrorism, Narcotics, and International Operations, chaired by Senator John Kerry, conducted an investigation. At the same time, Kerry received financial contributions from BCCI's front man David Paul, of Florida SunTrust. SunTrust failed, costing the American taxpayer over $2 billion. SunTrust chairman, David Paul, arranged for BCCI to invest $25 million in SunTrust bonds in 1988, and then repurchase the bonds 2 months later. The intent was to make SunTrust temporarily look healthier than it really was. This temporary financial support further substantiated the BCCI-SunTrust relationship. The bribe to Kerry, or whatever one wishes to call it, may be the reason that the Senate committee did not request the appointment of an independent prosecutor despite the serious corruption uncovered by the committee investigators. Many members of Congress were involved in the scandal, which also helped to eliminate any desire for an independent prosecutor. Cover-up of very serious crimes ignored by the Senate committee. Senate investigator Jack Bloom unsuccessfully sought to have Congress act on the alarming disclosures that he had uncovered. When much of the criminality focused on corrupt members of Congress, other U.S. officials refused to delve into those areas. In desperation, Senate investigator Jack Bloom quit his Senate investigative function and tried to get Justice Department officials to act. After being stonewalled there, Bloom sought to interest Manhattan District Attorney Robert Morgenthau in the scandal that had tentacles in New York. The overwhelming evidence that Bloom presented resulted in Morgenthau obtaining a grand jury indictment against BCCI and two cutouts, Clark Clifford and Robert Altman. They were charged with engaging in a multibillion-dollar scheme to defraud depositors, falsifying bank records, concealing illegal money laundering, and engaging in larceny. Even after the indictment, Justice Department officials refused to produce requested documents. By July 1991, Morgenthau had enough evidence to indict Clifford and Altman. They were charged with bank fraud and with receiving $40 million in bribes from BCCI as part of a conspiracy to give BCCI control of several banks in the United States. The Senate report. The committee issued a nearly 800-page report, accusing BCCI of using political insiders to commit fraud upon the United States on a global scale. The report stated that there exists an elaborate corporate spiderweb with BCCI's founder, Aga Hassan Abedi, and his assistant, Swaley Naqvi, in the middle. The report stated that BCCI's modus operandi throughout the world, including the United States, was bribery and subversion of government officials. The report stated that BCCI systematically bribed political figures around the world. Senator Hank Brown, a member of the Senate committee, stated at a news conference, "We found it was BCCI's overpowering use of the nation's political insiders like Clark Clifford that permitted BCCI's secret expansion in the United States." The report described an international operation that would exceed Spectre, the fiendish special executive for counterintelligence, terrorism, revenge, and extortion, found in James Bond novels and movies. Senator Kerry said that BCCI constituted international global crime on a level that boggles the mind. The report criticized U.S. bank regulators, the CIA, and the Justice Department, and offered a scathing portrait of political influence, international bribery, and inaction by agencies having the duty to act, becoming the catalyst for one of the biggest financial frauds in the world's history. The report listed the financial contributions or bribes paid to various members of the U.S. Congress, including former Senator John Culver and Senator Orrin G. Hatch. The report severely criticized two attorneys, Clark M. Clifford, a former cabinet member and advisor to various presidents of the United States, and his protege, Robert A. Altman, who have been charged with taking bribes from BCCI in exchange for hiding BCCI's ownership of First American Bank shares, a Washington holding company of which Clifford was the chairman. Senator Hank Brown, who was the subcommittee's ranking minority member, substantiated the fact that BCCI's financial contributions were so extensive that there was not a single committee of this Congress that wanted to conduct a complete, thorough investigation. The report stated that while Senator Hatch and Mr. Pillsbury, a former State Department official, worked on behalf of BCCI to halt investigations, Senator Hatch was requesting BCCI to lend $10 million to a business associate with whom the senator was in partnership. The report stated that BCCI used political insiders such as former Defense Secretary Clark Clifford and members of Congress to commit fraud on a global scale. It told how BCCI paid members of Congress, lobbyists, and attorneys to obstruct the investigation into its terrorists and drug money laundering activities. The report implicated Democrats and Republicans, lawyers and lobbyists, public relations firms, congressional staffers and former senators. The report treated with kid gloves Senator Hatch's frequent attempts to protect BCCI and to obstruct criminal investigations while receiving BCCI money. The report tried to make Senator Hatch's aide the scapegoat and recommended that the aide be investigated by the Senate Ethics Committee. The activities of attorney and former Senator John Culver were stated, in part. 322. Sen. Culver's role in lobbying Congress to assist BCCI was more significant than had been publicly understood, and he provided valuable advice to BCCI on how to handle congressional attempts to investigate the bank. Despite the gravity of the crimes depicted in the Senate report, much remained to be learned when the Senate committee discontinued its investigation and issued its report. CIA officials refused to produce hundreds of documents that it had on the BCCI operations, in which the CIA itself was involved. Refusal to request independent prosecutor. Despite the many unanswered questions concerning involvement of U.S. officials, the Senate committee refused to request appointment of an independent prosecutor. To have done so would have implicated many members of Congress in both major political parties. When questioned by reporters as to whether he would request appointment of an independent counsel, Senator Kerry replied, "There already is an independent counsel, Bob Morgenthau." That answer was a farce. A county district attorney has a limited budget, and has neither the funds nor the authority, nor the responsibility, to investigate a complex scandal with international implications of the magnitude of the BCCI scandal. The authority of a local county prosecutor is obviously inadequate to investigate the national and international aspects of the BCCI scandal. Morgenthau's yearly budget for prosecuting all criminal acts in Manhattan was approximately $50 million. Independent prosecutor Lawrence Walsh, for instance, spent over $40 million just to determine who was lying to Congress in the Iran-Contra affair. Hundreds of tips from informants, and the usual Justice Department obstruction of justice. Federal agencies received hundreds of tips for over 10 years detailing BCCI criminal activities. Federal agencies, including the FBI, Justice Department, Drug Enforcement Administration, and the Internal Revenue Service, had thousands of investigators, many of whom knew about the corruption for years, and no action was taken. As in every other scandal, Justice Department officials blocked corrective actions. An initial investigation in 1989 by Justice Department officials into BCCI's secret ownership of First American had been abruptly cancelled, protecting the criminal elements within BCCI, powerful Washington law firms, members of Congress, Bank of America, and others. Former BCCI officers informed the Senate committee that they believed the Justice Department's cover-up and failure to properly investigate BCCI was due to BCCI's extensive connections with the CIA and other U.S. intelligence agencies. An investigation would expose the unlawful Iran-Contra arms flow, the drug trafficking into the United States from throughout the world, CIA money laundering from its covert domestic proprietaries, bribing of U.S. officials, especially members of Congress, and God knows what else. The BCCI scandal would most likely have slowly drifted away and become worse, if it had been left up to those in charge of the U.S. Department of Justice and Congress. It would be one more major scandal kept secret from the American public. But a persistent investigator, Jack Bloom, went to a county prosecutor in New York when Congress and the Justice Department stonewalled the matter, and convinced a 73-year-old county prosecutor, Robert Morgenthau, to prosecute BCCI and the crooks associated with it. Soon after commencing the investigation, Morgenthau encountered the obstruction of justice tactics by Justice Department attorneys, who wanted to keep the lid on the scandal. Over a decade of ignoring informants 13 years before BCCI was seized in 1991, an American bank examiner, Joseph Vise III, warned in a memo that BCCI was rife with bad loans and that the bank used front men to disguise fraudulent transactions. The memo described the incestuous lending and ownership arrangements with affiliate companies in offshore havens, the practice of almost limitless lending to favored customers, and other serious banking irregularities. The memo referred to the ICIC Group, a Cayman Islands affiliate that the Federal Reserve called BCCI's alter ego, and estimated that it controlled 70% of BCCI, and that BCCI's front men operated through ICIC. Vise testified before a Senate subcommittee concerning the memo, which mysteriously disappeared from the government files. Vise then produced his copy of the document. The Senate committee then requested the original from the Comptroller's office, which refused to produce it. The committee then subpoenaed the document. Assistant Secretary of Intelligence at the State Department, Douglas Mulholland, testified about another hidden memo on BCCI. In January 1985, while he was Special Assistant for National Security to the Secretary of the Treasury, he received an unusual report from the CIA relating to BCCI. Mulholland further testified that the CIA forbade him from discussing the memo on the basis of national security. 36 A CIA telex message from CIA Director Richard Helms was entered into the Senate hearing record showing the CIA knew of the BCCI activities a decade before the scandal surfaced. The telex related to the wording of an agreement to grant power of attorney to a Washington law firm relative to a transaction involving Financial General Bank shares of Washington, D.C., later renamed First American Bank shares. House investigation. The House also conducted an investigation into the BCCI scandal. Representative Charles Schumer chaired the House committee, and the report was for all practical purposes a cover-up. Congressional investigator and cover-up artist Lawrence Barcella helped persuade Senator Orrin Hatch to give a speech on the Senate floor praising BCCI. 36 This is the same Barcella who in 1992 engaged in a cover-up of the House October surprise investigation. Barcella also helped to conceal a covert CIA operation supplying military equipment to Libya's President Muammar al-Gaddafi, after its cover was blown, by charging CLA operative Edwin Wilson with a federal crime for carrying out CIA operations. CIA Deputy Director Robert Gates had stated in 1988 to the head of Customs, William von Ropp, that BCCI stood for the Bank of Crooks and Criminals International. Yet, the CIA continued to deposit and launder funds in BCCI, covering up the criminal activities that would defraud people all over the world who had put their money into the bank. In the 1980s, U.S. Customs Commissioner William von Ropp unsuccessfully tried to get the Justice Department to act on the serious federal violations committed by BCCI. Ropp testified to Senate investigators that in 1988 he told Gates of the drug money laundering at BCCI, and that Gates refused to proceed with the information. Ropp did not know, apparently, that the CIA was itself laundering drug and other illicit money through BCCI. BCCI officer Nazir Chinoy tried to provide information to federal prosecutors about covered arms deals involving BCCI and the CIA. 36 Instead, Justice Department officials indicted Chinoy, and in that manner, the CIA drug smuggling was again kept under wraps. Justice Department officials were put on notice during a 1985 federal heroin investigation that money was being laundered in BCCI's Independence Bank of Encino in California. The Justice Department's DIA and the Treasury Department's Internal Revenue Service learned of the BCCI connection and the drug money laundering, and did nothing about it. To have done so would have exposed the CIA and bribing of federal officials. Tape recordings of a BCCI officer talking to an undercover investigator included the following statement: "Now we are trying to extend our operations into the United States. We have offices in New York, Atlanta, Miami, Houston, San Francisco. Also we have acquired some local bank which we take over very shortly." Kidder, Peabody and Company notified federal regulators from 1978 through 1981 that it was helping BCCI acquire an interest in First American Bank shares, Inc., while First American was telling banking regulators that First American had no connections to BCCI. 3 This information was prepared by Martin Siegel, showing that BCCI was behind the ownership change involving First American, the largest bank holding company in Washington. After the acquisition was approved in 1982, Kidder renewed its registration as an agent for BCCI, working in connection with the acquisition of First American. No reference was made on the application form that Kidder was working with the front men. Seeking to circumvent the block by Justice Department officials, U.S. Customs Officer Robert Mazur wrote to Senator John Kerry, chairman of the Senate Subcommittee on Terrorism, Narcotics, and International Operations, complaining about the cover-up within the Justice Department and Customs. Mazur wrote, "Tons of documents were not reviewed, and the CIA put a halt to certain investigative leads into a 1988 Florida inquiry that led to the indictment of BCCI officers in Tampa. We had drug traffickers, money launderers, foreign government involvement, Noriega, and allegations of payoffs by BCCI to U.S. government political figures. I will not elaborate on who these U.S. government figures were alleged to be, but I can advise you that you don't have all of the documents. Some were destroyed or misplaced. Senator Kerry refused to release the letters written by Mazur, but those who have seen them state they were political dynamite, exposing serious misconduct by many members of Congress. Dozens of members of Congress received political contributions or bribes from BCCI and its unlawful outlets in the United States, including the chairman of the investigating committee, Senator John Kerry, who received the highest reported amount of contributions. Kerry also failed to recommend appointment of an independent prosecutor in THIRD-BCCI scandal. In testifying before the Senate Committee 367, Mazur testified to the following facts: that his group discovered hundreds of leads indicating gross misconduct by BCCI officials, that Justice Department officials refused to send investigators who were needed to follow through on the leads, 308 that the leads indicated large political payoffs in the United States, that BCCI was financing unlawful arms transactions, that BCCI secretly owned U.S. banks, and other federal violations, and that Justice Department officials blocked exposure of these matters in numerous ways, including refusal to provide additional personnel, refusal to grant permission to obtain testimony outside the United States, and by reaching a plea bargain with BCCI before higher UPS were implicated. Mazur further testified that he resigned from the U.S. Customs Services because of his frustration at the cover-up by Justice Department officials and within the Customs Service. He described the discovery of BCCI's money laundering activities in Tampa, Florida, and the political payoffs, along with the secret ownership of U.S. banks. Justice and CIA caught red-handed feisty Congressman Henry Gonzalez's persistent investigations and demands for documents exposed the cover-up by Justice Department and CIA officials. Each of them had reported to congressional committees that every document in their files pertaining to BCCI had been released to the congressional investigative committees. These statements were proven false after the CIA inadvertently released sensitive documents disproving the statements. Media attention and charges of cover-up created a crisis situation, each of the two agencies blaming the other for cover-up. Acting CIA Director Richard Kerr testified to the Senate Committee on November 11, 1991, revealing that between 1983 and 1985 the CIA had sent several hundred reports to government agencies, including the Justice Department, chronicling BCCI's illegal activities. Justice Department officials had lied to Congress, stating initially they did not have any other documents. Thereafter, Justice Department officials sought to have CIA officials explain the discrepancy. By lying, but without success. Retaliating against FBI Director, Congress and the media demanded that an independent prosecutor be requested to investigate the Justice Department and the CIA. FBI Director William Sessions assured Senator David Boren that the FBI would investigate the conduct of Justice Department officials. This statement was an unprecedented threat to his bosses in the Department of Justice, and who were implicated in several major scandals. 2 days after Boren announced Sessions' intention this to the press, U.S. Attorney General William Barr announced an investigation of Sessions for ethic violations. The basis for the investigation of the FBI head? Sessions used government telephones for private business, allowing his wife to ride with him on government aircraft on a space-available basis, and installing a security fence at his home to protect government secrets. Big deal. If applied in the same manner, this charge could be leveled at major segments of the federal and state governments. Recognizing the phony and retaliatory nature of the charges, Senator Boren was among the congressmen who charged Justice Department officials with trying to obstruct justice by threatening the director of the FBI with phony charges. 370 It was ironical that while Attorney General William Barr was engaging in widespread cover-up and obstruction of justice of many of the crimes described within these pages, he sought the removal of the FBI director on these sham charges. President-assisted in cover-up Clinton had already played a key role in obstruction of justice relating to the vast CIA drug trafficking near Mena, Arkansas, while Clinton was governor of that state. After Bill Clinton became president and appointed Janet Reno as U.S. Attorney General, the two of them carried out Barr's previous plan to remove the director of the FBI who constituted a threat to government corruption. Without allowing Sessions to defend against the obvious sham charges, Reno and Clinton removed the FBI director. The lapdog press eulogized this removal and said nothing about its relationship with Sessions' intent to investigate Justice Department corruption. It is estimated that the BCCI corrupt practices cost innocent depositors from $5 to $15 billion in losses. Over 1 million depositors in 69 countries, including the United States, lost all or most of their savings and deposits. Part of BCCI's losses will be paid by the U.S. taxpayer through the losses of secretly owned savings and loans and the stockholders in the U.S. banks secretly owned by BCCI. The Independence Bank of Encino, California, 7. A BCCI bank, caused losses of $130 to $140 million. These losses are insured by the American public, who will pay the tab. U.S. investors in the bank holding company secretly acquired by BCCI lost large sums of money. First American Bank shares paid $225 million to acquire National Bank of Georgia in 1985, receiving only $90 million from its 1992 sale after the BCCI scandal broke. The $135 million difference is a loss to the U.S. investors who owned part of the bank holding company. Central banks and governments of third world nations will lose billions. These losses could have been prevented if the CIA or any of the other U.S. officials had performed their duties instead of engaging in felony cover-up. And the same goes for the members of Congress who also covered up. Of course, the same goes for each and every one of the other corrupt activities described within these pages. Vatican Bank scandal similar to the deaths of informants in other scandals such as Inslaw, Chapter 11 corruption, and October surprise, witnesses and informants to the BCCI scandal were killed or mysteriously died. The 1988 death of a New York City attorney, Cornelius Ahern, is believed due to the fact that he knew too much about the links between the BCCI scandal and the Vatican Bank scandal 372 of the 1980s. White House involvement. The White House had numerous tentacles to the BCCI scandal, and through its control over the Justice Department blocked or greatly reduced action against BCCI for years, despite knowledge of the bank's criminal activities. President Bush's deputy campaign manager, James Lake 373 simultaneously worked in 1992 for the main owner of scandal-riddled BCCI. 0.3% for attorney Ed Rogers, the right-hand assistant to President Bush's chief of staff, John Sununu, signed a lucrative employment agreement with a BCCI participant, Sheikh Kamal Adam, the former chief of Saudi intelligence. Adam was at the heart of the BCCI bank swindle. At the same time, the U.S. Attorney General and his Justice Department were blocking prosecution of BCCI. It was an interesting connection, to have a top-level campaign advisor for President Bush representing a major owner of the corruption-riddled renegade bank while the Justice Department was blocking prosecution of the multiple crimes involved in the BCCI scandal. British cover-up. It was the English government that first acted to shut down BCCI in 1992 when the scandal became public. BCCI was chartered in Luxembourg but actually operated primarily in England under British regulators and investigators. The Bank of England and other British checks and balances knew about BCCI corrupt activities for years, and covered up. England's security agencies, MI5 and MI6, surely knew what was going on, and did nothing. British media attention forced an investigation, conducted by Lord Justice Bingham, who issued a report in October 1992. The report did nothing to prevent another BCCI, and did not delve into those responsible for the world's worst banking scandal. The report described BCCI's performance as a tragedy of errors, misunderstandings and failures of communication. It wasn't a misunderstanding, nor failure of communication, that permitted BCCI to engage in worldwide money laundering, financing terrorists and drug cartels, threats and murders. It was criminal cover-up by every check and balance. The people sabotaging their own country's interest were not only in the United States. The Bank of England reported that it would seek a probe into allegations revealing that several of its employees took bribes from BCCI. It subsequently issued a whitewash report, stating that no evidence was found of bad faith, duplicity, cover-up, or conspiracy by British subjects in the BCCI corruption. The Bank of England entered into an arrangement with the bank's principal owner, Abu Dhabi, and under this agreement, important records and witnesses were allowed to leave England. In that way, those in England who aided and abetted the BCCI scheme escaped exposure. Justice Department cover-up. Something fishy is behind this government's reluctance to prosecute aggressively the well-connected predators of BCCI, stated William Safire in his November 1991 syndicated column. Until January 1992, High Justice Department officials blocked an investigation into BCCI corruption, according to the testimony of a former U.S. attorney in Miami, Dexter Lettinen. 375. He testified that in 1991, when he was building a case against BCCI, Justice Department officials in Washington blocked court orders to obtain documents from foreign countries concerning BCCI corruption. Lettinen also testified that in late August 1991 he received a phone call from a High Justice Department official who said he was calling on behalf of Acting Attorney General William Barr. The official said that Barr wanted him not to seek an indictment against BCCI. Congress also assisted in this cover-up by refusing to approve Lettinen's temporary U.S. attorney position to a permanent position, causing him to resign. Members of Congress demanded in 1992 that Attorney General William Barr request the appointment of an independent prosecutor to investigate BCCI. Barr refused to do so. He had earlier refused to appoint a congressionally requested independent prosecutor in the Inslaw matter, in the Bank of Lavoro matter, and in the Iraqgate matter. The prosecution of BCCI on the money laundering charge was not initiated by the Justice Department but on the initiative of local Customs Service agents. Justice Department officials had sought to block that prosecution, but this proved difficult due to media attention. Justice sought to limit the scope of the investigation by reaching a plea agreement allowing BCCI to ensure that the evidence collected during the investigation wouldn't be used against BCCI in any future federal charges. One of many reasons for Justice Department cover-up before William Barr came to the Justice Department, he was an attorney with the Washington law firm of Shaw, Pittman, Potts and Trowbridge. This law firm represented BCC for several years. A partner in the law firm, Kenley Webster, was representing a former BCCI chief executive, Swaley Naqvi, who had been indicted by a Manhattan grand jury on fraud, false accounting, money laundering and other charges. Naqvi had also been indicted in Tampa, Florida, on similar charges. Barr's former law firm also represented B. Francis Saul II, a director and powerful shareholder in Financial General Bank Shares Incorporated. Financial later became First American Bank Shares, a covert BCCI operation. Further, Barr had been legal counsel for the CIA, the same agency that was heavily involved with BCCI corrupt activities. He was CIA counsel during the time that George Bush was director of the CIA. Barr appeared with CIA Director Bush in hearings before Congress. Attorney General of the United States involved in massive drug trafficking Terry Reid wrote in his book, Compromised, that William Barr was an attorney for Southern Air Transport, to whom Reid routinely reported for coordinating arms shipments from Arkansas to Central America and drug shipments on the return flights. Reid wrote that he knew Barr during the 1980s as Robert Johnson. Miami attorney James F. Doherty II, representing an insurance group that had sued BCCI, appealed directly to Attorney General Richard Thornburg when evidence surfaced that BCCI was planning to destroy or move records of its corrupt activities. No response was received. 376 Justice Department officials blocked the testimony of two key witnesses before a Senate hearing on BCCI-3 who would have exposed not only BCCI's criminality but also the cover-up by Justice Department and CIA officials. Robert Mazur, who headed the Customs Service's investigation of BCCI in Tampa, and an assistant U.S. attorney, Mark Jakowski, had sought to file charges against BCCI, but Washington officials blocked the investigation. Justice Department officials shut down an investigation into the BCCI ownership of First American Bank shares in October 1989, allegedly so that it could focus on another probe. But when that probe was completed, Justice Department officials never went back to the far more serious matter of illegal ownership of First American Bank Holding Company. It wasn't until the Manhattan prosecutors started exposing the BCCI corruption and the Bank of England seized control of BCCI that Justice Department officials showed signs of life. At that point, Justice Department officials had to do something. Some reports state that as many as 20% of the members of both houses of Congress received bribes from BCCI. 278 Although known for years, the corruption surfaced in September 1991. BCCI accomplished its corrupt activities by bribing prominent citizens and high government officials throughout the world, including the United States. Top law firms and public relation firms in the United States fronted for the rogue bank, secretly enabling it to operate in the United States. Members of Congress, the CIA, Justice Department, and other U.S. government agencies were responsible for the continuation of most if not all of the criminal activities described in these pages. The mentality of BCCI suited to a T much of the criminality by U.S. officials. BCCI secretly and unlawfully owned several American banks in violation of federal law. Included in these banks secretly owned by BCCI were First American Bank of the District of Columbia and its 43 branches in New York City. U.S. authorities had known of BCCI's corruption and looting of deposits for years. Dozens of informants notified Justice Department officials and members of Congress of the corrupt activities. But, as in every other scandal within the federal government, nothing was done to stop BCCI's corrupt activities until the scandal broke in England, causing the bank to be closed. Hundreds of warnings before the bubble burst on this racketeering operation, depositors lost billions of dollars, wiping out the life savings of many people, especially those in undeveloped countries. Insiders, including drug traffickers 39 and the CIA 380, had advance notice of the pending collapse and took their money out before BCCI collapsed. Just prior to the Justice Department crackdown on the BCCI secretly owned bank in Tampa, forewarned drug dealers made a run on the bank, withdrawing over $10 million. Frontmen such as former Defense Secretary Clark Clifford and Robert Altman acted as cutouts or frontmen to cover up for the unlawful BCCI ownership. In 1979, attorneys Clifford and Altman deceptively acted to permit BCCI to unlawfully acquire ownership of First American Bank in Washington, D.C. Clifford was an attorney and veteran power broker in Washington, and he was a pillar of the Washington Beltway establishment. Other U.S. financial institutions were later acquired through attorneys acting as BCCI frontmen, or with their connivance. These included Independence Bank in Encino, California, and Centrust Savings in Miami. The Atlanta branch of BNL loaned or pledged nearly $5 billion to Iraq between 1985 and the summer of 1989. Jack Bloom, who initially learned of the criminal activities while an investigator for the Senate, believes that both Republicans and Democrats blocked an investigation because members of their own parties were responsible for covering up early warnings of the criminal activities. The same can be stated of the 1980 October surprise scandal and the many others within these pages. Prominent Washington figures made the BCCI scandal possible. There were numerous members of Congress, prominent attorneys Clifford and Altman, former Treasury Secretary John Connally, who bought a Texas bank with BCCI frontman Gaith Farone, former Atlanta Mayor Andrew Young, who borrowed money from BCCI and never paid it back, Ron Brown, chairman of the Democratic Party, a partner in the Washington law firm of Patton, Boggs, and Blow, which received $1.3 million in fees from BCCI, later joined President. 379 New York Times, October 28, 1991. 380 statements made to me by CIA informants. BCCI, Bank of Crooks and Criminals. 331. Clinton's Washington staff. In February 1992, a federal grand jury indicted David Paul, the former chairman of SunTrust Savings Bank in Miami, on fraud charges. The charges arose from a $25 million securities deal involving an investor linked to BCCI. Also charged were Gaith Farone, reportedly a front man for BCCI, and William Christopher Berry. The usual congressional bribing. BCCI penetrated the U.S. financial system through American law firms and attorneys who helped inflict upon the United States and other countries great financial harm and aided and abetted the drug money laundering, financing of terrorists, and other unlawful activities. They turned their legal expertise against the United States for profit. Crimes aided by jury members. The trial of attorney Robert Altman as part of the largest bank fraud in the nation and the world's history occurred in 1993 in New York City. Altman, with his boyish smile of innocence, was accompanied throughout the trial by his attractive wife and former television star, Linda Carter. Her lifestyle was enriched by the money her husband made through his role in the BCCI fraud. She was a popular sideshow to the trial. The jury, composed of many unsophisticated people, some of whom couldn't be expected to balance their personal checkbooks, were confronted with complex matters, compounded by the usual misrepresentation of legal counsel. On August 14, 1993, the jury acquitted Altman of the charges, proving again that crime pays, especially when cloaked in complex legal activities. The outcome of a jury trial by unsophisticated jury members is similar to playing a slot machine. There are those jury members who believe everything the prosecutor says, assuming that surely an innocent person would not be charged if the facts were not true. There are the jurists who are influenced by legal chicanery that tricks the jury. There are those jurists who are influenced by the look of innocence, such as displayed by Oliver North and Robert Altman. The BCCI corruption was effectively covered up by the New York jury members, followed by the cover-up of President Clinton's Justice Department. It remained for foreign countries to prosecute and punish many of those who played key roles in the BCCI debacle. Independent counsel versus special counsel. There are vast differences between an independent counsel and a special counsel. A special counsel is selected by the U.S. Attorney General, works under Justice Department officials, and submits a report to the Justice Department. If Justice Department officials are implicated, the most obvious expectation is that it will be a cover-up. The Attorney General's selection of the special counsel will be almost sure to obtain that result. An independent counsel or independent prosecutor, on the other hand, is selected by a panel of 3 appellate judges in the District of Columbia, following a request by the U.S. Attorney General. The Attorney General considers the request for an independent counsel following the request by a majority of the House or Senate Judiciary Committees. But even an independent counsel has 332. Its limitations. The person appointed by the federal appellate judges is often inexperienced, and may have a cover-up agenda. Chapter 18. Bank of Lavoro and Iraqgate. In the late 1980s, referred to as Iraqgate. It evolved around the Banca Nazionale del Lavoro, owned primarily by the Italian government. Implicated in the scandal with the bank were White House and Justice Department officials. The details of this scandal first surfaced in the alternate media, as is so often the case. While other members of Congress engaged in the usual cover-up of this scandal, Congressman Henry Gonzalez of Texas exposed the BNL corruption in 1991. He had to surmount the cover-up by other members of Congress, the CIA, Justice Department personnel, and the White House. BNL first attracted his attention when he learned that the small Atlanta branch of BNL had made over $5 billion in loans to Iraq. BNL was tied in with the Persian Gulf War and President Bush's arming of the Iraqis through loans which the American taxpayers will be paying for the next few decades. These loans made it possible for Iraq's Saddam Hussein to wage war against Kuwait and caused the U.S. taxpayers to be saddled with over $10 billion in debt over the next several decades. In November 1989, White House officials guaranteed the payment of loans made by banks to Iraq for the purchase of U.S. farm products under a program run by the U.S. Agriculture Department's Commodity Credit Corporation. The approval provided that United States taxpayers would indemnify the banks lending money to Iraq for the purchase of U.S. food supplies, if Iraq defaulted on the loan payments. Iraq had already made a name for itself by defaulting on earlier loans, and its income left little possibility of repayment. Instead of using the money to purchase U.S. food supplies, Iraq diverted billions of dollars off these farm loans to purchasing military equipment. In some cases, Iraq exchanged food shipments for arms, including poison gas and chemicals. Another of the many scandals involving high-level federal officials surfaced. 334. When farm products were actually purchased in the United States, the ships supposedly hauling the products to Iraq would be diverted in Europe, and the food supplies traded for military equipment and supplies. These loans, which would not be repaid by Iraq under the existing conditions, would unknowingly be paid by the American taxpayers. It was also obvious to U.S. officials that the war material being secretly purchased by Iraq would require some form of U.S. intervention in the future, in either money or lives, or both. The U.S. taxpayers, through their leaders, made possible the terrible bloodshed that occurred in the Gulf War. Billions of dollars were spent every year to fund U.S. intelligence services. Intelligence gathering agents are located throughout the United States and overseas. Obviously, high-level government officials knew of the fraudulent use of the loans, and the massive military buildup by Iraq. But despite repeated warnings to the White House, President Bush pushed to continue the program. It was as if Bush, a former CIA director, wanted Iraq to escalate its military might and start a Middle East war. U.S. knowledge of chemical weapons. Of the many insiders feeding me information were two people closely associated with production of chemical weapons in the United States for Iraq, who warned federal agencies of the problem prior to the Persian Gulf War, and who then experienced Justice Department persecution. One of these contacts was Louis Champon, who owned and operated Champon Flavors, a Florida company making flavoring, including bitter almond oil, a cherry flavoring, made from fruit pits. Champon had developed a technique for extracting a cyanide byproduct out of the fruit pits, and this fact became known to Iraq and Libya. Dr. Ihsan Barbuti and his son, Hyder Barbuti, approached Champon in February 1988, with a proposal to form a joint venture for the purpose of extracting a cyanide byproduct. Barbuti stated that the cyanide would be used for industrial purposes by a company in Europe. Unknown to Champon at the time, the Barbutis had ties to the Central Intelligence Agency, and had reportedly dealt with Iran-Contra figure Secord. They were also procuring agents for military supplies for Iraq and Libya. Champon entered the partnership with Barbuti, forming a new company called Product Ingredient Technology. Champon later discovered that his partners were shipping the cyanide to a CIA-affiliated weapon manufacturer in Chile, Cardian Industries, and that the cyanide was used to manufacture weapon-grade cyanide. The Barbuti side of the partnership brought in the CIA-related Wackenhut Corporation to provide security at the plant. After Champon became suspicious that weapon-grade cyanide was being produced under Barbuti's direction, Champon reported these facts to a Mr. Cabelley of the State Department on December 20, 1988. Nothing happened. The following January, Champon saw press reports stating that Dr. Barbuti was the designer and builder of a Libyan chemical warfare plant located near Bank of Lavoro and Iraq Gate 559. Rabta, Libya, causing Champon to again call the State Department, providing further information. Again, Cabelley stated he would look into the matter, and again, nothing happened. In July 1990, shortly before Iraq invaded Kuwait, Mr. Pusilico of the State Department called Champon, advising him to contact U.S. Customs Agent Earl Miller in Miami, who put Champon in touch with Customs Agents Jack Bigler and Martin Scram in Houston. They advised Champon not to divulge the information to anyone, that the matter was highly political, and that there would be no investigation or prosecution of the matter. Champon disclosed his information to investigative reporters at the Dallas Morning News and NBC. NBC aired the story nationally, which was then followed by the usual retaliation by officials in control of U.S. Customs, Internal Revenue Service, and the U.S. Department of Justice, bringing about the loss of Champon's business, followed by threats of death if Champon did not remain quiet. A year after Champon provided me with this information, another insider contacted me, Peter Khawaja. He had operated a security company called International Security Group, ISG, and a computer database company that became involved with U.S. intelligence agencies and the plant making the cyanide. His computer company was asked to install a computer-based system for product ingredient technology, and became prime security for Ihsan Barbuti International, including providing bodyguards. Khawaja was also asked to install a hydrogen cyanide detection system at IBI. During these activities, Khawaja made recordings of telephone conversations and data transmissions. The information disclosed, among other things, CCCBNL documents and letters of credit relating to the weapon-grade cyanide. Khawaja became suspicious, and conveyed his concerns to the CIA, the FBI, and Customs, who then undertook an investigation. Standard reaction to exposing U.S. corruption again, there was no cessation of activities. Instead, his wife, Eileen, suddenly died under mysterious circumstances. Khawaja received death threats over the phone. The local police started harassing him. The IRS harassed him with what Khawaja claims were unfounded liens and levies, followed by Kaft Bank foreclosing on his business. These were standard tactics used by U.S. agencies against whistleblowers. The plant producing the weapon-grade cyanide was eventually shut down, and a company called Century Arms International occupied the building. Khawaja said as late as 1995 he had seen missiles and bombs in the building, suggesting another covert operation. Defaulting on U.S. guaranteed loans. Iraq's invasion of Kuwait on August 2, 1990, caused it to default on its loans to the BNL Bank. The loans guaranteed by the U.S. taxpayers to the participating banks then became due. Making matters worse, Iraq had part ownership interest in some of these banks and stood to gain not only from receipt of the initial $5 billion, but would gain when the United States paid the various banks that loaned the money guaranteed by the U.S. Again and again and again, the U.S. taxpayers paid the tab and the interest required to finance it. In effect, they paid for their ignorance or indifference to government misconduct. 336. Some of the money furnished by the United States was used to purchase poison gas that was used on Iraqi Kurdish villages. 3*. Much of it purchased through Cardo and Industries in Chile, a CIA asset. Cardo supplied considerable war materials to Iraq and other countries under the guidance of the CIA. The Rome-based Bank of Lavoro, through its Atlanta branch, loaned directly and through other participating banks over $5 billion to Iraq under this program. The young manager of the Atlanta branch of BNL, Christopher P. Drogul, was ordered by his superiors in Rome to fund the loans and falsify the paperwork so that U.S. authorities would not discover the fraudulent diversion of funds from farm to military uses. In carrying out the scheme, the Bank of Lavoro borrowed money from other banks and then reloaned the money to Iraq at a slightly higher interest rate, relying upon the United States loan guarantees to protect itself from losses. The scheme required secret telexes, separate sets of books, phony taxes, and other devices to escape detection by bank examiners. The fraudulent program was known to bank employees as Perugina, the name of an Italian candy factory. Britain was also involved in the diversion of funds that made it possible for Iraq to invade Kuwait. Matrix Churchill, a machine tool company in England, secretly and unlawfully supplied military equipment to Iraq during this period, even while the company knew that Iraq was using poison gas on the Kurds. As usual, it appeared that the only people in the Western Hemisphere who didn't know about the scam were the American people, made possible by U.S. media cover-up and the public's refusal to devote enough time to reading something other than the bland news in the mainstream media. 2 BNL employees reported the scheme to the local U.S. attorney in Atlanta, causing the local U.S. attorney to raid BNL's Atlanta office and seize incriminating documents. The U.S. attorney discovered that bank officials in BNUL's home office in Italy knew of the scheme, directed it, and ordered the local bank manager in Atlanta to carry it out. But Justice Department officials in Washington did not want Italian officials blamed, which would implicate U.S. officials. To divert attention elsewhere, Justice Department prosecutors charged the young Atlanta bank manager, Christopher P. Drogool, with defrauding his bank by dispersing the $5 billion in loan proceeds without Home Office knowledge and approval. The Justice Department's indictment was based upon charges that the bank manager acted alone, dispersing $5 billion in funds without the knowledge and approval of BNL's Home Office in Italy, and therefore committed fraud. If the Home Office had known and approved of the scheme, the bank manager and employees could not be charged with defrauding the bank. Further, if Home Office officials were aware of the scheme, it would have serious political implications in Italy. Additionally, if BNL officials in Rome knew of the fraud associated with dispersing the funds guaranteed by the U.S. taxpayers, the liability of U.S. taxpayers to pay the billions of dollars that were fraudulently diverted. 381 San Francisco Examiner, July 26, 1993. Bank of Lavoro and Iraqgate 337. Would not exist. For the U.S. taxpayers to be liable, the young manager of this small branch bank had to be solely responsible and knowledgeable of this gigantic fraud. By covering up for the corruption, Justice Department officials and the White House were causing the U.S. taxpayers to pay $5 billions and several times more in interest charges. Is it any wonder that social programs such as Medicare, Social Security, and others must be cut? Following a standard pattern, Drogool's court-appointed attorney, seeking to protect the Justice Department and other federal officials, urged him to plead guilty. Drogool wanted to go to trial to clear his name. By pleading guilty, he faced 20 years in prison. The court-appointed attorney had falsely assured Drogool that if he pled guilty he would receive a suspended sentence. A week before trial, on September 2, 1993, Drogool reluctantly pleaded guilty to something that he had not done. The guilty plea avoided the trial that would have exposed much of the U.S. misconduct and that of Italian bank officials. In an unusual twist of not going along with Justice Department prosecutors, U.S. District Judge Marvin Shub demanded that Drogool explain truthfully at the sentencing hearing what had actually happened. Fearing a long prison term instead of the suspended sentence promised to him by his attorney and the federal prosecutor, Drogool obtained other legal counsel for his appearance at the sentencing hearing. The new attorney, Bobby Lee Cook, moved to have Drogool's guilty plea rescinded on the basis that the BNL bank manager acted in the multi-billion-dollar scheme with the knowledge and approval of his superiors in Italy. Judge Shub bravely granted the motion and rescinded the guilty plea, over the protests of Justice Department prosecutors, who knew the bank manager was not guilty. Cook demanded documents from the CIA and Justice Department that would show federal agencies had prior knowledge of the fraudulent BNL activities, and knew that high Italian officials in Rome had approved the activities that were apparently sanctioned by the Bush administration. At first, Justice Department officials denied having such reports. Congressman Henry Gonzalez, who had been exposing the BNL corruption for months on C-SPAN, submitted a CIA document to the court showing that Italian officials in Rome had knowledge of the multi-billion-dollar transactions and fraud. Several days later, CIA officials sent a letter to Justice Department prosecutors omitting the fact that the CIA had evidence that Rome officials were cognizant of the scheme. CIA officials then accused Justice Department officials of trying to get the CIA to provide U.S. prosecutors and the court with misleading information to support the imprisonment of the young BNL bank manager. As Congressman Gonzalez released more documents, it became obvious that the CIA possessed numerous documents showing that BNL officials in Rome knew of the loans and the diversion of the funds from farm products to military supplies. Further, that the CIA deliberately withheld this evidence from the court. It also turned out that federal officials had altered a list of high-technology items that were sent to Congress to obtain approval for the shipment to Iraq. The evidence indicated that high federal officials knew about the fraud being perpetrated by BNL and Iraq against the United States and had not only 338 deliberately covered up for it, but enlarged upon it. Evidence indicated that President Bush was determined to arm Iraq for attack upon its neighbors. Among the documents that surfaced was one written by Secretary of State James Baker, urgently warning the White House that Iraq was secretly using technology provided by the United States to build up its chemical, nuclear, biological and ballistic missile capabilities. Not only were Justice Department attorneys seeking to imprison an innocent bank manager, but were imposing a huge cost upon the American public. Justice vs CIA vs FBI foreign media exposure of the BNL scandal forced Justice Department officials to engage in tactics to protect officials in the United States and Italy, fraudulently charging Droguel with defrauding the Italian bank. Robert Gates, director of the CIA, and other government officials, told the House Banking Committee that the CIA knew nothing about the huge loans to Iraq. Congressman Henry Gonzalez, chairman of that committee, produced evidence showing they were lying. Droguel was pressured to plead guilty, despite the EG and common sense showing he was not guilty. The federal judge in the Droguel case refused to support the Justice Department's attempts to settle the case by laying the blame on Droguel. Unable to control the judge, Justice Department prosecutors attempted to disqualify him and to go shopping for a judge that it could control. The scenario leading to the rift between Attorney General William Barr and his Justice Department gang, the CIA and FBI Director William Sessions, followed this schedule. CIA officials submitted a document to an Atlanta district court that contained misleading information, conveying false information covering up the real facts. The document was intended to deceive 38 to deny that the CIA had knowledge of the BNL fraudulent loans for several years. The CIA would have been highly incompetent if, with all its agents worldwide, it did not know of the fraud that required participation of many people. Senator David Boren, suddenly showing an unusual display of duty, substantiated the fact that the document contained false information. In response to this public rebuke, the CIA drafted a memorandum to correct the falsified document. Justice Department attorneys objected to the CIA correcting the original report, as the Department of Justice would then have to explain its own deception. The CIA then acquiesced to the Justice Department's demands to continue the cover-up. But the next day, the CIA prepared a document for Justice Department officials to sign that would protect the CIA's lying. Justice Department officials refused to sign this document, as it would further show that they lied. CIA officials then testified in a closed-door Senate Intelligence Committee hearing, describing what happened. The CIA attorneys placed the blame for their cover-up on pressures from Justice Department officials. Never in the history of the Republic. New York Times syndicated columnist William Safire stated that never in the history of the Republic has the nation's chief law enforcement officer been in such flagrant and sustained violation of the law. Safire stated in a mild way what was normal conduct in the Justice Department, which I continuously observed for the past 30 years. Another cover-up costing the American public billions of dollars if the case against the young bank manager of BNL in Atlanta had gone to trial, the involvement of President George Bush and members of his administration, and of the government of Italy, would have been exposed. U.S. District Judge Marvin Shub, after hearing evidence, stated, "Were pawns or bid players in a far larger and wider-ranging sophisticated conspiracy that involved BNL Rome and possibly large American and foreign corporations and the governments of the United States, England, Italy, and Iraq." Justice Department attorneys lied 383 as they told Judge Shub that the manager of the small BNL branch acted on his own to lend $5 billion to Iraq without knowledge or approval of BNL's home office. Judge Shub replied, "Based on the information that I have seen and that has been revealed, that kind of conclusion could only come about in Never Never Land." During an August 23, 1993, sentencing hearing for 5 BNL employees, Judge Shub stated he would not sentence any of them to prison because the Justice Department's contention that they defrauded the parent bank in Rome was too incredible. He added that they were merely pawns and bid players in a far more wide-ranging conspiracy. Judge Shub said there were too many circumstances that made it implausible that the conspiracy was a small one involving only the Atlanta bankers, adding, "Smoke is coming out of every window." I have to conclude the building is on fire. Congressman Gonzalez had argued for an independent prosecutor to investigate the BNL affair. As in the INSLAW and BCCI case, the Attorney General appointed one of its own to investigate itself, former U.S. District Judge Frederick B. Lacy, to conduct a Justice Department investigation. Judge Shub said of the Lacy report, if Judge Lacy had investigated the Teapot Dome scandal, referring to the 1922 scandal which almost caused removal of President Warren G. Harding, he would have given out a medal instead of a jail sentence. Justice Department officials didn't care for this type of honesty and lack of control over the judge, and moved to disqualify him from presiding over the trial for BNL bank manager Drogool, which was set to start on September 8, 1993. Another judge was then selected to conduct the trial. Risking exposure of the role played by many people still in office, and especially the Justice Department, former President George Bush was subpoenaed to testify during the trial of bank manager Drogool. The subpoena was accepted by the Clinton Justice Department, which is responsible for defending the acts of past presidents while they were in office. Standard judicial cover-up tactic. The new judge, Ernest Tidwell, was more amenable to the Justice Department cover-up. Drogool's attorney, Robert Simels of New York, stated that the judge issued 2 rulings refusing to allow the bank manager to give evidence showing that President George Bush and White House officials acted to carry out the fraud. He said that the judge blocked him from introducing evidence concerning the role of U.S. intelligence agencies in making the sham loans to Iraq, and the Italian government's efforts and pressures upon the Bush administration to avoid indicting BNL. Judge Tidwell stated that this evidence was not related to the charges against Drogool. That was not so. This judicial strategy is repeatedly used against CIA personnel who for various reasons are charged with criminal offenses for carrying out their orders. The compromised judge renders orders barring the defendant from showing his CIA employment and that he was carrying out orders. They are barred from introducing CIA documents and barred from having CIA personnel appear. It happened to almost every CIA operative named in these pages. The Drogool trial was to have been the main stage for exposing the misconduct by the Bush administration leading up to the Gulf War. Gassing our own soldiers. Strong evidence exists that Iraq used chemical and biological agents against U.S. and other troops in the Persian Gulf War, and that U.S. intelligence agencies supplied these weapons to Iraq through a layer of intermediaries. Cardo and Industries in Chile was one of the CIA suppliers. Undersecretary of Defense for Personnel and Readiness, Edwin Dorn, stated that the Pentagon had concluded that Iraq did not use chemical or biological weapons during the war. To have said otherwise could have precipitated an investigation that threatened to expose the major role played by U.S. intelligence agencies in the arming of Iraq, including the sale of chemical and biological weapons. During a limited congressional investigation, Senator Donald Regal said that exposure to chemical and biological agents was widespread during the Persian Gulf War. In response to the denials by government officials, Regal stated, "I've seen our government lie to us before in other war situations. This is not going to be an issue that gets swept under the rug." But it was swept under the rug, as Regal surely knew it would be. The U.S. military-industrial group profited from the military buildup of Iraq, which cost the American taxpayers huge amounts after it became necessary to invade that country in 1990. Further, the Gulf War syndrome could very possibly be linked to the chemical-grade cyanide produced in the United States. Kissinger's role in the Gulf War spotlight wrote that as early as 1984 Kissinger associates were involved in arranging some of the loans from the Banca Nazionale del Lavoro to the Iraqi government to finance its arms acquisitions from a little-known subsidiary of Fiat Corporation. Referring to a confidential report prepared for the Economic Planning Group of the European Community by the Centre d'études transatlantiques, Spotlight reported that the deal set up by Kissinger Associates involved the secret sale of 5 million landmines and other war material. BNL was used for this transaction, funneling over $1 billion through a small BNL branch in Brescia. At the same time, the U.S. taxpayers were saddled with billions of dollars in debt to finance arms sales to both sides in the Iran-Iraqi war. Profiting from these secret deals were U.S. and foreign arms manufacturers, the arms merchants, Israel, and those in the United States who aided and abetted the activities. Brent Scowcroft and Lawrence Eagleburger were employed by Kissinger Associates. Scowcroft would become President Bush's national security advisor and Eagleburger acting Secretary of State. Spotlight stated, Cetra's data prove the scheme for financing and supplying Iraq's military purchases was set up by Kissinger Associates long before BNL's Atlanta branch became involved. The article continued, time we forgot those scapegoats in Atlanta, focus on the real culprit, Kissinger Associates. Referring to Charles Barletta, a former Justice Department investigator, Spotlight wrote, Barletta added that federal probers had collected dozens of such incriminating case histories about the Kissinger firm. But Henry Kissinger seems to possess a special kind of immunity. I'm not sure how he does it, but Kissinger wields as much power over the Washington national security bureaucracy now as in the days when he was the Nixon administration's foreign policy czar. He gets the payoff, others get the blame. Kissinger will remain unscathed until Congress finds the courage to convene a full-dress investigation of this Teflon power broker. Something fishy occurred on July 25, 1990, U.S. Ambassador to Iraq, April Glaspie, assured Iraq's Saddam Hussein that the United States was not interested in its dispute with Kuwait. Some reports state that April Glaspie assured Saddam Hussein that if Iraq invaded and seized only the northern part of Kuwait, the United States would not object. As stated in earlier pages, CIA operative Gunther Russbacher had several times described to me the details of the flight of State Route 71 aircraft to Moscow associated with delivering an agreement to President Gorbachev for signing. This agreement provided that the USSR would not intervene if the United States invaded Iraq. Possibly as a sign of good faith, one of the highly secret State Route 71 aircraft was left in Moscow. Bizarre as this sounds, and as stated earlier, a well-known and respected pilot admitted to me in 1995 that an State Route 71 was seen in a hangar at Moscow's airport. Congressional hearings. During congressional testimony before the House Banking Committee on November 10, 1993, Christopher Drogool was brought from federal prison to testify about the BNL scandal. He testified that he tried to report the criminal activities involving Iraq, his bank, and U.S. officials, but that the U.S. Attorney's Office in Atlanta repeatedly barred him from telling the truth. They wanted to protect the U.S. officials, Italian officials, and Iraqi officials, and to blame him. 342. For making loans totaling about $5.5 billion that were beyond his ability to make. Drogool testified, and the facts indicated, that he was merely a pawn in the scheme involving the United States, Iraq, Italy, Britain, and Germany to secretly arm Iraq. Not only did this conspiracy result in thousands of needless deaths, but the American public must pay this amount and the interest that will surely triple the original figure before the money is repaid somewhere in the 21st century. Regardless of his innocence, a federal judge sentenced Drogool to federal prison in 1994, on the basis that his superiors did not know his small branch was dispensing $5 billion, and that the United States government did not know of the scheme. Clinton's rhetoric. While on the campaign trail, Clinton stated he would recommend the appointment of an independent prosecutor to investigate U.S. involvement in the BNL fraud. But upon assuming the presidency, and through Attorney General Janet Reno, who appeared to be more of a figurehead for the Justice Department, the position was changed. The Clinton administration, including the Attorney General, argued that there was no U.S. involvement in the BNL corruption and that the BNL headquarters in Italy and the Italian government were not involved. Attorney General Janet Reno and President Bill Clinton were lying. Cover-up costing Americans billions. Attorney General Janet Reno refused to appoint a special counsel to investigate the BNL scandal and in February 1995 agreed that U.S. taxpayers had to pay BNL the loan guarantees that made possible the arming of Iraq. She was stating in effect that the manager of a small BNL bank branch in Atlanta approved $5 billion in loans without the knowledge of bank officials in Italy. This was of course ridiculous. Exposure of U.S. culpability. A 340-page report by an Italian parliamentary commission, said that the illicit loans to Iraq from BNL were part of a U.S. policy to channel military aid to Iraq, under the direction of President George Bush. The report stated in part, that the political direction of the whole operation was always firmly based in Washington is evident. Personalities in the Italian government and of BNL were aware of what was happening, or had received authoritative advice not to look too closely at the Atlanta branch operations. It is now evident, that the affair constituted an American political scandal. 384, Wall Street Journal, January 27, 1994. Chapter 19. CIA and DIA Drug Trafficking. Of many magazine and newspaper articles, books, congressional testimony, and television presentations. I first became aware of it in the 1950s while an airline pilot flying into Japan and while flying in the Middle East, out of Tehran, Beirut and other places. During matter-of-fact conversations with other pilots, they described the drug loads they were carrying for CIA-related airlines. At that time there was very little attention given to the drug trade, and I was as naive and indifferent to the problem as the remainder of the population. One of the first books linking the CIA to drug trafficking was Alfred McCoy's 38 and the Politics of Heroin in Southeast Asia 3, registered, published in 1972, and his heavily documented 1991 update, The Politics of Heroin, CIA Complicity in the Global Drug Trade 387. McCoy is a professor of Southeast Asian history at the University of Wisconsin in Madison and has made an exhaustive study of the CIA's involvement in drugs while living in various parts of the world. Professor McCoy started investigating the drug trafficking in the 1950s, questioning people in all phases of the drug culture from the growers to the end users. He spent considerable time in Southeast Asia and throughout the world obtaining first-hand knowledge of the drug trade. His books describe how CIA helicopters, supposedly fighting communists in Vietnam, were hauling drugs from fields to distribution points, and how the CIA operation included heavy sales to the American GIs. McCoy described the role of the PepsiCo bottling plant in the drug processing. Adolfo Calero was an executive with the PepsiCo bottling plant in Nicaragua, and as shown in several congressional hearings, he was a known major drug trafficker, and working with the National Security Council and the CIA in their CIA's role in drug trafficking into the United States has been the subject. 385 Professor, University of Wisconsin. 386 Harper and Row. 387 Lawrence Hill Books. 344 War Activities in Nicaragua. Statements given to me over the years by my various deep cover sources clearly show that the PepsiCo and Coca-Cola companies, or their agents in foreign countries, were involved in drug trafficking. McCoy describes the pressure put upon the media by the CIA to halt his book. He describes the many people who testified in closed-door congressional hearings for the past 20 years, leaving no doubt that the CIA was involved and primarily responsible for the drug scourge in the United States. Many other highly detailed books have been written about CIA drug trafficking by people who were part of the operation. These include, among others, Dope, Inc., 388 The Big White Lie, 389 Cocaine Politics, 3% Out of Control, 39. Bluegrass Conspiracy, 3 Degree 2 The Cocaine Wars, 3% 3 The Crimes of Patriots. 3 Degree 4 But only a fraction of 1% of the American people have read them, ensuring that they remain ignorant about the criminal and subversive activities by those in control of key government entities. Bizarre aspects of taxpayer-funded drug trafficking. There are many bizarre aspects of the epidemic drug trafficking into the United States by the CIA and its co-conspirators. One is the billions of dollars spent each year to fight drug trafficking, using the same government agencies to fight the battle as are themselves implicated in the drug trafficking. The American public is paying the salaries and government-related costs associated with the drug smuggling and drug interdiction. Entire communities have been turned into war zones, with thousands of people killed, thousands of people incarcerated, sometimes for life, and civil liberties taken away on the pretense of fighting the war on drugs. Congressional cover-up. Another bizarre and criminal aspect related to the CIA-related drug problem is the cover-up by members of Congress and much of the mainstream broadcast and print media. Dozens of people directly involved in the drug trafficking have testified to members of Congress of the drug trafficking. Hundreds of letters have been sent to members of Congress by informants describing the specifics of the drug trafficking and the involvement of people in control of the federal government. McCoy describes giving testimony in 1972 to congressional committees, including Senator William Proxmire, about the CIA role in the developing global narcotic trade. Heads cribs how members of Congress enthusiastically accepted the CIA's denial of any role in drug trafficking, despite the overwhelming evidence of its existence. 2 decades later, despite many closed-door hearings receiving testimony further supporting the CIA and DIA drug smuggling into the United States, members of Congress still keep this information from the public. Dozens of highly documented books have been written about the subject by people who either investigated the subject or who were pilots involved in the drug trafficking. I mailed petitions via certified mail to members of Congress since 1991 describing the operation and demanding that they receive the testimony and evidence of our small group of former government investigators or present and former CIA personnel. The only people who don't know about the sinister practice by government personnel, whose criminal conduct they fund as taxpayers, are the majority of the American people. As part of their jobs, those in the media are aware of this overwhelming amount of evidence, and are aware of the implications and the consequences. Their cover-ups are criminal acts under federal crime statutes. One of many DIA whistleblowers, Michael Levine, a 25-year veteran of the Drug Enforcement Administration, authored the 1993 book The Big White Lie, exposing the drug trafficking sanctioned by federal officials. The former DIA agent wrote that the so-called war on drugs is the biggest, whitest, and deadliest lie ever perpetrated on U.S. citizens by their government. He described how the CIA, the DIA, and other intelligence agencies blocked investigations and prosecution of high-level drug traffickers. Levine described how the CIA was primarily responsible for the drug epidemic as seen from his perspective. Levine repeatedly uncovered CIA links to the drug trafficking while he was a DIA agent. He discovered that the CIA was primarily responsible for the burgeoning drug activity from Central and South America into the United States, and that the biggest drug dealers were CIA assets. He found that federal judges and Justice Department prosecutors dramatically dropped the amount of bail for high-level drug traffickers who were CIA assets, and who had been accidentally charged. Levine described how the CIA supported drug traffickers who then seized control of the government of Bolivia. He went into detail describing how the top people involved in drug trafficking, such as the government of Bolivia, are protected against exposure and prosecution, and how these protected individuals are CIA assets. He wrote that U.S. officials are afraid the world would find out there wouldn't be a cocaine government in Bolivia if it wasn't for the CIA. He described how high DIA and Justice Department officials intentionally destroy drug cases and put conscientious DIA agents at risk, even causing their deaths. Levine uncovered how major drug cases involving CIA assets receive little or no media publicity, thereby protecting the vast criminal activities. Levine stated in his book The Problem with Raiding Suspected Drug Labs, that when the site was raided there was evidence of a prior drug lab but it no longer existed. Failed drug raids. 2 of my contacts who worked for the DIA told me why this occurred. William Collar, a former mid-level DIA agent, would learn about the planned drug raid and then instruct DIA contract agent Basil Abbott to warn the people running the labs of the impending raid. Abbott spoke Spanish well, and had become friends with key government contacts throughout South America, including Sonia Adela and her husband, Walter. During several years of frequent contacts with Abbott, he described in detail the hauling of arms to Central and 346 South America for the DIA and return flights loaded with drugs, often unloaded at DIA facilities. Abbott explained that this was why, as Levine stated in his book, The Big White Lie, that Levine couldn't figure out how the drug labs in Bolivia were found abandoned when they were raided. I asked Abbott the names of some of the people he warned, and he named, among others, Sonia Adela and her husband, Walter. Both of these drug traffickers, responsible for huge quantities of drugs coming into the United States, were protected against prosecution by officials in control of the U.S. Department of Justice. Levine described the huge drug trafficking by Sonia and Walter Adela and how the CIA, DEA, and Justice Department protected them. Justice Department obstruction of justice. Levine wrote about the situation that I encountered over a 30-year period, commencing while I was a federal investigator. When Levine sought to expose drug trafficking by CIA or DEA assets, Justice Department management commenced harassing him, fabricating charges, and even threatening to put him in prison. Terry Reid, a former CIA asset, and author of Compromised, ran into the same retaliation. When he discovered the CIA drug smuggling activities into the United States involving the CIA, DEA, and the National Security Council, Justice Department and Arkansas prosecutors sought to put Reid and his wife in prison through false charges. Input from talk show listeners. It frequently happened during my over 2,000 talk show appearances that callers would supply knowledge of government-related drug trafficking that they witnessed, adding to what I had learned. During a July 27, 1993, appearance on the syndicated talk show Radio Free America, hosted by Tom Valentine, a caller from Houston, Texas described his conversations with DEA pilots at a Houston area airport. The pilots had admitted to him that the crates on board the aircraft contained cocaine from Central America, but that the drugs were being used for sting operations. This excuse was a farce used to cover up for the criminal activities and silence the inquisitive pilots who may question the apparent illegality of the drug shipments. Another caller on that same program, an Air Force officer, told about the many large Air Force aircraft flying into Homestead Air Force Base with large quantities of drugs on board. One of my sources, a former DEA asset, Frank Nesbitt, described how the drug trafficking into the base was common talk among military personnel. The involvement of government personnel in drug trafficking, especially the cover-up by Justice Department officials, establishes the mindset throughout the United States. Among the many articles on CIA drug trafficking was the April 1988 story in The Progressive. The article described the testimony given by Michael Tolliver concerning his flights for the CIA hauling drugs from Central America into the United States, including landing with 25,000 pounds of marijuana at Homestead Air Force Base in Florida. The article stated that federal Judge Patrick Kelly found the testimony compelling enough that he called it to the attention of President Ronald Reagan, as well as the CIA, the FBI, Special Prosecutor 347. Lawrence Walsh, and Congress. Judge Kelly directed federal marshals to deliver the transcript of Tolliver's deposition directly to President Reagan. Tolliver's story was broadcast on CBS Television's West 57th Street. According to the article, no one from the Justice Department questioned Tolliver about his serious charges. DEA agents blowing the whistle. One of many former DEA officials who sought to expose the involvement of U.S. officials in the drug trafficking was Richard A. Horne, based in Myanmar. He sued the former top State Department and CIA officials in that Asian nation for subverting his official drug-fighting activities. 395 The suit provided still another sign of how top U.S. officials blow any interference in the highly profitable and destructive drug trade into the United States. Horne charged in his lawsuit that State Department and CIA officials retaliated against him because his exposure of drug traffickers interfered with the drug-related activities of State Department and CIA officials. Horne's lawsuit charged that Myanmar's government was making substantial progress in reducing the drug trade, much of it produced by Kun Sa, the opium warlord who worked with the CIA, and that the U.S. government was retaliating against the government for these drug eradication efforts. Other government agencies knew that Myanmar produced over half the heroin on the world market. Horne charged that the State Department's chief of mission in Myanmar, Franklin Huddle, Jr., worked with the CIA station chief to sabotage Horne's anti-drug efforts, and tried to bring about the death of an informant who had been assisting Horne in his activities. Clashes between conscientious government agents and corrupt government personnel are common. Yet, every government check and balance supports the officials involved in criminal activities. An October 27, 1994, Wall Street Journal report made reference to various DEA agents whose efforts have been blocked by CIA officials. Drug enforcement agents and CIA officers have clashed in Venezuela, Colombia, Haiti, and other countries where military and government officials have been accused of complicity in the drug trade. Supervising federal agent for the Drug Enforcement Administration, SEAL Reno Castillo, had repeatedly reported the large amount of cocaine being smuggled to Florida, Texas, and California, by mercenary pilots used by Oliver North. In an interview with the Texas Observer 3% and as written in his 1994 book on drugs, Castillo stated that he observed large quantities of drugs shipped to the United States through Ilopango Air Force Base in El Salvador. He said that in 1986 he reported these findings to his superiors in the DEA and to the U.S. ambassador to El Salvador, Edwin Corr. Castillo said that he told Bush about the drug trafficking during a cocktail party in Guatemala City in 1986, and that Bush just smiled and walked away from me. Southeast Asia drug trafficking. For decades the British and the French controlled the huge drug operations in Southeast Asia, which were taken over by the United States through the CIA. 395, Wall Street Journal, October 27, 1994. 396 Associated Press, June 17, 1994. 348. In the 1950s, Vietnam was a CIA operation that escalated, either intentionally or unintentionally, providing the logistics for the CIA to greatly expand the drug trafficking into the United States. Many Americans, brainwashed to believe that the Vietnam War was in the interest of freedom and to fight communism, supported the war that sacrificed the lives of 58,000 Americans. Great numbers were painfully injured and maimed for life. Even in death the GIs were misused. The CIA drug trafficking required large numbers of drug addicts. The drug addiction of many American GIs in Vietnam was highly profitable and made possible by the CIA drug trafficking. Even in death the GIs became unwitting participants in the drug trafficking. Plastic-wrapped drugs were shipped into the United States in the bottom of caskets, in body bags, and in body cavities. Upon arrival at Air Force bases, and especially Travis Air Force Base in California, the drugs would be removed from the caskets and bodies. These were identified by secret codes. Many articles have been written about this sordid practice in the alternative press, but withheld by the mass media. In one instance, an officer from the Army's Criminal Investigation Division uncovered a large-scale heroin smuggling scheme using the bodies of dead GIs who perished in the CIA's Vietnam War. His group filed reports with the Pentagon describing how the bodies were cut open, gutted, and filled with sacks of heroin. Approximately 50 pounds of heroin with multimillion-dollar street value were stuffed into each body. Crates returning to the United States from Vietnam on military aircraft often contained bags of heroin, and also identified by coded labels. The cover-ups in the military, in the CIA, in the Justice Department, weren't isolated rogue acts, as the practices were too widespread, and exposure blocked by high-level officials. Any time an investigator reported the problem, he or she was ordered to stop. These aspects of the CIA's Vietnam War that used Americans as pawns are never brought up at Memorial Day ceremonies. The American public is led to believe that the hundreds of thousands of dead, maimed, or injured Americans suffered for an honorable cause. This is not to discredit those who endured the fighting, but to bring reality into the picture. In typical fashion revealed throughout these pages, the military hierarchy reacted to the report by disbanding the investigative team. Other reports plus those given to me by my CIA contacts provide further confirmation of this sordid practice. This cover-up made possible the continued drug smuggling and constituted criminal cover-up. The CIA's war in Nicaragua had many of the same qualities, except that American GLs were not sacrificed as in Vietnam. The CIA's war in Nicaragua provided the logistics for bringing large quantities of drugs into the United States. Again, the American public was manipulated to believe that Nicaraguans did not have the right to choose their desired form of government. CIA-funded and directed assassination squads killed tens of thousands of people, while the CIA smuggled large quantities of drugs into the United States. 349. Operation Code Names. The CIA drug trafficking is handled in an organized manner, like major corporations, such as General Motors. Different geographical areas and different types or levels of operations are given code names. In the Golden Triangle area of Southeast Asia, the code names included Operation Short Flight, Operation Burma Road, Operation Morning Gold, and Operation Triangle. The CIA transferred some of its operatives who developed the drug trafficking in the Golden Triangle area of Southeast Asia to develop and operate drug trafficking into the United States from Central and South America. They reportedly included Theodore Shackley, Edwin Wilson, and Frank Turpil. In Central and South America, the code names for CIA drug trafficking included Operation Snow Cone, Operation Toilet Seat, and Operation Watchtower. Operation Toilet Seat. The CIA used Boeing 727 and C-130 type aircraft to haul drugs from Central and South America to offshore locations in the United States, throwing the drugs out the rear ramp into the ocean in waterproof containers. The planes were leased or operated by CIA proprietary airlines and flown either by CIA/DIA/DIA crews or by airline pilots supplementing their regular income by becoming contract agents. Pilots heavily involved in drug transportation. One of my confidential sources, Gunther Russbacher, gave me the names of several airline pilots who regularly flew drug operations for the CIA, including 2 captains from United Airlines and a retired Pan American pilot. One of the United Airline pilots bragged that he made twice as much money flying illegal cargo as he did on his regular airline job. Many pilots have admitted to me during the past 40 years that they hauled drugs under the direction of the CIA, DIA, and the military. These contacts were my early indication of CIA drug trafficking, commencing in the early 1950s. Numerous aircraft charter operators engaged in hauling drugs. CIA-fed media releases claimed that the United States had to fund the Contras for freedom purposes and to combat communism. The real reason appeared to be the profitable drug trafficking. My CIA contacts stated the CIA was shipping arms to both sides, defending this practice in a tongue-in-cheek comment, "How else can the CIA keep the war going?" The CIA sought support from Congress for its Contra operation by reporting that the Sandinistas were trafficking in drugs and claimed that the Contras were not doing the same. Actually, U.S. intelligence agencies were selling arms to both the Contras and the Sandinistas and taking drugs as part payment. The drugs were then shipped back to the United States in the same aircraft used for shipping the arms. To stimulate congressional and public support for continuing to support the Contras, the CIA installed video cameras in an aircraft flown by CIA pilot Barry Seal and secretly video recorded the placement of drugs on board the aircraft at a Central America arms and drug transshipment point. The White House stated that the drugs were loaded by the Sandinistas, making the tapes available to Congress and the media. The White House sought to inflame public 350 opinion against the Sandinistas so that Congress would vote for funding the Contras. The people represented as Sandinistas loading drugs in that video were actually Contras. The scheme worked, Congress voted money for the Contras and the public generally was oblivious to having been duped. All types of aircraft were used for flying arms to Central and South America and returning with drugs. Many CIA aircraft were large airline or military types, landing in the United States at military or general aviation airports. *7 DIA aircraft used for drug trafficking operations were usually single and twin-engine general aviation aircraft and usually landed at private airports. 3% among the well-known names operating out of Mena Airport was Barry Seal, one of the CIA's drug pilots. He coordinated frequently with Oliver North, who used the drug profits to purchase arms that went to Central America. Seal was becoming a threat to the CIA drug operations. He knew too much, and he talked too much. He thought that the threat of exposing high-level CIA and DIA officials in the drug trafficking to Congress was insurance for him. If he had known that Congress already knew about the drug trafficking and kept the lid on the scandal by cover-ups, he surely would not have been so confident and cocky. Seal was killed on February 19, 1986, and on the day he was killed the FBI seized his personal belongings, hiding evidence of his CLA-sanctioned drug operations. Vast distribution network. After the drugs were unloaded at drug transshipment points, CIA-affiliated trucking companies transported the drugs throughout the United States. 0.3% organized crime took much of the drugs upon arrival in the United States. Details of this CIA organized crime relationship is found in other pages. CIA drug money laundering. The CIA laundered some of the money obtained from drug trafficking in the Far East through covert CIA financial institutions and other banks that knowingly accepted the funds. These included Nugan Hand Bank, Bishop, Baldwin, Rewald, Dillingham, and Wong, the Vatican Bank, Bank of Lavoro, and Bank of Credit and Commerce International. Operation Backbiter. A code name identifies the situation where a CIA or DIA drug pilot is set up and sacrificed. Operation Backbiter. Targeted CIA or DIA drug pilots are 397. Almost all military bases became drug transshipment points, and especially Homestead, Davis Monahan, Luke, McGuire, McClellan and Travis. 398 frequently mentioned airports include Mena Airport and others in the vicinity, Angel Fire Airport, Marana Airport, Spirit of St. Louis Airport, McMinnville Airport, Coolidge Airport, Midland Odessa, Lakeside Airport, Addison Airport, Shamrock Airport, Pietra Negro, northeast of El Paso, and Redbird Airport in Dallas. The airport at Mena, Arkansas, was a well-known CIA arms and drug transshipment point, and was featured on 2 television shows, Frontline and Now It Can Be Told, and in numerous newspaper stories. 399 CIA contacts identify some of the CJA-related drug haulers: MNX Trucking, Jay's Truck Driver Training School, Jiffy Truck Driver Training School, and Zapata Trucking Company, a division of the Zapata Corporation in Houston. 35. Routinely set up by top echelon people. Customs and DIA officials are told about the arrival of a targeted pilot at a certain airport and he is arrested upon arrival. The pilots are charged and prosecuted, denied the right to have CIA or DIA personnel testify in their behalf, and refused the right to obtain government documents on the basis of national security. Operation Watchtower. Operation Watchtower was one of many drug trafficking operations from Central America consisting of the placement and operation of low-frequency radio beacons to guide low-flying pilots from Colombia to Panama. It also consisted of making available to the pilots the radio frequencies and schedule of drug interdiction aircraft so as to avoid detection. Because of the extremely low altitude that these drug-laden aircraft flew, often at only 500 feet, they could not receive the line-of-sight radio signals ordinarily used. Radio signals from an aircraft on a particular frequency actuated a relay at the radio beacon site that started up the gasoline engine-powered generators and the radio transmitters. Military involvement. The CIA utilized the Army Intelligence Agency in Operation Watchtower, which began in the mid-1970s. U.S. Army Colonel A.J. Baker was ordered to oversee part of Operation Watchtower and turned the operation over to Army Colonel Edward P. Cutolo, who also commanded the 10th Special Forces based at Ft. Devens, Massachusetts. Cutolo had supervised Operation Orwell for the intelligence agencies. This operation spied on political figures for the purpose of blackmail. Many of my deep cover sources described the military's passive or active role in the drug trafficking into the United States. Army Colonel Edward P. Cutolo, who had been ordered by the CIA to supervise Operation Watchtower, grew increasingly concerned about its flagrant illegality, and conducted an investigation in an attempt to bring it to a halt. Fearing he might be killed because of his investigation, he prepared a 15-page single-spaced affidavit dated March 11, 1980, describing the CIA drug trafficking and other activities. Cutolo gave copies of it to several trusted friends *, with instructions to release the affidavit to government officials and the media if he was killed or died. He was prophetic. Cutolo was killed, as were several other people working with him to expose the drug trafficking operations. Their deaths, as with dozens of others, protected high U.S. officials and the sordid operations they inflicted upon the United States. The affidavit described the installation and operation of the radio beacon towers and several of the drug flights in which he participated. The first one occurred in December 1975, headed by Colonel A.J. Baker, under whom Cutolo worked. Cutolo stated in his affidavit that, in the February operation, 30 high-performance aircraft landed safely at Albrook Air Station, and the mission was 22 days long. 400 The Spotlight, October 14, 1991, Writers Exchange, October 1991 edition, Called to Serve, 1991 Author Colonel James Gritz, Freedom, Novdec 1993, Freedom, Jan-Feb 1993, Freedom, Jan-Feb 1995, authored by U.S. Army Colonel William Wilson. 401 Colonel A.J. Baker, Hugh B. Pearce, Paul Neri, and eventually to Colonel James Gritz and William Tyree. B-62. The affidavit listed key people meeting the aircraft, including Colonel Manuel Noriega, who was then Panama's Defense Force officer assigned to Customs, CIA operatives Edwin Wilson and Frank Turpil, and Mossad operative Michael Harari. Harari worked closely with U.S. intelligence agencies in the drug trafficking operation, sharing the profits for Israel and sharing the blame for the U.S. drug epidemic and associated crime wave. Harari had authority from the U.S. Army Southern Command in Panama to operate on military bases. Israel's Mossad participation in drug trafficking made Israel a participant in undermining the welfare and security of the United States, a very grave offense. Operation Orwell. The Cutolo affidavit described another unlawful mission, Operation Orwell 402, which consisted of spying on politicians, judicial figures, state law enforcement agencies, and religious figures. Compromising information was distributed to certain members of the military-industrial complex. Colonel Cutolo stated in his affidavit that the compromising information was needed to silence these people if information on the criminal activities leaked out. Mr. Edwin Wilson explained that it was considered that Operation Watchtower might be compromised and become known if politicians, judicial figures, police, and religious entities were approached or received word that U.S. troops had aided in delivering narcotics from Colombia into Panama. Based on that possibility, intense surveillance was undertaken by my office to ensure that if Watchtower became known, the United States government and the Army would have advance warnings and could prepare a defense. This was another way of accomplishing the CIA's plausible deniability, to downplay and defend against inquiries. The affidavit listed some of the people against whom the surveillance was directed, acted with the support of a network of Mossad personnel throughout Latin America and worked mainly in the import and export of arms and drug trafficking. Edwin Wilson explained that Operation Watchtower had to remain secret. There are similar operations being implemented elsewhere in the world. Wilson named the Golden Triangle of Southeast Asia and Pakistan. Wilson named several recognized officials of Pakistan, Afghanistan, Burma, Korea, Thailand, and Cambodia as being aware and consenting to these arrangements, similar to the ones in Panama. Referring to the huge profits received by the CIA from the SAE trafficking, the affidavit continued. Edwin Wilson explained that the profit from the sale of RDs was laundered through a series of banks. Wilson stated that over 70% of the profits were laundered through the banks in Panama. The remaining percentage was funneled through Swiss banks, with a small remainder being handled by banks within the United States. I understood that some of the profits in Panamanian banks arrived through Israeli couriers. I became aware of that fact from normal conversations with some of the embassy personnel assigned to the embassy in Panama. Wilson also stated that an associate whom I don't know also aided in overseeing the laundering of funds. Wilson indicated that most of Operation Watchtower was implemented on the authority of Kleins. Referring to Operation Orwell, which spied upon politicians for subsequent blackmail, I was notified by Edwin Wilson that the information forwarded to Washington, D.C., was disseminated to private corporations who were developing weapons systems for the Department of Defense. Those private corporations were encouraged to use the sensitive information gathered from surveillance of U.S. senators and representatives as leverage to manipulate those congressmen into approving whatever costs the weapons systems incurred. As of the date of this affidavit, 8,400 police departments, 1,370 churches, and approximately 17,900 citizens have been monitored under Operation Orwell. The major churches targeted have been Catholic and Latter-day Saints. I have stored certain information gathered by Operation Orwell on Fort Devens, and pursuant to instructions from Edwin Wilson have forwarded additional information gathered to Washington, D.C. Certain information was collected on suspected members of the Trilateral Commission and the Bilderberg Group. Among those that information was collected on were Gerald Ford and President Jimmy Carter. Edwin Wilson indicated that additional surveillance was implemented against former CIA Director George Bush, whom Wilson named as a member 2p of the Trilateral Commission. It is easy to understand why members of Congress can be blackmailed into covering up for criminal activities involving personnel of intelligence agencies or the Justice Department when information on their personal lives is secretly collected by the FBI and U.S. intelligence agencies for blackmail purposes. The affidavit described some of the weapon manufacturers who received the CIA information. Edwin Wilson named 3 weapons systems when he spoke of private corporations receiving information from Operation Orwell. An armored vehicle. An aircraft that is invisible to radar. A weapons system that utilizes kinetic energy. Edwin Wilson indicated to me during our conversation, which entailed the dissemination of Operation Orwell information and the identification of the 3 weapons systems, that Operation Orwell would be implemented nationwide by July 4, 1980. The affidavit made reference to classified information and the activities of the CIA in the United States and in Latin America. Referring to people working with Edwin Wilson, the affidavit continued, each operation had basically the same characters involved, with Edwin Wilson, Robert Gates and William J. Casey. As Colonel Cutolo suspected, Neri was killed, apparently to silence him. Paul Neri was one of the people that Cutolo entrusted with the affidavit and who had been requested to make the affidavit public upon his death. In distributing the affidavit to members of Congress and the media, Neri wrote, both Col. Rowe and Mr. Pierce agreed to go public, after the meeting with Larkin Smith, to call for a full investigation into the events described in Col. Cutolo's affidavit. But both men died prior to the meeting with Smith. Referring to the Mossad, Neri's cover letter stated, with the deaths of Col. Cutolo, Col. Baker, Col. Rowe, it is hard to believe the deaths of these men are not the work of the Israeli Mossad. It is equally easy to attribute the death of Col. Cutolo directly to Operation Watchtower inquiries. Meeting the same cover-up response that I received for the past 30 years from the establishment media, Neri's letter stated, for your information, a copy of the affidavit will be sent to the New York Times, the Washington Post and the Boston Globe. The men who died so far were good men. They attempted to let the public know what really occurred in Latin America, and in the never-ending drug flow. In 1980, Col. Cutolo died in an accident while on a military exercise. Just prior to his death, he notified me that he was to meet with Michael Harari, an Israeli Mossad agent. It is my belief, though unsubstantiated, that Harari murdered Col. Cutolo because of the information Col. Cutolo possessed. I believe that Col. Cutolo died in his attempt to Operation Watchtower. 404 Neri was an employee of the National Security Agency. 356. Colonel Baker enlisted the aid of Colonel James N. Rowe, and between Col. Baker, Col. Rowe and myself, we set out to prove that Harari murdered Col. Cutolo, and that Operation Watchtower netted Edwin Wilson and Frank Turpil of the CIA a large sum of tax-free dollars. Prior to getting very far into the investigation, Col. Baker died. We had no doubt as to the guilt of Thomas Clines, whom we suspect was the mastermind behind Operation Watchtower. Neri went on to describe how Harari and Col. James Roe *5 were in the Philippines when Roe was assassinated, and that it is a unsubstantiated belief that Harari murdered Col. Roe or arranged it. Neri's letter continued, I believe Harari's motive for murdering Col. Roe was due to Col. Roe's inquiries about Harari's movements and relationships to Edwin Wilson, Thomas Clines, and Manuel Noriega. Referring to another death in the small group seeking to expose Operation Watchtower and the associated deaths, Neri wrote, in June 1989, Mr. Pierce was killed in a helicopter accident. Was hated by many different factions in the United States. The perfect place to assassinate him would be outside the U.S., where the law enforcement authorities are not as apt to control the evidence, crime scene, etc. This fact was known to, and they acted on it as a precaution. The Special Forces team assigned to guard the U.S. representative didn't arrive on the ground in Jonestown until minutes after the U.S. representative was dead. Two facts in dispute are, did the Special Forces team deliberately delay in reaching Jonestown? If so, why did they delay, and on whose orders did they delay? That the Special Forces team were the people that actually killed the U.S. representative. This is possible, as the person who told me that version is a person who has always proved to be a creditable source. A number of special forces were training the ranchers in and around the Jonestown complex in security measures. 363. Mossad's drug trafficking. Several of my CIA and DIA sources who were directly involved in the drug trafficking described the Mossad's role in Central and South American drug trafficking. These sources described how the Mossad marked their drug packages, how the Mossad shared space on CIA aircraft flying drugs into the United States, and about the vast network of Mossad operatives throughout Central and South America engaging in drug smuggling. Mossad operatives connected with the drug operations included Michael Freddie Harari and David Kimchi. Both worked hand in hand with the CIA and the drug traffickers, including the Medellin and Cali cartels. When U.S. forces invaded Panama to arrest Noriega, Harari was caught in the fighting. Despite the fact that the Mossad's role in drug trafficking was serious and that he was a co-conspirator with Noriega, the U.S. intelligence agencies allowed Harari to escape in an Israeli jet. If Harari had been captured and questioned, Israel's involvement in the drug trafficking could have come out, as well as that of U.S. intelligence agencies. Former OSS operative Russell Bowen worked with or alongside the Mossad and Harari for many years. He told me that Harari had started his vast Central and South American operations by hauling cigarettes and then branching out into drugs. Another CIA operative came forward. Another of the many confidential sources with whom I had contact was Trenton Parker, who played a key role in CIA activities in the Caribbean. Ironically, Parker had crossed paths with Russ Bacher in the early 1980s, which provided further confirmation of Russ Bacher's status, and Parker provided me with information on CIA activities that Russ Bacher had withheld. Once Parker gave me preliminary information about the activities Russ Bacher then enlarged upon. Parker provided me with a confidential employee status report showing his CIA status from December 23, 1964 to May 24, 1992, and his last rank was Colonel in the United States Marine Corps. It showed that he had a top-secret clearance, and that he was attached to the Marine Naval Intelligence and to the CIA. His serial number was 553-60-1458, with an additional MSID identification number of 207-2458. The reports identified Parker as a member of the ultra-secret Pegasus Group, with headquarters in the U.S. Department of Labor offices in Fairfax, Virginia. The status report listed his alias, Pegasus 222. Parker stated that the CIA and Justice Department had sacrificed him in 1982 to protect an ongoing secret scheme called Operation Snow Cone. He had been charged by the Security Exchange Commission with a money laundering operation, which was part of a CIA operation under Operation Interlink and Operation Gold Bug. This CIA operation was accidentally exposed by the SEC, which was unaware of the CIA's role in the ongoing unlawful operation. Usually Justice Department officials in Washington quickly step in and the charges are dropped. But in this case the SEC charges were filed and publicized by the media. It was therefore too late to pressure the SEC to retract the charges. There was another possible reason for filing charges against Parker. Parker stated that his handlers had asked him to be part of an expanding drug operation. 364. In Nigeria called Operation Indigo Sky, and that he refused. He didn't care to get involved in drug trafficking, and living conditions in Nigeria were deplorable. Justice Department prosecutors and CIA personnel encouraged Parker to plead guilty, assuring him that he would be released as soon as attention to his case no longer existed. Parker pled guilty in 1982, he refused all newspaper interviews, and was promptly hidden in the federal prison system, including months of diesel therapy which kept him from a law library and telephone. The opportunity to seek legal relief arose while Parker was in an Arizona prison where he could prepare and file a post-conviction motion. This motion was heard by U.S. District Judge Marquez in Tucson on February 12, 1986, after which the judge ordered the prison warden and the U.S. attorney to release Parker immediately. In 1992, U.S. Attorney Michael Norton in Denver charged Parker with money laundering charges that had been part of his CIA operations. At his arraignment in Denver, the judge ordered him released pending trial, set for April 1993. Before his release, Parker occupied a cell with Stuart Webb, a private investigator whom I had met earlier, and who was trying to expose the HUD and savings and loan corruption in the Denver area. Webb showed Parker some of my writings, and Parker contacted me upon his release. Parker said that he had been with the CIA for approximately 30 years and was part of Faction B4-7 in the CIA, and was identified as Pegasus 222. While waiting for trial, Parker filed papers with the court listing the secret CIA operations that he would reveal at his trial. He also filed a list of documents that he would submit, including the confidential status report showing him to be a colonel in the U.S. Marines assigned to the Office of Naval Intelligence and to the Central Intelligence Agency. Once Parker filed the list of documents with the court, an assistant U.S. attorney in Denver complained to the judge that Parker should have filed the documents under seal because they revealed secret CIA activities. Because of those revealing documents, U.S. Attorney Norton dismissed all charges against Parker, which avoided revealing the agency's dirty linen. Parker called me on March 23, 1993, stating, "All charges have been dropped. I'm going underground. Don't ask any questions." He then hung up. As time went on, over the years, I occasionally talked to Parker. He was adamant that he wanted nothing else to do with any of the corruption in government, feeling as I did. He felt that the nation's checks and balances were too corrupt, and the public too illiterate about government misconduct and too indifferent, for anyone to show any meaningful concern. Parker told me that the CIA, with Vice President Bush's approval, set up a sham drug bust in Miami during March 1980 using 4,000 pounds of cocaine, the biggest drug bust at that time. The purpose of the scheme was to generate support in the United States for the newly appointed drug czar, Vice President George Bush, justifying the use of the U.S. military in the so-called war against drugs. In carrying out the scheme, the CIA reportedly coordinated with Jorge Ochoa, a Colombian drug dealer. Ochoa organized many of Colombia's drug dealers to contribute cocaine for a large shipment into the United States, advising that there was safety in numbers. Most of the dealers didn't know that this was a planned drug bust and that they would lose whatever cocaine they contributed to the shipment. After the drug dealers contributed their cocaine into Ochoa's warehouse, Ochoa switched large quantities of bad cocaine that he had accumulated with good cocaine contributed by other dealers. Later, Ochoa sold the cocaine obtained in the switch for about $50 million. The 4,000 pounds of cocaine, including the bad cocaine that Ochoa had switched, was then shipped to Miami and seized by U.S. Customs as planned. Bush got good publicity for his role as drug czar, and Ochoa and his insiders made over $50 million by replacing good cocaine with bad cocaine. The sting operation in which Parker participated used an informer to notify DEA agent Phelps in Bogota that the drugs were arriving at Miami International Airport on a particular flight at a given time. Phelps then notified DEA and Customs at Miami, so they could be present at the aircraft's arrival and to seize the drugs. There were comical elements to this planned drug bust. Parker described what he observed at Miami International Airport when the 4,000 pounds of cocaine arrived on board Tampa Airlines. Watching the scene from an unobserved distance via binoculars, Parker said that the airplane with the 2 tons of cocaine arrived at the parking area, but there were no custom agents there to seize the drugs, despite the considerable planning that went into the operation. Several people working with Parker were at the aircraft, presenting the appearance of being there to unload the cargo. However, they intended to run off as the DEA and custom agents appeared. But there were no agents. The pilots wanted the drugs unloaded fast and wanted to leave. To avoid losing the drugs intended for the planned seizure, Parker's people unloaded the crates containing the drugs onto the tarmac. The cocaine was hidden in boxes of Levi jeans, with yellow bands on the boxes containing the real Levi's, and white bands on the boxes containing the cocaine. Parker's people sprayed the boxes containing the cocaine with ether so the custom agents couldn't possibly overlook the presence of drugs. The absence of the expected DEA and custom agents presented Parker with a problem. He advised his men by radio to stand by. An hour later, Parker saw through his binoculars a couple of custom agents, engaging in frivolity, walking slowly toward the boxes, obviously unaware of the presence of drugs. Parker then radioed his men to stay clear of the area. Parker watched through his binoculars as the agents poked holes in the boxes to check for possible drugs. The third box that they poked caused white cocaine powder to escape. Parker then radioed his people to immediately leave the area. Parker boarded a commercial airline for return to Denver. That night the U.S. media described the drug find as the largest discovery in the nation's history. DEA and Customs officials described the drug find as the result of an intensive coordinated effort between the DEA and Customs. CIA complicity in establishing the Medellin cartel. Parker told how the CIA set up the meetings in which various Colombian drug dealers organized into a drug trafficking cartel. Parker mentioned 2 preliminary meetings in late 1981 arranged by the CIA, in which the individual drug dealers in Colombia planned to organize into a cartel for shipping drugs to the United States. He stated that the first meeting occurred with 20 of the biggest cocaine dealers in Colombia present, that the second and final meeting was held at the Hotel International in Medellin attended by about 200 drug dealers, pushers, and smugglers. The Medellin cartel was established in December 1981, and each of the members paid an initial $35,000 fee to fund a security force for the cartel members to protect their drug operation. Russ Bacher confirmed the meetings that Parker mentioned, and that there had been a preliminary meeting in September 1981 in Buenaventura, Colombia, which established the format for the subsequent meetings. Russ Bacher attended the September 1981 meeting, which was initiated by the CIA to facilitate drug trafficking into the United States, permitting the CIA to deal with a group rather than many independent drug dealers. At least half a dozen former CIA, OSS, and DEA personnel gave me many hours of statements over a 3-year period concerning Central and South America drug operations in which U.S. intelligence agencies and the Mossad participated. CIA planning and funding the kidnap of Ochoa's sister. Prior to organizing the Medellin cartel, the CIA created a crisis situation, providing an impetus for the Colombian drug dealers to form the Medellin cartel. Parker described the CIA operation in early December 1981 that led to the kidnapping of Jorge Ochoa's sister, Leona, from a university outside of Bogota. Parker said that, acting in his CIA capacity, he paid a group known as M19 to carry out the kidnapping and to also kidnap Carlos Leder. Leder escaped after he was captured. The CIA paid the M19 group $3 million, of which $2 million was in guns and $1 million in cash. Parker said, "We made arrangements with Colonel Noriega, and this was the point where Noriega became involved with the CIA and the drugs." He continued, the deal was that the meeting between M19 and Ochoa and Escobar would be held in a neutral point, namely Panama. During the second week of January 1982, everything was set up. Another one of my CIA sources, Russell Bowen, played a role in the kidnapping of Ochoa's sister. He piloted the DC-3 aircraft that flew Ochoa's 368 sister, Leona, to a remote location, where she was held until the ransom was paid and she was released. Crossing of paths. As Parker was elaborating upon one of his money laundering flights, I learned that his path had crossed that of Gunther Russbacher, adding further confirmation to Russbacher's ONI status. Parker described the purpose of a flight from Dobbins Air Force Base near Marietta, Georgia in January or February of 1982, and included a description of the pilot. He said the pilot was a Navy LT commander with the nickname of Gunsel. Russbacher had told me that Gunsel and Gunslinger were nicknames he used. Parker stated that the pilot was very articulate, which fit Russbacher's description. Russbacher confirmed that he did fly such a flight, and that the route of flight and the name of one of the passengers coincided with Parker's description. Parker described the series of short flights with the first landing at Grand Cayman Island, where Parker picked up $5 million in cash from a CIA source. The plane then went to Nassau, where Parker paid Prime Minister Lyndon Pindling plus $81 million to get rid of a place called Norman's Cay. Parker explained that Norman's Cay was a main drug transshipment point operated by Colombian drug dealer Carlos Leder, whom he described as one of the 5 keys of the Medellin cartel. Parker stated, Leder was getting way out of line, he was shooting at people, and when he finally shot at Walter Cronkite, who happened to be sailing around in the area, Walter broke the news and a lot of people were saying, how can this guy be operating out of Norman's Cay just off the shores of the United States? Parker stated that Leder was then forced to leave Norman's Cay and return to Colombia, where he joined the Medellin cartel. Parker said that before leaving Nassau he was joined by Robert Vesco, and then the CIA aircraft flew them to Havana, where they were met at the airport by security guards and Fidel Castro. Parker said, I personally delivered $2 million to Fidel Castro. And for those $2 million he was to see that a shipment of arms was to go to M19, which was a right-wing revolutionary force that we wanted to keep active so that we could have pressure on the government to bring about certain things that we wanted to do. And we needed pressure from below and pressure from above. He agreed to do that and he did do that. Parker continued, I took the remaining $2 million and flew into Panama City, Panama, and there I checked into Holiday Inn, where he met with the head of Colombia's M19. Parker added, I delivered my $1 million to him and then I met with Colonel Noriega and delivered $1 million to him. That $1 million was to pay Noriega to act as the neutral party to negotiate the release of Ochoa's sister. Sure enough, Ochoa's sister was released. Parker continued, and then he was also supposed to make an offer that he could and would provide protection for the drugs coming into the United States through 418 Lyndon O. Pindling. 369. The back door to the Midway. And what that was, is that we had already made a move on the cartel to close down some of the small operations. At that time Noriega offered a connection into the Sandinistas, the drug operations. Refinery plants were set up there. And that's what we wanted, as we wanted to show the Sandinistas as being the bad guys and justify U.S. involvement. What we were doing was also financing operations because a certain group in the CIA was going ahead and flying guns down into Nicaragua, dropping them off by parachutes to the Contras. They then went over to the Sandinistas, picked up drugs and flew them into the United States, after which the money would be returned to the Sandinistas. In effect we were taking over some of the flying services for the Medellin cartel. The money from the drugs produced the money for the guns, and that is how the operation worked, and Bush knew the whole goddamn thing. Parker explained that after completing that trip, he flew back to Denver where he was to go to trial on charges relating to a CIA operation called Operation Gold Bug. He explained that he was on a $1 million self-recognizance bond, which was rather bizarre since any offense requiring that large a bond would be too serious to permit release on one's own recognizance. Parker thought that charging him was a mistake unless it was to silence or discredit him. Parker said, "First, my trial was to start on February 2, 1982. Second, when it came up by a pure fluke." He explained how the CIA was to protect him from prosecution. Prior to trial, his CIA handlers instructed him to remain silent about the CIA operation as it was ongoing and that any exposure of it would have serious consequences. His handlers stated that he would receive a very light prison sentence or probation and would soon be free. More fuel for charges that CIA was involved in Kennedy's assassination. Parker said that after President Kennedy decided to pull U.S. troops out of the CIA Vietnam operation, which would cause the loss of billions of dollars from the CIA drug trafficking, certain CIA factions decided to assassinate Kennedy. Pegasus people learned of the plot and told Kennedy 2 weeks before he was assassinated. These statements by a deep-cover CIA operative and Marine Corps officer certainly raise serious questions and add further fuel to the speculation and charges that the CIA was involved in Kennedy's assassination. In light of other CIA criminalities, there should be little doubt that the CIA has the mindset to assassinate a president of the United States. Parker stated that after Kennedy's death the Pegasus unit was not able to function as intended because of the corrupt activities of U.S. presidents after the Kennedy assassination. He named Johnson, Nixon, and Bush as knowing of the planned assassination, and that the Pegasus group had taped telephone conversations making reference to the operation. He stated that Reagan was not implicated like the others, he was more of a figurehead for powerful factions controlled by former CIA Director Bush. 370. Parker described the necessity of Pegasus going underground within the CIA because of the inability to report to a president, and that the files on corrupt CIA operations gathered by the Pegasus group were moved to various secret locations. Denver was one of the sites. Parker said that his Pegasus group secretly gave files on the CIA criminal activities from 1976 to 1982 to a member of the Joint Armed Services Committee, Congressman Larry McDonald. These files revealed corrupt activities by several U.S. presidents, federal officials, the CIA, and other members of government. Parker said that McDonald let it be known to the press that he was going to reveal startling evidence upon his return from the Far East showing that the CIA and certain high-ranking public officials were part of an operation responsible for drug trafficking since 1963 from Southeast Asia. McDonald boarded KAL Flight 007, which was shot down by the Russians. Referring to the 3 naval officers killed at Fort Ord, Parker had seen one of my petitions to Congress reporting, among other matters, the crash of a Navy helicopter at Fort Ord on April 30, 1991, and the death of 3 naval officers from the Office of Naval Intelligence, one of whom was a woman. He was interested in knowing their names and physical descriptions, as 2 men and a woman disappeared from his Pegasus group at about that time. He thought the crash might explain their sudden disappearance. He added, "The Pegasus units have been systematically exterminated, people have been knocked off." Since the Pegasus unit was collecting evidence of CIA criminality, the members were frequent targets of assassination by other CIA and intelligence groups. Parker described many of the CIA operations in which he played a role, and his description coincided with information given to me by Gunther Russbacher and other CIA sources. Operation Mother Goose. Parker told me his various assignments in the CIA from when he first joined the Office of Naval Intelligence. He was involved during 1964 in the CIA scheme called Operation Mother Goose, dealing with joint military selection, recruitment, and training of qualified enlisted men with security ratings. These people were educated and trained in basic covert and undercover activities. After training, they were released from active military duty to enroll in colleges and universities under the GI Bill. While under CIA supervision, they infiltrated student activities and student movements as they related to the Vietnam War and other political areas. Parker trained at the United States Marine Corps base at Camp Pendleton, California. Operation Backdraft. Parker's next CIA assignment was an enlargement upon Operation Mother Goose called Operation Backdraft. This operation provided financial assistance to students while attending college and trained them to infiltrate and disrupt student activities. Parker participated in this program while attending college and university programs in Southern California. Another CIA contract agent, Ron Rewald, was used in a similar operation and was later recruited by the CIA to operate a proprietary in Hawaii known 371 as Bishop, Baldwin, Rewald, Dillingham, and Wong. To qualify Parker for use in financial operations, the CIA obtained employment for him with New York Stock Exchange brokerage firms from 1971 until 1974 in California and Colorado. While in this position he supplied confidential information to the CIA on customer accounts and transactions. Eventually he opened his own brokerage firm as a front for the CIA through the SEC and NASD. This is similar to the operation described to me by CIA operative Gunther Russbacher, in which Russbacher received training at Mutual Life Insurance Company, and then incorporated and operated a number of CIA financial institutions headquartered in Missouri. These institutions had offices throughout the United States including Denver, Dallas, Houston, Atlanta, and Traverse City, Michigan. Operation Anaconda. Another CIA assignment was participation in Operation Anaconda in the mid-1970s, through which CIA personnel ran for state and federal political office. Another purpose of the operation was to swing key elections to a particular candidate, away from one whose interest may be detrimental to the CIA. This was used against Senator Church and Representative Pike after their committees exposed CIA misconduct. Parker elaborated upon other CIA operations in which he was involved, including infiltration of U.S. financial institutions, drug operations in Central and South America, and the Nigerian operation known as Indigo Sky. Parker appeared as guest on several talk shows with Tom Valentine of Radio Free America *9 during one appearance on July 29, 1993. He shared the 2-hour program with former CIA employee and author Fletcher Prouty 42 degree describing the mechanics of the CIA's Operation Interlink. Prouty stated during the show that Parker's revelations make this one of the most important shows on the CIA that has ever occurred. Prison release brought about by book. After federal charges were dropped against Parker, the state of Arizona filed money laundering charges against him, arising from Parker's earlier CIA activities. Extradition papers were filed with Colorado authorities where Parker was residing, seeking to have him extradited to Arizona. Parker felt that this charge arose from activities of the United States Department of Justice. Fighting extradition, Parker filed into court records the expanded second edition of Defrauding America, referring to the sections explaining Parker's CIA activities and telling how Justice Department officials sought to silence or discredit CIA assets by filing sham charges and incarceration. The judge refused to honor the extradition papers from Arizona, ordering Parker released from custody. Parker felt that the book played a key role in his release. A year later, in June 1994, the state of Arizona again sought to extradite Parker from Colorado. Colorado Attorney Dennis L. Blewett said to me that almost 20 law enforcement personnel surrounded Parker's home and arrested him, based upon the Arizona extradition papers. Parker then sought to have the papers filed in the previous extradition attempt, in the possession of another judge, sent to the court where the new extradition request was to be heard. Blewett and several friends went to the clerk of the court where the case was pending, requesting help in getting from the other judge the necessary documents. When the clerk heard the name of the book Defrauding America, she reached under the counter and pulled out a copy. When she realized that Parker was in the book, she told the group not to worry, that she would get the records for Parker. Reportedly, the clerk and the two judges had a copy of the book with Parker's activities described in detail. Arizona requested that a $500,000 cash bond be required for Parker's release pending a hearing on the extradition request. The judge settled for $3,500. After Parker was released, he called me, describing the events, and said that even the Thornton City Police, who arrested him, had a copy of Defrauding America in the police station, and it was being read by the people on duty. Several times Parker credited the book with bringing about his release. The way he described the events caused me to chuckle. Describing meeting Foster at Mena, Parker described a meeting he had at Mena, Arkansas, at which there were present CIA asset Terry Reed and Rose law firm partner Vincent Foster. Parker said that CIA money laundering was the primary topic of discussion. This meeting provided extra support for the fact that the law firm was involved in the CIA-related activities. An OSS mole inside the CIA, Russell Bowen, was one of many intelligence agency sources who gave me many hours of information concerning his activities for the OSS and CIA. Ironically, Bowen said he was a mole within the CIA representing a group of about 75 people from the former Office of Strategic Services. During World War II, Bowen was a lieutenant colonel in the military and was one of the youngest P-38 fighter pilots during the war. He received the Distinguished Flying Cross, the Distinguished Service Medal, and other decorations for meritorious service. During World War II, he was brought into the OSS by General William Donovan, who was selected by President Franklin Roosevelt to form this intelligence unit. When President Truman disbanded the OSS in 1947, several dozen OSS members secretly maintained their organization under the cover of the CIA and were known as Faction 3 in the Central Intelligence Agency. After the war, in his OSS/CIA role, Bowen was the pilot for United Nations Secretary General Dag Hammarskjöld, the Shah of Iran, and eventually Fulgencio Batista, the former dictator of Cuba. He and I had crossed paths when my piloting duties took me to the Middle East on temporary assignment from my base at Oakland, California. 421 during a telephone call in June 1994. 374. Bowen was flying DC-3 and C-46 aircraft from Kabul to Beirut via Tehran, and I flew the same type of aircraft in the same general area. Bowen was flying material for the CIA, and I was flying Muslim pilgrims to Mecca from throughout the Middle East, including Baghdad, Tehran, Beirut, Jerusalem, Jeddah, and Abadan. Bowen surprised me when he said that two employees of the same airline that I worked for, Transocean Airlines, were CJA operatives, Alan A. Berry, General Manager for Iranian Airways in Tehran, and Henry R.F. Hank Meyerhofer. I had flown for Transocean Airlines and had known them when I flew in the Middle East during the early 1950s, but had no idea they were engaged in such activities. Bowen told how he started up several airlines in South America after the war that served as covers for the CIA. He also mentioned knowing a friend of mine, King Parker, who also started several airlines in South America and who occasionally flew with me in the 1980s in my Beech Twin Bonanza aircraft. Parker has since passed away. Parker had flown PBY aircraft for the Royal Canadian Air Force during World War II, while one was a Navy flight instructor in PBY seaplanes at Jacksonville, Florida in 1944. Casey's undercover CIA operations. Bowen said that he reported directly to William Casey in the CIA during the 1960s and 1970s. He indicated that Casey was with the CIA in a covert capacity after World War II and long before becoming its director in 1981. Bowen said that he flew dozens of covert CIA operations in the Middle East and Latin America, under Casey's direction. Bowen also mentioned meeting Casey and other handlers on his trips to Washington at secret places and receiving verbal instructions and suitcases filled with money. Casey was part of the OSS during World War II until it was disbanded by President Truman in 1947. He then became a covert operative for the CIA with no publicized connection to the agency until 1981, when President Reagan appointed him director of the CIA. Garbage collector. Bowen was known in the CIA as a garbage collector, a term used to extract CIA operatives from foreign countries who had been compromised or were wanted by the local police or military. Bowen told me of the time in 1983 when Theodore Shackley ordered him to fly into San Jose, Costa Rica. The purpose was to extract a CIA asset, Sam Cummings, who was hiding in the Piper aircraft compound using the alias of Mark Clark. Cummings was the president of the CIA-related Inter-Arms Corporation of Virginia, the largest small arms company in the world. Cummings had been in Costa Rica on a sensitive CIA mission to provide arms for dissident groups. One of the meetings resulted in 2 locals being killed and Cummings charged with their murder. Cummings was the brother-in-law of Senator John Tower, who was implicated in the CIA October Surprise Operation and other CIA operations in South America. Extracting Cummings was utmost priority to the CIA as failure could expose a highly sensitive operation. The CIA had given orders that Cummings was either to be extracted from Costa Rica, or killed to silence him. BYYS. Among the people involved in the extraction were William P. Clark, Reagan's national security advisor, who was in Costa Rica at that time, Joseph Fernandez, a close friend of George Bush and who later became CIA station chief in Costa Rica, and Felix Rodriguez, who was a veteran of the CIA Bay of Pigs fiasco. Parker named another person working with him was Martha Honey, who would later write several books on the CIA involvement in Central America. Bowen gave me many details about the CIA drug trafficking. He stated that he was in CIA drug trafficking commencing in 1950, operating in the Middle East, Central and South America, and in the Golden Triangle area. The frequent cross-questioning of CIA and DIA personnel confirmed that Bowen was with the CIA and involved in CIA-directed drug trafficking. Bowen's statements often confirmed the CIA role mentioned by some of my other confidants. Much of this information was given during question and answer sessions but also in a pilot-to-pilot manner. No embellishment, just routine conversations concerning routine piloting activities. None tried to impress me. They simply stated facts. Bowen elaborated upon his dealings with the Medellin and Cali drug cartels as a CIA operative and the role played by the Mossad in these dealings. Bowen was a friend of Theodore Shackley, a CIA kingpin in CIA drug activities, working closely with the cartels. Bowen said that the CIA provided Theodore Shackley the alias of Robert Haynes. Bowen worked with Shackley from the early 1950s to 1984. Crashing in the Andes in 1959, Shackley was on board a C-46 aircraft flown by Bowen when an engine failure forced them to crash land high on the eastern slopes of the Andes in Bolivia. I've also flown C-46 aircraft, and know that with an engine out, it is very difficult to maintain level flight, and especially at the altitude being flown over the Andes. The plane crashed, but everyone survived. I had an opportunity to question Shackley on this crash while I was a guest at the National Convention for the Association of Former Intelligence Officers held at San Francisco in November 1995. While eating lunch at the convention, I suddenly spotted Shackley and his wife sitting immediately across from me. Since I did not know if he had read my earlier books in which I made reference to him, and since I wanted to be low-key at this convention, I didn't introduce myself to him. However, I wanted to get Shackley's reaction to the plane crash described by Bowen, and asked former National Security Agency agent Joe T. Jordan, who sponsored my appearance at the convention, to ask. Jordan said that Shackley stated unequivocally that it was untrue. I didn't think that Bowen would lie to me on a matter like that, so I called Bowen at his Florida residence, advising him of Shackley's reply. I asked, was there something going on with that flight that he would not want anyone to know that he was on it? Bowen responded, of course, it was loaded with drugs. Bowen then enlarged upon the purpose of that trip. He stated that this trip occurred several years before Shackley was made CIA station chief in Miami, and that Shackley was instrumental in setting up the CIA drug trafficking into 376. The United States from South America. Bowen said that the series of flights went from Miami, to Colombia, to Quiaqui, to Lima, and then to Arequipa. After the plane left Arequipa going eastbound over the Andes, one of the 2 engines failed, causing the aircraft to lose altitude. Bowen was able to maneuver the aircraft into one of the few available flat areas, and crash-landed the plane. Bowen said that Shackley had arranged for cocaine to be loaded on board the aircraft, where it was hidden in the tail section. Bowen, Shackley, and the others then abandoned the crashed aircraft. Eventually the Bolivian authorities discovered the drugs, but the pilots and passengers were long gone. This would explain why Shackley wanted to distance himself from that crash. Bowen said that Shackley went to Ascension, Paraguay to arrange for drugs to be shipped to Miami, meeting with the head chief of one of the Indian groups, Quadium, and a lieutenant colonel in Paraguay's military. The name of the town where that meeting was held was Guadian. Bowen said that these people were the backbone of Stroessner's intelligence and drug-dealing activities. Bowen described the conflict between different CIA factions, stating that Shackley wanted to smuggle the drugs into the United States, and another faction, with whom Bowen was associated, wanted to block this practice. Bowen said, at that time, Shackley was the leader in bringing the drugs in. Shackley's team wanted the drugs in. The team I worked for did not want the drugs in. I asked who set up that initial drug operation, and he said, he was the mastermind of the drug operation. He had full authority to set it up. I asked, would you have any knowledge of whether McLean or Washington was aware of this drug operation? They ordered him to do it. I said to Bowen that Russ Bacher had told me of the three factions within the CIA that had different and contradictory agendas, and that Russ Bacher was with the Office of Naval Intelligence faction. Bowen replied, the Naval Intelligence faction is the most dangerous of them all. I grew up with them in Arlington. Money laundering proprietaries. Bowen described one of the CIA proprietaries operated by Shackley, Intercredit, with offices in Medellin, Amsterdam, and Ft. Lauderdale, Florida. During the Vietnam War, Shackley helped manage the extensive CIA drug operations in the Golden Triangle area, and was the executive director of the CIA Phoenix program. Shackley directed the CIA's secret war against Laos in the mid-1960s, and later became chief of station in Saigon. He directed the transfer of tens of millions if not billions of dollars received from the CIA-promoted heroin trade in the Golden Triangle of Burma, Thailand, and Laos. When Shackley was chief of station for the CIA in charge of Central and South American operations, he reportedly directed the massive drug trafficking into the United States that subsequently blossomed. He directed the operation known as Track 2, which led to the overthrow of the Salvador Allende government in Chile in 1973. He was just the man to coordinate the CIA's development of the burgeoning drug trafficking from Central and South America into the United States. 377. Bowen gave me details of the CIA ties to the Medellin drug cartel that Russ Bacher and Parker had described to me earlier. Each gave me details of the formation of the Medellin cartel from another perspective. Bowen described another side to the kidnapping of Ochoa's sister, Leona, which Parker had earlier described. Bowen was unaware of the role Parker played in the kidnapping. Bowen said that he flew the DC-3 aircraft that flew Ochoa's sister, after she was kidnapped, from a small dirt airstrip near Bogotá, Colombia to a dirt strip at Ipiales, in the southwestern part of Colombia, near Paso. Bowen worked under Shackley when Shackley was transferred to Vietnam, and described Shackley's role in the deadly Phoenix program. Bowen said that the people doing the killing, often Hmong warriors, were paid in drugs by the CIA for every person they killed. Unusual attempt to expose CIA drug trafficking. Bowen, like many other CIA operatives, became disenchanted with the CIA drug trafficking. In 1981, he wrote anonymous letters to U.S. Customs in Miami, reporting the details of the drug operation in the hope that it would be stopped. Nothing happened. During a flight in 1982, he tried another way to get publicity which backfired on him. Bowen said that he was requested by CIA operative Henry Meyerhofer to fly a trip to Medellin, Colombia, carrying a government undercover agent and to return with another agent. But when Bowen arrived in Medellin, Shackley placed 800 pounds of cocaine on board the return flight, including 200 pounds belonging to the Mossad in bags imprinted with the Mossad's two triangles resembling the Star of David. On the return flight to the United States with the cocaine, he decided to land at an airport that had intensive surveillance for drug trafficking, Sylvania Airport in Georgia. His intent was to alert the authorities to the cocaine load and, in his way of thinking, cause the local police to take action against the CIA. This was rather naive, but his heart was in the right place. Bowen was blowing the whistle on the huge international drug operation involving some of the highest officials in the U.S. government. The plan backfired. Bowen was arrested for drug trafficking. Standard silencing tactic. Bowen said that at his trial in 1985, the U.S. district judge refused to allow him to have his CIA handlers, including Meyerhofer, appear as witnesses. During Bowen's trial, Justice Department prosecutors and the judge protected the Mossad's role in the drug trafficking by withholding from evidence the 200 pounds of cocaine with the Mossad's identification on it. If those bags of cocaine with the triangles representing the Star of David were presented as evidence, serious questions would have been raised. The judge refused to allow Bowen to produce records and testimony showing that he was carrying out CIA activities. Refusing to allow evidence to be presented that is necessary to a person's defense, when covert government activities are. 422 on March 2, I-984. Interestingly, Meyerhofer had been an employee of Transocean Airlines in Beirut during the time I was a captain for the airline. 378. Involved, is a standard pattern by federal judges. Almost every CIA and DIA person with whom I have talked, and who has been imprisoned, experienced this pattern, including Russbacher, Rewald, Recanasi Utto, Wilson, and others. Bowen's court-appointed defender displayed the usual lack of aggressiveness, with no desire to raise a defense that would expose covert government activities. It is probable that the naive jury felt that Justice Department prosecutors surely would not lie or bring false charges against an innocent citizen. They convicted Bowen, and he was sentenced to 10 years in prison. During his imprisonment, Bowen was sent to Springfield Federal Prison Hospital, where he was repeatedly injected with Procan, which prisoners refer to as Russian lobotomy because it reportedly destroys the memory. I asked, "What happens if you resist taking the shots?" He replied, "Burly guards come in and hold you down, while another prison attendant shoots the drug into you." Another DIA source. Another one of my many confidential sources was a former DIA pilot, Basil Abbott, who had flown drugs from Central and South America for the DIA from 1973 to 1983. During several years of frequent discussions and many letters, Abbott gave me a chronology of his DIA activities. At first he was a confidential informant and then a contract pilot, flying arms to Central America and drugs on the return flights. Abbott described receiving pilot training from DIA agent William Collar at the FAA Academy in Oklahoma City, preparing him to fly drugs in and out of short dirt strips in Central and South America. Classroom training was given on how to avoid radar detection, the routes to fly and the hours to fly them so as to avoid detection by drug interdiction aircraft. Collar trained Abbott in numerous aircraft, including the Cessna 180, 185, 206, 210 and 310, and Piper Aztec, Aerostar and Navajo. Abbott received training on how to survive if forced down in the jungle, and how to ditch the aircraft in the water. He received a DIA flight manual written by Collar which described the technique for landing and taking off from unpaved and short runways, as found in Central America. During Abbott's DIA employment he worked out of DIA offices in Denver, Charleston, and in 1978 the DIA facility at Addison Airport, north of Dallas. Abbott named other DIA pilots who, acting under DIA orders, flew drug flights from Central America to the United States. These pilots included Cesar Rodriguez, Daniel Miranda, and George Phillips. Abbott was ordered by the DIA to fly arms to numerous Central America locations. One of these flights, occurring in 1982, flew arms into a dirt strip near Bluefields, Nicaragua for the Mosquito Indians. From there, Abbott flew to a strip known as B2E, where drugs were loaded for the return flight to the United States. Some of these flights landed at a small airfield near Memphis, Tennessee. These flights were profitable for everyone involved, including the pilots. In addition to being paid in cash for each flight, pilots flying for the DIA were given part of the drug loads, which they later sold. Abbott received $60,000 and 50 pounds of pot for this flight to the Mosquito Indians and return with drugs. 379. Abbott described flying drug loads out of small landing strips in Nicaragua, Antigua, Honduras, Costa Rica, Salvador, Guatemala, Belize, and Mexico. He arranged for fuel supplies and ground facilities at these locations, and regularly bribed local politicians to cooperate and protect the arms and drug flights. Abbott's fluency was helpful in these activities. In addition to English, he spoke several languages, including Spanish, Swedish, Norwegian, and Danish. During his DIA-associated activities he circulated in prominent Central America society, socializing with well-known political figures, including Alfredo Stroessner in Paraguay. Abbott described a Bolivian 707 that regularly hauled drugs into Panama with the D's knowledge. When Abbott asked his DIA handlers about it, they told him to forget it. These flights were hazardous in many ways. Abbott described DIA pilots flying arms to the M19 group in Colombia, during which some of the pilots were assassinated. TT was like Grand Central Station at some airstrips in Belize and Nicaragua, was how Abbott described the frequency of drug flights arriving and departing. Abbott told how he and other DIA personnel flew to Santa Cruz, Bolivia, in a Convair 340 to set a trap for the son of the Israeli ambassador, Sam Weiskel, involving a large shipment of cocaine to the United States. When the drug bust occurred, several people were killed. The DIA seized the drugs and then reshipped them as if they were DIA loads. Weiskel escaped the drug bust, but was later captured. However, he was soon released when Israel complained. Shades of Inslaw. Abbott told me about a flight to Panama with DIA agent George Phillips. 423 While stopped for fuel at Belize, Phillips opened an aluminum suitcase that held rolls of tapes and discs marked Inslaw. Phillips told Abbott that the tapes were money records of a fake company used by a group of drug dealers. This software, called Promise, was initially stolen from the Inslaw company by Justice Department officials, who then sold the computer program to foreign governments and to drug cartels. Peril of knowing too much. On a flight to Cancun, Mexico, in June 1983, Abbott was seized by DIA agents acting with Mexican police. While in jail he was interrogated by DIA agents Richard Braziel, Tory Schutz, Jerry Carter, and Assistant U.S. Attorney John Murphy. When Abbott wouldn't answer the questions, Mexican police, under Braziel's request, severely beat Abbott. U.S. agents then transported Abbott to a county jail in San Antonio, Texas, where he was visited by CIA agents who assured him that he would be released shortly. Instead, Abbott was sentenced to 8 years in prison by Judge Shannon. DIA agent Richard Braziel then told Abbott the sentence was only for show, and that they would get him released if he did not say anything about the DIA and CIA drug operations. Abbott was eventually released. After his release on probation, Abbott tried to obtain media interest in DIA drug trafficking, including The Larry King Show. He had no more success than I had during 30 years of attempting to expose the escalating government corruption, including 10 years of reports to Larry King. Abbott even tried to give his evidence to Manuel Noriega's attorneys to show how Noriega was simply a part of the CIA, DIA, and Mossad drug trafficking into the United States. One source did respond to Abbott's publicity efforts, the DIA, FBI, and Department of Justice. They fabricated a reason for arresting Abbott while on probation, stating that he had left the geographical limits of his parole at Dallas by flying a private plane to nearby Austin. Upon readying his plane for the return flight to Dallas, DIA agents arrested him, charging him with violating parole conditions. During his parole revocation hearing, Abbott said that he had called his parole officer by phone and advised him of his trip to Austin, and had received permission to do so. Abbott was arrested at the Austin, Texas airport by Texas Department of Public Safety agent Robert Nestoroff, and falsely charged with drug smuggling, even though there was no evidence to support this charge. Abbott felt that Nestoroff sought to have him put in prison because Abbott had knowledge of Nestoroff's drug activities and had previous contact with Nestoroff. After the hearing, the parole officer rendered a decision stating that he had not proven that he was not dealing in drugs. Abbott was expected to prove a negative, when there was no evidence that he had been involved. Abbott started contacting me after the second arrest, and in dozens of detailed letters and over 100 hours of questioning by phone, divulged a great amount of information about the CIA and DIA involvement in drugs. This information coincided with what I had learned from many other sources. Dangerous to expose government corruption. Abbott described his frequent contacts with the DIA's Central America Bureau Chief, Sante Berrio, and how the DIA silenced Berrio to keep the CIA and DIA drug smuggling operations from the public. Berrio was the DIA chief pilot for Central and South American affairs, and for some reason high-level DIA officials wanted him out of the way. DIA and Justice Department attorneys charged Berrio with federal drug offenses, causing his imprisonment. When brought before U.S. District Judge Fred Shannon in San Antonio, Berrio tried to describe his DIA duties and the DIA and CIA drug trafficking, but Justice Department attorneys and the judge blocked him from proceeding. After being returned to his jail cell, a prison guard gave Berrio a strychnine-laced peanut butter sandwich, causing immediate painful convulsions and subsequent death. The official autopsy report covered up for this murder, reporting that Berrio died of asphyxiation. Keeping quiet after Berrio's death. After Abbott was first arrested and pled guilty to the charges against him, District Judge Shannon asked him why he pled guilty rather than trying to defend himself. Abbott replied that he didn't want to end up dead like DIA pilot Sante Berrio. 381. Assassinating Abbott's wife. Abbott described acquiring a common-law wife in Norway who later bore their child. She moved to the United States and started an import business bringing sweaters into the United States from Norway and Iceland. Abbott feared for the safety of his wife and daughter after the DIA targeted him, and he sent them back to Sweden. After he was arrested and in federal prison at Bastrup, his wife in Sweden tried to get media attention on the DIA drug trafficking by talking to newspapers in Germany, hoping that this attention would force the DIA and Justice Department to release Abbott. Instead, she joined the long list of those who posed a threat to U.S. officials and their criminal activities. She was assassinated. Abbott's grief over his wife's assassination, and the constant attempts by government agents to silence him, made him determined to expose the corruption in the DIA, CIA, and Justice Department. He sent me many letters describing in great detail the DIA and CIA drug operations, including maps of landing sites, people he contacted, and the names of other DIA pilots. Abbott was released from prison on November 14, 1994, and became one of several former prisoners who credit my letters, along with a copy of the second edition of Defrauding America, with bringing about their release. Operation Buyback. Abbott told of an operation, which CIAONI agent Gunther Russbacher enlarged upon, involving smuggling drugs in frozen shrimp, using a CIA front company, Pacific Seafood Transportation Company. Russbacher and other CIA operatives confirmed the drug trafficking by Pacific Seafood. Russbacher said that shrimp containers were filled with ice and everything but shrimp. He said it was part of a joint DIA-CIA operation called Operation Buyback. Abbott described many of the people with whom he came in contact, who were also heavily involved in drug-related activities. He described his close contacts with Eric Arturo Del Valle, a member of Panama's Jewish community, and who was the president of Panama. Arturo's family was in the sugar export business, which Abbott said was also a subterfuge for cocaine exports to the United States by the Mossad. Abbott described the relationship between the major Bolivian drug traffickers, Sonia and Walter Atala, and the Roberto Suarez cocaine gang and the CIA. The Atalas leased a Boeing 727 in 1980 and 1981, painted the name Lloyd Aero Boliviano on the side, and used it to haul cocaine into Tocumen Airport from Bolivia and Paraguay. At Tocumen Airport the cocaine was offloaded to a warehouse owned by the Atalas, which was a front for exporting Hitachi radios and television sets back to Bolivia and Paraguay. From Tocumen Airport the cocaine was loaded onto small planes, or onto Taka Airlines, flying to the United States. Every morning at 6 a.m. Taka departed Tocumen for El Salvador, Belize, Costa Rica, Nicaragua, and eventually to New Orleans, Miami, and Houston. Cocaine was offloaded at one or all of these stops in the United States. 382. The cocaine would sometimes be driven from Attila's warehouse at Tocumen to the Free Trade Zone, placed into another of Attila's front companies, and eventually put on ships going to the United States. Abbott described the frequent presence of Manuel Noriega at CIA and DEA drug transshipment points. He said that Noriega's CIA code name was Nelson. Belize as a major drug transshipment point. Abbott described the enormous drug trafficking occurring in Belize, and how that country was used by the CIA for training Contras, similar to what was occurring in Arkansas at Mena and Nella. Abbott described Operation Bushmaster in Belize, which was intended to take over the drug business from the many independent drug smugglers, being taken over by the CIA for greater profit and greater security. Busting independent drug traffickers was one of the joint CIA Justice Department tactics to control the drug business into the United States. So powerful was the CIA that it literally took over the government of Belize. Abbott frequently delivered arms that he had picked up in Louisiana, Texas, and Arkansas to Belize, among other destinations. These consisted of AR-15s, M16s, ammunition, M1s, grenades, machine guns. He described the shipments of anhydrous diethyl ether into Belize for a cocaine processing lab on Mischer's land, where there was a Minute Maid orange plantation. He described a cocaine processing lab north of Cuatro Ciénegas, Mexico, in the state of Chihuahua. Abbott stated that Robert Corson and he helped set up the lab, after which DEA agents arrested Abbott. Abbott stated that from that CIA lab the cocaine was transported by land, and sometimes by air, to the Strip at Lajitas in West Texas, on land controlled by Walt Mischer. From there it was then flown to other parts of the United States. The Arkansas connection. One of the Arkansas airstrips into which Abbott was directed to deliver the drugs was south of Interstate 30, just southwest of Memphis, Tennessee, called Marianna. Several of my other deep cover contacts described that same airport to me, and the role played by state police in protecting the drug and arms operations. Abbott described how Arkansas State Police blocked off the roads leading to small airstrips when drug flights arrived. He described one such instance occurring in the spring of 1982. Abbott flew a Cessna 210 containing 300 kilos of cocaine from one of several warehouses at Tocumen owned by drug traffickers Walter and Sonia Attila, to the Crop Duster landing strip at Marianna, Arkansas. He made a fuel stop in Belize, famous for transition of drug-loaded aircraft, and then proceeded to his Marianna destination. A Memphis-based DEA agent took the cocaine from Abbott, while an Arkansas state trooper blocked the road leading to the landing strip. A week later, Abbott took off from that strip with 6 suitcases of money, delivering the money to Cesar Rodriguez at Isla Contadora. Abbott said the plane was provided by Robert Corson through Jim Bath of Houston. Further confirmation of CIA DEA theft of planes. Abbott described the CIA stealing of general aviation planes within the United States for use in the CIA unlawful arms and 383 drug shipments, which coincided with what several of my CIA contacts had stated to me for the past few years, and as described by former CIA asset Terry Reid in his book, Compromised. Some of the stolen planes were registered in the company name of Pacific Seafood Transport. The stolen aircraft were repainted and new serial numbers applied, after which they were flown to Central and South America with loads of arms, and then drugs on the return flights. Mexican airliners and drugs. It was in the early 1990s that Abbott described to me how he arranged for the unloading of drugs from Mexican airliners in the Mexican desert. At the time this sounded rather bizarre, but his detailed description of the events over a period of several years convinced me that he was telling the truth. Further, an article in the New York Times was headlined, "Drug Plane Unloaded in Mexico, Maybe by Police." The article described a Caravel passenger jet being landed on a dry lake bed near Todos Santos, Mexico. The Caravel was a French-built airliner that was flown by United Airlines during the 1960s. Normally this operation would have gone unreported, as many others had occurred. But this drug operation was reported because of the unusual events surrounding its occurrence. The aircraft's nose wheel was damaged upon landing, preventing a subsequent takeoff. The article described how heavily armed federal police immediately proceeded to unload the plane after it landed, and then proceeded to dismantle and destroy the aircraft. All identifying documents and avionics equipment were removed from the plane, the wings cut off, and an attempt made to blow up the plane. A large hole was bulldozed in the ground and the plane was buried. Complications developed while the plane was being destroyed. The state police commander and several deputies arrived to investigate, and were confronted in a tense standoff with the federal police, who advised that the Army had been notified and the situation was under control. The 30 federal policemen involved in the drug operation were suddenly transferred and unavailable for questioning by the federal prosecutor in the Baja California jurisdiction. Making reference to the use of large jets in similar situations, Mexican Foreign Minister José Angel Gurria said in a recent interview that drug traffickers had stopped using large passenger jets. This is doubtful. High-level involvement. Putting together the many reports from my contacts in the CIA, DEA, and high-level drug traffickers, Mexican officials at every level are heavily involved in drug trafficking that is funded by drug users in the United States. This high-level involvement became obvious in late 1995 when newspaper articles published stories about the tens of millions of dollars hidden by present and former Mexican officials in Mexican and foreign banks. Reports had surfaced that Mexico's president, Escobedo Zedillo, had received huge financial and other donations from the drug cartels, and that the brother of former President Carlos Salinas de Gortari had over $84 million hidden in Swiss bank accounts, plus unknown. 384 sums in other banks. 424 Swiss police arrested Raúl Salinas' wife, Paulina Castañón, when she and her brother tried to withdraw some of the drug funds that he had hidden in Swiss bank accounts. Mexican police had arrested Raúl Salinas for allegedly masterminding the September 1994 murder of a top official in the ruling political party, José Francisco Ruiz Massieu, and could not get to the funds. His wife and her brother used forged documents to withdraw the funds, and were subsequently arrested by Swiss authorities, who stated that the funds were associated with drug-related activities. CIA cable analyst in Lati 1993, made contact with another deep-cover CIA operative and State Department employee, Michael Maholi, whose primary duty was monitoring cable traffic at different CIA locations. Maholi started giving me information and a different slant on the role of federal officials in drug trafficking from Central and South America into the United States. As with most of my other contacts, these factual conversations continued for years. Maholi was liaison officer for the U.S. Embassy in Panama and worked for the U.S. State Department and CIA for over 2 decades. Maholi wrote in one of his letters about his role at the U.S. Embassy. He have spent time in South American countries providing photos, documents, maps, and all intel for the U.S. embassies in Central and South America. I first became acquainted with Agent Hunt in 1985 in Panama, where I was the liaison officer for the U.S. Embassy. He was always accompanied by North and his team. This went on for several years. I recall reading Cable Traffic where his name came up repeatedly. Maholi detailed the drug trafficking involving the CIA and the State Department. Hunt was on several covert missions and detached to Operation Whale Watch, which involved me buying drugs from Colombians and trading them for arms and ammo. My part in the operation was to provide a cover or front through the use of offshore oil rigs, so that Hunt, myself, and others, could complete these transactions. These offshore oil rigs were all CIA Offshore Geological Survey and Logistics Services. Other letters followed, and included considerable. During my contacts with William Casey, I was drafted into the Southern Zone so that we could start operations on spying on Panama, Colombia, and other countries that were making huge amounts of money from drugs. They needed weapons and firepower. We, the CIA, provided them. They in turn sold us drugs, many instances of cover-up conspiracies that continue to multiply as we are talking. On one tour to South America I worked on a CIA-owned oil rig operated by a company called Rowan International, based in Houston, Texas. Rowan is a worldwide drilling exploration company with very friendly liaisons in Central America and South America, as well as Africa and Middle. 424 Dallas Morning News, November 25, 1995. 385. East. Wiley and Balboa Harbor off the coast of Panama, on THIRD Rowan Houston, at approximately 2 a.m., a helicopter landed on the heliport. I was monitoring cables and traffic when our radar detected a small support group which turned out to be patrol boats, 4 in all. At this point I thought the rig was going to be taken over by hostile forces. But instead I could not believe who was getting out of the chopper. It was Noriega and another man. I contacted the company man and he informed me that this meeting was not to be documented and to go back and resume the task of cable and traffic. I found out later that this man with Noriega was Michael Harari. I found out later that they were trying to raise money from CIA by selling drugs to plan the destruction of a hydroelectric power plant on the Orinoco River in Venezuela. Over a period of many months, Mayholi gave me details of CIA and Mossad drug trafficking. He named the companies owning the oil rigs off the coast of the United States, Central and South America, Nigeria, and Angola, Santa Fe, Zapata, and Rowan. He physically saw Evergreen International Airlines and Southern Air Transport hauling drugs, confirmed by cable traffic he handled. I had repeatedly heard from various investigators and CIA contacts that various divisions of the Zapata Corporation *25 such as Zapata Petroleum, Zapata Offshore, Zapata Cattle Company, were heavily involved in drug trafficking. The oil rigs were used to carry out the drug operations. Drugs would be offloaded from ships onto the drilling platforms and then taken into the nearby coastal areas in helicopters that were constantly carrying supplies and personnel. Mayholi confirmed that this practice existed, having learned about it from CIA cable traffic and his own observations while on the rigs. Mayholi told how he was transferred from his detachment in Greenland under Lt. General John W. Carpenter to USAK to Central America, where he learned about the CIA role in drug trafficking. He also became a standard expendable, as the CIA did to him what they do to most CIA-related assets dealing in drugs. When they learn too much about the operation and threaten an exposure, the CIA, working hand in hand with Justice Department prosecutors, charge the person with a drug offense for having carried out CIA orders. In another letter, Mayholi wrote in part, the real mission was to funnel weapons and money to the Nicaraguans, and also to bring illegal drugs into the United States. Being a CIA-funded mission, the rig had Naval SEAL teams diverted through its location. Rowan International was a cover for a branch of Zapata Oil. Zapata Oil and Exploration had many land-based operations in Central and South America as well as offshore rigs. We had access to military cryptographics such as the KW-135, the KL-16, KL-10, and the CW-4 to decode and sift out any cable traffic from transmissions from Guatemala, El Salvador, Costa Rica, and Panama. 386. Mayholi confirmed what other CIA sources had told me about the CIA drug trafficking through Pacific Seafood. He wrote, this company used a number of vessels to carry out covert missions to run weapons, drugs, and cash from country to country. Not only would their shrimp trawlers use the oil rigs for loading, unloading and refueling, and also to deliver large sums of money for aid to the Contras. The shrimpers would constantly converge on our rig to convert, store and transport all of the above. The crews were all seasoned paramilitary experts in their abilities to search and destroy, CIA-trained, and specialists in their fields. It was from one of the shrimp boat captains that I would come to meet Barry Seal's main right-wing contact from Morgan City, La. His name was Russell Hebert, and the name on his shrimp boat was Southern Crossing. This boat had state-of-the-art radar, high-tech navigation systems, extra fuel tanks, and a crew consisting only of special forces or SEALs. Mayholi wrote that he remembers Russell Bowen flying onto the rig and then flying 2 DIA agents to Colombia. I called Bowen, who lived in Winter Haven, Florida at the time, and asked him about this flight. Bowen confirmed that it was him. I said to Bowen that Mayholi mentioned having seen him at the oil rig, and Bowen then confirmed it, stating it was part of the operation that extracted CIA agent Sam Cummings from Costa Rica. Mossad's drug trafficking on CIA and Zapata oil platforms. Mayholi described the drugs that he had seen on the oil platforms operated by the CIA and Zapata Corporation 426, some with the Mossad Star of David triangles on them. In one letter he wrote, "A shrimp boat arrived with a load of cocaine with the markings of the Mossad's famous two triangles that resembled the Star of David." Mayholi described how the drug planes would fly low and proceed from the offshore oil rigs to the United States at very slow speeds of approximately 120 knots, so that they would appear on radar as helicopters servicing the rigs. Bringing the famous Ochoa drug family into the picture, Mayholi described how the Ochoa drug cartel used the coastal oil rigs for drug transshipments. Mayholi described the role of a Venezuelan naval officer by the name of Lizardo Marquez Perez, who was in charge of this drug operation, and frequently seen on the oil rigs by Mayholi. Mayholi described the cover-up of the drug operation by such people as the chief of the DEA cocaine operations in Washington, Ron Caffery, Oliver North, CIA official Dwayne Claridge, Army Lieutenant General Paul Gorman, and others. Excerpts from some of Mayholi's letters. "A person I've met on several occasions was in the Colombia cartel, Carlos Leder. During Operation Backdoor he and several of his soldiers were planning to use CIA oil rigs and the shrimp industries to import drugs. 426 Zapata Corporation was headquartered in Houston, Texas. Acts. Into America. Carlos had DEA personnel assigned to work with him. I myself have been to his home on Norman's Cay in the Bahamas. He had a stash of drugs shipped back and forth to Everglades City in the 10,000 Islands area of southern Florida. When the rig Rowan Midland was in Venezuela, Carlos had a regular agent of his as a tool pusher to oversee all shipments coming and going. The CIA would buy drugs and supply friends of the Colombian government with money and weapons. Operation Backdoor, they used the remote mangrove swamps to unload huge loads of pot and cocaine to get it to Miami to distribute. With help from CIA and DEA agents, Carlos would set up a few loads as decoy to make it look good so he could get major shipments into the United States. Operation Backdoor had a priority of grave importance. I was to monitor some of the cable and equipment, also scramble transmissions made from his boats and planes, so he could go undetected. Also to make sure his money could be on the rig when he wanted it. Carlos got to be mouthy. The government set him up and double-crossed him. The rig was then moved to Aruba and once again set up as a relay station and command center. The M19 group was also involved in several covert missions. Members of their right-wing force were actually flown and boated to Florida to recruit forces and promote a revolution in the U.S. and an invasion of drugs to southern Florida. Operation Backdoor simply meant the drugs would come to America via the back door. The role of the Venezuelans in CIA-related drug trafficking was revealed in the 60 Minutes show on November 21, 1993. Mayholi described his dealings with drug trafficker Barry Seal. Mayholi said that Seal was involved with the Noriega cartel in a top-secret operation. Seal's Miami contact was a person using the name of Lito. Mayholi described how Seal had a fleet of aircraft hauling drugs that flew mostly at night with the pilots using night vision goggles. They flew through airspace windows when the military radar would ignore the targets. As the planes approached the oil rigs off the coast of the United States, the planes flew close to the water, avoiding radar detection. Mayholi wrote that Seal was paid large amounts of money by CIA contacts, and that in 1982 and 1983 Seal brought in more than 5,000 kilos of cocaine, grossing over $25 million. Mayholi elaborated upon his role in Operation Screamer, which was a mammoth sting operation aimed at penetrating the network of mercenary pilots that were flying drugs in competition with the CIA. On this operation Mayholi worked under DEA agent in charge Randy Beasley. Mayholi told how Seal offered to turn informant, allegedly implicating high federal officials, including former Watergate prosecutor Richard Benveniste. Mayholi stated that this made Beasley and others uneasy. Why? Because they themselves were dirty. Mayholi said that SEAL had an informant number, SG1-84-0028. That number, or the initial CI, would be substituted for SEAL's name on all reports in his case file. National Security Agency. Central Security Service. Fort John-Go, Meek, Maryland 22739U000. Capt. Scott A. Beale, January 10, 1994. CIA. Station Chief. United States Embassy. San Jose, Costa Rica. Re. Agent Classification Confidential. Dear Capt. Beale. Due to the highly sensitive nature of classified agency documents that have been requested, appropriated measures have been taken by our Special Operations Division Advisor at NS.A Headquarters, Fort Meade, Maryland, to acknowledge verification and existence of 0.N.I. Special Operations Division Officer, Michael Mayholi. His significant involvement and cooperation relevant to deep cover covered CI.A, ONI, and D.FA intelligence operations conducted in conjunction with U.S. Naval SEAL Teams 2, and ITI, Delta Force Units 7 and 9, and USMC. Recon detachments deployed to both South and Central American countries, consist of monitoring cable transmissions and as an observer of ongoing missions. Agent Mayholi was considered on active status from 1976 to 1988. Mayholi had assigned surveillance command units in Veracruz, Mexico, Puerto Barrios, Guatemala, Managua, Nicaragua, Sanada, Ana, El Salvador, Tegucigalpa, Honduras, San Jose, Costa Rica, Panama, Cartagena, Colombia, and Caracas, Venezuela. Be advised that a substantial accumulation of classified and top-secret documents pertaining to Agent Mayholi's assistance to the deployment and recovery of the above-mentioned personnel covered operatives, combined with the tracking of hostile troop logistic positions and movement, have been turned over to ONI and CIA authorities at Langley Command Center. The Office of Strategic Services has and is conducting a current review and trace of documents still existing, and of those that may have been destroyed under presidential directive status, and will forward the results of their investigation to your liaison officer in San Jose, Costa Rica ASAP. Operation Whale Watch. Operation Whale Watch was one of the CIA's drug trafficking operations using CIA-affiliated oil rigs off the coast of the United States and Central and South America. Mayholi described how 2 oil rigs were deliberately sabotaged when security was breached and the crews on the rig learned about the drug trafficking and voiced their displeasure. Mayholi wrote, "I have information on offshore activities involving the sabotage of 2 more drilling rigs involving the deaths of more than 82 persons. One off the coast of the Yucatan Peninsula in Mexico, and the other off of the coast of Newfoundland. Both rigs were CIA-owned and operated. Due to leaks in security, they were destroyed by our own government officials. Ranger I was ASME submergible deep water drilling rig off the coast of Halifax, Newfoundland, operated by the sister company of Exxon Oil, Shamrock Drilling of Ireland. The Shamrock Company was funneling money through Ranger I to Canada and was detected by a breach in security. Thus, they picked a winter storm as a perfect cover to flood the computerized ballast systems, triggering the rig to list to the port side and sink to the bottom of the North Atlantic. This took place in February 1989 at 3 a.m. in the morning. All 42 hands lost. No bodies recovered. Then there was Operation Odessa. This was a jack-up offshore drilling rig that was stationed off the coast of Nicaragua and had to be moved due to civil unrest in that nation. This was a prime rig where command officers of the CIA had communication offices. I've spent many days and nights reading cable traffic and monitoring daily activities. This rig was a mothership for distribution of drugs, weapons, and money for all parties concerned. The rig moved north because of hostile government takeover. 5 days after entering Mexican waters, the rig was blown up. This involved Hunt and his strike team. This information was intercepted during a non-routine check of all COMSAC radio transmissions. I believe the reason was that the Mexican government was paid huge sums of money for the cover-up. Reasons released to the media were offshore oil platform explodes, all 46 aboard dead. Over a period of time Mayholi furnished me with additional information that made clear the CIA's involvement in drug trafficking into the United States, the details of the operations, the Mossad involvement, and other areas of CIA corrupt activities. I received documents and letters showing Mayholi's CIA status. A letter written by the Israeli embassy in Washington dated October 20, 1993, made reference to the CIA Mossad drug operation, Operation Whale Watch, stating in part, these agents include CIA intelligence officers Michael Mayholi, Dwayne Claridge, Stephen Tucker, along with 2 National Security Council officers, Lt. Col. Oliver North and Lt. Robert Hunt Michael Harari. A letter dated October 25, 1993, sent by the National Security Agency identified Operation Whale Watch, confirmed my contacts as being part of the 427 Hunt was reportedly a part of Navy SEAL Team 6 and 2. More about Hunt in later pages. 390. Operation and with the CIA. The letter stated in part, Operative Special Agent in Charge Michael Mayholi, CIA, due to the sensitive nature of Operation Whale Watch we cannot authorize any further information on this top-secret mission. Cross-check on names of drug smugglers involved in Operation New Wave. CIA operative Robert Hunt described what he knew of the drug trafficking. He recited a list of people involved in Operation New Wave, the heroin operation described to me by Gunther Russbacher. The names given by Hunt included almost all the names Russbacher had listed, including David Fuller, Patrick O'Reilly, Michael Cobb, John Woodruff, Brett Sanderson, and Prekala Monty Major. He named Mossad agents, including Robert Silberman, Simon Goldblatt, Ariel Cold-Ehrman, Delilah Kaufman, and David Turner. Hunt said Goldblatt was a field supervisor assisted by Marta Bleiblatt. The large number of Mossad agents working with the San Francisco CIA office surprised Hunt. Enlargement on earlier discoveries. The large number of CIA and DIA sources and private investigators that contacted me made it possible to enlarge upon what earlier sources had described, and provided further corroboration of the information provided. Russbacher enlarged upon Operation Indigo, which Parker had told me and which was described in Parker's court filings. Point 48. Referring to Operation Indigo, he said that the full name was Operation Indigo Sky, and confirmed that it had been in operation since approximately 1976. Russbacher said that the operation consists of producing heroin in poppy fields in Nigeria and processing in the capital city of Lagos, along with transportation to Europe and the United States. Russbacher stated that the intent of Operation Indigo Sky was to get an alternate source of supply for heroin coming from the Golden Triangle area and the Indian subcontinent. The operation began with the 1976 purchase of the Star Brewery in Lagos and its subsequent multi-million-dollar upgrade into a heroin processing facility. The brewery's name was changed to Star of Nigeria and then to Red Star. The transportation of the drugs from Lagos was initially by the CIA and DIA and then changed to contract operators. Most of the processed drugs in Operation Indigo Sky went from Lagos to Amsterdam, where it was further packaged and then shipped to European and United States destinations. Russbacher described the different ways the drugs are shipped into the United States, including being shipped in sealed containers leased from Philips Electronics and other companies. He described ways of circumventing customs inspections in the United States and those incidents in which customs and the DIA protected the drug shipments. He described the swapping of sealed containers at bonded warehouses in Hoboken, New Jersey and other locations, and the secret unloading of drugs at airfields throughout the United States, including Boeing Field in Seattle. Further confirmation of customs involvement in drug trafficking. Further support for the DIA and CIA informants who reported drug trafficking activities by U.S. Customs agents was provided by an Associated Press story on May 3, 1993. The article described an 8-volume file prepared in December 1990 that disappeared from a final Washington report in 1991. The missing files described Customs Service drug smuggling and reported a pattern of drug trafficking by customs inspectors. This report was sent to Washington and then removed from government files. Most newspapers refused to print the AP story, but I found it in the Oakland Tribune. Largest heroin seizure in U.S. history. Another CIA drug operation. Much of what is written in the media is not what it seems. In May 1991, federal agents seized over 1,000 pounds of heroin in an Oakland, California warehouse, the largest heroin seizure in the nation's history. Due to the compartmentalization common to intelligence agencies, the arresting agents were unaware that they interrupted a large-scale drug smuggling operation involving the CIA and other government agencies. 5 people were charged with importing heroin, possession with intent to distribute heroin, and conspiracy. A subtitle to a San Francisco Examiner article describing the case stated that it was the largest ever seizure. Over 1,000 pounds of high-grade China white heroin was smuggled into the port of Oakland from Taiwan. The 1991 seizure of the largest quantity of China white heroin involved the arrest of 2 families from Thailand, living in Danville, California. The case was assigned to Judge Vaughn Walker *9, the same judge that was handling the contempt of court case filed against me for having sought to report the criminality that I had uncovered. His actions, and those of the Justice Department attorneys, showed evidence of covering up the drug operation that involved covert government agencies. Apparently, they learned that the drug seizure involved an ongoing CIA drug smuggling operation, and they now had to keep the lid on the drug seizure and avoid a publicity-generating trial. Standard practice of Judicial and Justice Department obstruction of justice. Despite this being the biggest heroin seizure in the nation's history, Justice Department prosecutors and District Judge Vaughn Walker approved a lenient sentence for most of the defendants. Through a plea agreement reached in July 1993, the defendants pled guilty in exchange for probation or a short prison sentence. Several of the defendants pled guilty to knowing a federal crime had been committed and failing to promptly report it to federal authorities. This offense violated Federal Criminal Statute Title 18 U.S.C. Section 4. This plea agreement with its lenient terms eliminated a trial that could have exposed high-level government connections to the heroin operation. Ironic contradiction. Judge Walker was approving the charge of misprision of a felony against several of the drug trafficking participants for failure to report the federal crimes. At the time he was holding me under virtual house arrest since December 1990, while I waited for a trial on a criminal contempt of court charge for having sought 429 USA vs. Chen, ETAL, CR 91-2096 VRW. 2. To report the federal crimes I had discovered, including the CIA and Justice Department involvement in the drug trafficking. U.S. District Judge Marilyn Patel had me arrested in November 1990 on criminal contempt of court charges in retaliation for reporting to a federal judge what I was required to report under Federal Criminal Statute Title 18 U.S.C. Section 4. Under that statute, it is a federal crime for any person, knowing of a federal crime, not to immediately report it to a federal judge or other federal tribunal. I responded to that obligation by filing my charges with the court. It was ironic. I was charged with criminal contempt of court for complying with that statute, while Justice Department prosecutors and Judge Walker were charging the participants in the nation's largest heroin smuggling operation with misprision of a felony for not reporting the criminal activities. Aware of the involvement of federal personnel in drug trafficking into the United States, and suspecting this heroin case might be another government-funded drug operation, I asked Russ Bacher if he knew anything about it, and he admitted that he did. During the late 1980s, Russ Bacher had been assigned by the CIA to coordinate government-related drug trafficking through the West Coast. This involved monitoring and protecting the drug operations coming into the states of California, Oregon, and Nevada. He gave me details about the operation that he would not know unless he was involved in its operation. Even though he was in prison when I asked, Russ Bacher was in frequent touch with CIA personnel and kept up to date on covert activities. Operation New Wave. Russ Bacher first told me about the operation on August 23, 1993. He said that it was a major heroin trafficking operation into the United States, and that the code name for the parent operation was Operation New Wave. A part of that operation was called Operation Backlash. Russbacher stated that the operation, sanctioned on September 21, 1987, originated in San Francisco, and operated out of the offices of Levi International Imports Pier 51. He then gave me the names of many key participants in the operation. He said that key personnel from the CIA included David Fuller from Los Angeles, John Beardsley from Mississippi, and Patrick O'Reilly from New York City. He said that those involved from the U.S. Department of Justice included Russ Taylor out of Lincoln, Nebraska, Saul Tratafiore out of Williamsport, and Sandy Weingarten out of St. Louis. Russbacher stated that they were all attorneys, and, he believed, also assistant U.S. attorneys. Drug Enforcement Administration participants in the drug operation, according to Russbacher, included Michael Cobb out of Orlando, Florida and John David Pigg out of Oklahoma City. Pigg was killed in July 1993 in Anadarko, Oklahoma, reportedly for expressing disenchantment with the operation. Russbacher described Navy Task Force liaison personnel as himself, using his Navy alias of Robert Andrew Walker, John A. Woodruff, and Oswald L. E. Winter. Referring to customs, Russbacher identified key participants as David Cohen out of the El Paso office, Precilla Monte Major out of the San Francisco office. Tollin Weber, also out of the San Francisco office, Brett Sanderson out of the Seattle office. Naming Mossad agents during a telephone conversation on September 6, 1993, Russbacher gave me the names of the Mossad personnel implicated in this drug trafficking operation who handled drug distribution in the San Francisco area. First name is Robert Silberman, out of Chicago. Second name is Marta Bleiblatt, also out of Chicago. Third name, Simon, last name Goldblatt, he is out of Haifa and attached to New York. Fourth name, Ariel Cold-Erman, San Francisco. Fifth one is Kazam Merchant, out of Los Angeles. Sixth one is David Turner, San Jose. Silberman and Bleiberg work for a company called Idico. Goldblatt is a field supervisor on Operation White Elephant. The next one, the last three, are attached to Operation Lemgolem. I told him that I would list their names in the next edition of Defrauding America, and he warned me about the viciousness of the Mossad and their killing of people in various countries whose statements or conduct displeased them. I have no use for the Mossad and the harm they've inflicted upon the United States, and I'll take my chances, was my reply. Implications of the Mossad's involvement: the repeated discovery that the intelligence agency of a foreign country, Israel, was heavily involved in several of the drug operations conducted against the American people by America's intelligence agencies was disturbing. Throughout my discoveries I learned of the involvement of Mossad agents in the smuggling of drugs into the United States and other crimes, including the October Surprise Scheme, the theft of the INSLAW software, and the looting of Chapter 11 assets. Examples of corruption given within these pages are only a fraction of what I discovered during 30 years of investigations, whether it be related to aviation fraud or any other segment of criminal activities. The involvement of the Mossad and Israeli personnel, including those who became American citizens, repeatedly came to my attention, and much of it has not been identified. Russbacher said that the intent of the operation was to bring heroin into the United States from the Far East using freighters, cruise line transports, and other international lines. The ships would bring heroin from Far East ports through Central America, sometimes through northern South America, and then into the United States. Some of the intermediate points included Acapulco, Mazatlan, Swantanago, Cabo San Lucas, and Ensenada. United States ports included San Diego, Los Angeles, San Francisco, and Seattle. At San Diego, a transshipment point, non-military vessels went to the federal port known as O1, District 00.01. In Los Angeles they used the Long Beach Basin. Also used were tankers, including the Greek tanker line Orion, which docked at Manhattan Beach, California. The oldest freighters would normally be Pan-American or Iberian registry. Drugs were also transshipped from Colombia, many times in ships of Norwegian registry, until 1989, and these were mostly cruise ships. Russbacher. 394. Elaborated on the method of packing drugs on ships. On the cruise liners it was generally in the freezers, brought on board inside carcasses of beef. Also in the flour bags, 100-pound bags. They are referred to as flour barrels. On other types of ships it was either stored in the paint lockers, or there was a separate compartment built. I asked, what is the remuneration or rewards for the different agencies that are involved in this operation? Russbacher stated that there is a split profit sharing where the profits are divided among various proprietaries or front companies used by the different agencies. The drug trafficking operation was coded as NW688-01B-NSC, and called Operation New Wave. One segment was named Operation Backlash and coded BL421D06. Russbacher said the operation was still active, but limited to DIA and Customs involvement. He said the CIA and Department of Justice dropped from active participation in March 1993, except for the criminal prosecutions in San Diego and San Francisco that had to be completed. I asked Russbacher why the Department of Justice filed those charges when the filings might expose involvement of Justice Department personnel. He said that the many individual fiefdoms in the CIA, Justice Department, and other agencies, and the compartmentalizing of information, result in charges being filed by a local office against a person or operation that may be sanctioned by high officials. Since the defendants in the San Francisco action were from Thailand, I asked Russbacher how that country fits into the operation. He said the drug shipper in Thailand was a CIA front called Vanderbergen International Shippers in Bangkok. They're the ones that are responsible for gathering out of Southeast Asia, he said. Russbacher said that Hong Kong was sought as a drug shipment point, but they couldn't get an agreement going with the British out of Hong Kong. The problem was, they wanted a higher percentile participation than our government was prepared to give. Instead of using Hong Kong, we used Macau. 80% of the morphine block, we are not talking about the liquid, comes out of Macau, before it becomes morphine sulfate. Many books have described the decades of British drug trafficking, originally through the British East India Tea Company, which still exists. Russbacher told me that there were large amounts of drugs being shipped from the Philippines in the operation. Russbacher described the role played by the Mossad in the drug trafficking into the United States in Operation New Wave and Operation Backlash. He said the Mossad's role was to guard the shipments until they reached the United States, adding that one of his Mossad contacts was Delilah Kaufman, a paralegal with an Italian law firm in the San Francisco Bay Area. In 1991, part of the operations were suspended due to increased awareness at the southern transshipment ports. More federal funds were allocated for DIA and Customs agents, causing smuggling by certain DIA and Customs factions to be compromised. Even though the drug trafficking involved personnel from almost every federal agency responsible to prevent such trafficking, the smuggling was compartmentalized. With the addition of new DIA and Customs agents, the danger of discovery increased. Federal judge receiving bribe money. Because of U.S. District Judge Vaughn Walker's extremely lenient sentences given to most of the Thai defendants charged with the largest known heroin shipment in the nation's history, I asked Russbacher, do you know where Judge Vaughn Walker fits into this operation? Russbacher replied, he is one of the people getting a payoff. Through Shamrock? I asked. Through Shamrock, yes. And you know this to be a fact? Did you see this on a printout, or did he simply tell you that? Rodney, I was very strong in this. I basically babysat the operation for about 4 months. I don't want to go into it. Did you have any conversations with Walker? I asked. No, I did not. But a woman by the name of Denise Stedman out of the San Francisco had numerous conversations with him. She is the one we used. After learning about this operation, and finding that another U.S. district judge reportedly received bribe money, it fit in with the information I received from other CIA personnel. It also fit in with what Russ Bacher had told me during the past several years. Judge Walker had me under virtual house arrest since December 10, 1990, while I awaited trial on contempt of court charges for having sought to report to a Chicago district court the criminal activities that I uncovered. That action sought to report the federal crimes in the Ninth Circuit bankruptcy courts, and sought relief from the judicial attacks upon me by Ninth Circuit judges. Now that I had information linking Walker to the CIA, DIA, Customs, and Justice Department drug operation, I decided to file another report with the courts under federal crime reporting statutes. Reference to Justice Department. Criminality in polite terms. In a classic understatement, Lamar Smith, chairman of the House Task Force on International Narcotics Control, said, "I personally am convinced that the Justice Department is against the best interests of the United States in terms of stopping drugs." Eastern Airline whistleblower. Another insider describing drug trafficking was a former Eastern Airlines captain, Gerald K. Loeb. He discovered a pattern of drug trafficking from Central and South America into the United States on EEL aircraft. Loeb saw dozens of instances, while he was pilot, of suspicious shipment of drugs into the United States and the shipment of drug money from Miami to Panama and Colombia. Eastern Airlines as drug-related conduit. Loeb frequently noticed, in departures from Miami for Central America, containers placed on board the aircraft, which followed a pattern of usually arriving at the last few minutes before departure. This was followed by same containers being offloaded in Panama or Colombia in the presence of armed 396 guards. The activity indicated drug and drug money trafficking. Loeb described how he gave detailed information of the drug trafficking to the Federal Bureau of Investigation, the Airline Pilots Association, to EEL President Frank Borman, and to Time magazine's Jonathan Beatty, all of whom kept the lid on the criminal activities. Dozens of times custom agents discovered drugs hidden behind aircraft inspection plates as the Eastern Airlines aircraft arrived in Miami. Eastern pilots were concerned over the drug trafficking, as they themselves could be charged with drug-related offenses. As ALPA chairman of legislative affairs for the Eastern Pilots Group in Miami, Loeb received many complaints from pilots about drugs being found on their aircraft as it arrived in Miami. Loeb testified to Congress that there were over 60 cases reported to him where this happened. FBI cover-up and their retaliation against crusaders and informants. Loeb developed a friendship with a young Eastern Airlines station agent in Panama City, Panama, who revealed to him that cocaine was being shipped on Eastern Airlines planes from Colombia and Panama into the United States. Loeb contacted a friend, Governor Thompson of New Hampshire, and described the massive drug smuggling and drug money shipments that he had discovered. The governor then contacted Justice Department officials, who arranged for Loeb and two other Eastern Airlines employees to give information to the FBI in Miami. Loeb identified these FBI agents as Special Agent in Charge F. Corliss, Assistant Special Agent William Perry, and Agent Rod Beverly. The Eastern Airlines employee from Panama was threatened by the FBI, warning that he himself would be charged with a federal crime if he reported the drug and drug money trafficking. Under federal criminal statutes, these threats constituted federal crimes. 43°. But when the criminal acts are perpetrated by the same agency responsible for prosecution, the system fails. Threat of prison. If they testified, FBI agents also contacted other witnesses that Loeb had said were willing to testify about the drug trafficking, including an Eastern Airlines flight attendant, a ground service agent, and others. Instead of taking information from these people, FBI agents threatened to file criminal charges against them. One of the charges the FBI agents threatened to file against them was misprision of felonies for not reporting the criminal activities earlier. This threat of prison caused the witnesses to remain silent, which is apparently what the FBI agents wanted. Some of these witnesses then blamed Loeb for what had happened, and then went undercover. The FBI traumatized witnesses to keep them from reporting the criminal acts involving federal personnel, and is a practice that I had seen for years. Loeb testified before numerous congressional committees, including Senator John Kerry's Subcommittee on Terrorism, Narcotics, and International Communications. Referring to the meeting in Miami with the FBI, Loeb. 430 Title 18 U.S.C. 1512, 1513. 397. Testified *3. That the FBI reported to Eastern Airlines President Frank Borman what Loeb and the other witnesses had said, and that the FBI said something had to be done to silence him and the other witnesses. Referring to his testimony, Loeb wrote in part, "The officials at Eastern Airlines and the corporate officers deemed to be outrageous conduct. Having learned from the FBI within hours of my giving that information, they hired 2 private detectives and was an ongoing scenario, particularly from Panama, the hub operation, and Colombia. Our crews were very aware that they were unwittingly being duped and flying cargo, as called, that was unlisted in their aircraft, unmanifested, into ports of call in the United States of America." Loeb testified that a private detective agency hired by Eastern Management, Intercontinental Detective Agency of Miami, offered bribes of $2,500 and $5,000 to people to discredit Loeb and the Airline Pilots Association, who was representing the pilots on whose plane drugs were found. Borman fired Loeb for being disloyal to the company, after which Loeb fought the dismissal. Eventually, Loeb took a financial settlement and left the airline. 2 weeks after Eastern fired Loeb, the airline fired another pilot, Ramon Valdez, who had hired an investigator to obtain additional evidence on the drug and drug money trafficking involving Eastern Airlines aircraft. Initially, many Eastern pilots wanted to testify about the drug trafficking and drug money laundering. But after they saw what happened to Loeb after he reported the activities to the FBI, they all suddenly developed amnesia. Cover-up by Eastern Airlines President Loeb told me that when he first reported the drug trafficking on Eastern Airlines aircraft to Eastern President, Frank Borman, that Borman told him to mind his own business. Instead of responding to the serious problem, Borman and other Eastern management proceeded to harass Loeb. Loeb reported the drug trafficking to the president of the Airline Pilots Association, Henry A. Duffy, and explained that over 24 Eastern Airlines pilots were actively involved in drug trafficking. The ALPA president reportedly told Loeb that drug trafficking was none of the union's business. I encountered a similar attitude when I brought to his attention major air safety irregularities that were playing a key role in a series of fatal airline crashes. Cover-up by Time magazine. Loeb described the details of the drug trafficking, the reaction of Eastern Airlines management and the FBI to the drug trafficking, to Times reporter Jonathan Beatty, and how Times management refused to publish the story. Time had covered up for many government criminal activities, including the October surprise, the air safety and criminal activities related to a series of airline crashes. That I brought to their attention, the CIA drug trafficking from Central America, the assassinations by CIA-trained assassination squads, and much more. Under federal criminal statutes, this conduct is called misprision of felonies. Blocking of testimony by Noriega's pilot. Loeb told how, during the criminal proceedings against Noriega, that Noriega's attorneys had told Loeb that they had audio and video tapes of Noriega and Bush, and would release the tapes if the charges were not dropped against Noriega. One of the attorneys asked Loeb to pass the information to the Justice Department prosecutors, warning that if the charges were not dropped, the tapes would be released. The judge refused to permit this type of testimony or evidence, thereby protecting the CIA and DIA involvement in drug trafficking that was a far greater offense than what was charged against Noriega. Judicial cover-up of serious federal crimes is common. I asked Loeb if the airlines that took over the Central and South America air traffic after Eastern Airlines went out of business became involved in the drug trafficking. He stated that American Airlines encountered similar problems. He also described how Braniff Airlines was heavily used by drug traffickers before that airline went out of business. The House Committee on Government Operations issued a report concerning hearings held in March 1992, related to misconduct by federal personnel. The report was entitled Serious Mismanagement and Misconduct in the Treasury Department, Customs Service, and Other Federal Agencies and the Adequacy of Efforts to Hold Agency Officials Accountable. The report stated in part, this is the third in a series of hearings looking into allegations of mismanagement and misconduct by the U.S. Customs Service. Witnesses have testified about attempts by both Customs and Internal Affairs to prevent investigations from going forward. These are serious allegations. This hearing focuses on the implementation of the Customs Reorganization Plan and the accountability of the Inspector General. But what is really at issue here is the overall effectiveness of counter-narcotics law enforcement efforts along the U.S. Mexico border. The credibility of the Customs Service is at stake. Allegations of improper associations between law enforcement agents and drug traffickers are bad enough, but the inability and unwillingness to properly investigate such allegations cause the public to lose faith in the ability of the United States government to fight the war on drugs. The report revealed that government officials sought to block the testimony of witnesses, showing the existence of obstruction of justice, which by itself is a crime. The criminal mindset behind these acts was never addressed. Included in the report was a letter to the committee signed by anonymous field agents of U.S. Customs, stating in part, "We are writing to you to advise you of the continuing systemic corruption at the U.S. Customs Service. The reorganization of the Office of Enforcement has only removed necessary checks and balances. Integrity is virtually a non-existent commodity in customs management." 399. Former DEA agent Michael Levine describes in The Big White Lie how the Drug Enforcement Administration destroyed evidence, resulting in high-level drug traffickers escaping prosecution. Testimony of Ramon Millian Rodriguez. Hundreds of people directly involved in drug trafficking and drug money laundering have testified in closed-door congressional hearings about the CIA, DEA, and Customs involvement in these activities. This revealing testimony rarely gets into the hearing records available to the public. Many of these witnesses sought to give evidence to various U.S. agencies about the drug trafficking and drug money laundering, and were blocked. On February 11, 1988, Ramon Millian Rodriguez, a major drug money launderer, testified in congressional hearings in 198-8432 that he had tried to blow the whistle years earlier on the drug trafficking and drug money laundering. Rodriguez testified that he also contacted members of Vice President George Bush's South Florida Task Force in 1983, including people that he knew as Sathas and Summerall, and was likewise rebuffed. Rodriguez testified, as did others, that insiders in government provided the Medellin and Cali cartels with information about the names and identification of DEA agents, the radio frequencies and the schedules of Coast Guard and Navy interdiction aircraft. Rodriguez described the huge amount of drug money shipped from the United States, and the logistic problems associated with moving large pallets of money out of the United States. He described the drug traffickers' use of Eastern and Braniff Airlines for shipment of drug money from the United States to Central and South America. The shipments were in containers or on pallets, and often loaded without any cargo manifest. In Panama and other Central and South American countries, the airliner would be met by armed guards, the drug money unloaded, and then taken to banks, such as Banco Nacional de Panama. Station agents and other airline employees working for Braniff or Eastern would be in the pay of the drug cartels or other drug traffickers. Rodriguez elaborated upon the complexities and sophistication involved in drug money laundering, requiring expertise in accounting, banking, logistics, security, bank secrecy laws, and the mechanics of incorporating. Dummy corporations would be set up, and the money transferred from one corporation to another to mask the money path. Cutouts would be used to separate high-level personnel from the source of the drugs or drug money. A series of accounts would be set up with dummy corporations through which the drug money would be processed. These dummy corporations would be filed with the Secretary of State of various states in the United States, especially Florida, California, and New York. Some legitimate businesses were used to front for the drug money laundering. Dummy corporations were also set up in the country where the destination banks were located. A Panamanian corporation could be used as a cutout for a Swiss, Liechtenstein, Luxembourg, or Hong Kong company. Another tactic was to make a Panamanian company. 432 hearings before the Subcommittee on Terrorism, Narcotics, and International Communications, February 11, 1988. 400. A stockholder of a Netherlands Antilles company. Rodriguez testified that his money laundering out of the United States amounted to approximately $200 million per month, or over $2 billion a year. This huge amount was just for his operation, and primarily for drug activities in New York and Chicago. Rodriguez also testified that he had as many as 50 aircraft flying the money out of the United States, including Boeing 727s. Rodriguez was on the board of directors of several banks, including Ponce de Leon Savings and Loan in Miami. He identified some of the countries favored for money laundering as Switzerland, Hong Kong, Panama, Curacao, Cayman Islands, and the Bahamas. Asked what happens to the drug money laundered from the United States into foreign banks, Rodriguez replied that it would be invested in real estate, stocks, bonds, CDs, and other financial investments within the United States. Cooperation of U.S. bankers in massive drug money laundering. Rodriguez testified that many U.S. banks cooperated in his money laundering, and that they often had a special representative who dealt with drug money launderers. He identified the banks routinely and knowingly dealing in drug money as Citibank, Citicorp, Bank of America, First National Bank of Boston. He testified that there was competition among U.S. banks to receive the drug money. Describing the power of the drug cartels in Colombia, Rodriguez testified that the cartels owned airlines, soccer teams, radio and TV stations, newspapers, and politicians. Rodriguez described how Colombia's M19 kidnapped one of the Ochoa women, how the individual drug traffickers merged into a group, and formed its own army of 2,000 people. This testimony coincided with what other CIA assets had stated to me, including Gunther Russbacher, Trenton Parker, Russell Bowen, and others. Rodriguez testified that drug proceeds were used to fund the Contra fighting, a fact that is well known to everyone except the American public. Companies used in drug trafficking and drug money laundering. Rodriguez described some of the companies used in drug-related activities. One was Frigorificos de Punta Arenas, a shrimp warehouse used as a front with a chain of interlocking companies, including Ocean Hunter. Ocean Hunter imported shrimp into the United States and hid drugs inside the shipments. The company was also used to launder money to the Contras. Despite the drug-related activities of Frigorificos, the Reagan-Bush administration awarded lucrative contracts to that company to provide humanitarian assistance funds from the State Department. Rodriguez testified that the CIA was involved in the weapons shipments and drug money laundering with his various companies. Senator John F. Kerry made reference to the repeated denials by White House and National Security Council officials about U.S. arms shipments to Iran and the Contras, while the arms shipments were continuing to occur. During testimony by various witnesses, whenever a witness was about to name a U.S. politician or the CIA involvement in the drug trafficking, Kerry interrupted the witness and said this. 401. Would be discussed in executive or closed-door session. The American public never heard of the criminal activities by high-level government officials and various government agencies. Senate testimony by Noriega's pilot, Floyd Carlton. Manuel Noriega's pilot, Floyd Carlton, testified to a Senate subcommittee that he offered to give information in July 1986 to the U.S. Drug Enforcement Administration office in Panama, and the DEA refused to take the information. Carlton's evidence was very valuable since he had frequent direct contacts with Noriega and the Medellin and Cali drug cartels. The evidence included taped telephone conversations, documents, personal information about money laundering, drugs, weapons, corruption, assassinations. But to have allowed Carlton to give that information would expose the CIA, DEA, and Mossad involvement in the drug traffickers. Carlton testified that one of the DEA agents in Panama, who refused to receive the information, was Thomas Tyre. Standard obstruction of justice tactic. Using a standard Justice Department tactic to silence or discredit whistleblowers, U.S. agents arrested Carlton in January 1987, charging him with drug trafficking. The charges were made in such a way that Carlton would not be allowed to testify about the CIA role, which he had earlier sought to expose. Even though Carlton was sentenced to federal prison, he was released and put in the Federal Witness Protection Program after testifying on behalf of the Justice Department in later cases. Hooded witness Floyd Carlton gave testimony to Congress while wearing a hood, hiding his identity. Carlton testified about large quantities of drugs shipped to the United States from Colombia and Panama on Eastern Airlines, a fact that Eastern Airlines Captain Gerald Loeb had described to me in detail. Carlton corroborated that the ranch that John Hull ran in Costa Rica was used by drug trafficking aircraft. Hull was a close associate to Dan Quayle and George Bush. CIA making Noriega a key drug kingpin. Senator Kerry stated what was already well known, that, had been on the payroll and an employee of the CIA for many years, and, I have been given to understand, up until rather recently. It is not inconceivable, but it is most probable that this activity that the CIA had with this thug who was in their employ, and how proud they must have been that one of their own, that they nurtured for so many years, had risen to this power position. Recognizing the seriousness of the drug problem, the published 1988 report by the Subcommittee on Terrorism, Narcotics, and International Communications said in part, "The reason for believing is a matter for national security is that the Latin criminal cartels who have profited from the depravity of some Americans constitute an international underworld so extensive, so filthy, and so powerful that it can literally buy governments. 402. And destabilize entire societies. This is a national security matter. Latin drug trafficking directly detracts from our ability to defend ourselves from military attack. Drug abuse has affected readiness within our armed forces. Aiding and abetting drug trafficking and drug money laundering by future President of the United States for years, Arkansas papers carried stories of the CIA arms and drug trafficking in the vicinity of the Mena, Arkansas, airport. Prosecution had been blocked by Arkansas and federal officials. A May 21, 1992, Arkansas Times article carried a front-page story of the drug trafficking, including 3 pictures of CIA contract agent and drug pilot Barry Seal, drug trafficker Jorge Luis Ochoa, and George Bush. Below their picture was the title, "Bad Company." A subheading read, "Arkansas's most notorious drug smuggler testified about his links to Colombia. His ties to Washington have yet to be explained." The article brought together the CIA's Mena operations, the drug smuggling, the shooting down of a CIA C-123 over Nicaragua, Lt. Col. Oliver North's arms shipments to Central America, and drug shipments back to the United States. The criminal activities surrounding the CIA arms and drug trafficking at Mena Airport were well known to local residents, the local police, the Arkansas State Police, and the media. The local Arkansas Gazette published numerous investigative articles describing the criminal activities and the cover-up by the state attorney general and Governor Bill Clinton. Charles Black, assistant deputy prosecutor for Polk County, told Governor Clinton in 1988 about the drug trafficking, and asked that Clinton provide $1 million to coordinate the evidence and prosecute. Clinton said he would get back to Black, and then never did. In 1991, the Arkansas Citizens Committee demonstrated in Little Rock, complaining about Clinton's refusal to investigate and prosecute the complaints concerning massive drug trafficking in Arkansas. During a White House press conference, senior White House correspondent Sarah McClendon asked President Clinton about his knowledge of the drug trafficking at Mena Airport. Clinton replied that this was a federal problem. Responsibilities under law for these criminal activities involve state as well as federal authorities. CIA liaison with organized crime to distribute drugs and coordinate drug money laundering. Much testimony has been given by hundreds of insiders to congressional committees over the years depicting the involvement of U.S. intelligence agencies in drug trafficking into the United States, drug money laundering, and the joint operations with organized crime. An example of this type of sworn testimony is found in several manuscripts marked confidential, consisting of depositions taken in June 1991. One of the witnesses was CIA agent Richard Brennicky, who testified in a joint investigation by the United States Congress and the 403. Arkansas State Attorney General's Office #23. Brennicky's testimony described the drug trafficking, CIA ties to organized crime, and CIA money laundering. The transcript stated that the testimony would be made available to the special prosecutor in the Iran-Contra case, and for other purposes. In the transcript of that testimony, Brennicky described his activities on behalf of the Central Intelligence Agency. Brennicky testified about his expertise in handling financial transfers worldwide, including money transfers for the Central Intelligence Agency, commencing in 1968, and continuing until 1985. Brennicky testified to handling money for them, handling East Bloc weapons purchases primarily made in Yugoslavia and Czechoslovakia. He described flying as pilot for the CIA from 1968 through 1980, including flying aircraft from Mena, Arkansas, including military C-130 aircraft, starting in April 1984, to various airports in Panama, including Tecaman Airport at Panama City, and into Colon. Brennicky produced pilot logbooks showing the flights that he made for the CIA into Mena and other locations. Brennicky testified that the weapons shipments were met by members of the Panamanian Defense Forces and by Michael Harari. He identified Harari in congressional testimony as a Mossad agent and Manuel Noriega's partner in a number of business deals in Panama. I know that firsthand because I had to deal with him. Heads cribbed carrying weapons and military forces trained in Arkansas, from Mena to Panama City in Panama. He testified that the weapons frequently came either from government stores or through to Miami Gun Shop in Miami, Florida. He testified that his co-pilot on many of these flights was Harry Rupp, a friend of mine who lives in Denver, Colorado. Brennicky described drug trafficking flights from Medellin to Mena and to Iron Mountain Ranch in Texas. He identified Rich Mountain Aviation at Mena Airport and Fred Hampton as owning and operating the CIA front operation. When asked by congressional investigators about the nature of the cargo flown back to the United States, including into Mena, Brennicky testified, "I found the cargo to be cocaine, in some cases marijuana." He testified that on each return flight he carried 400 to 500 pounds of cocaine, which was loaded by Panamanian Defense Force soldiers onto the CIA aircraft. Sale by CIA of drugs to organized crime families. When asked about the disposition of the drugs, Brennicky testified that upon landing at Mena Airport the drugs would be either offloaded onto other aircraft, or stored in Rich Mountain Aviation's hangar. Brennicky testified that in some instances the drugs were received by Freddie Hampton of Rich Mountain Aviation, and in some cases members of John Gotti's family in New York. One of them was an individual known to me by the name of Salvatore Reali. Brennicky testified. Director of Security for Kennedy International Airport in New York City, Mr. Reali was one of Mr. Gotti's lieutenants. I watched the two of them interact. Mr. Gotti would provide directions, Mr. Reali would carry them out. It was his job to make sure that cargo being shipped through Kennedy was not lost, but properly located, and in some cases avoiding customs. This testimony linking organized crime with the CIA in drug trafficking caused the congressional investigators to ask, "Are you saying that you saw Mr. John Gotti, the famous head of the organized crime syndicate, in New York, together with Mr. Reali?" Brennicky replied, "Yes, sir, I did." Gotti crime family in business with the CIA. In response to another question as to whether Mr. Gotti and Mr. Reali were connected with the Central Intelligence Agency, Brennicky replied, "Yes. As far back as 1968 and early 1969, we had begun to launder money from organized crime families in New York. At that time, Mr. Gotti was an up-and-coming member of one of the families. I got to know them at that time. We used to wash their money out overseas and put it in Switzerland in nice, safe places for them." "So you worked for Mr. Gotti as well as for the CIA?" "Actually the CIA told me to do that on his behalf." So the CIA was in partnership or association with Mr. Gotti? Yes, sir, I would say a partnership. Can you describe the nature of the partnership? Sure. The organized crime members had a need for two things: they needed drugs brought into the country on a reliable, safe basis, they needed people taken out of the country or people brought into the country without alerting customs or INS to the fact that they were being brought into the country. They also needed their money taken offshore so that it would not be subject to United States tax where they might have to declare its source. And so we performed these kinds of functions for them. Mr. Branicki, are you saying that the CIA was in the business of bringing drugs into the United States? Yes, sir. That's exactly what I'm saying. And that they were in partnership with John Gotti in this operation. I would say that they worked with Mr. Gotti and his organization very closely. Whether it was a formal partnership, I don't know. But there certainly was a close alliance between the two. Branicki testified that the Gotti people told him the drugs would be taken to the New York City area, specifically Kennedy International Airport. He testified that the CIA handler he was working for was Robert Carrot, and that Carrot paid the various CIA assets in the MENA area. Branicki continued. Mr. Carrot is a full-time employee of the Central Intelligence Agency. I and the CIA have dealt with the Gotti mob since 1968. Did the Gotti organizations, through Reali, pay money to the CIA for the drugs? Yes, they did, somewhere in the $50,000, 000 bracket. How do you know how much money? 405. Because I banked that money for them in Panama City, and ultimately transferred it to other locations in Europe. What would be the procedure for you to receive the payment from the Gotti organization for the drugs? Generally the money was given to us in cash. Us, you mean the CIA? Us, meaning the people I worked with, who were also associated with the Central Intelligence Agency. We would transfer the money to banks in Central and South America. And from there transfer it via accounts that I had established back in 1970. Let's take a payment from Mr. Reali Inkish, and follow the procedure step by step as you know it for the transmittal of that money from the Gotti organization to the Central Intelligence Agency. Okay. That money was delivered to us in cash. There were occasions where there were wire transfers, but the generally followed method was cash. That would be stored in the aircraft on its return trip to Panama. Once it reached Panama, we would put it into a bank account, which at that time was in the Banco de Panama. And the account name was the initials, IFMA, which was a company that I set up in Panama City in 1970. The money would be subsequently and almost immediately transferred to Spain or Liechtenstein, from there it went to Monte Carlo, and the ultimate destination was Zurich or Geneva. But in any case, Switzerland. The money was given to you by the agent for the Gotti organization. Yes, sir. And there were other people besides the man that I've named. Branicki identified the names of the CIA accounts that he had set up, offering the incorporation papers that were filed in the late 60s and early 70s. Branicki testified that he personally transferred the money out of one account and into others. He testified that he discussed the money transfers with CIA employees Robert Carrot and Robert Ellis, protesting the CIA drug involvement. Branicki described his adverse reaction to discovering the CIA involvement in drug smuggling into the United States and the CIA's involvement with drug money laundering. In answer to a question, Branicki testified, "When I found that we were bringing drugs into the United States, and that we were receiving money which was being put into accounts which I knew to belong to the United States government, as I'd set them up specifically for that purpose, I called Mr. Don Gregg, who was a CIA officer with whom I was acquainted, and complained about the nature of what we were doing." Office of Vice President and President in Drug Trafficking and Drug Money Laundering. Donald Gregg worked closely with George Bush when Bush was director of the CIA, and became his national security advisor when Bush was Vice President of the United States. Bush later nominated Gregg to be ambassador to South Korea. When asked about Gregg's response to Branicki's concern about the drug trafficking, Branicki testified, 406. I was told that it was not my business, what I was flying in and out of the country. That I was hired to do specific things, and if I would do those things and not pay any attention to anything else, we would all be very, very happy. I didn't like that. He said, shut up and do your job. I subsequently talked to Mr. Gregg on a number of occasions as well as to other people in the Vice President's office to voice my concern over the use of drugs, importing drugs into the United States and using the cash generated from that to perform operations. Brennicke supplied the investigators with telephone records of that and other calls, providing further credibility to his statements. Returning to questions about how the drug money from the Gotti crime family went into the CIA accounts, Brennicke explained, I set up, in 1969 or 1970, a number of corporations in Panama City. Those corporations in turn opened bank accounts. Those bank accounts were accounts that I would normally use in the course of my business with the CIA to transfer money into the accounts, and from there to transfer them into specific accounts in Spain or, as I say, in some cases other countries in Europe. The ultimate destination was Switzerland, where those funds were. I knew where they went, because I'm the person who went in and gave the order to the banker to move them. And you had an arrangement with the CIA to organize those banks for the CIA, to open the account. That was what I specialized in doing. I laundered money there. When I was first recruited by the CIA, which was in 1968, 1969, all we were doing was selling mutual fund stock offshore. Name the banks opened for the CIA. Panama City, Banco de Mexico. At one point we were using a Citibank correspondent down there whose name escapes me. We had Aman on site who worked for us, as well as worked for Ron Martin, a man named Johnny Molina. John would spend a lot of his time in Panama City and worked in one of the banks that we used. I set up more than one account in Madrid that was used. I set up an account in Brussels at Bank Lambert that was regularly used. I set up accounts at Credit Suisse, a Swiss bank, and Bank of Credit and Commerce, commonly referred to as BCCI. Also, a bank that no longer exists called Bank Hoffman. I set up a bank in Panama City on behalf of the mutual fund company I worked for so that I could ultimately control how the transfers were handled. And you organized a bank in Panama for the CIA. I organized it for the company I worked for. It was subsequently used by the CIA, and it was used by members of the organized crime families. The bank was called U.S. Investment Bank. It really existed in Panama City. You could actually go in and open a check account there. And the money that you got from the Gotti organization that you put on the airplane and returned to Panama on the next trip, you personally took to a bank in Panama City. 407. You bet I did. Let's take Banco de Panama, the Panamanian National Bank down there, as an example. I would go in and meet with, for instance, Johnny Molina. John worked for one of the banks down there. I think it was Citibank that he worked for at one time. In any case, I would go in. I knew the bank officers by name. And I would provide them with directions as to how the money was to be transferred and where to transfer. That is, it was to be transferred by cashier's check and courier to Madrid in a specific account there, or it was just wire transferred to Madrid as a transfer of funds from IFMA, a Panamanian corporation, to IFMA's affiliates in Madrid or Brussels at Bank Lambert. They needed to know that. And then I would have to tell them at the other bank that money was coming into that account. So you would notify the CIA bank, or the bank having the CIA account in Spain or in Switzerland. Yes, that the deposit had been made in Panama. How would you notify them? Generally by telephone. And they would be told that, there were a variety of codes that were used, but the message was very simple. You're going to receive money in this account. The money will probably stay in the account anywhere from 24 to 72 hours, at which time it will be transferred out of that account. Did you ever utilize bearer bonds for the purpose of laundering money? Sure. It was handled in two ways. When U.S. Investment Bank was active in Panama, it would issue bonds, no names on them, which was common. It's common in Europe. It's common in Central and South America. And those bonds actually belong to the individual that is carrying them, as, for instance, the stock in IFMA belongs only to the person who happens to have it in his hand at that moment. You lose it, you lose your money. And what would you do with the bearer bonds? The bearer bonds would be taken generally by courier, in some cases to Banco de Mexico in Mexico City, and transferred from there or sent from there by their couriers. By 1986, it was getting uncomfortable in Panama, and so some of the Venezuelan banks in Caracas were used. The same procedure was followed, though. The money would be deposited into an account. You would walk into the bank, for example, and sit down with the vice president or managing director of the bank. You were clearly a large depositor and a large customer of that bank. And you just simply explained that you wanted to deposit the money in this bag, and he would just kindly go ahead and do so for you. Drug trafficking controlled from CIA headquarters in Washington. Mr. Brennicky, under whose direction were you working in order to carry out the function of depositing the money from the sale of the drugs to the New York crime family? Bob Carrot, an officer of the Central Intelligence Agency in Washington, DGW. 408. Brennicky clearly stated, without hesitation, times, dates, places, and either telephone logs or notes that he made of conversations with his CIA handlers in Washington. Brennicky testified to, and provided the congressional investigators with writings that he sent to his CIA bosses in Washington complaining about the CIA role in drug trafficking and drug money laundering and its operation with major crime families in the United States. He provided the investigators with copies of bank account records, corporation papers, and detailed testimony, wherein there could be little doubt that his testimony was true. Brennicky testified about the criminal charges made against Heinrich Rupp concerning looting the Aurora Bank in the Denver area, saying that was common in our line of work with the CIA. When asked if Brennicky ever complained to CIA Director William Casey about these activities, Brennicky replied, "Yes, I did on a number of occasions." And Mr. Casey's telephone logs would reflect phone calls to me, made to me in Lake Oswego, which was at that time the location of my office. Seeking Israel's help to shut down drug operation. Brennicky testified about Israel's involvement in the drug operations, and that he had gone to Israel because I tried everybody in the US government first, and they sure as hell weren't going to help shut down the operations. Do you have any knowledge of the money coming from the Gotti organization being used for any other purposes, other than depositing in the bank accounts for the CIA? Sure. We had to run the operations at Nella, for instance. The training facilities at Nella had to be paid for. Nella was a training base for military and paramilitary folks from south of the border, Mexico, Panama. *4 The base was operated by the Central Intelligence Agency. Brennicky identified CIA agent Terry Reed as one of the flight instructors at Nella. Reed co-authored the book Compromised with John Cummings, describing the drug trafficking and money laundering in Arkansas and Mexico, and involving Arkansas personnel, including Governor Bill Clinton and some of his staff. Getting the drug money back into the United States. Did you establish an account in the United States to get that money back into this country? Yes, I did. I established an account at Brown Brothers Harriman in New York City around 1980. That's a bank in New York City. How do you know that the money you picked up and that you received in MENA from the Gotti organization, and took to Panama, wired to bank accounts in Europe, came back to the United States? I ordered the transfer of funds. And to whom did you report these actions? I reported them to Don Gregg, Bob Carrot, Bob Ellis, and from time to time other people. I not only have notes, I have letters that I wrote to some of these people. Copies of these letters were submitted to the congressional investigators. One of the investigators, Chad Ferris, Chief Deputy Attorney General for the state of Arkansas, tried to discredit Brennicky by asking hostile questions. Why would you care about the use of drugs as part of the CIA plan? If you were so concerned about the use of drugs in the operation because of the reasons you've described, why did you continue to take part in the operation? What do you hope to achieve by testifying here today? What's the purpose of your testimony, to you personally? Branicki was under subpoena, and obviously had to answer truthfully. Further, Branicki was following orders when he did what he did. He also knew the risk of opposing high-level officials in control of the CIA, DIA, and Justice Department. Branicki testified about the Justice Department's sham charges against him for having testified during a 1988 federal court trial in Denver concerning Heinrich Rupp, and his testimony that he saw George Bush and Donald Gregg in Paris during the period of October 18, 19, and 20, 1980. Branicki stated that in the Denver proceedings Justice Department attorneys offered him a plea agreement, that if Branicki pled guilty to perjury concerning his statement about seeing Bush and Gregg in Paris, he would not receive any prison time or fine. No perjury charges were ever filed against Branicki for this testimony. Branicki's testimony corroborated testimony of many others, and statements made to me over a period of years by CIA personnel and DIA personnel, and with numerous investigative media articles and highly specific expose books. Branicki was involved in many other CIA activities. Tape recordings made of telephone conversations between Branicki and Russ Bacher, in my possession, described their role in the CIA's operation known as Operation Gladio, which sought to destabilize the Italian government in the 1950s. Branicki had given a speech at the University of Arkansas in 1991, which was videotaped, further describing these events. Testimony by IRS investigator Bill Duncan. One of my sources was William Duncan, who was an investigator for the Internal Revenue Service. Duncan spent several years investigating drug money laundering in Arkansas, and the role played by Governor Bill Clinton, the Arkansas Development Finance Authority, Dan Lassater's brokerage business, and the Stevens financial powerhouse. Duncan had functioned in the capacity of congressional investigator for the Subcommittee on Crime, and discovered as part of his investigation the involvement of Arkansas officials and the CIA in drug trafficking and drug money laundering. Duncan was a criminal investigator for the U.S. Treasury Department from 1973 through 1989, involving matters surrounding drug trafficking and drug money laundering in the Mena, Arkansas area. In addition to what Duncan stated to me, I received a transcript of his congressional testimony, marked confidential, given to a joint investigation by the United States Congress and the Arkansas State Attorney General's Office. 410. In June 1991. During the deposition, Duncan was asked what his duties were concerning the Mena airport activities. He replied, "I was assigned to investigate allegations of money laundering in connection with the Barry Seal organization, which was based at the Mena, Arkansas airport." Duncan testified in detail about the drug money laundering he uncovered, involving the CIA, and how attorneys with the Department of Justice stonewalled the prosecution. Duncan found, as I had in the past, that Justice Department attorneys routinely obstruct justice by refusing to have witnesses willing to testify appear before the grand jury. Or, they can control the testimony by asking witnesses only perfunctory questions and blocking the witnesses from testifying on meaningful activities. Duncan testified as to the tactics used by Justice Department officials to protect the CIA and those people working with the CIA in the drug trafficking and drug money laundering. He testified that important witnesses were not called to testify before the grand jury, that important witnesses with valuable information were not allowed to present this information, being limited literally to giving their name, address, phone number, and type of employment. Duncan testified to how Vice President of the Union Bank in Mena, Gary Gardner, wanted to testify about the CIA money laundering and how Justice Department prosecutors blocked this testimony. Duncan testified that he gave the U.S. Attorney's Office in Fort Smith, Arkansas, the names of 20 witnesses to call for the grand jury appearance, who had direct knowledge and evidence of the drug money laundering, and that only 3 were called. Duncan testified to the cover-up by U.S. Attorney Asa Hutchinson and other Justice Department officials, that permitted the money laundering to continue. Of the 3 witnesses that were allowed to testify, Duncan testified that two of them were angry because the U.S. attorney refused to allow them to give evidence to the grand jury. I also encountered this common tactic when circumvented the stonewalling by Justice Department attorneys. I appeared before a Denver grand jury in the mid-1960s to give testimony as a federal investigator about the corruption at United Airlines and within the Federal Aviation Administration relating to a series of air disasters. One of the witnesses not allowed to testify to any meaningful activities was Kathy Corrigan Gann. Duncan testified, she was the secretary for Rich Mountain Aviation, who participated in the money laundering operation upon the instructions of Hampton and Evans. She basically said that she was allowed to give her name, address, position, and not much else. I talked to another witness. His name was Jim Nugent, a vice president at Union Bank of Mena, who had conducted a search of their records and provided a significant amount of evidence relating to the money laundering transaction. He was also furious that he was not allowed to provide the evidence that he wanted to provide to the grand jury. 41. Duncan's testimony continued. At a later date, I came in contact with the deputy foreman of the grand jury, who had previously given testimony to an investigator for the House Judiciary Subcommittee on Crime, concerning her frustrations as the deputy foreman of the grand jury. Her name was P.J. Pitts. She was perpetually involved in the grand jury as it heard evidence concerning the Barry Seal matter, and she related to me the frustrations of herself and the entire grand jury because they were not allowed to hear of money laundering. She stated to me that they specifically asked to hear the money laundering evidence, specifically asked that I be subpoenaed, and they were not allowed to have me subpoenaed. She said the whole grand jury was frustrated. She indicated that Mr. Fitzhugh, who at that time was the U.S. attorney, explained to them that I was in Washington at the time and unavailable as a witness, which was not the truth. When asked about how Duncan's superiors responded to the cover-up, Duncan testified that he complained to his superior, Paul Whitmore, Chief of Criminal Investigation, and to the group managers, Tim Lee, Charles Huckabee, and Max Gray. Duncan continued, they were very frustrated. Mr. Whitmore made several trips to Fort Smith, Arkansas to complain to the U.S. Attorney's Office. He related to me on several occasions that the U.S. Attorney wrote him a letter telling him not to come to his office anymore, complaining that was unprofessional behavior. Mr. Whitmore felt there was a cover-up. Do you agree with Mr. Whitmore's conclusion? Absolutely. We experienced a variety of frustrations from 1985 on, not being able to obtain subpoenas for witnesses we felt were necessary. I had some direct interference by Mr. Fitzhugh in the investigative process. Specifically, he would call me and interrupt interviews, tell me not to interview people that he had previously told me were necessary to be interviewed. IRS demanding perjured testimony to cover up for CIA drug trafficking. Did you have any interference or interruptions from anyone within the U.S. Treasury Department? They interfered with my testimony before the House Judiciary Subcommittee on Crime. The Internal Revenue Service assigned to me disclosure litigation attorneys, who gave me instructions which would have caused me to withhold information from Congress during my testimony, and to also perjure myself. Drug money bribe to U.S. Attorney General. How did you respond to the Treasury Department? I told them that I was going to tell the truth in my testimony. And the perjury, subornation of perjury, resulted because of an allegation that I had received, that Attorney General Edwin Meese received a several $100,000 bribe from Barry Seal directly. I received that. 412. Information from Russell Welch, the state police investigator. And they told me to tell the subcommittee on crime that I had no information about that. Duncan testified about other aspects of upper management acting to prevent exposure of the drug trafficking and drug money laundering. His testimony continued, I received a subpoena from Deputy Prosecutor Chuck Black from MT Ida, to present evidence to the grand jury for the purposes of seeking indictments against the individuals at Mena. The Internal Revenue Service told me I would have to go back and deal with the same disclosure litigation attorneys who attempted to get me to withhold information from Congress and perjure myself, and I refused to do that. They withdrew support for the operations and basically kept me in the regional office in Atlanta and did not allow me to fulfill my responsibilities. This ultimately resulted in my resignation in June of 1989. Addressing questions concerning the obstruction of justice, Duncan testified, "My superiors and I had continuing discussions because none of us, my managers nor myself, had ever experienced anything remotely akin to this type of interference. We couldn't understand why there was this different attitude. I had found Asa Hutchinson to be a very aggressive U.S. attorney in connection with my cases. Then all of a sudden, with respect to Mina, it was just like the information was going in but nothing was happening over a long period of time. As soon as Mr. Fitzhugh got involved, he was more aggressive in not allowing the subpoenas and in interfering in the investigative process. He was reluctant to have the state police around, even though they were an integral part of the investigation. For instance, when the money laundering specialist was up from Miami, Mr. Fitzhugh left Mr. Welch in the hall all day until late in the afternoon and refused to allow him to come in. We were astonished that we couldn't get subpoenas. We were astonished that Barry Seal was never brought to the grand jury, because he was on the subpoena list for a long time. And there were a lot of investigative developments that made no sense to us." Duncan testified that the IRS briefing attorney from Washington wanted him to cover up during the grand jury testimony. "Did you get the impression that she was ordering you to cover up the investigation?" "Absolutely. I would have thought a complete disclosure to Congress about the problems that we encountered was in order, but quite the opposite was true. They obviously did not want any negative testimony coming from me concerning the U.S. Attorney's Office." Attorney Brian Sloan, a personal assistant to the Commissioner of Internal Revenue, Larry Gibbs, said, "Bill is just going to have to get the big picture." Duncan testified that among the federal agencies that should have been involved in the Arkansas investigation were the U.S. Customs Service, the FBI, and the Drug Enforcement Administration. Among the state agencies were the Arkansas State Police, Polk County Sheriff's Office, and the Louisiana State Police. Duncan, 413, testified that none of the law enforcement personnel, who had knowledge and evidence of the drug trafficking and drug money laundering, were called by the Justice Department to present evidence to the grand jury. Duncan testified that even though allegations of narcotics smuggling, massive amounts of drug money laundering were involved, conspicuously absent during most of that time were the DEA, FBI, and Customs. During Duncan's testimony, it was revealed that the U.S. Attorney's Office at Fort Smith received instructions from the Miami U.S. Attorney's Office to shut down the Mina investigations at a point in time when they were ready to indict and present information to a grand jury. During another congressional deposition on July 24, 1994, Duncan testified, by the end of 1987, thousands of law enforcement man-hours and an enormous amount of evidence of drug smuggling, aiding and abetting drug smugglers, conspiracy, perjury, money laundering, had gone to waste. Not only were no indictments ever returned on any of the individuals under investigation for their role in the Mina operation, there was a complete breakdown in the judicial system. The United States Attorney, Western Judicial District of Arkansas, refused to issue subpoenas for critical witnesses, interfered in the investigations, misled grand juries about evidence and the availability of witnesses, refused to allow investigators to present evidence to the grand jury, and in general made a mockery of the entire investigative and judicial process. Purely and simply designed to impede the Congress of the United States in their investigation of issues which impact on the very heart of our judicial system, and ultimately the security of this country. Evidence indicates that the Mina, Arkansas airport was an important hub waypoint for transshipment of drugs, weapons. The evidence details a bizarre mixture of drug smuggling, gun running, money laundering, and covert operations by Barry Seal, his associates, and both employees and contract operatives of the United States Intelligence Services. The testimony reveals a scheme whereby massive amounts of cocaine were smuggled into the state of Arkansas, and profits were partially used to fund covert operations. Two witnesses testified that one of the Western District of Arkansas assistant U.S. attorneys told them that the U.S. Attorney's Office received a call to shut down the investigations involving confidential transcript of testimony of Arkansas state official. Another transcript sent to me, marked confidential, was of testimony given by Russell Welch to the congressional and Arkansas state investigators in June 1991. Welch was an investigator for the Arkansas State Police for 16 years, and testified along the lines of IRS investigator William Duncan. He added that U.S. Attorney Michael Fitzhugh of Miami blocked an investigation into the CIA drug trafficking and money laundering as Asa Hutchinson had done. He testified to the refusal by the Justice Department to issue subpoenas for those who had knowledge of the drug-related crimes. Welch testified that despite the fact that he had considerable knowledge of the federal offenses, the Justice 414 Department refused to allow him to appear before the grand jury. Welch testified that one of the lady members of the grand jury had seen him in the hall outside the jury room and demanded of Fitzhugh to have Welch testify. Angrily, Fitzhugh told Welch the grand jury wanted to hear from him, but Fitzhugh refused to allow this. Cover-up idea asked how other federal agencies blocked investigation and prosecution of the drug trafficking and drug money laundering. Welch testified that the cooperation from the Drug Enforcement Administration in Florida was absolutely zero. We didn't get a lot of support from the Arkansas Drug Enforcement Administration. Referring to drug trafficker Barry Seal, Welch testified there was obvious government involvement with him. Seal was heavily involved in drug trafficking and drug money laundering with the CIA, and also with Arkansas officials and power brokers, including members of then-Governor Bill Clinton's administration. Welch described, as did others, that the practice was for aircraft flying into Arkansas from Central America to airdrop the drug loads at selected sites in western Arkansas, and that helicopters would then pick up the drugs. He described the amount of drugs Barry Seal brought into Arkansas as billions of dollars of cocaine and drugs over an 8 to 10 year period of time. Welch testified about the feelings of the grand jury as he referred to the deputy foreman, Patty Pitts. She expressed concern that they weren't being allowed to investigate the Mena airport, that Mike Fitzhugh wasn't giving them the evidence that they needed to have, and wasn't giving them the witnesses they needed to have. She felt like they were being hindered. Judicial assistance in obstruction of justice, referring to the practice of certain federal judges to block the prosecution of government-related drug offenses. He said U.S. Attorney Fitzhugh told him that a federal judge would never let it get to court, and we would be wasting our time. Attempt to disable Welch. Welch said to me that while he was presenting evidence of the massive drug trafficking to Arkansas officials in Little Rock, he suddenly became deathly sick, and was rushed to the hospital. Fortunately for him, the doctors discovered the problem. They told Welch that he had been sprayed with military-grade anthrax. Obstruction of justice by NSC. The General Accounting Office started a probe of the Arkansas drug operation in 1988, and was shut down within 4 months by the National Security Council. Several congressional committees started to investigate, and then shut down. Governor Bill Clinton blocked an investigation and prosecution. 435, Wall Street Journal, June 29, 1994. 415. Polk County Prosecuting Attorney Joe Hardigree, who had accumulated considerable evidence of CIA drug trafficking and drug money laundering, complained that a cloak of secrecy prevented prosecution of the drug-related offenses because of links between the drug traffickers and the federal government. In a prepared statement to a Mena Star reporter in 1988, Hardigree said that the investigation of prosecution of drug-related crimes had come to a grinding halt because of links between the drug traffickers and the White House. 6 Hardigree added, I have good reason to believe that all federal law enforcement agencies from the Justice Department down through the FBI to the Drug Enforcement Administration received encouragement to downplay and de-emphasize any investigation or prosecution that might expose Seal's activities and the National Security Council's involvement in them. By 1983, the Arkansas State Police had almost 36 volumes, several thousand pages of reports and evidence, providing overwhelming evidence of the drug activities. Since 1983, the drug trafficking and money laundering in Arkansas were investigated by agents from the local Polk County, Internal Revenue Service, the FBI, and Arkansas State Police, and despite massive evidence of the criminal activities, officials in the U.S. Department of Justice and Arkansas Police blocked prosecution. Every attempt by the individual investigators to appear before a grand jury to present their evidence was blocked by Arkansas and federal officials. Arkansas Citizens Committee. One of the concerned group of citizens was the Arkansas Committee, in which Charles Reed #7 Mark Swanee, and Tom Brown of Springdale, Arkansas, were heavily involved. Reed and his group investigated the CIA's unlawful weapons shipments and drug trafficking activities in Arkansas, focusing on the Mena area. In 1989, the group sent a petition to Governor Bill Clinton asking the state to convene a grand jury to receive their evidence, to conduct an investigation, and to prosecute. The group discovered the drug trafficking operations of CIA and deconnect Barry Seal, at that time one of the biggest drug traffickers in the country. Every time Seal was accidentally arrested by a law enforcement officer, he was subsequently released after intervention from officials of the CIA and Justice Department. This get-out-of-jail pass was typical for covert CIA-related personnel. In 1972, for instance, Seal was arrested in New Orleans with 14,000 pounds of explosives intended for Cubans working with the CIA, and promptly released. The Arkansas State Police received hundreds of citizen reports detailing the criminal activities, reportedly consisting of several thousand pages in 34 volumes. Governor Bill Clinton was advised of the activity, and it was requested that he order state law enforcement personnel to investigate. Despite the gravity of the reported drug activities, Clinton and the U.S. Attorney refused to conduct an investigation. Helping to obstruct justice was Asa Hutchinson and then Michael Fitzhugh, the local federal prosecutors, obviously acting on orders from their Washington Justice Department officials and U.S. Attorney Generals. Forcing Justice Department into cover-up grand jury hearing. By 1987, public pressure forced the U.S. Attorney to convene a grand jury and go through the motions of investigating. In typical cover-up fashion, the U.S. Attorney blocked state and federal investigators, who had evidence of the drug trafficking, access to the grand jury. Witnesses who could provide evidence, and who were called, were not asked questions about the drug activities, being asked by the U.S. Attorney non-relevant questions. The Justice Department tactics included asking questions about things the witness knew nothing about, and not asking questions about things they did know. The witnesses recognized what the U.S. Attorney was doing, and complained about the tactics when outside of the grand jury room. Arkansas Development Finance Authority (ADFA) was promoted by Governor Bill Clinton as providing low-interest loans for schools, churches, and other noble purposes, and passed by the Arkansas legislature in 1985. Clinton had control of who received loans from ADFA. The first 5 loans went to Clinton's friends and associates, including Park on Meter, a company partly owned by Webster Hubbell, a Rose law firm partner and later de facto head of the U.S. Department of Justice. That $2.85 million loan was never repaid, and the records of loans and payment schedule were kept from the public. There was no noticeable improvement in the POM plan to show where the money was used that was to fund that purpose. POM was involved in secretly manufacturing weapon parts for the CIA's unlawful arms shipments to Central America. Marketing Director ADFA. Former Director for Marketing at ADFA was Larry Nichols, who turned whistleblower and presented evidence to the media concerning activities at ADFA. He was one of the first to go public about Governor Clinton's misuse of state offices for his sexual encounters. Nichols stated that there was virtually no accounting of the money received by ADFA, or the repayments on the loans. He said that money would appear in a particular account and then suddenly disappear, a technique that IRS investigator William Duncan said was a zero-balance tactic commonly used in drug money laundering. Nichols stated that the huge amount of money coming into ADFA would be periodically transferred to other banks, including the terrorist and drug-related Bank of Commerce and Credit International. He said that drug money was laundered into a Chicago bank in which Congressman Dan Rostenkowski had a part interest. A 17. Lassater, Incorporated. Bond brokerage houses are a convenient vehicle for drug money laundering. In Arkansas, key drug money laundering facilities were Lassater and Company, Stevens Companies, and Arkansas Development Finance Authority. Dan Lassater, a close friend of Governor Clinton, and a key campaign contributor, operated a bond brokerage business in Little Rock, which was a primary source for CIA and other drug money laundering. Clinton was responsible for sending tens of millions of dollars of Arkansas bond business through Lassater's bond brokerage business. Clinton personally lobbied on behalf of Lassater, for Arkansas to use the Lassater firm for much of its bond business. This lobbying occurred while the media reported that Lassater was the target of a federal drug investigation. Lassater also had a major drug trafficking and drug money laundering operation at his Angel Fire Resort in New Mexico, as reported to authorities by present and prior employees. An investigation and prosecution of the CIA-related operation was blocked by federal agencies, again protecting the involvement of these agencies in criminal drug-related offenses. In 1987, Lassater was sentenced to 30 months in prison for distributing drugs for recreational use, although he was known to be a major drug trafficker. A trial was avoided through a plea agreement, eliminating the risk that the CIA and ADFA would be exposed. Lassater's top aide in his businesses was Patsy Thomason, who operated the businesses while Lassater was in prison because of this conviction. When Clinton became President of the United States, he appointed Thomason Director of White House Administration. Even after Lassater was charged with drug trafficking in Arkansas, Governor Clinton personally lobbied to approve a state bond sale to Lassater's company, netting Lassater a $750,000 fee. Lassater handled considerably over $500 million in Arkansas bond contracts. 43° state bond sales are lucrative and require relatively little work, and are prime contracts for bribes of the approving government officials. The bond business is a free lunch for those who are well connected politically. Lassater sold high-interest, high-risk deals to small banks and savings and loans, causing some of them to fail, incurring large losses for the American taxpayers. Involvement of the powerful Stevens family. After Lassater went to prison, he changed the name of Lassater Incorporated to Phoenix Group, Incorporated, which was later purchased by the powerful Stevens interests. Stevens handled much of the ADFA funding after Lassater went to prison. Since much of the funding for ADFA came from CIA-related drug money, it is safe to assume that Stevens knew about the source of that money and the corruption related to ADFA. The connections between Bank of Credit and Commence International, First American Bank, and Stevens Incorporated, have been discussed in other pages. Jackson Stevens helped BCCI secretly obtain ownership of American banks. After Lassater went to prison, Governor Clinton transferred the bond business to Stevens Incorporated. Jack Stevens was reportedly involved in drug-related activities, according to Larry Nichols, Director of Marketing for ADFA. Stevens funded Clinton's campaign to the tune of $2.8 million, the exact amount, according to Larry Nichols, that it received in profit from a concocted transaction of a student loan fund that was under Clinton's control. Stevens also contributed large amounts of money to Clinton's campaigns through Worthen National Bank. Repeated unrefutable evidence of the drug trafficking and drug money laundering. The Arkansas Gazette exposed the drug trafficking, drug money laundering, and the unlawful purchase by BCCI of American banks using Stevens' empire to facilitate the purchase. Pressures caused the paper to go out of business, one of the dangers of exposing government misconduct. One of the last articles written by the Arkansas Gazette described how Stevens helped the unlawful acquisition. Kurt Bradbury, then a financial analyst for Stevens Incorporated, and now chairman and chief executive officer of Worthen National Bank of Arkansas, provided research about Financial General, including a copy of its latest annual report. Financial General was the parent company of the National Bank of Georgia, the bank run by Bert Lance. After Financial General and National Bank of Georgia were purchased, the holding company was renamed First American Bankshares and run by Clark Clifford and Robert Altman. Over the years, many people testified about the CIA involvement in the drug-related crimes. Many television shows depicted this problem. The drug trafficking involving the CIA, with obstruction of justice by Justice Department and other agencies, continued, year after year. The public remained either ignorant or apathetic, seemingly more interested in trivial matters than the enormous implications of enormous corruption in government. Associations, comprising retired or former members of the U.S. intelligence community, have repeatedly reported instances of the CIA-related drug trafficking and drug money laundering. IRS reporting the drug money laundering and CIA obstruction of justice among the concerned people who spoke out on the Arkansas drug-related activities were William Duncan, IRS investigator at that time, Russell Welch, an Arkansas state investigator, Charles Black, a Polk County deputy prosecuting attorney, where much of the MENA activities was ongoing, Terry Reid, a CIA contract agent, who discovered his Mexico CIA proprietary was used for drugs. Despite the large amount of evidence IRS investigator William Duncan had, and Arkansas State Police investigator Russell Welch, and the nearly 24 witnesses ready and willing to testify to the grand jury, the Justice Department prosecutor refused to allow them to appear before the jury. U.S. Attorney Fitzhugh refused to allow Duncan to testify, or his other witnesses, even when the foreman of the grand jury requested that they appear. The CIA controlled the Justice Department so as to halt any investigation and prosecution of the criminals and criminal activities in the Arkansas area associated with the CIA crimes. Clinton controlled the state police and blocked any state investigation and prosecution. But there were some renegade investigators that had to be dealt with, including Bill Duncan. Colonel Tommy Goodwin, director of the Arkansas State Police, also acted to block any investigation into the weapons shipments, drug trafficking, and drug money laundering. The May and June 1989 edition of Freedom magazine said that 2 congressional subcommittees and the U.S. Customs Service are investigating secret activities around the quiet mountain town of Mena, Arkansas, including alleged drug running and arms smuggling. The February-March 1992 issue of Unclassified described the large amount of evidence proving the existence of drug trafficking and drug money laundering at Mena Airport, and cover-up by the media. It stated in part, Unclassified is genuinely puzzled about the absence of major media attention to Mena, especially given Clinton's prominence in the presidential race. Angel Fire Resort. For several years several of my CIA contacts described the CIA-related drug trafficking and drug money laundering in the Angel Fire, New Mexico area, including that occurring at Angel Fire Ski Resort. As stated earlier, this resort was owned and operated by Dan Lassater. An investigation into Angel Fire Resort was triggered in 1985 after former Angel Fire employees reported drug trafficking and drug money laundering. This resulted in investigations by local and federal law enforcement officials. Lassater owned Angel Fire Resort from 1984 to 1987, and sold it after he was sentenced in 1986 to 2.5 years in prison for distributing drugs in Arkansas. Routine cover-up and obstruction of justice. A January 1991 memo written by Customs Service Air Interdiction Officer Lawrence E. Frost described the findings of drug trafficking at Angel Fire. During 1988, significant information was developed by Special Agent Norm Scott of the FBI and I regarding a large controlled substance smuggling operation, as well as a large-scale money laundering activity being carried out in the Angel Fire, New Mexico area. The memo described how Frost and Scott requested information about Lassater from the Drug Enforcement Administration, which was in the D's possession because of the Arkansas investigation and trial. The same memo referred to that request and the negative response. At no time did I ever receive any information from DIA regarding any of the alleged conspirators in this case, although I knew that DIA had previously arrested and convicted the primary target of the investigation, Dan Lassater. If the DIA had cooperated and furnished information, it is possible that Frost and Scott would have discovered Lassater's links to the CIA drug trafficking, the CIA drug money laundering, and God knows what else. Tactic of cover-up by Justice Department attorneys. The standard tactic used by Justice Department personnel to cover up for crimes committed by its protected government personnel, or associates of Justice Department officials, is first to block any investigation, either on the federal level, or if on the state level, pressuring local law enforcement personnel to cooperate in the cover-up. If a grand jury investigation should occur, keep witnesses away that could divulge information on government involvement. If calling the witness cannot be avoided, the U.S. Attorney, who asks the questions in grand jury proceedings, avoids meaningful questions and limits the questioning to mundane matters. Also, have witnesses appear who will give false testimony, who are protected against being charged for perjury. DIA whistleblower. On November 21, 1993, 60 Minutes aired a show in which several DIA officials and agents appeared, described smuggling of large quantities of cocaine by the CIA into the United States, the liaison with Colombian drug traffickers, and the obstruction of justice by U.S. officials. Robert Bonner, a former head of the Drug Enforcement Administration, and Annabelle Grimm, a DIA agent in Caracas, Venezuela, exposed the drug trafficking that was protected against prosecution by Justice Department and DIA officials. In one instance described by Bonner and Grimm, over 1,000 kilos of cocaine were brought into the United States with the help of the CIA's station chief, James Campbell, and CIA agent Mark McFarlane. Bonner and Grimm explained how the local CIA agents circumvented the complaints by the DIA, going directly to the CIA's top command in Washington, again making clear that the drugging of America involved top officials in the United States government, and that these were not rogue operations. Appearing on the show with Bonner and Grimm was General Ramon Guillen Davila of the Venezuelan National Guard, explaining that drugs were regularly shipped into the United States in liaison with the CIA. He described one load, 1,500 kilos, that was so huge it would not fit into the Boeing 707 cargo door. He stated that the drug trafficking was approved by the CIA, and that he had immunity, otherwise he would not be on the 60 Minutes program subject to arrest. Grimm described the huge warehouse in Caracas used by the CIA to store the drugs before shipment to the United States, which was built with U.S. taxpayers' dollars. Davila explained how the CIA conspired with Venezuelan officials, including himself, to bring drugs into the United States in CIA-controlled aircraft. At that time Davila was head of a joint CIA-Venezuelan task force responsible for halting drug trafficking. The CIA, made aware of the 60 Minutes show ahead of time, quickly issued a statement on November 19, implying that the drug shipment was an accident, rather than an intentional act. 443 Many people, and much planning, were required to smuggle this huge quantity of nearly pure cocaine into the United States and bring about its sale. There was nothing accidental about this complex operation. Making reference to the CIA statement that the CIA smuggling, distribution, and selling of the ton of pure cocaine was an isolated incident, my CIA contacts laughed. They recognized that the ton of cocaine to which the CIA had to make reference was only a small part of the CIA drug smuggling operation. The CIA tried to show that it took corrective action when this multi-million-dollar operation was discovered, stating that one CIA officer resigned, and a second had been disciplined. Many people implicated in a drug sale, even as little as 1 ounce, or who was present when others were talking about drug sales, have been sentenced to many years in federal prison. When the same offense is committed by a government official or agent, the offense becomes far worse, and calls for much longer prison sentences. Since Justice Department officials covered up for the drug trafficking, and since they are the only officials under our form of government that can prosecute for federal crimes, the criminal conduct by federal officials goes unpunished. Chief State Department official responsible for overseeing international narcotics matters, Melvin Levitsky, explained that an indictment against General Guillen would require the United States to cut off aid to Venezuela, and therefore no charges should be filed. Much of the world's coca, from which cocaine is obtained, is grown in Bolivia, Peru, and Venezuela, and constitute a major part of their income. This fact is no secret to the CIA, and the CIA relies upon this source for much of its cocaine smuggling into the United States. Obviously, great financial and physical harm is inflicted upon the American people by the drug trafficking. A giant hoax is being played upon the American people by the so-called multi-billion-dollar-a-year drug war financed by the U.S. taxpayer. The fact that hundreds of federal officials are involved in the drug trafficking into the United States, including the nation's highest law enforcement agency, indicates the magnitude of the subversive activities against the United States. Very few newspapers reported anything related to the CIA statement, the charges made on the 60 Minutes show, or the significance of the serious charges. They engaged in their standard cover-up. Standard excuses used for obstructing justice. The standard CIA excuse, when questioned about its drug smuggling, is that it is a sting operation, or to obtain information about drug smugglers. DIA agent Grimm said on 60 Minutes that these explanations were ludicrous. When Justice Department officials were questioned, they replied that there was no evidence of criminal wrongdoing. Justice Department officials said their investigation revealed instances of poor judgment and management, leading to disciplinary actions for several CIA officers. The CIA station chief involved in the massive drug trafficking, James Campbell, was promoted and then retired. When asked by Mike Wallace of 60 Minutes about the CIA drug smuggling, Senator Dennis DeConcini replied, "I think they made a mistake." DeConcini. 443 New York Times, November 20, 1993. 422. Helped protect the massive looting of the savings and loans, and covered up the criminal activities that I reported to him over a period of years. DeConcini did admit that the mistake leading to over a ton of cocaine reaching the United States can kill people, and probably did. The senator, a former prosecutor, excused the failure to prosecute any of the CIA people. Not a single government employee responsible for bringing this huge quantity of drugs into the United States was punished. Double standard. Tom Brown, the pastor of a small church in Arkansas, helped expose the unlawful arms and drug trafficking in Arkansas that was part of the government's involvement in Central and South America. To silence and discredit him, the same Justice Department officials who aided and abetted the massive drug smuggling into the United States retaliated against Brown. The church grew and used peyote and pot in their services as part of their religious beliefs. No payment was received with this practice. Justice Department prosecutors charged Brown with a criminal offense, and U.S. District Judge H. Franklin Waters of Fayetteville, Arkansas, sentenced him to 10 years in prison. Brown wrote that Judge Waters was involved with Don Tyson of Tyson Foods as corporate attorney in the 1970s, while Tyson was involved with drugs. Brown heard that Waters was appointed a federal judge in the Western District of Arkansas to protect high-level government personnel from being exposed. Duplicating what I repeatedly encountered, Judge Waters played a significant role in covering up the MENA operation since 1982. Death to a protesting airline pilot. Evergreen Airlines, based in McMinnville, Oregon and Marana, Arizona, was a long-time CIA operation, hauling weapons from the United States and hauling drugs into the United States. As in every operation involving corrupt federal officials, especially those connected to the CIA, death is often the consequence of voicing objections to the criminal activities in which these agencies have been involved. Dean Moss suffered the ultimate consequences. On an Evergreen DC-9 flight on contract to the military, Logair, the captain mysteriously died. This flight, that would be fatal for Moss, occurred on February 9, 1989. Dean Moss had as his co-pilot Philip E. Bartash, as the DC-9 took off from Hill Air Force Base in Ogden, Utah, headed for San Antonio. The aircraft failed to pressurize as it climbed to altitude, and Moss reportedly left the cockpit with a portable oxygen bottle to determine the cause of the pressurization failure. When Moss did not return to the cockpit, Bartash wrote in subsequent reports that he descended to 13,000 feet altitude, put the plane on autopilot, and then went back to the cabin looking for the captain. He found the captain lying on the floor of the aircraft's cargo compartment. Bartash then called Lubbock International Airport, notifying the tower that he had a medical emergency on board, and that he was coming in for a landing. A medical team was in place when the aircraft landed, and doctors at Lubbock General Hospital pronounced Moss dead. The doctors reported the cause of death as cardiac arrest due to massive hemorrhage of the stomach from a caustic substance that ate up his stomach. It is a common intelligence agency assassination. 423. Tactic to force drano or some other toxic chemical down the victim's throat, resulting in massive hemorrhaging from the stomach. It is believed that a security guard was on the aircraft and that the security guard hid and then disappeared after the aircraft landed. Lubbock Judge L.J. Blalock and pathologist Ralph R. Erdman reported the death as a homicide, which was listed in that manner on the Lubbock police report. The television show, 60 Minutes, ran a June 27, 1993, story on the flight, seeking to portray Dr. Erdman as incompetent for reporting the death as a homicide. This is the same 60 Minutes who said they were too busy when Colonel Rowe contacted them to reveal the CIA and Defense Department drug pipeline involving Operation Watchtower. Death of a Marine Corps whistleblower. A June 17, 1993, television show, Connie Chung's premiere Eye to Eye, addressed the matter of assassination of an informant and drug trafficking into the United States in military aircraft. The show focused initially on a Marine Corps pilot, Colonel James Sabo, assassinated in his on-base housing several days before exposing large-scale CIA drug trafficking using military aircraft. He was shot in the mouth. One of the guests, a pilot and former Army captain, Tosh Plumley, admitted he flew many flights loaded with cocaine from Central America into Air Force bases. Some of these military bases were named by my CIA contacts: Homestead Air Force Base, China Lake, 29 Palms. He stated that he flew civilian and military aircraft into these bases, and flew for the CIA and other government agencies. A private investigator and former military investigator, Gene Wheaton, appeared on the show, confirming that he discovered this to be true. He also made reference to the shipment of arms to both sides in the Nicaraguan War. The military tried to make Sabo's killing look like a suicide, even though there were no fingerprints on the shotgun found next to the body. The victim's brother, Dr. David Sabo, a neurologist, said on the show, "There's no question in my mind that this was ordered by the military, it was carried out by the military. He was set up by the military and by people he knew very, very well. I will prove it." Murders of GI informants listed as suicides. It is believed that many military people are listed as suicides when in reality they were reportedly killed after threatening to expose epidemic drug trafficking in the U.S. military. Relatives of U.S. servicemen, who military officials said committed suicide, formed an organization called Until We Have Answers, and demanded investigations into the deaths. For the number of questionable suicides represented by the families was 72 in late 1993. Congressman David Levy and Frank Pallone requested that Secretary of Defense Leigh Aspin direct the Department of Defense to conduct investigations into the deaths. They also added a rider to the Defense Authorization Bill requiring the Inspector General to reinvestigate any finding of suicide, if requested by the family. 444 Unclassified, October-November 1993. 424. Air Force Captain Edward Consuegra disappeared in December 1992, after he discovered serious irregularities in a government contract with Unisys Corporation. That contract had been arranged by a former CIA official, Deputy Director of the CIA, Frank Carlucci. Unclassified wrote that there were eerie similarities to the Inslaw case here. They pointed out that in each case there was a major computer contract, large-scale corruption involving a government official with intelligence agency connections, and a person who learned too much and who threatened to expose the criminality. Mossad agent describing CIA drug trafficking describing the conduct of U.S. officials. Ben Menashe writes in his book, Prophets of War, that whenever U.S. officials were caught red-handed doing something illegal, they usually lied like crazy and accused everyone else. Ben Menashe's book tells about the drug trafficking into the United States by the CIA and the Israeli intelligence community, and how the profits went into the coffers of these intelligence agencies and into private companies controlled by key government personnel. He tells how the Mossad and Israeli agents profited from drug trafficking into the United States from Central and South America and how the CIA protected and assisted in this operation. People working closely with George Bush were key participants in the CIA drug trafficking from Central America into the United States. John Hull, a friend of Dan Quayle and George Bush, was heavily involved in the drug trafficking by making a fuel stop available on property that he owned in Costa Rica. Another close friend of Bush was Felix Rodriguez, who played a key role in the illegal arms and drug trafficking that were key parts of the Contra scandal. CIA operative Gunther Russbacher mentioned the frequent visits of Senator Dan Quayle to the CIA's arms and drug transshipment point known as John Hull's Ranch in Costa Rica. He stated that Quayle was deeply involved with the Contra operation and drugs, as well as being closely associated with noted drug trafficker Felix Rodriguez. Russbacher said, "Quayle was one of our bag boys. Sham basis for invading a foreign country and killing its citizens in 1990, President Bush ordered the U.S. military to invade Panama on the basis that Colonel Manuel Noriega was violating U.S. laws by allowing drug trafficking through Panama. This was bizarre in light of the fact that CIA operative and then director of the CIA, George Bush, paid Noriega for years to engage in drug-related activities with the CIA and the Mossad, including the drug trafficking associated with the so-called Iran-Contra affair. The invasion of Panama caused hundreds of deaths, including 26 U.S. servicemen, and billions of dollars in damages, on the pretense that Noriega was dealing in drugs and presumably U.S. agencies were not. People in control of U.S. intelligence agencies were themselves engaging in drug trafficking against. 445 It was reported that the so-called John Hull's ranch actually belonged to Douglas Sipple and John Hood, who hired Hull to reside on and manage the property. 425. Their own country, and by nature of their positions of trust, their crimes were arguably worse than those committed by Noriega. President George Bush ordered the invasion of Panama to capture and bring to the United States Manuel Noriega, on the pretense of halting drug trafficking. Noriega did in fact aid in drug trafficking, assisting the CIA, DIA, and other U.S. entities, and the Mossad. He assisted Oliver North and his associates, including Vice President Bush, in the unlawful arms flow to Central America and the drug-laden aircraft returning to the United States. The actual reason for President Bush's invasion of Panama is only speculation at this time. Further, Noriega's activities occurred in Panama, and as head of state he had the right to hold these activities legal, just as some people in the United States have argued for legalization for drugs. Many CIA personnel believe that Noriega was taken out because he knew too much about the involvement of U.S. officials, and that he was demanding too high a cut for his part in the CIA drug trafficking. After the invasion, the United States saw that key banking positions, used for money laundering, were filled by people who would continue the drug money laundering. This continued an uninterrupted conduit for U.S. intelligence agencies' drug money laundering. More judicial cover-up. The federal judge presiding over the trial of Manuel Noriega barred attorneys supposedly defending Noriega from presenting any information on the CIA's role, or that of George Bush, in drug trafficking or anything of a political nature. The U.S. District Judge repeatedly refused to allow CIA documents to be introduced that Noriega needed to defend himself. Noriega's U.S. attorneys limited their defense arguments so as not to expose the CIA involvement in drug trafficking. To obtain a conviction, Justice Department prosecutors rewarded known drug smugglers with reduced prison terms, protected them against the consequences of their perjury, and compensated them for testifying against Noriega. In a November 27, 1991, article, The Arizona Republic described the huge payments to major drug traffickers who testified as Justice Department officials wanted them to testify, so as to bring about General Noriega's conviction on drug charges. In some cases the funds paid out of the U.S. Treasury by Justice Department personnel paid for testimony from drug traffickers that were guilty of major drug smuggling into the United States. Justice Department prosecutors dropped charges and reduced prison terms for many of the witnesses. 3 of them, facing life terms with no possibility of parole, and with a collective 546 years in prison, were released and given immunity from further prosecution. They were given large financial payments, and their families brought to the United States. The star witness against Noriega was his former pilot, Floyd Carlton, who faced life imprisonment with no parole, for having flown cocaine into the United States. Justice Department prosecutors allowed Carlton to transfer his drug-related assets from Panama to the United States, with no risk of forfeiture or income taxes. Carlton was also given several $100,000, along with permanent U.S. residency for himself, his wife and children, and a nanny. 426. Another Panamanian who was paid for his testimony was Ricardo Bilonic, who reportedly earned $47 million during a 3-year period drug trafficking. He faced 50 years in prison, unless he testified as Justice Department prosecutors wanted him to testify. His prison sentence was greatly reduced, he was allowed to keep millions of his drug-related income, and relieved of income tax liabilities. Colombian pilot Roberto Streetinger, considered by Justice Department personnel as one of the top drug traffickers, and who flew cocaine into the United States, was given a greatly reduced prison sentence. Justice Department personnel returned to Streetinger his seized bank accounts, Mercedes-Benz automobile, a 40-foot yacht, an airplane, and 2 guns, including AK-47 assault rifles, Uzi, and MAC-10 submachine guns. Ironically, the usual cover-up argument to deny the existence of government corruption, such as October Surprise, is that testimony from felons cannot be relied upon. But when it suits government personnel, the testimony of felons is not only considered reliable, but payments are made to testify as prosecutors wanted them to testify. Further, perjured testimony is protected against prosecution. On July 10, 1992, a federal jury in Miami sentenced Manuel Noriega to 40 years in federal prison for trafficking in drugs. Replacing Noriega with a team heavily involved in drug activities, the drug trafficking through Panama into the United States didn't stop with Noriega's kidnapping. The Bush administration arranged for the new president of Panama to be Guillermo Endura, president of a Panamanian bank extensively used by Colombia's Medellin drug cartel. The formation of this cartel was orchestrated by the CIA. Picked for vice president was Guillermo Ford, part owner of the Dadeland Bank of Florida. He reportedly was heavily involved in drug money laundering. Ford was also chairman of Panama's Banking Commission. Another official selected by the Bush administration to be Attorney General of Panama was Rogelio Cruz. The New York Times said of Michael Harari in a January 2, 1990, article, an Israeli reputed to be Gen. Manuel Antonio Noriega's closest associate may have eluded capture on the night of the United States invasion because he was warned to flee 6 hours before the American troops swept into the capital, the deputy commander of Panama's new police force said today. Harari, working closely with Noriega in the drug trafficking, undoubtedly warned Noriega of the impending attack, which undoubtedly played a role in the casualties suffered by the invaders. 26 American GLS were killed, but this is still small in comparison to the hundreds of innocent people killed in Panama as a result of President Bush's invasion orders. Compounding the harm inflicted upon Panama, the American public will pay over $1 billion in taxes for aid sent to Panama after the U.S. invasion. Harari, a Mossad colonel, was well known in Europe and elsewhere as one. 446 The Arizona Republic, November 27, 1991. 427. Of Mossad's primary killers. He carried out numerous assassinations in Europe. After killing a waiter by mistake in Norway, Israel sent him to Central America, where he took control of the Mossad's widespread drug trafficking, collaborating with U.S. personnel in sending shipments to the United States. Speaking of Israeli control of Panamanian drug activities, the Washington Jewish Week stated, "Do not reflect well on Israel or the Panama Jewish community, they are engaged in contraband and money laundering. In general, they engage in very aggressive and unfair business practices." Numerous CIA operatives have written about the criminal activities of the CIA. Philip Agee, for instance, has written books on the CIA drug trafficking. Agee had been with the CIA for many years. The Associated Press printed quotes from Agee's speech at Oregon State University in Corvallis. Bush is up to his neck in illegal drug running on behalf of the Contras. Much of the heroin entering the United States comes from Southeast Asia in the Golden Triangle area. A March 26, 1990, U.S. News & World Report article stated, for more than a decade, Kun S.A., the warlord of opium, has flooded Washington with offers to end the poppy production within his Golden Triangle fiefdom in exchange for financial aid. The U.S. has not responded, and this year the region's crop could double from the levels of just a few years ago. ATT. Gen. Dick Thornburg unsealed an indictment against the man considered responsible for 40% of the U.S. heroin supply. But S.A. is not likely to be booked soon. In the remote hills of Burma, a private army of thousands protect him. Cross-checking and confirmation. These new deep-cover intelligence agency people provided confirmation of each other's status and of the statements given to me by others, and this included Gunther Russbacher. Further, as other covert operatives gave me information about the criminal and subversive activities of officials in control of federal agencies and operations, Russbacher loosened up and exposed sensitive and corrupt activities of which he had knowledge. CIA-engineered wars and drug trafficking. The CIA-engineered Vietnam War provided the logistics making possible massive transportation of drugs from the Golden Triangle area of Asia into the United States. The CIA-engineered conflict in Nicaragua resulted in and made possible massive transportation of drugs from Central and South America into the United States. These developed into multi-billion-dollar-a-year profits for the CIA. Most of the profits were reportedly hidden in offshore financial institutions. It is no longer far-fetched to consider that the CIA may have deliberately generated these conflicts primarily to develop its drug trafficking operation into the United States. Nor is it far-fetched to consider that these acts and consequences may be part of a scheme to financially and morally destroy the United States. The mindset within the CIA, including the Phoenix program that assassinated 40,000 Vietnam villagers, the Vietnam War that killed millions, and the CIA's massive drug trafficking into the United States, is such that deliberate infliction 428 of harm against Americans, and people of other countries, cannot be questioned. CIA asset Terry Reid blows the whistle. Terry Reid, a former CIA asset, and co-author John Cummings, authored a 1994 book describing what Reid discovered as a CIA asset in Arkansas, compromised Clinton, Bush, and the CIA. 7 Reid, a former U.S. Air Force intelligence officer, a successful businessman specializing in advanced computer-controlled manufacturing, was recruited by the CIA to train Contra pilots in Arkansas, and later to start up a CIA proprietary in Guadalajara, Mexico. Reid's activities in the Mena, Arkansas area brought him into contact with the CIA and National Security Council's arms and drug trafficking, and the cover-up by Governor Bill Clinton and members of his staff. Reid's first employment with the CIA was as a flight instructor for Contra pilots in Mena and Nella, Arkansas. He worked with Barry Seal, another CIA asset, who described to Reid the involvement of Arkansas officials in CIA-related drug trafficking and drug money laundering. Reid was in frequent contact with people who later became front-page news. Before Reid learned about the full extent of the drug smuggling operation, Reid frequently worked with Barry Seal until Seal was killed. Seal told Reid that millions of dollars of drug money was being laundered through the Arkansas Development Finance Authority, the Dan Lassater Brokerage Company, and involving officials close to Governor Bill Clinton. Seal told Reid that bags containing large amounts of drug money were dropped into remote locations near Nella, and then picked up by helicopters or surface vehicles. Drug money and Arkansas bond business. After Seal was killed, Lassater's bond business dropped heavily, suggesting that Seal was indeed laundering money through Lassater's business. Reid described how Oliver North and William Barr authorized him to start a CIA proprietary in Mexico whose function allegedly would be to ship arms to Central and South America. The business was to be a high-technology trading and consulting firm, but unknown to Reed, developed into a CIA gun-running and drug operation. Reed moved his family to Mexico, thinking the operation was legitimate and of long duration. Without knowing about the CIA and NSC involvement in the drug smuggling operation, Reed worked closely with Oliver North, Felix Rodriguez, Barry Seal, and others. Reed's suspicions about the CIA drug operations through the proprietary that he headed was confirmed in July 1987, and he advised his CIA handler that he wanted out of the operation. Under cover of darkness, Reed moved his family back to Arkansas, and went into hiding. He encountered government prosecution as I encountered when I and others encountered after we discovered and sought to expose high-level corruption. For 3 years the Reeds had to fight Justice Department attorneys to avoid prison. Fortunately, and very unusual, the public defender appointed to defend the Reeds was a young female attorney who actually fought to protect her client, rather than protect government officials with whom she must work during her career. 447 authored by Terry Reed and John Cummings. 429. Oliver North's donation scheme. Oliver North was reportedly involved in the scheme described in earlier pages in which stolen planes were used to fly arms south from the United States and drugs on the return trips. Reed described how Oliver North explained the stolen plane operation to him in 1983 when they met in Oklahoma City. Reed explained how the CIA needed an arms manufacturing company for shipping weapons to Central America, and that it purchased the Iver Johnson Arms Incorporated, moving it from New Jersey to Arkansas. Like many other CIA proprietaries, the person listed as the owner was a cover for the CIA. In this case it was reportedly Philip Lloyd. Reed described a late-night meeting in a World War I ammunition bunker outside of Little Rock, Arkansas, discussing drug trafficking and drug money laundering in Arkansas. Reed stated that the people he saw at this meeting included Governor Bill Clinton, Clinton's chief of security, Arkansas State Police Lieutenant Raymond Young, Clinton's aide in charge of the Arkansas Development Finance Authority, Bob Nash, attorney Robert Johnson of the CIA proprietary, Southern Air Transport, Reed's handler, John Cathy, Max Gomez. Clinton's chief of security, Lieutenant Raymond Young, waited outside the bunker while the meeting occurred. Young was the same Arkansas State Police officer who filed and carried out the fraudulent charges against Reed at a later date. Reed's incarceration would protect Governor Clinton, Young, Nash, the CIA, and the others implicated in the drug operations. Reed had been in frequent telephone contact with the man he knew as Robert Johnson. Johnson directed the drug trafficking and drug money laundering, the training of Contra pilots and fighters in Arkansas, and authorized Reed to set up the CIA proprietary in Mexico. At a later date, Reed learned that Robert Johnson was really William Barr, appointed by President George Bush to be Attorney General of the United States, the nation's top law enforcement position. Bob Nash was an aide to Governor Clinton, head of the Arkansas Development Finance Authority, and liaison with the CIA in drug money laundering through ADFA. The purpose of this meeting was to protest Arkansas officials taking too great a percentage of the drug money laundered by Missouri officials, and the attention caused by the drug conviction of Bill Clinton's brother, Roger Clinton. Reed described in Compromised Barry Seal dropping from aircraft bags of money into isolated clearings in Arkansas, including on property owned by Little Rock industrialist Seth Ward, upon which resided Ward's son-in-law, Vince Shellnut. Shellnut worked for bond broker Dan Lassater. Reed described how the bags of money, sometimes millions of dollars at a time, would be dropped onto Ward's property, picked up by Shellnut, and then laundered through Lassater's bond brokerage business. Ward owned and operated a company called Park on Meter, which made parking meters, and made weapon parts for the CIA that were shipped in violation of the Boland Amendment to Central America. Ward's oldest daughter, Susie, was married to Webster Hubbell, a partner in the Rose Law. 430. Firm, who was later number 3 man in the U.S. Department of Justice and de facto head of the Justice Department, while Janet Reno served as the titular head. Lassater Incorporated handled much of the drug money laundering in Arkansas until Dan Lassater was convicted of drug trafficking and sent to prison. Testifying against Lassater was Bill Clinton's brother, Roger, who was also charged with drug trafficking but given a reduced sentence in exchange for his testimony against Lassater. Damage control Reed CIA contact, William Barr, known at that time by his alias, Robert Johnson, told Reed that Attorney General Edwin Meese had appointed Michael Fitzhugh to be U.S. Attorney in western Arkansas, and that he would stonewall any investigation into the Mena, Arkansas drug-related activities. Linked to global drug money launderer, BCCI. After the CIA temporarily pulled part of the drug money laundering out of Arkansas, which had funded ADFA, Arkansas had to borrow funds from First American Bank in Washington, a part of BCCI, another operation that was closely linked to the CIA. This money source was arranged through one of Stevens' companies, the same company that played a key role in getting BCCI into the United States, while violating laws prohibiting ownership of American banks by foreigners. In 1977, Stevens arranged for BCCI to secretly purchase Financial General Bank shares, a bank holding company. This holding company was then renamed First American Bank Shares. Clark Clifford, former Secretary of Defense, and his law partner, Robert Altman, assisted in this unlawful acquisition. Worthen National Bank, a subsidiary of Stevens Incorporated, denied in 1991 knowing anything about BCCI. The CIA laundered much of the funds obtained through drug trafficking and other racketeering enterprises into offshore banks, and then part of the money would come back into the United States through purchasing of real estate and corporations, or making loans. Drug cartels do the same. One of many tactics used to launder drug money by Lassater. Lassater used a straw man for many of his shady security trades, Dennis Patrick. Lassater induced Patrick to open a brokerage account at the Lassater Company, being promised huge profits without putting any money into the account. Patrick was a clerk in the Whately County Circuit Court. Without signing any papers and without putting up any money, Patrick was notified that he made $20,000 profit, and asked to come in and sign papers. Another attempted murder. When an investigation commenced into Lassater's operation, Patrick became a liability. 3 attempts were made to kill him, and 3 people in 3 different criminal trials were sentenced to prison for these attempts on Patrick's life. 448 Spotlight, November 23, 1992. 431. Attacking a potential whistleblower. With the knowledge that he acquired during his CIA connections in Arkansas, the CIA and Arkansas officials, including Governor Clinton, saw Reed as a threat of exposure. Arkansas State Police fraudulently charged Reed and his wife with fraud, conspiracy, and mail fraud, relating to the theft several years earlier of Reed's aircraft, and allegedly making a false claim to the insurance company. For 3 years the Reeds had to fight Arkansas State Police agencies, which included Governor Bill Clinton's chief of security, Raymond Young. Reed reported that Young forged documents, used perjured testimony, falsified evidence, seeking to put Reed and his wife in prison. Reed describes how U.S. District Judge Frank Thies blocked their defenses, and dismissed evidence showing the sham nature of the charges, claiming the evidence was irrelevant. During their attempts to defend themselves against the false charges, Time magazine sought to discredit the Reeds and what they were exposing. The April 20, 1992, Time article was entitled, "Anatomy of a Smear," with the subtitle, "Terry Reed Loves to Tell Reporters Scandalous Tales About Bill Clinton and the Contras. The trouble is the stories are false." Time falsely stated that Reed had no connections to the CIA or Barry Seal, despite the massive amount of specific data given to the 7IME reporter, Richard Beer. The article stated that the only trouble with Reed's sensational tale is that, not a word of it is true. Time was obstructing justice by misstating the facts and seeking to cover up for the criminal activities by the CIA and the Clinton Group. In response, Freedom magazine, which had been exposing the CIA drug trafficking in Arkansas, published a May 1993 article entitled, "The Drugging of America, expanding on the criminal activities by exposing the time cover-up and obstruction of justice. Freedom magazine wrote, according to knowledgeable sources interviewed by Freedom, Terry Reid was one of the players in CIA covert operations based at MENA. The Reids filed a 31-page lawsuit against Time magazine in Little Rock on April 8, 1993. Time magazine was one of the publications that I repeatedly notified of the criminal activities I discovered, starting while was a federal investigator. Never once did the magazine report the criminal and treasonous conduct perpetrated against the American people. Wall Street Journal cover-up an article by author Edward J. Epstein, appearing in the April 20, 1994, Wall Street Journal, sought to discredit Terry Reid and cover up for his exposure of the crimes involving Arkansas officials and the CIA. Reid's co-author, John Cummings, was a former prize-winning investigative reporter at New York's Newsday. #9 Reid had nothing to gain by his exposure activities, and Cummings had sufficient experience and credentials to evaluate the truth of what he discovered, and which he wrote about in Compromise. In seeking to cover up 449, Cummings had co-authored Heist, Gambetta, The Improbable Rise and Fall of John Gotti and His Gang, and Death Do Us Part. 432. For these serious crimes, which would have also exposed Israel's sordid conduct, Epstein wrote that the disclosures of criminal misconduct in Compromise must be fabrications because Justice Department officials refused to prosecute or even to present the evidence to a grand jury. Epstein wrote that the book presented no credible evidence showing Clinton's involvement in the CIA activities, or that Oliver North was involved. Epstein addressed the obstruction of justice by Justice Department officials as Justice Department's reluctance to bring a case against Contra support activities that were approved by the President and the CIA Director. Epstein sought to ridicule anyone who claimed the CIA and Clinton were involved in Arkansas drug trafficking and drug money laundering. It would be difficult for any journalist who does any amount of reading of the numerous exposé books and articles describing the details of these criminal activities to doubt that they exist. The American public paid heavily for this type of cover-up. Epstein's article surely was appreciated by the corrupt element in government. Rebuttal: in response to Epstein's article, CBS News correspondent Bill Plant and CBS News producer Michael Singer responded in a May 3, 1994, letters to the editor column, appearing in the Wall Street Journal. There is a trail tens of millions of dollars in cocaine profits. It is a trail that has been blocked by the National Security Council. As the CBS News story revealed, Mr. Clinton was asked by a state prosecutor for help to pursue the case. Help was promised but never arrived. Mr. Parrott, who had done his own investigation of MENA, was concerned enough about the drugs for guns operation to call Mr. Clinton. And former Clinton staff people have told CBS News that the governor was aware of what was going on there. MENA is a perplexing and difficult story. There is a trail tens of millions of dollars in cocaine profits, and we don't know where it leads. It is a trail that has been blocked by the National Security Council. The FAA, FBI, Customs, CIA, Justice, DIA, and the IRS were all involved in MENA. President Clinton's drug policies. Clinton's drug activities in Arkansas could be expected to be followed up with sympathetic activities after he became President of the United States. And this he did. The California legal newspaper, Daily Journal, wrote in its July 21, 1994, issue that the Clinton administration has been undermining existing anti-drug efforts on all fronts. The article stated charged President Clinton with dismantling almost the entire White House office created to lead the fight. It stated, Surgeon General Jocelyn Elder's repeated calls for drug legalization, government-led domestic marijuana eradication has been substantially curtailed. The President has ordered a massive reduction in Defense Department support for drug interdiction, proposed that Congress cut $100 million in drug treatment funding and $130 million in drug prevention education. For 1995, the President wants to cut 625 positions from federal drug enforcement agencies, the DEA, FBI, Border Patrol, U.S. Customs Service and others, and reduce federal drug 433. prosecution personnel by more than 100 positions. All of these steps in the face of the massive threats associated with drug trafficking would be normal for someone directly or indirectly involved with the drug trafficking into the United States. These activities are also synonymous with Clinton's efforts to block investigation and prosecution of the Arkansas drug activities while he was governor, and synonymous with the charges that he was closely allied to Arkansas drug activities. FAA cover-up of drug trafficking. The number of concerned government employees exposing the cover-up and obstruction of justice by federal personnel escalated as my activities became known. Shortly after Christmas 1994, several present and former FAA investigators assigned to the agency's drug task force revealed to me the obstacles they faced from FAA management in retaliation for reporting drug activity involving aircraft that they discovered during their official duties. One of them, David Jennings, told me how he was fired by FAA management for continuing to make such reports. He and other FAA inspectors assigned to the security and drug divisions revealed numerous instances of FAA management interference with this agency's lawful responsibilities. Their statements showed that the same problems I found as a federal investigator for the FAA have not changed, and if anything, worsened. During this same time period, considerable media and congressional attention focused on the FAA because of numerous airline crashes. But as usual, none of the attention was focused on the hardcore corruption that I tried to expose for the past 30 years. Pious-sounding statements continued to deceive the American public. CIA drug trafficking unknown only to the American public. One of the many bizarre aspects of this massive drug trafficking, involving key government agencies and branches of government, including the White House, is the illiteracy and indifference of the American public when so many highly documented books have been written about the activities. Hundreds of witnesses have testified before Congress for degree about their direct knowledge and/or participation in this drug trafficking. Many television shows have addressed this fact, with witnesses who were part of it. The criminal elements are aware of it. Those connected with the intelligence agencies are aware of it. Numerous articles appear in newsletters pertaining to these agencies describing the drug trafficking. The media, with its awareness of these facts, certainly knew about it. The cover-up by the print and broadcast media personnel, who have access to these reports, constitute far more than illiteracy or indifference. These acts are crimes under federal criminal statutes, far worse than federal offenses for which many people are in prison. 450 Senator John Kerry's office released on October 14, 1986 a classified report describing the testimony of over 4 dozen witnesses before the committee that he headed. This report described the drug trafficking into the United States by persons associated with the CIA and other government agencies. 13 of the government people identified in the drug trafficking were among the defendants in the Christic Institute's lawsuit. No actions were taken by any law enforcement agency against these government employees. 434. Obstruction of justice by independent prosecutor Walsh. In 1991, Arkansas Attorney General Winston Bryant gave independent prosecutor Lawrence E. Walsh boxes of evidence showing the CIA's role in Arkansas drug trafficking. This evidence consisted of depositions, Arkansas State Police reports, investigative files, sworn statements, FBI reports, and court documents, proving the existence of drug-related activities in the Iran-Contra operation involving the CIA, the National Security Council, the Mossad, and other government officials. Walsh covered up for it, even though this was the most important part of the Iran-Contra affair that he was charged to investigate. Walsh's cover-up was a crime far worse, and with far greater impact upon the United States, than the offenses that he spent over $40 million investigating. I also presented Walsh with evidence concerning criminal activities implicating federal officials, and encountered the same cover-up. Walsh had an even greater responsibility to make this evidence known than the average citizen, under federal crime reporting statutes. In talking to the press, Congressman Alexander said, "I've never seen a whitewash job as good as has been executed in this case. It is unbelievable to me that such crimes can be gotten away with in this country." Obstruction of justice by Congress. The May and June 1989 edition of Freedom magazine said, two congressional subcommittees and the U.S. Customs Service are investigating secret activities around the quiet mountain town of Mena, Arkansas, including alleged drug running and arms smuggling. Congressional testimony proving the existence of government-related drug trafficking is routinely kept from the American people, despite knowledge of the great harm being inflicted by the criminal activities, and the evidence of a secret and destructive element that has taken over key segments of the United States government. Hundreds of insiders, including former CIA, DIA, and other deep cover operatives, have testified to Congress for years about these drug activities, and this testimony, and the crimes they clearly prove, have been kept from the public. This cover-up, this obstruction of justice, has permitted great harm to be inflicted upon the United States and the American people. At this stage, most of the media, most of Congress, definitely those in control of the Justice Department and other government agencies and branches of government that are implicated through cover-ups, have a vested interest in blocking the American public from finding out about these unprecedented crimes. Under federal criminal statutes, these cover-up activities have made members of Congress, the media, and others, co-conspirators in the crimes and treasonous activities. Threats to reporters by their editors. THAD repeatedly learned about the threats made against reporters not to report these criminal activities. This serious problem was written about in the May-June 1989 edition of Freedom magazine as it related to investigative television reporter Teresa Dickey and another reporter, who had investigated the Mena drug activities. The article stated, 435. In 1987, reporter Teresa Dickey put together a series of television news segments probing airport operations. According to Dickey, she received a phone call from Joe Evans, Fred Hampton's partner at Rich Mountain Aviation, who threatened her if story was not accurate, she would damn well regret it. After the third segment of the Mena Connection aired, Dickey said she was instructed that it was to be her last. Her news director called her in and said bluntly, "There will be no more calls to Mena, Arkansas, or you will be out of a job." Another media source felt he could not comment because of duress he had experienced earlier while investigating drug smuggling around Mena. "I'll be out of a job if my employer knows I even talked to you guys," was all that he would say. British investigation. An investigation into drug trafficking was conducted by a British law commission headed by Lord Louis Blom Cooper, which then conducted a year of hearings. The London Times referred to the commission's report as a scorcher, which found, the use of Antigua by the Mossad for drug trafficking and for training and arming the private armies of Colombia's drug barons. Lying by CIA officials to the White House, claiming that the Israeli operations in Antigua were to train rebel forces to oust Panama's Manuel Noriega. Mossad's training of hundreds of Colombians into killers for assassination purposes. A long-standing practice by U.S. authorities to cover for the crimes of the Mossad group, which supported my findings and as described by my CIA and DIA sources. Exposed the role played by Israeli Major General Pinchas Shacher in the arms and drug operations. Shacher was the official representative for Israel military industries in the United States, with special access to the Pentagon and other guarded U.S. military installations. According to reports, CIA Director William Sessions wanted the British report entered into Shacher's file and to suspend his special privileges. Attorney General William Barr rejected the recommendation, keeping the American public in the dark about this part of the epidemic drug trafficking. The article described how the Bush White House sought to ignore the report, just as the many other reports have been hidden from the American public. The U.S. media became accomplices in the cover-up. Justice Department officials referred inquiries to the State Department, claiming it was a foreign affair matter, and the State Department referred inquiries to the Justice Department, claiming it was a criminal matter. This fact is difficult for the average American to comprehend, especially in light of the media cover-up of the activities. Few Americans can believe that the people in control of the CIA, DIA, and other intelligence agencies, would commit these serious crimes and inflict such great harm upon the American people. It also takes the concurrent cover-up by many others in the three branches of the federal government to make such a vast operation possible. These include the Attorney General, the Department of Justice, the Treasury Department, Customs, Drug Enforcement Administration, and many others. 436. Sham drug busts occasionally occur to give the public the impression that drug enforcement agencies are carrying out their drug interdiction responsibilities. One sham drug bust occurred in Miami in the early 1980s to justify hiring more federal personnel, and to reflect favorably on the newly appointed drug czar, Vice President George Bush. Another huge drug bust was set up in the Los Angeles area in 1989, at Sylmar, in which 20 tons of cocaine were seized. The purpose of this drug bust was twofold. One was for public relations, indicating to the American public that the huge amount of money and taking of constitutional rights were justified. The second purpose was to reduce the amount of drugs in circulation. The drug prices were plunging due to an oversupply, restricting the CIA's income from its drug trade. Some drug busts are made to eliminate competition from drug traffickers not connected with the intelligence agencies. Another reason is to bust a CIA drug trafficker who may be getting out of line or who knows too much. Washington Post cover-up. A Nexus magazine article described how Washington Post investigative reporters discovered massive drug trafficking through Mena, Arkansas, how the story was typeset and scheduled to run in the Sunday Outlook section on January 29, 1995, and the killing of the multiple-page story. The article was written by Dr. Roger Morris and Sally Denton, veteran investigators with established reputations. The Nexus article stated, Morris worked for the National Security Council staff at the White House during the Johnson and Nixon administrations. He has taught at Harvard and has written a series of acclaimed books on foreign policy. Denton is the former head of news agency UPI's Special Investigative Unit, and is the author of The Bluegrass Conspiracy, which exposed the involvement of Kentucky political and law enforcement figures in an international arms and drug smuggling ring. The broad picture is not new to readers of the Sunday Telegraph, which published a story making some of the same points on October 9 last year. The Wall Street Journal has also done original reporting on the subject. A copy of the article passed to the Sunday Telegraph, appears to be absolutely explosive. Based on an archive of more than 2,000 documents, it says that Western Arkansas was a center of international drug smuggling in the early 1980s, perhaps even the headquarters of the biggest drug trafficking operation in history. The activities were mixed up with a U.S. intelligence operation at the Mena Airport in Arkansas that was smuggling weapons to the Nicaraguan Contras. The article makes clear that the alleged scandal is not confined to the activities of the Arkansas political machine and Mr. Clinton. It embraces the highest levels of the federal government over several years. These are only a small fraction of the newspaper articles dealing with cover-ups, obstruction of justice, and other offenses by the American broadcast and print media. Deep cover asset Tosh Plumlee, another source providing me confidential insider information about the role of U.S. agencies smuggling drugs into the United States through Mexico. And 437. Other countries was a former deep cover military and CIA asset from 1956 to 1987, William Robert Tosh Plumlee. Among the many government operations in which he was involved while connected to military and CIA intelligence was fighting alongside Fidel Castro's rebel forces in Cuba, flying aircraft in Southeast Asia for Air America and other operations, and flying arms to Central America, and drugs on the return trips, all under orders from his government handlers. Ironically, Plumlee had worked for the same airline as I had in 1950, Pioneer Airlines, and worked at Redbird Airport in Dallas, where I worked as a ground and flight instructor in instrument and airline transport pilot courses. Tosh had flown and/or had contacts with key people in the Contra and drug operations, including Bill Cooper. Operation Whale Watch and Operation Watchtower. Plumlee confirmed the existence of Operation Whale Watch and Operation Watchtower, drug smuggling operations involving the CIA, U.S. military, National Security Council, and others. He described his drug flights from Central America to the United States for the CIA, with stops at places he marked on the maps. He described in great detail the close cooperation between Mexican and U.S. government personnel in the drug smuggling into the United States. He described a ranch, heavily protected by Mexican police, that was used for drug smuggling. He described one of the drug corridors running the length of the Baja Peninsula, with refueling stops, including an airstrip immediately north of Cabo San Lucas. He described another common drug route that he flew. Starting in Panama, he made stops at Santa Helena in Costa Rica, Puerto Escondido in southern Mexico, up through Baja and then to Mexicali. He delivered the drugs to airfields throughout the southwest. He described Borrego Desert airstrips and a location near Humboldt Mountain in Arizona where drugs would be pushed out of the aircraft. He described another airstrip near Buckskin Mountain close to the Colorado River, and at abandoned mines between Parker and Havasu City, Arizona. In the 1960s he flew missions evacuating defecting Russian missile technicians out of Cuba, trained Cuban pilots in Nicaragua and Happy Valley, prior to the Bay of Pigs fiasco. He flew in Southeast Asia, in Laos and Cambodia, in 1967, about the time of the Tet Offensive. Stings that never happened, Plumlee said. We were documenting the loads and the routes and waiting for the big busts. But the busts never seemed to add up to the amount of cocaine we were bringing in. He said that many of the men in the black crews with whom he worked felt extremely uneasy about the illegality of the drug shipments. They occasionally talked of exposing the drug trafficking as a group, and complained to their DIA and CIA contacts. They were told, "You've got to keep the big picture in mind, or you might blow a major sting operation." The pilots were given the line by their handlers that the drugs were for undercover operations to catch drug traffickers. 438. Plumlee said that the DIA, CIA, and FBI were spying on each other's covert deals, and occasionally busted each other's operatives. He described landing a DC-3 loaded with over 1,200 pounds of cocaine in Scottsdale, Arizona, where he was to meet an FBI contact, who failed to meet him. Plumlee then called the FBI, trying to contact the agent. Plumlee said, "The FBI thought I was some kind of nut." That trip had started from an airfield called The Farm, near McAllen, Texas. His instructions were to deliver the arms to the Contras, and then return with a load of drugs. Apples, pears, and bananas. Plumlee described some of the code words used in radio and other communications. Apples was the code word for small arms and ammunition. Oranges referred to artillery, C4 explosives, and primer cords. Pears referred to electronics. Bananas referred to personnel. Reporting over the radio, "Bananas are delivered," would refer to, for instance, a government dignitary deposited on the ground. Code 6 referred to the flyway through central Mexico, across the U.S. border at Piedras Negras, and into the Big Bend region of Texas. Code 7 referred to the air route along the Baja Peninsula, through San Felipe and Mexicali, to drop points in the Anza Borrego Desert, 29 Palms, or the former Patton bombing range east of the Salton Sea. Plumlee sent me a map containing the San Felipe phone number of a major drug trafficker at the Delgado Ranch, Luis Carlos Quintero Cruz. Plumlee was part of a major drug deal in 1986 involving Quintero that was related to the Contras. Some of the data Plumlee conveyed to me corroborated what Basil Abbott and other sources had described to me for the past several years, including the drug operations in the Bluefields area of Nicaragua. Arkansas drug drops. Plumlee described the airdrops of cocaine-containing bags in the areas around Russellville and Mena in Arkansas, mostly in national forest areas, and the subsequent pickup by helicopters. He described how he was involved in several of the helicopter pickups. He said that the aircraft would go north from the Bayou Buff area to Mena and also up to Antlers, Oklahoma. Most of these drops would be at night, with daytime pickups by helicopters. He described how helicopters would pick up the drug drops in daylight, with some company authorized to pick up blue-colored drug-laden bags, and another company pick up a different color. One of the helicopter companies that he mentioned was American Services. Plumlee said that he knew of about 125 pilots flying drugs for the CIA, the DIA, and the FBI, some of whom would infiltrate other government groups to determine what they were doing. Occasionally, one government agency would arrest a pilot flying for another government agency. The agency behind the arrested pilot might either call and obtain the pilot's release, or simply sacrifice the pilot and disavow any relationship. The pilot then goes to prison, sometimes for life. Method of payment. He described how CIA assets get paid, either by check from the CIA. 439. Proprietary or front companies, with which they operate undercover, or by cash. He said that his checks or money usually came from military intelligence sources, from Citgo, and sometimes regular military pay. He said to this day he still has not received a military discharge. Association with the famous Barry Seal. Plumlee described his role in Operation Grasshopper, a top-secret military operation in which famous drug trafficker Barry Seal was a part. Another operation in which he was involved was code-named AMSIG. Seal was also a part of that operation. Plumlee described the government's double cross of Seal, which led to Seal's assassination, the intent being to keep Seal from testifying about the government's drug and money laundering activities. He said that Seal was a military operative in the early days of AMSIG, a joint operation involving Mexican and American government personnel. It was involved in drug trafficking. Plumlee described an incident in Mexico where a prisoner, seeking to give him and his DIA agents information about the killing of an American pilot by a Mexican drug lord, was then killed by Mexican guards. In the early 1970s, Plumlee was attached to an operation in Miami, Florida called J. Imwe, which involved assassination attempts upon Fidel Castro. Plumlee was involved in black cover operations with the Pentagon while also working with the CIA. He became a CIA contract pilot, taking orders out of the Pentagon, and also worked through the staff of the National Security Council. Plumlee worked in the CIA's Jim Wave operation, which was another CIA assassination scheme to assassinate Castro. He worked for various CIA proprietary or front companies, including Riddle Airlines, the Dodge Corporation, Intermountain Aviation, Evergreen Helicopters 45. ACT Technology, Air America, CDG American Services, In Air, and other companies that he couldn't remember. As standard CIA procedures, he was given different CIA aliases when working in different undercover operations. These aliases included Buck Pearson, James Plumlee, James H. Rawlings, William H. Pearson, Juan Carbello, James H. Rawlings, and some that he couldn't remember. He flew many black operations, 452, including flying arms to Central America and drugs into the United States, being advised that these activities were in the national interest. He described the heavy involvement of the military, the Pentagon, the staff of the National Security Council, in these activities. He described how the military and intelligence groups worked with mafia people, casino-associated crime groups. He described assassination attempts on Dominican dictator Rafael Trujillo, Fidel Castro, kidnapping people in foreign countries. He described how these illegal operations were given the pious-sounding name of national security, the same label used to support secrecy on subversive and criminal activities against the United States. Plumlee described how one of the Contra commanders on the Southern Front, Eden Pastora, also known as Commander Zero, refused to engage in drug trafficking as the other Contras did. The CIA then tried to assassinate Pastora during a media conference held at La Penca, Costa Rica, during which Pastora was expected to expose the CIA drug trafficking. Presidential spin doctors, the Reagan and Bush administrations, were accusing the Sandinistas of drug trafficking, seeking public and congressional support for the war against this third world country. But Plumlee described how he discovered that it was the Contras, supported by the United States, who were heavily involved in drug trafficking. Actually, other sources who flew arms to Central America said they delivered arms to both the Contras and Sandinistas, and that both sides paid with drugs. U.S. Mexican government involvement in drug smuggling into the United States. Z. Plumlee described the heavy amount of arms trafficking from the United States into Mexico and then to El Salvador, and the drug trafficking on return flights. He described what another deep cover source had told me, that many of the arms came out of Juárez, Texas, at the Mexican border. Secrets codes to prevent interdiction. As other sources said to me, Plumlee described how the military gave him contact codes to get back into the country without being intercepted. Referring to the secret codes given to him that halted drug interdiction flights, Plumlee stated, "I have seen interdiction planes turn away after we squawked our transponders, and let us into the country, not molested, and not have customs waiting for us when we land. At a certain geographical point upon entering U.S. airspace, the pilot would call a particular ground station from the air and say, for instance, Bravo 1, after which the ground station would answer, OK Bravo 1, we have a lock. The pilot would then hit the squelch button on a preset transponder code, and if the code was correct, there would be no interdiction and customs would not be waiting the plane's arrival." Stealing arms from U.S. armories. Plumlee described the stealing of guns and ammunition from National Guard arsenals throughout the United States, which was then used to supply the Cuban rebels, the Contras, the Mexicans in Chiapas, Mexico, and other Third World countries. The purpose being to destabilize other countries or overthrow a particular government. Private arms merchants, working with the CIA, Department of Defense, and other Pentagon operations, obtain the documentation necessary to move the arms out of the United States. He made it clear that the National Security Staff, not necessarily the National Security Council, knew about the arms and drug trafficking. Risks of working undercover for the U.S. government. Anyone involved in undercover work for any of the government agencies is a disposable asset. The government can fraudulently charge the person with 44. A crime and sentence the person to prison for a long prison term. The government can discredit the person, can seize the person's life's assets, and the government can kill the person. U.S. tactic to keep the secrets. Speaking about how people in control of government agencies keep the government drug trafficking from the American people, Plumlee said, "We've lost a lot of people that's been killed or assassinated or discredited because for whatever reasons, they were going to blow the whistle on current operations they were involved with." When asked if government personnel would kill an operative that was getting ready to divulge a secret operation, Plumlee replied, "Elements within the agencies that are involved would definitely put hitmen out, if it was going to jeopardize their ongoing operation. Independent operatives within the agency sometimes take it upon themselves to protect the operation, and also to protect their profit margins." Plumlee discovered that the unlawful arms shipments and drug trafficking into the United States involved the CIA and other government entities, and even the National Security Council and the White House. Decoding devices given to drug cartels. He described how the drug cartels had sophisticated decoding devices that decoded DIA and CIA messages, and that the cartel decoded a message showing that one of the traffickers, named Rodriguez, had given testimony to the DIA. The cartel then beheaded the informer. Plumlee brought out that different agencies would file charges on people working for other agencies, so that they could show greater results and support their request for higher funding. Exposing the crimes to Congress. After Plumlee decided that the drug operations were not lawful undercover operations, but rather criminal in nature, he contacted members of Congress and the media, expecting, as I did in the past, that they would exercise their duty and receive information, and use it in such a way that the crimes would be halted. Plumlee testified under oath to several House and Senate committees, including the Senate Foreign Relations Committee. He described to them in detail the CIA and DIA drug trafficking into the United States through Mexico and other countries. He testified to the close cooperation between Mexican and U.S. officials in the drug smuggling operation. He described how witnesses who were suspected of exposing the U.S. involvement in drug smuggling were assassinated. The usual congressional obstruction of justice. In 1983, several years before the Contra scandal erupted in the U.S. media, precipitated by the shooting down of the Hasenfuss flight, Plumlee met several times with Senator Gary Hart's aide, Bill Holden, giving details, maps, and other evidence of the government's involvement in drug trafficking. The evidence included details, documentation, CIA maps, field maps, coded flyways, names, military code operations, that left no doubt that these activities did exist. This information was passed on to various congressional committees, none of whom 442 allowed the American public to know about it. Senator Hart conveyed the information to Senator John Kerry, chairman of the Subcommittee on Terrorism, Narcotics, and International Communications. Several of my other informants who were an active part of the arms and drug trafficking also contacted Senator Kerry, among others. In a February 14, 1991, letter to Senator John Kerry, Senator Hart stated, Mr. Plumlee raised several issues including that covert U.S. intelligence agencies were directly involved in the smuggling and distribution of drugs. He provided my staff with detailed maps and names of alleged covert landing strips in Mexico, Costa Rica, Louisiana, Arizona, Florida, and California where he alleged aircraft cargoes of drugs were offloaded and replaced with contra-military supplies. He also stated that these operations were not CIA operations but rather under the direction of the White House, Pentagon, and NSC personnel. My staff brought these allegations to the attention of the Senate Armed Services Committee and the Senate Intelligence Committee at the time, but no action was initiated by either committee. In 1991, journalist Art Goodtimes of the 7 Telluride Times-Journal wrote a January 13, 1991, letter to Senator John Kerry, offering to provide maps, data, testimony of former CIA agent Tosh Plumlee. The letter advised that Plumlee was involved in flying in Central America and had evidence of the U.S. government's involvement in illegal drug trafficking through Mexico, El Salvador, and Panama. The letter described Plumlee's evidence of government's involvement with illegal drug operations, infiltrated by military undercover operatives, Plumlee's intent to get a federal investigation into the illegal covert activities instigated by various agencies of our government in Central America. A DIA report dated February 13, 1990, marked secret, stated in part, Buendia *3 had allegedly gathered information on the relationship the CIA had with known narcotic traffickers in Veracruz area. The CIA narcotic trafficker situation was very delicate. Information on CIA arms smuggling and the connection the CIA had to narcotic traffickers. Shortly thereafter, Eden Pastor, aka Commander Zero, who had given Buendia information on CIA arms smuggling, allegedly suffered a CIA-sponsored bomb attack while traveling in Costa Rica. It was later learned that Buendia had allegedly obtained information that would expose high-ranking members of the PRI political party who were assisting the CIA with arms smuggling and knew of the CIA link to narcotics traffickers. Plumlee was only one of many people having direct knowledge of these criminal activities and who gave this information to members of Congress. Hiding for his safety from retaliation by U.S. authorities after Plumlee recognized that the CIA and related government entities were actually responsible for much of the drugs smuggled into the United States, he went underground, hiding from his prior handlers, and settled in a small town near Denver. In a book Plumlee was writing, he described the government corruption that he saw in Mexico involving both Mexican and U.S. officials, and how both either participated in or did nothing to halt the drug trafficking. Another hoax upon the American people seeking to get public support for the U.S. attempts to undermine the Nicaraguan government. President Ronald Reagan appeared on television holding up a picture allegedly showing Nicaraguan Sandinistas loading drugs onto a plane in Nicaragua. The plane was piloted by Barry Seal. Plumlee, a friend of Seal, said that the picture was not taken in Nicaragua, but in Panama, and misrepresented what was actually taking place. Plumlee said that the C-123 aircraft from which the picture was taken had on it a global positioning instrument wherein a satellite could identify the location of the aircraft, and the record shows that the plane never went to Nicaragua. Plumlee stated that the camera in the C-123 aircraft was rigged up by the CIA at Rickenbach Field, and that he helped rig the switching arrangement. The idea was to show that the Sandinistas were engaging in drug trafficking, when in fact, as Plumlee stated, it was the Contras, who the U.S. were supporting, who were most active in drug trafficking. Plumlee described how Barry Seal thought he had an ace in the hole against federal prosecution. This ace in the hole was Seal's threat to report the CIA's White House involvement in drug trafficking to the media and to Congress. If Seal had known what I found during the past 30 years, that these same checks and balances have been involved in a continual pattern of felony cover-ups and obstruction of justice, he would have realized these ace-in-the-hole safeguards were meaningless. Seal had information about the U.S. involvement in drug trafficking, and about the sophisticated military hardware taken out of U.S. Army arsenals at Ilopango in Honduras and shipped to third world countries. These included sophisticated electronic gear, decoding devices, Stinger missiles, some of which ended up in the hands of drug cartels. However, Seal's threats to make such reports were probably the reason the Justice Department and its control of federal judges resulted in him being charged with felonies, and sentenced to a halfway house where drug cartels who were exposed by Seal would retaliate and assassinate him. In other words, the government officials put a contract out on Seal's life, and made the drug cartels aware of Seal's undercover status. Seal was assassinated at the halfway house. In this way, the CIA, DIA, the White House, and others, were protected from exposure. Mexican-US cooperation in drug smuggling. Plumlee described the Mexico-CLI relationship in smuggling drugs into the United States, making a mockery of the professed U.S. concern about drug trafficking. During a taped interview for Jeremiah Films in 1995, Plumlee stated, 444. The result of that testimony was that the testimony was sealed. The committee censored it, calling it national security and top secret. A lot of the pilots that flew and testified to the committees had the same problem. Their testimony was not released. Pilots and other ground crew personnel who made these allegations in 1982 and 1983, were systematically purged from those operations. There was systematic character assassinations of a lot of good people that had done a lot of black operations. One in particular was Barry Seal, who was a personal friend of mine. They discredited people with fake documents. We flew some of the drugs into Air Force bases along the southeast coast, and some in the west and the southwest, including Homestead Air Force Base. DIA has a very good handle on around Arkansas and Louisiana, but their investigations were completely shut down, stopped in their tracks. And the people who had the information about this operation were suddenly transferred and can't be found now. Starting about 1981, the drug smuggling problem was just really starting to escalate. It didn't really start until the latter part of 1981 and 1982, about the same time that Reagan said we're fighting a drug war, and a lot of money was appropriated for that. From the time that the money was appropriated to start, we saw a 400% increase in the illegal drugs that were coming into this country. Plumlee continued, as he referred to the high-level block, similar to what I ran into during the past 30 years, when concerned people tried to expose the government-related misconduct, someone had the power to intercept that information, to destroy the information and the operatives that had gathered the information. Even to the point of putting them in jail, discrediting their character, by assassinations, assassinating their character by labeling them as cartel drug runners. As I discovered for the past 30 years, that someone were people in control of the U.S. Department of Justice. Referring to how easy it would have been to halt the drugs coming into the United States in 1981, Plumlee stated, "What I'm saying is the cartel could have been shut down in 1981. The information was there from the informants that had infiltrated the cartel." Plumlee said that he flew over 6,600 pounds of cocaine into the United States in government-sanctioned operations. He said that most of his flights were for military intelligence, a fact little known, as most of the blame goes to the CIA. He said that his military handler was out of a military fort in Arizona. At the request of his military handlers, in 1988, Plumlee started a pilot recruitment agency in Southern California called Pilots Aviation Network, for the purpose of pilots to continue flying drugs for the various U.S. agencies. Sudden reversal of position. Plumlee appeared on CBS television as CBS televised CIA Director John Deutsch's appearance before a high school in the Watts area. 445. Of Los Angeles. After Deutsch was filmed denying any CIA involvement in drugs, CBS showed Plumlee stating in a 30-second clip that he flew drugs, that he did so under orders of individuals, and that the CIA was not involved. After I saw that segment, I contacted Plumlee, since he had earlier gone into great detail describing the CIA involvement in drug smuggling. Plumlee had clearly stated this fact to CBS during over the last few years and had provided the TV network with documentation. Plumlee was outraged that CBS took his statements out of context, as Plumlee was referring to another drug smuggling operation that was controlled by the National Security Council, the Pentagon, and the White House. In response, I wrote a November 22, 1996 letter to Bruce Rines, CBS News producer in Los Angeles, complaining about that cover-up and which I experienced for the past 30 years, and advised him that I also had considerable evidence of covert agencies and the military smuggling drugs into the United States, and had over 24 former agents of the FBI, CIA, DIA ready to testify to these activities. Rines responded in a November 25, 1996 letter, stating, "Your name has surfaced quite frequently in my research surrounding the allegations of the CIA's involvement with the distribution of crack cocaine in south-central Los Angeles." He made no attempt to obtain any information from me. On the contrary, I was cancelled from 2 scheduled CBS television productions after that time. Plumlee provided me with various documents relating to the drug trafficking by U.S. forces. One report, marked secret, dated February 13, 1990, stated in part, "Apparently a month ago XXXXXXXX and Avina Baitais were engaged in conversation when Avina Baitais told XXXXXXXXX that the flow of drugs into the United States is the best solution to Latin America's problems. The poisoning of American youth is the best answer to the downtrodden Latin American masses in retaliation against the imperialistic actions of the United States," has learned that the reporter from Veracruz Velasco, before his death, was allegedly developing information that, using the DFS as cover, the CIA established and maintained clandestine airfields to refuel aircraft loaded with weapons which were destined for Honduras and Nicaragua. Pilots of these aircraft would load up with cocaine in Barranquilla, Colombia, and en route to Miami, Florida, refuel in Mexico at narcotic trafficker operate Dan's CIA-maintained airstrips. Cubans were working a similar type of refuel operations, picking up cocaine in Medellin, Colombia, and flying it through Cuba into Miami. An August 10, 1976 FBI report from the special agent in charge of the Phoenix office to the FBI director confirmed that Plumlee had flown a large shipment of arms to Albuquerque, for later flight to San Diego, that there was a 1963 government report on the matter in Phoenix File 26-20103, and that the file has been destroyed. The FBI report further stated, this would fit into the time frame Plumlee alleged on August 10, 76, wherein he was instructed to leave a plane loaded with arms in New Mexico. The 1976 date suggests that the United States was clandestinely shipping arms to Mexico, Central or South America, quite possibly in an attempt to 446. Overthrow another government. In another FBI report it was stated that Plumlee had advised special agents of the Cincinnati division that through one Larry Allen, Miami, Florida, he arranged to fly munitions to the Castro forces in Cuba. On or about July 5 he flew a DC-3 airplane from Miami International Airport to an abandoned military airport on Marathon Island in the Florida Keys, where the plane was loaded with arms and ammunition and flew to Cuba, and was paid $900 by Allen. The FBI report stated that it was his desire to establish his credibility concerning his past activities in establishing contact with the FBI in Arizona in the event he should ever become involved in borderline activities. The report stated that Plumlee agreed to provide a written report to the Phoenix FBI office. The report stated that Plumlee was also flying for Regina Airlines and Riddle Airlines. It was obvious from the FBI's own reports that they knew of the drug trafficking into the United States by the CIA and the military, and that this includes knowledge by the FBI director. Routine overthrowing of governments. There were many other similar reports, which indicates that the US armed Castro to overthrow the Batista government, and then after Castro takes over in Cuba, the CIA seeks to overthrow him, duplicating what has been routine operations on a global scale by the CIA and other US covert agencies. Among the various covert agency handlers mentioned in the reports were Larry Allen, Johnny Smith, Frank Sutter, John Rosselli, and John Martino. Plumlee has a long history of working in covert activities. After joining the Army in Dallas, he worked under several case officers with OSS and CIA ties, including Captain Edward G. Sewell. He received pilot training under the GI Bill at White Rock Airport, after which he worked at Red Bird Airport south of Dallas, becoming involved with several CIA front companies. He was sent to the Miami area where he became involved in covert operations in Cuba, the Caribbean, and Central America. Most of this time he flew guns and ammunition for various factions in half a dozen countries. Plumlee said he was driven by the adventure and the paychecks. He explained that in his covert operations he had to keep other federal agencies from knowing about the clandestine and usually illegal operations. He was one of a handful of Norte Americans fighting to overthrow Batista and install Fidel Castro. He described how covert activities have the ring of unreality to the public because of their lack of knowledge about the activities. Those who work the 8 to 5 shift cannot comprehend what goes on in covert operations. Plumlee tried to leave covert operations after a tour in Vietnam, but as so often happens, his handlers kept calling him for other operations. He wrote, "It was in Mexico where I saw the widespread government corruption on both sides of the border. Someone in Washington was turning a blind eye toward drug shipments from Colombia being smuggled through Mexico and into 4A7. The United States. It was obvious, our intelligence information was being tampered with at the highest level. Millions of dollars, dirty drug money, was being routed through Panama by the cartel, some of it to be used to influence the upcoming presidential election. Some of the illegal cargoes were flown and transported by other CIA operatives and military personnel holding civilian status, thus covering their CIA military affiliations from public view." Plumlee described the operation known as Operation Grasshopper, which was a top-secret military operation, and involved such notable drug traffickers as Barry Seal. He described the protection of the government's involvement in drug trafficking by other government agencies, including the American Mexican Special Operations Group whose function was to block drug trafficking. He said that Barry Seal was an operative in this group in its early days. Plumlee described the brutal murder of a former Air America pilot in Cueto Loco Lobo, near Oaxaca in southwestern Mexico by a Mexican named Pepe Suequis. Plumlee described how the informant describing the killing of the American pilot, Maurice Luis Gonzalez, was horribly mutilated and left to die in a Mexican prison for informing American authorities of what had happened. Many other sources provided corroboration of these government-related drug smuggling activities. Many deep-cover government and other sources, other than those named in these pages, provided me with overwhelming evidence of drug trafficking by government officials and other employees. There is not the slightest doubt in my mind that these activities are occurring. Most of the American people are totally uninformed on these subversive and criminal activities, or the cover-ups by Justice Department employees, federal judges, members of Congress, and most of the mainstream media." In his book, Called to Serve, Colonel James Bo Gritz described his several meetings in May 1987 with Kun S.A., the head of the largest heroin-producing region in Southeast Asia. Gritz had been on a team mission trying to locate missing prisoners of war when he found evidence of massive heroin production being purchased by U.S. personnel. Kun S.A. and U.S. drug pipeline. Kun S.A. described to Gritz how he sought U.S. help in replacing the heroin crop with another saleable commodity and how this offer was refused. He described how heroin production in the Golden Triangle area shot up from 40 tons in the early 1950s to 700 tons in the early 1960s. During the first set of meetings, Kun S.A. said to Grits that he might consider telling who his largest past U.S. customers were for the heroin, but would not disclose the present customers. During the second set of meetings occurring in mid-1987, Kun S.A. brought his aides together for a meeting with Grits, at which time the group provided Grits specific information on who in the United States were his main customers for heroin. Grits wrote in his book that these U.S. customers were, Theodore Shackley. Shackley was identified to me by many of my deep cover sources as being actively involved in drug trafficking. 448. Richard Armitage, also CIA, later holding the key position of Assistant Secretary of Defense in the United States. In his Defense Department position, Armitage was responsible for locating missing POWs. But if these POWs were found and returned to the United States, their hero status would make whatever they had to say meaningful. And they could be expected to describe the U.S. involvement in drug trafficking, very possibly the most explosive and subversive activity ever exposed in the United States of America. Daniel Arnold, also CIA, handled the arms and drug sales formerly handled by Armitage. He served as CIA station chief in Thailand. Jerry Daniels, a CIA agent, replacing Armitage when Armitage returned to the United States. Santos Traficante, head of one of the many criminal cartels with which the CIA had been doing business for decades. Grits's trip to visit Kun S.A. was known to Justice Department officials, who sought to have him arrested, but Grits left the United States before this could be accomplished. Costa Rica Report on U.S. Arms and Drug Trafficking. An 80-page report by the Costa Rican government, dated July 20, 1989, officially detailed and documented the U.S. role in drug trafficking in Central and South America. The report, titled, Special Select Commission Appointed to Investigate Drug Traffic Crimes, was the official Legislative Assembly report of Costa Rica. Excerpts from the 115-page Spanish report reveal what the mainstream U.S. media kept from the public. It clearly showed that the movement of arms from the United States to Central America was associated with massive shipment of drugs on the return flights. One of many CIA sources, another one of my many deep cover sources, was Gene Chip Tatum, describing what he discovered while a helicopter pilot for the U.S. Army and the CIA. Tatum provided me with affidavits, letters, details, and copies of military flight plans showing the names of well-known individuals and records of drug shipments. This evidence showed drug trafficking into the United States from Central and South America, and also within the states. Tatum joined the U.S. Army in 1971, and was initially assigned to Vietnam. He was later trained as a helicopter pilot. He also became commander of a unit in the ultra-secret operation known as Pegasus. In the 1980s he flew helicopters in Central and South America, flying medevac helicopters taking Contras and civilians to emergency care centers. Tatum was command pilot of one of two helicopter flight crews from the 3/498th Medical Company based at Fort Stewart, Georgia that were sent in 1985 to Palmarola Air Base in Honduras. Each crew consisted of a pilot, co-pilot, medic, and the crew chief. Tatum was part of the medevac mission for Joint Task Force Bravo. Under cover of his Army helicopter pilot duties, he was instructed to support a covert group of missions under Operation Pegasus. Initially unknown to Tatum, these assignments included hauling large white coolers, marked medical supplies, from remote jungle sites to landing strips. 449. For pickup by fixed-wing aircraft. These coolers were usually transferred to C-123 and C-130 aircraft, flown either by military or private pilots. The coolers were flown to Panama and then the United States. Once, during a hard landing, one of the coolers broke open, and while taping the coolers shut he discovered that instead of the contents being medical supplies they were filled with bags containing cocaine. He subsequently discovered that these falsely marked coolers were frequently placed on board his helicopters. Tatum had frequent contact with Oliver North while North was assigned to the White House's National Security Council, and William Barr, who later became Attorney General of the United States, in control of the U.S. Department of Justice. While under orders of the National Security Council and the CIA and working undercover as a U.S. Army helicopter pilot, he was instructed to infiltrate the 3/498th Medical Company and pose as a medevac pilot. In this capacity he flew wounded personnel to medical stations. But priority was given to CIA and NSC assignments over the carrying of wounded personnel. While at Palmarola Air Base in Honduras, Tatum flew helicopter flights to Ilopango, El Salvador, where Corporate Air Service, a CIA-owned aviation company, was based, and to various Contra camps in Honduras and Nicaragua. Although the reason for his assignment to the medevac unit was to move wounded personnel to treatment centers, he discovered that the one common denominator on all Pegasus missions was the movement of large white coolers in and out of Contra camps. On one flight out of Palmarola he carried as passengers pilots Bill Cooper and Buzz Sawyer, who would later die while flying over Nicaragua after being hit by a surface-to-air missile. The only survivor of that flight, Eugene Hasenfuss, was the person responsible for kicking military cargo out of the back of the aircraft. He survived because he carried a parachute, and jumped out of the aircraft before it crashed. His subsequent capture and interrogation precipitated the exposure of the Iran-Contra affair. Describing one of his operations on one of his flights to Ocotal in Costa Rica, Tatum carried Felix Rodriguez, a close associate of Vice President George Bush in the Contra operation, General Gustavo Alvarez of Honduras, and Joseph Fernandez, another CIA agent. Upon landing at Ojo de Agua y Tamborcita they were joined by Michael Harari, a former Mossad agent and security advisor to General Manuel Noriega of Panama, by William Barr, and Barry Seal. Seal had flown Noriega and Harari to the meeting in his Learjet aircraft. The purpose of the meeting was to determine where over $100 million in drug money had disappeared on the three routes from Panama to Colorado, Ohio, and Arkansas. This theft was financially draining the operation known 450 as the Enterprise 454. By comparing computerized records, Tatum said that it was determined that the loss of money occurred on the route from Panama to Arkansas. Tatum said that at the end of the meeting he went with Fernandez to the helicopter where a portable secure phone was set up to communicate with Washington by satellite link. The first call was made by Fernandez to Oliver North, informing North that the money loss was occurring on the Panama to Arkansas route, and that means either Seal, Clinton or Noriega. 15 minutes later, the portable phone rang, and Vice President George Bush was on the line, talking to William Barr. Barr said at one point, referring to the missing funds, "I would propose that no one source would be bold enough to siphon out that much money, but it is more plausible that each are siphoning a portion, causing a drastic loss." Barr told Bush that he and Fernandez were staying in Costa Rica until the following day, after first visiting John Hull's ranch. Barr then handed the phone to Tatum, who was instructed by Bush to be sure that Noriega and Harari boarded Seal's plane and departed, and for Tatum to get the tail number of Seal's plane. Tatum noted that the aircraft number was N13S, and Tatum said that Barr then dialed another number, immediately reaching then Governor Bill Clinton. Barr explained the missing money problem to Clinton, explaining that over $100 million of the Enterprise monies had disappeared, along the Panama to Arkansas connection. Barr suggested that Clinton investigate at the Arkansas end of the Panama to Arkansas route, and that he and Oliver North would continue investigating the Panama end of the connection, warning that the matter must be resolved or it could lead to big problems. The SITCOM phone equipment was then stowed on the helicopter, and Tatum waited for Noriega and Harari to leave in the Learjet piloted by Barry Seal. Tatum then flew his passengers to Tegucigalpa, the capital of Honduras. A copy of the flight plan that Tatum filed, dated March 25, 1985, follows. Tatum wrote on the back of the flight plan, "Meeting with Gen Noriega/SITCOM with North and Gov of AK concerning missing monies. Dropped off Noriega at airport in SD. Met Barry Seal in 13SN. Seal took Gen Noriega and Harari." Several days later, Tatum flew from Tila, Honduras to La Ceiba, picking up Oliver North, Felix Rodriguez, General Alvarez of Honduras, and Amram Nir. They then flew into several villages on the Nicaragua/Honduras border to determine their suitability for cargo drops by CH-47s the following month. Examining cocaine plants, Tatum then flew the group to Santa Ana, Honduras, meeting with Enrique Bermudez and other Contra leaders, and visited a cocaine processing facility. Tatum described the strong smell of jet fuel and acetone, and the large fuel pods that had the tops stripped off of them and in which were fuel and leaves. Tatum repeated what North said, "One more year of this and we'll all retire," adding, "If we can keep those Arkansas hicks in line, that is," referring to Barry Seal and Governor Clinton. While General Alvarez went with the Contra leader to discuss logistics, North, Rodriguez, and Aminir continued through the wooden building, inspecting the cocaine. Tatum repeated what North said, "Bush is very concerned about those missing monies. I think he's going to have Jeb arrange something out of Colombia." As Tatum listened to these conversations, he remembered the Army officer's remarks in Ojo de Agua when Tatum complained about the carrying of drugs. "Tell no one. There's no one big enough in your chain of command." Having heard North discuss the involvement in the drug activities of Vice President Bush and Governor Clinton, Tatum recognized what the Army officer had previously stated to him. Tatum then flew back to La Ceiba and then to Tila, returning the following day to home base at Pomarola, where Tatum put a few notes on the back of the flight plan filed with base operations. The note read, "Ram ACM/Rodriguez for night. USN to Waspam/Santa Ana/Leme no problems recon successful Rodriguez, North, near, Dr. Gus. Others." During another trip, Tatum picked up at Dustoff Operations 6 coolers marked medical supplies, which contained cocaine, and flew them to an airstrip at Trujillo, where they were given to a C-130 crew bound for Panama. Tatum asked the pilot, "Who gets these?" The pilot looked at the manifest and said that a Dr. Harari would be called on arrival. The alleged doctor was none other than Mossad operator Michael Harari, and the phony doctor title went along with the phony medical supply labels on the coolers. Another military flight plan showed Tatum making a flight on April 9, 1985, into a small village 40 kilometers east-northeast of Ocotal in Nicaragua. Tatum met Felix Rodriguez and Contra leader Enrique Bermudez, and the three of them inspected a cocaine processing facility located in a large tent, containing all American equipment. Inside were several women packaging cocaine. 4 110-quart white coolers, marked medical supplies, were then put on board Tatum's helicopter for subsequent loading onto a civilian C-123 at San Lorenzo. Tatum then flew back to his home base, at which time he wrote on the back of the flight plan details of the cocaine lab inspection. White House and CIA cocaine operation during a flight from Palmarola to El Paraiso, Honduras. His passengers told Tatum that they worked for corporate air services out of Ilopango Air Base in El Salvador and that they were meeting with Contra leaders to coordinate airdrops to various Contra camps. When the meeting was over, Tatum was given a white cooler marked vaccine, weighing over 200 pounds, and instructed to deliver the cooler to a C-130 at Las Mesa Airport in San Pedro Sula, Honduras. The cooler was dropped while being taken from the helicopter, and Tatum used aviation tape to reseal it. After removing the old tape and looking inside the cooler, he discovered that the contents consisted of what appeared to be over 100 bags containing a white powdery substance, cocaine. The Racel-led cooler containing the cocaine was then put on a C-130 that was departing for Panama. Public-funded medical units used for smuggling drugs. This discovery reminded Tatum of the white coolers that he had been asked 452 to deliver by helicopter to Arkansas's Mena Airport while assigned to special operations at Ft. Campbell in Kentucky in 1983 and 1984. He was ordered several times to deliver white coolers marked medical supplies to Little Rock Air Force Base and to Mena Airport. The Medevac unit at Ft. Campbell, the 324th Medical Battalion, was a supporting unit for Task Force 160, a special operations unit under CIA control. Flight crews of the 324th Medical Battalion rotated in and out of Honduras on tours that lasted 4 months. That's how Tatum came to be assigned to Central America and discover the drug smuggling operation in Central America and Arkansas. Tatum described people that met his helicopter arrival at Mena Airport. He described meeting Dan Lassater, who was usually accompanied by a plainclothes policeman who produced a badge and identification showing him Tobe Raymond Buddy Young. Tatum said that Young showed up in Honduras posing as a member of the Arkansas National Guard. Occasionally, Lassater was accompanied at the Mena Airport by Jerry Parks, who helped in the offloading of the coolers. Jerry Parks operated a security company that had close ties to the Clinton administration in Arkansas. Some years later, Parks had a falling out with Clinton, and had threatened to expose information about Clinton and the drug activities. This caused him to become one of many people in Arkansas that had sensitive information who was either killed or died under mysterious circumstances. One of the many military flight plans filed by Tatum dated March 1, 1985 described delivering 2 white coolers marked medical supplies to dust off operations. Felix Rodriguez then ordered Tatum to deliver the coolers to him at Tila, Honduras. Tatum checked the contents, and found them filled with about 100 kilos of cocaine. As ordered, he delivered the coolers to Rodriguez, who was waiting in front of an old DC-3. Tatum then returned to his home base at Palmarola, and made the following notation on the back of the military flight plan that he had filed with base operations: Q/U2 coolers med supplies. Checked contents: white powder APPR 100 sacks each. Rodriguez instructed Tatum to obtain the secret frequencies used by the military at a tactical communications site called Skywatch, which was the focal telemetry point of several military satellites in this hemisphere. The military had refused to release this information to the CIA, causing the agency to contaminate the water supply with an unusually high concentration of chlorine, causing widespread stomach cramps and diarrhea among the soldiers. This required calling for medical personnel to fly to the site and treat the personnel affected by the CIA contamination. While the personnel were being treated, Tatum went into a communication van and copied the frequencies from the equipment in use. Upon his return to Palmarola that afternoon, Tatum called CIA agent Donald Gregg on a secure telephone line, passing along the frequencies that he had copied. Gregg then instructed Tatum to pass the frequencies to CIA agent Claire George at Langley. Before having the call transferred, Tatum told Gregg of his discovery of cocaine in the coolers. Gregg repeated the false excuse that the coolers were bound for the world courts as evidence against the Sandinistas. Tatum was then 453. Transferred to Claire George, who took the information and was advised that he would pass the information to Dewey, referring to Dwayne Claridge of the CIA. Tatum then went to base operations and noted this information on the back of the on-file flight plan and the mission briefing sheet. Copies of some of these forms are on following pages. On this particular flight Tatum wrote, "North arranged for water contamination at TAC site. I flew medevac to site, and while medic attended I collected TAC fosses for North. Upon departure forced to auto-rotate. Declared emergency bad torque and cracked tail boom." One of many military flight plans filed by Tatum that I examined was a March 5, 1985 flight that carried Amaramnir, a CIA and Mossad asset, General Gustavo Alvarez, a Honduran Army Chief of Staff who often used the alias, Dr. Gus, a Honduran colonel who was the general's aide. On this mission Tatum flew into 6 villages listed on the flight plan, picked up soldiers, and took them to Iparizo, Honduras. At Iparizo, as they prepared to leave, 4 large white coolers were put on board the helicopter. Pointing to the coolers, Tatum asked Rodriguez, "Evidence?" Rodriguez responded by patting the cooler with his hands, saying, "You catch on fast." Tatum landed at San Lorenzo, Honduras, dropping off Rodriguez and the coolers. Upon return to home base at Palmarola, Tatum wrote on the back of the operations flight plan, 4 coolers sim to cocaine cooler during one flight to Tegucigalpa on March 15, 1985, Tatum met with Barr, Harari, and Buddy Young. Barr represented himself as an emissary of Vice President George Bush, who would be arriving soon. Tatum periodically reached Barr by phone at the CIA's Southern Air Transport in Miami, and under the name, Robert Johnson. The purpose of the meeting was to arrange for Vice President Bush's arrival. The following morning, Young and Harari flew back to Palmarola with Tatum. Because of the high noise level in the helicopter, the passengers, Young and Harari, wore headsets and spoke over the aircraft intercom system to each other, possibly unaware that Tatum could hear their conversation. He was copying this conversation on his knee pad until he ran out of paper. Tatum recorded the conversation. Young, Arkansas has the capability to manufacture anything in the area of weapons, and if we don't have it, we'll get it. Harari, how about the government controls? Young, the governor's on top of it. And if the feds get nosy, we hear about it and make a call. Then they're called off. Why the hell would anyone want to fight for a shithole like this? Harari, what we do has nothing to do with preserving a country's integrity. It's just business, and third world countries see their destiny as defeating borders and expanding. The more of this mentality we can produce, the greater our wealth. We train and we arm, that's our job. And in return, we get a product far more valuable than the money for a gun. We're paid with product. And 454. Young. Harari. 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 We credit top dollar for product. Look, one gun and 3,000 rounds of ammo is $1,200. A kilo of product is about $1,000. We credit the Contras $1,500 for every kilo. That's top dollar for a kilo of cocaine. It's equivalent to the America Kmart special, buy 4, get 1 free. On our side, we spend $1,200 for a kilo and sell it for $12,000 to $15,000. Now, that's a profit center. And the market is much greater for the product than for weapons. It's just good business sense. Understand? Damn. So you guys promote wars and revolutions to provide weapons for drugs. We provide the non-numbered parts to change out and we all win. Damn. That's good. It's good when it works. But someone is, how do you say, has his hand in the coffer. Well, we get our 10% right off the top and that's plenty. GOFUS can make it go a long way. Who is GOFUS? Governor Clinton. That's our pet word for him. You know they call the president POTUS for President of the United States. Well, we call Clinton GOFUS for Governor of the United States. He thinks he is anyhow. That's your problem in America. You have no respect for your elected officials. They are more powerful than you think, and have ears everywhere. You should heed my words and be loyal to your leaders. Especially when speaking to persons like me. Your remarks indicate a weakness, something our intelligence analysts look for. Ah hell, Mike. Everybody knows the Clintons want the White House and will do anything to get it. We know about the cocaine. Hell, we've picked it up before with Lasseter when he was worried about going on Little Rock Air Base to get it. Clinton thinks he's in charge, but he'll only go as far as Casey allows. Me and my staff, we keep the lid on things, you know, complaints about night flying. Arkansas people are private folks, they don't like a lot of commotion, and Mena just isn't the right place for the operation. It keeps us busy at the shredder, if you know what I mean. Dan's the man. He does magic with the money. Between him and Jack Stevens we don't have to worry a bit. Then we got Parks. If there's a problem, he's the man. We call him the Archer. That's the code name that Casey and Colby told us to assign to that position. Finus oversees our drop zone. Nash, he's just the boss yes man. Personally, I think he's a mistake. Seal and his guys, I like his attitude and leave the driving to us. You like Seal? Hell, he's the only one I trust, tespect is the word. Do you see him much? We. 455. Young, hell, yes. We test drive Clinton's rides before we send Eamon, you know. Say, how much coke do you reckon you can make in a week? Harari, one camp can produce 400 keys a week. The others are about half that. But that's just our operation here. We have other sources in various parts of the world. Why do you ask? Young, the governor wanted to know our capacity. Harari, who else is on the team? Young, well, hell, I forgot who I told you about. Harari. Young, okay, there's the manufacturers, hell, these two. Upon landing back at his base, Tatum made a notation on the back of the previously filed flight plan. This was emission to Tegucigalpa. Bush visit/met with Barr and had dinner at German restaurant. Tatum was alerted for a flight at 5 a.m. to pick up 3 wounded soldiers at a Contra camp near Choluteca, Nicaragua, and instructed to pick up 2 observers on the way at Choluteca, Oliver North and Lt. Col. Navarro. At the Contra camp 2 of the casualties were loaded. The last casualty had a piece of wood sticking out of a bad wound to the upper left portion of his body. As the medic cleaned the area, he found a hole the size of a softball adjacent to the impaled object. As the medic sought to clean the area, it caused a clear view of muscle hanging and the inside of the chest cavity. North saw it and fainted. Tatum caught him and popped an ammonia capsule under his nose to revive him. The flight then departed for San Lorenzo, Honduras, where the casualties were unloaded. Back at base, Palmarola, Tatum completed the mission brief back report, writing in part, arrived at SLN arrival at the helipad. The emergency vehicles were not waiting. There was no answer on medevac FQCY FM 45.10 or on 49.10. Confusion on ground causing ground time delay of 15 minutes. Medic's duties were compounded when Mr. North fainted. As I looked over the many copies of flight plans that Tatum provided to me, they provided still more evidence of the following. Mossad agent Michael Harari was on many of the flights associated with the drug trafficking. William Barr, who Bush appointed to be the top law enforcement officer in the United States, U.S. Attorney General, played a key role in the smuggling of drugs into the United States. Tatum's statements about reaching Barr at Southern Air Transport in Miami through the name of Robert Johnson confirmed what Terry Reid, author of the book Compromise, had told me and had written. Nothing like having a member of this drug operation appointed Attorney General of the United States in control of the U.S. Department of Justice. The drugging of America involved the CIA, the military, the White House through Oliver North, George Bush, and Governor Bill Clinton, among many others. 456. That Mena, Arkansas was a key CIA transshipment point for cocaine coming into the United States on return flights from Central America, delivering guns to kill people in Nicaragua in President Reagan and President Bush's alleged honorable war against the people of Nicaragua. At one time, thinking that Oliver North did not know about the cocaine trafficking, upon returning to Palmarola Air Base, Tatum called Washington and advised North of the cocaine discovery. North told him, the Sandinistas are manufacturing cocaine and selling it to fund the military. It was bound for the world courts as evidence. Tatum was assigned to fly helicopter flights in Honduras and Nicaragua, working CIA missions, and under orders of Oliver North, CIA Operations Amaramnir and Felix Rodriguez. In carrying out these orders and missions, he associated with William Barr, George Bush, General Manuel Noriega, Mossad agent Michael Harari. The control word for the missions that he flew was Pegasus. This operation was secretly embedded in an Army medical unit. He said that CIA agent Henry Hyde was responsible for the finances of the unit, including arranging lines of credit. / Gene Chip Tatum. 457. Neutralizing others. Tatum described how he flew assassination teams to various locations to neutralize certain people, including a Mossad agent, an army chief of staff of another country, and president of a third world country. He described how Amram Nir was assassinated by the CIA Archer assassination team that he flew into Morelia, Mexico. Tatum said that Nir was a renegade Mossad agent that the Mossad was pleased to see eliminated. Nir was also scheduled to testify in the Iran-Contra hearings and had first-hand knowledge of the CIA and Mossad drug trafficking. Tatum said that he fired an air-to-air heat-seeking missile from the Hughes 500 helicopter that he was flying at the Cessna 210 aircraft that had been chartered by Nir. In Tatum's words, "I prepared a SIGLOC on the Baron frequency which we used to track the target." Tatum said the missile exploded below the Cessna, causing it to descend in an out-of-control condition. Tatum said that he left the operation in 1992 after he was instructed to neutralize Ross Perot in whatever manner required. Possibly this plan explains Perot's sudden dropping out of the presidential race. He was warned that no one leaves the operation and that he would pay the consequences. Tatum did leave and eventually Justice Department employees charged him and his wife with a federal offense. I filed a friend of the court brief on his behalf #5 and included with it an affidavit signed by him which described in general terms the CIA NSC drug trafficking which he had discovered. The brief informed the court that Tatum had evidence of these federal crimes, that he wanted to provide evidence of these offenses, and that his knowledge of such offenses may have motivated Justice Department employees to charge him with federal offenses. As usual, the federal judge refused to receive the evidence, despite the mandatory requirement of Federal Criminal Statute, Title 18 U.S.C. Section 4. The following page contains a copy of the March 28, 1985 flight plan with Tatum's notations on the front showing passengers Joe Fernandez, Michael Harari, Felix Rodriguez, General Alvarez. This was the flight in which a determination was sought as to where the drug money was disappearing. Present at the meeting were William Barr and Colonel Manuel Noriega, followed by the sitcom phone call to Oliver North and Governor Bill Clinton. The following is a declaration that Tatum gave me, which I had intended to file in a friend of the court brief, which partially described his CIA-related activities. Declaration. I, Dois Gene Tatum, declare. I was a helicopter pilot for the United States Army from 1982 to 1986, cities which time I flew missions in Central America and also from Ft. Campbell, Kentucky. From 1986 to 1992 I was an agent for the Central Intelligence Agency, operating under a deep cover assignment. During this time I witnessed activities involving high-level U.S. personnel that I felt were unlawful, and I reported these activities to my superiors in the U.S. Army and to my handlers in the Central Intelligence Agency, to the National Security Council, and to various individuals, including William Barr, Oliver North, George Bush. Among these activities were rampant drug smuggling into the United States involving people in control of the Central Intelligence Agency, the Drug Enforcement Administration, the Armed Forces of the United States, among others. I have documented some of these activities on military flight plans, showing as passengers on certain flights, the following: William Barr, Buddy Young, Felix Rodriguez, Oliver North, Joe Fernandez, Manuel Noriega, and Mike Harari. I have visited cocaine laboratories with the above people, who were inspecting the drug smuggling operations in Central America. I have documented on some of these military flight plans the nature of the cargo being carried in white coolers that were fraudulently marked as medical supplies, which accidentally discovered to be cocaine. During one flight and related meeting, I was present while there were discussions as to where drug money was being siphoned on the Panama to Arkansas run. Present at this meeting were Manuel Noriega, William Barr, Joe Fernandez, Mike Harari, General Gustavo Alvarez. Participating in this meeting via satellite telephone was Vice President George Bush, Oliver North, and William Jefferson Clinton, then Governor of Arkansas. I had reported these illegal operations to my superiors, including William Barr, Oliver North, George Bush, Felix Rodriguez, Joe Fernandez, Don Gregg, Dewey Claridge. After I refused to perform a mission that I felt were beyond my willingness to execute, I notified my handlers that I wanted out of the operation, which at that time was known as Operation Pegasus. Their response was to warn me that no one leaves the operation. I declare under penalty of perjury above facts are true and correct to the best of my knowledge and belief. Executed this day of August 1996 in the county of Hillsborough, state of Florida. AKA Gene D. Tatum. 460. A pattern of long-term drug trafficking directed by the National Security Council in the Reagan-Bush White House, with CIA and military involvement and other complicity, was revealed by examining the dozens of military flight plans Tatum had given to me. These activities will be explored in depth by Tatum in his book describing the drug activities involving U.S. personnel. Although Tatum was assigned to a military medical evacuation team, his CIA handlers often diverted his flight to drug-carrying activities, resulting in casualties not being evacuated for medical treatment. This diversion of life-saving helicopter support resulted in the military sending the following message. Circle the wagon. Reaction to San Jose Mercury disclosure of CIA-related drug activities. In August 1996, the San Jose Mercury newspaper in California ran a three-part series describing the role of CIA assets selling crack cocaine to the blacks in the Los Angeles area. The articles caused a major reaction from various black leaders. This in turn required the mainstream media to address the articles, and major disinformation then followed. The San Jose Mercury articles were accurate, but relied upon a small percentage of the sources that I had, none of whom actually flew the drugs into the United States. The mainstream print and broadcast media, whose cover-ups and disinformation allowed the decades of CIA drugging of America to continue, began an intensive spin control to discredit the San Jose Mercury's articles. The chorus blasting the San Jose Mercury articles included the New York Times, Washington Post, Los Angeles Times, Newsweek, all of which knew of the overwhelming number of insiders testifying to Congress, the great number of highly detailed and documented books proving that the CTA had engaged in drug smuggling into the United States for decades. Using bankruptcy court assets to finance CIA drug purchases in Los Angeles, there was far more to the drugging of the blacks than known by the San Jose Mercury. Russ Bacher described to me in 1991 the drugging of the blacks in Los Angeles, and how the CIA used money looted from Ninth Circuit bankruptcy courts to finance the purchase of drugs. Russ Bacher had described how trustee Charles Duck provided some of the funds for CIA drug purchases. Drugging of blacks was also described to me over a period of years by a former New York City Vice Squad detective, Jim Rothstein. He was a detective on the New York City police force from 1965 to 1980. Rothstein described to me over several years how he discovered and reported the drug sales by the CIA to the blacks in New York City, via Virgil Tripstone. Rothstein said that Al Caroni, a member of one of the New York City crime families, was a CIA asset and involved in the drug sales, reporting directly to CIA Director William Casey. Rothstein said that the direct sales between the CIA and key blacks in the New York City area continued from approximately 1967 to 1973, at which time the CIA sold drugs to organized crime figures who then took over the drug sales to the blacks. I had contact with Caroni's daughter and she confirmed the CIA and mafia relationship of her father. Rothstein gave me the name of another CIA asset involved in the drug sales to the blacks, Mario Lazzo. 463. Wars to cover for CIA drug trafficking. One article in the Washington Post described the belief by San Jose Mercury reporter Gary Webb that the Contra War was not a real war at all. It was a charade, a smokescreen, to provide cover for a massive drug operation by criminal CIA agents and others. Based upon what I have learned from my many deep cover sources, I believe that to be absolutely true. And that would apply also to the Vietnam War. As could be expected, pressure was apparently put upon the San Jose Mercury, causing the publisher to issue an apology stating that reporter Gary Webb did not have enough evidence to support his statements, and that the reporter would be reassigned to a post 150 miles from his Sacramento residence. Chapter 20. Silencing Whistleblowers. Criminal activities. There must be a procedure in place to silence or discredit whistleblowers. Justice Department employees, federal judges, members of Congress, and a silent mainstream media, makes cover-up possible. Standard tactics to keep the public from learning what is being done to them. I repeatedly encountered the tactics used to keep the public from learning about the corruption, the criminal and treasonous activities that I encountered during the past 30 years, commencing while I was a federal investigator. The cover-ups and obstruction of justice that I encountered, and the brutality of the consequences of this misconduct, motivated me to continue my exposure activities. Key party to the obstruction of justice. The cover-up by most of the media and all of Congress plays a major role in the complicity of silence. But the tactics addressed at this moment are the tactics of the nation's highest law enforcement agency, the United States Department of Justice. Justice Department prosecutors have standard tactics to silence people who threaten to expose corruption involving federal officials, fabricate charges against the person, or simply charge them with offenses that they committed under orders of their CIA handlers. Seize all assets, preventing hiring their own legal counsel, and require them to rely on the usually ineffective court-appointed defender. Block them from raising matters relating to their CIA activities. Block them from subpoenaing CIA people with whom they worked. Deny to them access to CIA documents, or bar the introduction of these documents that may be in their possession. Have CIA personnel engage in perjury and subornation of perjury as they falsely testify against him or her and deny that the person had any CIA connections. Pay informants to testify against the person, either through money. The great number of people involved in these government-directed reduction in prison sentence, or vacating prior criminal charges. Put all evidence under seal, preventing public access to the testimony and documents. Discredit charges made by informants by claiming they are felons and their word cannot be accepted as true. Simultaneously, the same Justice Department buys testimony from hardcore criminals to imprison targeted informants. Deaths also conveniently occurs every one of the criminal activities within these pages, and the U.S. officials implicated in them, were protected by the pattern of convenient deaths and false charges by Justice Department prosecutors against anyone who constituted a potential threat of exposure, including whistleblowers, informants, protesting citizens, and victims. Killing witnesses or informants is nothing new for a government that seeks to assassinate foreign leaders, invades foreign countries, undermines foreign governments, kills foreign citizens, and routinely executes criminal acts against its own citizens. These acts have greatly accelerated as every government and non-government check and balance covers up. One of the first whistleblowers to be killed, which I reported in my 1978 first edition of Unfriendly Skies, was Federal Inspector Henry Marshall, an employee of the Agricultural Stabilization and Conservation Service. He was killed in June 1961 on a farm in Texas, much to the relief of high federal officials. Marshall had evidence linking a multi-million-dollar commodity fraud to an LBJ aide and to Lyndon Johnson himself. Alongside Marshall's body was the .22 caliber rifle that had fired the fatal bullets. Texas authorities obligingly ruled Marshall's death a suicide, even though the position of the wounds indicated it would have been physically impossible for them to have been self-inflicted. An AP article appearing in the Dallas Times-Herald reported that convicted swindler Billy Sol Estes secretly testified before a grand jury impaneled at Franklin, Texas, relating to the Marshall death. Estes testified that he was present when Lyndon Johnson and two other men discussed having Marshall killed because Marshall knew too much about illegal manipulation of cotton allotments. Johnson reportedly gave the order to have Marshall slain. Estes identified the two men as Clifton Carter and Malcolm Wallace. Carter was once Johnson's top political aide in Texas and later his White House liaison to the Democratic National Committee. Wallace was a former University of Texas student body president. The Marshall killing and its relationship to Lyndon Johnson had been the subject of intense gossip and rumor in Texas political circles for years. Estes, who had aged considerably since Marshall's death, agreed to testify concerning the Marshall killing at the urging of U.S. Marshal Clint Peoples of Dallas, who had pursued the case for more than 2 decades. Other testimony in the grand jury hearings revealed that Johnson approved the killing out of fear that Marshall would give Attorney General Robert F. Kennedy evidence concerning cotton allotments incriminating LBJ. Kennedy was known to have no love for Johnson. The deaths of key people in the alleged murder conspiracy prevented further grand jury investigation. Former President Lyndon Johnson died January 22, 1973, on his ranch near Austin, Texas. Wallace died in a car accident in 1971, and Carter died September 22, 1971. The grand jury came to the conclusion that Marshall was killed, but reached no conclusion as to who may have done "You're going to get killed." When FAA inspectors warn another inspector his life is in danger by reporting safety violations and related criminal acts, the public might get the impression FAA inspectors are not going to report safety problems. "You're going to get killed," was the warning I received from several FAA employees as I tried to expose the FAA corruption. If other inspectors feared for their lives if they reported safety violations at favored airlines, such as United, they could not be expected to report the misconduct. The CIA, heavily involved in activities surrounding the John F. Kennedy assassination, has a long history of assassination plans. The death rate of people associated in some way with the JFK assassination was extraordinarily high. A partial list of these people, and of those who posed a threat to U.S. officials because of their knowledge of activities described within these pages, follows: killings and mysterious deaths associated with the JFK assassination. It has been reported that over 100 key witnesses to the JFK assassination died within a few years of the killing. The London Sunday Times estimated that the odds of sudden deaths among approximately 3 dozen witnesses over such a short time span to be 100,000 trillion to 1. Despite the pattern of killings and mysterious deaths of informants under these unusual conditions, the Warren Commission held that they did not establish any relationship with the Kennedy assassination or constitute a conspiracy to silence opposition to the Warren Commission findings. Pattern of retaliation commencing with the scandals of the 1980s. The pattern of killings, mysterious deaths, and persecution of informants and whistleblowers continued with the escalating pattern of criminal activities described within these pages. A partial list follows. Attorney Dexter Jacobson was killed on August 14, 1990, just prior to presenting evidence of rampant Chapter 11 judicial corruption to the FBI. Several months before his death, Jacobson and I had exchanged information on the Chapter 11 corruption each of us had uncovered. The conduct of local police constituted a cover-up that aided the killers to escape detection. Paul Wiltshire was found dead on July 23, 1993, under mysterious circumstances. He was an investigator and attorney living in Washington, D.C., who was in frequent contact with Gunther Russbacher and myself. He and I shared information with each other. He had recorded 60 tapes of statements made by Russbacher during about 6 weeks of daily questioning taking place in the Missouri State Prison at St. Charles, Missouri. These tapes revealed CIA secret operations in which Russbacher was involved. Russbacher warned Wiltshire that these tapes were never to be revealed to anyone unless he died. I had a set. 467. Of them in the event something happened to Wiltshire's originals. More about Wiltshire's death in later pages. Shortly before Wiltshire's death, he wrote a 105-page report to Attorney General Janet Reno describing evidence that he allegedly acquired concerning several of the criminal patterns described in these pages. His letter stated that Bush administration holdovers in the Justice Department, along with others tied to the CIA, were blocking exposure of the criminal offenses. The first page of his letter stated in part, "The lives of key participants, other witnesses, and even myself, are now in grave danger as a result of my passing this information on to you. If you let this information fall into the hands of the wrong persons, some or all of those who know the truth, could well be silenced in the very near future." Barbara Wegler died from unknown causes on March 5, 1995. Several weeks earlier I was in touch with her concerning her investigation of covert activities based upon information given to her by Bill Tyree. She was to provide me with information about what she found, but died before she could do this. Her interests included Operation Watchtower, CIA involvement in Jim Jones' Jonestown, and other activities. Attorney Gary Ray Pinnell was killed on February 11, 1991, in San Antonio, Texas, just prior to presenting evidence of Chapter 11 judicial corruption to the FBI. Judge-appointed trustee Martin Seidler was under investigation by the grand jury in Pinnell's murder on the basis that he was associated with Charlie Rummels, a prime suspect in the attorney's death. Many of those who were corruptly stripped of their assets after they exercised the statutory protections of Chapter 11 wanted to testify before the grand jury looking into Pinnell's death, but they were blocked by Justice Department attorneys. Some of those who sought to testify were of Hispanic origin, some coming from as far away as El Paso. When they returned home, they were harassed by Immigration and Naturalization Service personnel. Danny Casolaro was killed on August 10, 1991, as he was obtaining evidence of corruption linking Justice Department officials to INSLAW, October Surprise, and BCCI. He was a Washington-based freelance reporter, and was killed in the Sheraton Hotel in Martinsburg, West Virginia. After Casolaro was killed, his body was embalmed before the family was notified, violating state and county rules and blocking a thorough autopsy, which might have revealed incapacitating drugs. Alan D. Standorf was murdered on January 4, 1991, and his body found on January 31, 1991, in the back seat of a car parked at the Washington National Airport. Standorf was a source of information for Casolaro. CIA operative Michael Reconnaissance had introduced Casolaro to Standorf. It is believed that Standorf, an electronic intelligence employee for the National Security Agency, was a key source for some of the information obtained by Danny Casolaro linking the Justice Department to the various parts of the scandals. Casolaro had previously told a friend, Bill Turner, that a key source of information on the scandals that he was investigating had disappeared. 468. Attorney Dennis Eisman was shot to death in April 1991, 24 hours before he was to meet with Michael Reconnaissance, who was involved in numerous CIA activities, including October Surprise and INSLAW. Eisman was building a defense for Reconnaissance against the charges filed by Justice Department prosecutors as they sought to silence him. Shortly before Eisman was killed, he was to meet in Philadelphia with a woman who would deliver to him important evidence of corruption by Justice Department officials. Attorney John Crawford, one of the attorneys who worked with Reconnaissance, died from a heart attack in Tacoma in April 1993. This death raises questions, since he was one of several attorneys and investigators working with Reconnaissance to die within a relatively short period of time. Paul Maraska was working with CIA operative Michael Reconnaissance. He opposed and started to expose corrupt activities carried out by the CIA and CIA contract agent John P. Nichols, and which included the Wackenhut Corporation, including George Wackenhut. He was killed in January 1982 in the San Francisco condo that he shared with Michael Reconnaissance. Larry Guerin, a private investigator, was killed in Mason County, Washington in February 1987, as he conducted an investigation seeking evidence for Michael Reconnaissance relating to the INSLAW scandal. Alan Michael May was killed in his San Francisco home on June 19, 1991. May was involved with Michael Reconnaissance in the October 1980 movement of $40 million bribe money to Iranian factions. May had requested that Reconnaissance not divulge May's ties with the Iranian hostage scandal out of fear for his life. Within 4 days after the Napa Sentinel published Reconnaissance's description of the October Surprise operation, May was killed. The local coroner's report stated death was due to a heart attack. However, a subsequent autopsy revealed that May had polypharmaceuticals in his system. Vala Delahanty disappeared on August 18, 1992, as she was trying to warn Michael Recanati Otto about a plan by DIA and Justice Department officials to set him up on a drug charge. The skeletal remains of her body were discovered in a ravine at Lake Bay, Washington on April 13, 1993. Her disappearance and death prevented her from testifying on behalf of CIA agent Michael Recanati Otto and against the Justice Department and DIA. Delahanty's sister, Debbie Baker, told me that Volley had called her shortly before her disappearance and stated that she had very sensitive information concerning the Inslaw matter and the DIA and Justice Department's attempt to falsely imprison Recanati Otto. Volley reportedly wrote to Recanati Otto stating that she had information showing the DIA agent Hurley was working with John Munson to set up Recanati Otto. Volley was an alcoholic and was living with Munson. The evidence strongly indicates that Munson collaborated with DIA and Justice Department personnel to frame Recanati Otto on sham amphetamine manufacturing charge. Several months before Volley's body was found, Munson reportedly told people at a local bar, while he was under the influence of alcohol, that she was dead. Later discovery of her body proved him correct. Pete Sandvigen, who resided on Whidbey Island in Washington, was ready to leave from the Navy Air Station on Whidbey Island, as part of further investigation into Inslaw. His body was found on December 2, 1992. The gun, 469, that he carried was found without the ammo clip, raising questions. Sandvigen had been part of a 26-man CIA team in Afghanistan during the late 1980s. He tried to help Recanati Otto defend against the Justice Department's amphetamine charges, along with exposing the Inslaw scandal. Alfred Alvarez and two friends who were part of the Cabazon Indian Reservation, were killed in July 1981. Alvarez opposed the operations and takeover of the Indian Reservation by the CIA Front, Wackenhut Corporation. Deaths in the family of former FBI agent Darlene Novinger. Novinger said to me that she discovered during an FBI investigation that Vice President George Bush and two of his sons were using drugs and prostitutes in a Florida hotel while Bush was vice president. She said that when she reported these findings to her FBI supervisors, they warned her not to reveal what she had discovered. Novinger had been requested to infiltrate drug trafficking operations in South America and the United States. She was pressured to quit her FBI position. Her husband was beaten to death, and 4 hours after she appeared on a July 1993 talk show for describing her findings, her father mysteriously died. A dead white canary was left on his grave as a warning to her. After receiving death threats, she went into hiding, from where she occasionally appeared as guest on talk shows, and called me from undisclosed locations. Attorney David Meyer was killed by gunshot on February 6, 1989, in the San Francisco Bay Area. On February 7, 1989, he was to have appeared in the U.S. District Court at San Francisco before Judge Paul Vukasin, Jr. 458 defending people in drug-related charges that were reportedly tied in with covert CIA drug trafficking activities. Meyer was an activist seeking to expose the Contra-drug connection involving the Reagan-Bush administration, the CIA, Justice Department officials, and others. His investigation and files disclosed links between high federal officials and associates, and a number of major federal crimes. Abbie Hoffman was reportedly killed in his home on April 12, 1989, just prior to delivering a manuscript on the October surprise operation to Playboy's Chicago offices. Wife of DIA drug pilot Basil Abbott was killed in Europe in 1982 after talking to European reporters about the DIA drug trafficking operation into the United States. She sought publicity to obtain the release of her husband who had outlived his usefulness to the DIA. Barry Seal, pilot for the DIA and CIA, shot to death on February 19, 1986, after he learned too much about the drug smuggling operation and threatened to reveal what he knew. Robert Maxwell died after falling or being thrown off his yacht shortly after his role in the Inslaw affair was publicized. He had considerable knowledge and/or participation in U.S., Israel, and British intelligence agencies, in Inslaw, and other areas associated with assassinations and mysterious deaths. 457 Tom Valentine, Radio Free America. 458 A friend of Earl Bryan, Edwin Meese III, and other parties implicated in October Surprise, Inslaw, Chapter 11 Corruption, Justice Department pattern of cover-up, are all part of the Reagan-Bush coterie. 470. Charles McKee and other Defense Intelligence Agency agents on Pan Am Flight 103 died when the plane was blown apart over Lockerbie, Scotland. McKee's team was returning to Washington, in defiance of orders, to give testimony to Congress on the CIA and DIA drug trafficking activities. Reported assassination of 3 Navy officers on the evening of April 30, 1991, at Fort Ord, California, including Admiral John D. Burkhart, Captain Samuel J. Walters, and a female Navy officer, whose first name was Marilyn. John David Pigg was killed in July 1993 in Anadarko, Oklahoma. He was a CIA agent involved in a major heroin operation involving several federal agencies. *5. Through San Francisco and other key U.S. cities, which is discussed in more detail in later pages. He reportedly wanted to get out of the operation, and it was suspected that he constituted a threat of exposing the multi-billion-dollar-a-year operation. William Casey, director of the CIA, a key participant in the October Surprise operation and its related Iran-Contra arms and drug activities. He experienced seizures on the morning that he was to testify before the Senate Intelligence Committee and underwent brain surgery. He died several months later on May 6, 1987. Friends believe that Casey would have told the truth if he had testified, thereby implicating people in high positions. CIA operatives have told me that the rumor within the CIA is that Casey's medical condition was induced by drugs. Former Senator John Tower was killed in a plane crash at New Brunswick, Georgia on April 5, 1991, just as the October Surprise scandal was again surfacing. Tower was involved in the October Surprise and Iran-Contra operations, as was his aide, Robert McFarlane. Thomas Wilhite threatened to expose the CIA role in Bishop, Baldwin, Rewald, Dillingham, and Wong to newspaper reporters. He died in a plane crash within 24 hours of announcing his intention to blow the whistle. Wilhite was a friend of Ron Rewald, who was the fall guy when its cover was blown by a Honolulu television reporter. Who were the assassins? The people or groups responsible for the assassinations, according to my CIA contacts, included teams within the intelligence community and the FBI. 2 of my sources who were close to the assassination teams in the CIA were Gunther Russbacher and Commander of Navy SEAL Team 2, Robert Hunt. These activities are described in other pages, and their description of the assassination teams showed that the intelligence agencies have separate fiefdoms, and that some of these fiefdoms had their own assassination groups. They even targeted other CIA personnel. Several of my CIA contacts described an FBI agent noted for his assassination activities and how they feared him, Charles Chucky Peters, employed by the Federal Bureau of Investigation in the Chicago area. Russbacher told me about the assassination orders that he had to carry out during his CIA career. He said one of the termination operations. 459 Central Intelligence Agency, Drug Enforcement Administration, Customs, U.S. Department of Justice. 47. Was called the Omega Plan. Another one of my sources formerly with the ONI and CIA described the assassination operation known as Operation Ringwind, in which he trained some of the assassinators. Killings occurring in foreign countries. Francis John Nugan operated a covert CIA proprietary known as Nugan Hand Bank in Australia. After the cover was blown on Nugan Hand by a Hong Kong financial reporter, Nugan was found shot to death, holding a rifle with an unspent bullet in the bolt-action operated chamber. Nugan had information on CIA links to money laundering, drugs, and other criminal activities that threatened to expose a fundamental operational pattern. House Hanglavi worked with Iranian arms dealer Cyrus Hashimi on covert arms sales to Iran. Shortly after trying to obtain documents establishing arms sales between the United States and Iran through Israel, an assassination attempt was made on his life. Anson Ng was shot to death a month before Casolaro's murder. Ng was in Guatemala working for Financial Times to interview Jimmy Hughes, who had important information on misconduct relating to murders occurring on the Cabazon Indian Reservation. Hughes had fled to Central America to escape the fate of other informants who had been killed or prosecuted by Justice Department officials. Jonathan Moyle was a journalist investigating the sale of military equipment by arms merchants in Chile to Iraq as part of a CIA operation. Moyle was killed in April 1990 while in Santiago, Chile. Arnold Raffel was one of several top officials in the Carter administration participating in the October surprise operation. He was killed in a plane crash with Pakistani President Mohammad Zia-ul-Haq in which sabotage is suspected. Mohammad Ali Rajeh, a former Iranian official, reportedly met with George Bush and William Casey on October 18, 1980, just prior to their flying to Paris to formalize the October surprise agreement. Rajeh was killed in a bomb blast in his Tehran office. Cyrus Hashimi was a key party in the October surprise operation and was killed after telling a reporter that his arms sales to Iran were part of the October surprise operation. Mehdi Hashimi was head of Khomeini's Office for Export of Militant Islamic Fundamentalism and a part of the October surprise operation. He was executed in Iran on September 21, 1987. Shapur Bakhtiar was an Iranian living near Paris who had evidence proving the existence of the October surprise operation. He was killed on August 6, 1991. Hassan Sabra, chief editor of the Lebanese weekly Al-Shira, who had been exposing the October surprise and arms for hostages operation, was shot on September 21, 1987, the same day that Mehdi Hashimi was executed in Tehran. Sadiq Ghatbzadeh was foreign minister of Iran during the Iranian hostage crisis. He negotiated with the CIA in the October surprise operation. Ghatbzadeh encouraged Ayatollah Khomeini to go along with the October surprise scheme advanced by the Americans. In October surprise, Secretary of State Alexander N. Haig's aide, Michael Ledeen, tipped off the Khomeini regime to an alleged coup attempt involving Ghatbzadeh, resulting in his death. Ayatollah Mohammad Beheshti reportedly sent a representative to the October 1980 Paris meeting. Beheshti was killed by a bomb explosion at the Islamic Republic Party headquarters in "Was going to use me after I had been sanctioned by the agency. He was going to use me to put a cap in his head and become the new governor of the state of Missouri. But it didn't work." I asked, when you had to pay him off, what was he doing, looking the other way as it related to the CIA proprietaries? Russ Bacher responded, "Sure. Absolutely." Russ Bacher said to me that Missouri Secretary of State Blunt worked with the CIA in the past in covert activities, and that he and other CIA personnel paid Blunt bribe money to carry out CIA proprietary activities. One of the significant aspects of the letter was how state prosecutors and officials criminally misused government offices against private citizens and brazenly put into writing details of the scheme, confident that no state or federal officials would prosecute. That is what always astounded me through the 30 years of discovering major corruption implicating federal officials. None ever feared prosecution for their crimes. The letter revealed that the sham charges were return of a favor to a Mr. Christian, and that the prosecuting attorney 464 Southwest Latex Supply was a spin-off from National Financial Services Corporation. National Financial was to buy the stock from Southwest Latex. Because they were not registered, the trade was not outside of Southwest Latex and considered a violation of the Blue Sky Law. National Financial Services provided the money to start up Southwest Latex Supply and it was considered a daughter corporation from NSF. 465 Russ Bacher stated that Southwest Latex Supply manufactured the 5-gallon buckets used to package the C4 explosives sold by CIA agent to Libya. 478. Carrying out his part of the conspiracy would be rewarded with a judgeship * copyright. State of Missouri. Office of Secretary of State. Jefferson City, 65102. Roy D. Blunt. Secretary of State. May 14, 1989. 2. Scott S. Sifferman. Prosecuting Attorney. Lawrence County Courthouse, Mount Vernon, Missouri 65712. Re. Southwest Latex Supply. Dear Mr. Sifferman, I have tentatively set my schedule to be in Mount Vernon on June 14, 1989. We will need you to do the following. 1. Have the charges ready to be filed for selling unregistered securities, fraud, and commingling of funds. Please forward for my review. 2. Schedule Press and Miller People. 3. Itinerary. As you have seen, we have no grounds for these charges, but I owe one to Christian, and, with full press coverage, I should pick up some strong support in Webster's stronghold for 1992. I have spoken to the Lawrence County Republican Committee. They have assured me you will be recommended for the judgeship after the charges are filed. I will personally make the statements to the press, and they will not have any credibility after that. Pursuant to our conversation, we should set the bond high, and you can advise Mr. Tatum. He can then present our scenario. You and John can handle it from there. Sincerely, Roy Blunt, Secretary of State. The rewards. The prosecutor who assisted in carrying out the scheme, Scott Sifferman, was later appointed a judge in the state of Missouri, as promised. Russ Bacher said that other state officials who participated in the scheme that eventually resulted in his state imprisonment included State Prosecutor Scott Zimmerman, who prosecuted Russ Bacher knowing the charges to be false, William Webster, a nephew to former FBI and CIA Director William Webster, former Missouri Governor John Ashcroft, former LT Governor Mel Carnahan. On August 15, 1993, I sent a copy of the Blunt letter to Missouri's Secretary of State, Judith Moriarty, requesting a clean copy of the letter I sent and which should be in their files. She never responded, and I sent another request on September 3, 1993. Obviously, a letter by a prior Secretary of State outlining a plan to charge a person with a crime, for which that person is currently in prison and which admits in its contents that the charges are false, isn't the type of letter that a state official wants exposed. No response to either letter. I sent a letter to Missouri's Governor Mel Carnahan on October 1, 1993, requesting his assistance in obtaining a copy of the Blunt letter. Carnahan was LT Governor of Missouri during the 1989 scheme to incarcerate Russ Bacher, and was a close friend to the writer of the letter, Roy Blunt. The governor had a vested interest in preventing exposure of the Blunt letter. The Missouri governor had the power to pardon Russ Bacher, and I demanded that he do so. Other ways of keeping government crime secret. A reminder, Justice Department prosecutors have a standard tactic to silence whistleblowers, concerned citizens, covert operatives who know too much about high-level criminal activities. The technique is to falsely charge the individual with a federal offense, suborn or reward witness to testify falsely, and file charges against a wife or aged parent. In addition, have a federal judge, often a former Justice Department attorney, bar the defendant from calling key witnesses such as CIA personnel, and block the introduction of documents on the excuse of national security. It works like a charm, in sending innocent people to prison and protecting high-level officials from having their participation in criminal activities become exposed. A small sampling of victims that I encountered include such intelligence community assets as Gunther Russ Bacher, Ronald Rewald, Richard Brennicke and Heinrich Rupp, Oswald L. E. Winter, Richard Craig Smith, Lester Coleman, Basil Abbott, Michael Maholey, Russell Bowen, Terry Reed and his wife, and many others. 480. Judicial immunity given to corrupt prosecutors. An article in the San Francisco legal newspaper Daily Journal described the judicial immunity given to corrupt prosecutors. The article stated in part, prosecutorial misconduct is encouraged if not indirectly condoned by pervasive judicial abstention and buck passing. Dismiss a case based on prosecutorial misconduct, they rarely do so, either finding the wrongdoing harmless or suggesting that alternative remedies such as contempt. This is intellectually dishonest and an abdication of courts' duty to preserve the integrity of the judicial system in proceedings before them, it is well documented that in reality there is no effective sanction for prosecutors who engage in unethical conduct. Recently, the House Committee on Government Operations investigated 10 cases in which federal judges found that very serious prosecutorial misconduct had occurred. This misconduct included violation of grand jury rules, violation of defendants' Fifth and Sixth Amendment rights, knowing presentation of false information to the grand jury, and mistreatment of witnesses. The committee's report notes that courts often do not themselves take disciplinary action but defer to the Department of Justice, which is much like the fox guarding the chicken coop. The report documents the fact that the Justice Department effectively ignored the court's findings of governmental abuse, and that not one of the individuals involved was sanctioned, thereby raising serious questions regarding what the department considers prosecutorial misconduct. There is virtually nothing that an aggrieved party can do when a court declines to sanction unethical government conduct, because prosecutors are absolutely immune from suit. In Imbler v. Pacman, 424 U.S. 409, 431, the Supreme Court ruled that a Los Angeles deputy district attorney who intentionally suborns perjury cannot be sued by the defendant who is wrongfully convicted even after the conviction is reversed. Although this immunity does leave the genuinely wronged defendant without civil redress against a prosecutor whose malicious or dishonest action deprives him of liberty, the Supreme Court, quoting an earlier case, decided that it is better to leave unredressed wrongs done by dishonest officers than to subject those who try to do their duty to the constant dread of retaliation. In other words, it is better to have people go to prison, sometimes for life, by the lying or misconduct of prosecutors, rather than hinder the prosecutors in their prosecution of other people, many of whom may be innocent. Chapter 21. Federal Government. As a criminal enterprise. Government were, and are, either directly involved in the activities described within these pages, or were involved in the cover-up. Either way, these are criminal acts for which prison sentences are provided. Their dereliction of duty, their aiding and abetting, their complicity of cover-up, caused and made possible the infliction of incalculable harm upon the American people. As stated in the 1978, 1980, and 1990 editions of Unfriendly Skies, and more so in the several editions of Defrauding America, at the epicenter of the corruption described within these pages are attorneys and officials in the U.S. Department of Justice and federal judges. Without their criminal conduct, none of these criminal activities could have been perpetrated or continued. The same applies to the mainstream media and to members of Congress, all of whom played key roles in the obstruction of justice. Organized crime in the U.S. Justice Department. The heading in the Forum section of the Sacramento Bee registered read Organized Crime in the U.S. Justice Department, accurately reflecting the decades of criminality in the most misnamed agency of the federal government. The article stated in part, indications point to a widespread conspiracy implicating government officials in the theft of INSLAW's technology. INSLAW, bad as it was, constitutes only the tip of the iceberg. For 30 years, Justice Department attorneys blocked every attempt that I made to report the government corruption that I initially discovered as a federal investigator. With thousands of investigators in the Department of Justice, these people in control of key positions in the three branches of the federal crimes could not have escaped detection. My letters and my federal actions made certain that they knew of the federal crimes. If my reports of the pattern of criminality had received the reaction in the three branches of the federal government and from the media that a properly functioning government requires, there could not have been the epidemic corruption that now exists in government. Even now, the criminal activity continues and increases in frequency and severity as the public concerns itself with such trivia as ball games, a whale trapped in the Arctic ice fields, or an endangered species of cockroach being threatened by much-needed development of natural resources. Thousands of people have been financially destroyed and their lives made miserable by the coordinated theft of their assets in Chapter 11. Many deaths in fraud-related airline crashes would not have occurred if Justice Department attorneys had not engaged in the cover-up. Decades of financial deprivation and financial problems for individuals and the United States itself will result from the savings and loan debacle. Responsibilities of Justice Department under federal law. The responsibility for ensuring that the laws of the United States are properly enforced falls to the United States Department of Justice, which is under the control of the U.S. Attorney General. He or she is appointed by the President of the United States. In practice, the Attorney General routinely misuses the Justice Department to protect the criminal acts of those who appointed him or her. Responsible for protecting the civil rights of American citizens within the U.S. Department of Justice are numerous divisions. These include, for instance, the Federal Bureau of Investigation, responsible for investigating the many crimes that I reported to it, the Civil Rights Division, with the responsibilities to investigate the civil rights violations that I reported to them, the Criminal Division, responsible for preventing the many criminal activities that I reported to them, the U.S. Trustee, who is responsible for preventing the rampant fraud in bankruptcy courts that I and others reported to that office, the Drug Enforcement Administration, responsible for preventing the massive drug trafficking, including that committed by the CIA and DEA. This is the Justice Department that has persecuted me continuously since mid-1987, retaliating against me for reporting the federal crimes that I uncovered, who retaliated against me for exercising lawful and constitutional protections to halt the barrage of civil and constitutional violations inflicted upon me. Every one of these divisions has been routinely used to commit the federal crimes that they have a duty to prevent. Succession of corrupt attorney generals. A succession of attorney generals have been implicated in corrupt acts and federal crimes, but have escaped prosecution because they held the highest law enforcement position in the United States. Attorney General John Mitchell, for instance, went to prison for his activities. Subsequent attorney generals have 483 committed federal offenses involving far more serious crimes, and were never prosecuted or called to task by the checks and balances in government. Attorney General Edwin Meese, a former California attorney and Alameda County District Attorney, was prominently associated with an escalation of the sleazy and corrupt activities in government. He was implicated in the 1980 October surprise scheme that helped bring the Reagan-Bush team into power. As a reward, or to protect the Reagan-Bush team from prosecution in that scandal, the Reagan-Bush administration appointed Meese U.S. Attorney General. Meese was then used to protect Reagan and Bush from the October surprise scandal and others that followed. In addition to the October surprise criminality, Justice Department officials misused this powerful agency to steal the software from the INS people, showing their corrupt mindset. This was followed by protecting the rampant drug trafficking into the United States by the CIA and DEA. In every area of major criminality implicating federal personnel, Justice Department attorneys and officials have engaged in obstruction of justice and other crimes of cover-up. When the stench from Meese's activities forced him to resign, he was replaced by Richard Thornburg, who continued the criminal activities of INS law, the obstruction of justice activities, and the persecution of whistleblowers and informants. Thornburg left the Attorney General position in 1991 to run for the Senate seat vacated by the death of Senator John Heinz in a plane crash in Philadelphia. A Pennsylvania newspaper identified Thornburg as the Harrisburg Mafia. President George Bush, who had a long-time relationship with the CIA, then appointed 46. William P. Barr as U.S. Attorney General. Barr was general counsel of the CIA while Bush was director of the agency. From the very beginning, Barr blocked investigations into the major scandals that were surfacing almost daily, including those that directly involved the Justice Department and the CIA. Barr has a long history of CIA relations. Barr blocked an investigation of the part played by Justice Department officials in the INS law affair, denying the request by the House Judiciary Committee for an independent prosecutor. 4 Barr refused to appoint a special prosecutor to investigate the White House's funding of Iraq's military build-up. Barr refused to appoint an independent prosecutor to investigate the White House's role in the Bank of Lavoro scandal. He refused to appoint an independent prosecutor to investigate INS law. The House and Senate Judiciary Committees had requested the Attorney Generals to request appointment of an independent prosecutor in each of these matters. Previous involvement in major criminal activities. It has been a common practice to appoint someone to the highest law enforcement position in the United States who has been involved in criminal activities, and act as damage control. Before William Barr was appointed U.S. Attorney General by President George Bush, he was legal counsel for the CIA's Southern Air Transport, and former CIA operative Terry Reid said that he 469 October 27, 1991. 470 sometimes called independent counsel. 484. Personally saw Barr in drug-related activities. Another source, Gene Tatum, also personally encountered Barr in similar activities. This same general practice is applied to the political selection of federal judges who then act to block any prosecution or revealing civil actions. Bush was heavily involved in the overall drug smuggling activities, acting with Oliver North and other drug traffickers, and it would be only normal to put one of their own at the head of the nation's top law enforcement agency. Further, U.S. attorneys are selected to ensure that this plan works. This problem reflects one of the major flaws in our Constitution. It was visibly reflected during the presidency of Ronald Reagan, George Bush, and Bill Clinton. Prosecuting federal judges who don't cooperate. Justice Department attorneys, misusing the power of the U.S. government, have tremendous ability to destroy persons who threaten to expose their dirty games. U.S. Attorney Joseph Rossaniello at San Francisco charged U.S. District Judge Aguilar in June 1989 with misusing his judicial position, IFA racketeering enterprise, and obstructing justice. What did Aguilar do? He allegedly made false statements to an FBI agent who talked to the judge on the beach at Waikiki during a Hawaiian vacation. He also suggested to an attorney the use of a particular defense in the trial of Aguilar's brother-in-law. Also, Aguilar told his brother-in-law not to call him because the brother-in-law's phone may be tapped. The real reason for prosecuting Aguilar for these relatively minor offenses, compared to the monumental offenses committed by other federal judges and Justice Department officials, was that Aguilar often disagreed with the Justice Department prosecutors in judicial proceedings. Aguilar halted the deportation of refugees that Justice Department attorneys wanted deported. He also engaged in a heated argument with U.S. Attorney Rossaniello in open court, threatening Rossaniello with contempt of court. Unlike the continuing Justice Department and judicial corruption, no one was harmed by Aguilar's acts and he made no money or profited in any way. Compare the alleged offenses charged against Judge Aguilar with the pattern of obstruction of justice and felony persecution of informants by Justice Department personnel, or the FBI's pattern of lying to grand juries and trial juries. Another judge charged with a crime by Justice Department officials was former U.S. District Judge Claiborne in the Las Vegas District Court, who was noted for rendering decisions contrary to those wanted by the Justice Department. Claiborne's accountant had failed to list the profit made on one of several real estate transactions on his income tax report. Justice Department prosecutors then charged Claiborne with income tax evasion. The mere investigation by the FBI arm of the Justice Department can cause a member of the U.S. Senate and House to lose an election. The Justice Department can easily fabricate charges, especially conspiracy or misprision of felony offenses, by stretching facts clearly out of proportion to reality. Possibly the fear of what the Justice Department can do was one of the reasons every member of the U.S. Senate from 1991 to 1993 refused to respond to my multi-485-page petition to investigate the corruption I brought to their attention. But this was no excuse for them aiding and abetting the criminal activities. They had a duty to perform. When they accepted their position, they assumed the responsibilities that went with the pay, the perks, and the prestige. Pattern of criminal activities by Justice Department attorneys and officials. For 30 years I have been intimately connected with the criminal acts committed by Justice Department officials and their various divisions. Their misconduct in the 1960s, which I initially discovered while a federal investigator, had devastating consequences in the aviation areas that I brought to their attention. Since then, as these pages reveal, the criminality in the U.S. Department of Justice has increased many times over, very possibly making it the key cog in the pattern of racketeering activities against the American people. If Justice Department personnel did, in fact, do any of the acts described within these pages, these same personnel would have to misuse the power of the federal government and of the Justice Department to block the reporting of these crimes. These Justice Department attorneys have made it standard practice to misuse Justice Department facilities to falsely charge dozens of informants and whistleblowers with federal offenses to block their reporting of crimes implicating federal officials. Placing a young lady in prison. A federal judge sentenced a young lady to federal prison for failure to remember details of stock transactions that happened several years earlier while she was a stockbroker for Drexel Burnham Lambert. Lisa Jones, a 24-year-old dropout and runaway who became financially successful at the Wall Street investment firm of Drexel, was one of the first witnesses called by Justice Department attorneys investigating insider trading and other security violations at Drexel. She refused to fabricate testimony requested by Justice Department attorneys, who then retaliated when she could not remember details of the stock transactions. Justice Department attorneys charged her with perjury and, would you believe, obstruction of justice. Lisa Jones was victimized in the battle between Drexel and Justice Department attorneys and sentenced to 18 months in federal prison. The young woman suffered the indignities accompanying federal imprisonment, including frequent transportation with leg irons, handcuffs, and body cavity searches. Lisa Jones joined the many thousands of citizens who became victims of Justice Department and judicial corruption and, understandably, developed psychological problems. After all this, Drexel's attorneys sued the young lady for payment of legal fees that Drexel had agreed to pay. In response to Drexel's claim that they would sue Ms. Jones for the amount of money that they had advanced, San Francisco attorney Daniel Buchan stated, "It is inconceivable to me that Drexel would sue Lisa after all that she's gone through, and in view of her serious psychological problems." All issues of compassion and decency aside, however, one simple fact seems certain: Lisa has virtually no assets. She could not even begin to repay the cost of her legal representation. 486. Sending senior citizens to prison. Justice Department prosecutors charged Leona Helmsley with evading income taxes and sentenced the 72-year-old woman to 4 years in federal prison, leaving behind her 81-year-old husband who could be expected to be dead before she would be released. Helmsley's accountants had claimed as business expenses charges that Justice Department attorneys considered personal items. Helmsley's income tax forms were made out by professional tax preparers, who determined that the deductions were business-related. The accountants who made that determination were never charged with any wrongdoing. Helmsley paid over $4 million federal income taxes in the disputed tax year, and the amount owed by the disputed charges was a very small percentage of that amount. Seeking to show that the judge who sentenced Helmsley to prison did himself commit a serious federal crime, I mailed to the federal judge on April 25, 1992, a list of the criminal activities that my CIA sources and I were trying to report, and demanded that he receive our testimony and evidence. I reminded him of the mandatory requirements that we give our evidence to a federal court and that the court receive it. 47 He refused to receive our evidence. While aiding and abetting and covering up for the serious crimes, and sending informants to prison, Justice Department prosecutors found time on December 15, 1992, to indict Bobby Fischer for playing a chess game in Yugoslavia, charging him with violating the presidential order barring business relations with communist countries. 10 years for a telephone conversation. On December 7, 1990, Judge Samuel Conti sentenced a young black girl from Oakland, California, the mother of 2 infants, to 10 years in prison on a conspiracy charge. The young girl had a telephone conversation with another person concerning the sale of drugs. The conversation never went any further, but federal agents, monitoring the phone call, charged the girl with conspiracy. She was in tears when U.S. Marshals drove her back from the federal courthouse in San Francisco to the Dublin Federal Detention Center after Judge Samuel Conti sentenced her to 10 years in a high-security prison. This same judge played a major role in blocking my exposures of the criminal activities and in protecting the many people who were implicated in the attacks upon me. He, as with many other federal judges, should be impeached and sentenced to a long prison term. But this will never happen because crooked federal judges and Justice Department attorneys have a stranglehold on the justice system. Prison for refusing to commit perjury. Justice Department prosecutors charged a Sacramento area real estate developer, Marcel Cordy, with a federal offense for refusing to testify falsely against a bank official whom Justice Department prosecutors wanted to convict. U.S. Attorney David Levi of Sacramento wanted Marcel to testify against a bank official and alter the facts in his testimony. Marcel was willing to testify.